ಆಯ್ತು ಕೊಡಿ ಕೊಡಿ ಸರ್ 230 ಇಲ್ಲ.
My lords, 482 petition, my lords, under.
Can you please?
Yeah, please, sorry, my lords.
Yes. Can you please wait? ಕೊಡಿ ಆಯ್ತು. ಹಾ ಹಿಂದೆ ಬರಬೇಡಿ, ಫಸ್ಟ್ ರೋ ಮಾತ್ರ ಹೇಳಿ. Move the vacation bench. Yes. Move the vacation bench. ಏನಾಗಿದೆ? ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ? ತಗೊಳ್ಳಿ. 420 ಬೇಲ್ ತಗೊಳ್ಳಿ. ಎಸ್ ಸರ್. ಎಸ್. ನೋ ಸರ್. ಸಾರಿ. 376. Give it. Yes. 230. Yes. ಅವ್ರದ್ದು ಕೊಡಿ 230ಗೆ ಕೊಡಿ. ತಗೊಳ್ಳಿ. ಫ್ರೈಡೆ, ನಾಟ್ ಟುಮಾರೋ. ಅದಲ್ಲ ಇದು 230 ತಗೊಳ್ಳಿ. ಈಗ ಫ್ರೈಡೆ ಸರ್. ಆಯ್ತು ಕೊಡಿ. ನಿನ್ನೆಯಿಂದ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಯಾಕೆ? ವೆಕೇಶನ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ ಕೊಡಿ. ತಗೊಳ್ಳಿ ಪ್ಲೀಸ್. ಫ್ರೈಡೆ. No, don't join there. Wait. First room mugili first. Hinde barbadi. Wait. I'll come back to you. Yes. Withdraw madidira. 230 ಗೆ ತಗೊಳ್ಳಿ. Wait, Raju. Wait. ನೀವು ಹಿಂದೆ ಇದ್ರಿ. Wait. When do you want? Tomorrow 230 settlement ಕೊಡಿ. Yes, Sarvana. At 230. Friday. ಯಾವತ್ತಿಗಿದೆ? Friday is before Saturday ಅಲ್ವಾ? ಕೊಡಿ. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಕೊಡಿ. ಫ್ರೈಡೆ. ಎಸ್. ಪಿಟಿಷನ್ ದಿ ಫಾದರ್ ಇನ್ ಲಾ 498 ಓಪನ್ಸ್. ಆಮೇಲೆ ಸೊ ವಾಟ್ಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ ಸರ್? ಬೇಲ್ ಇಲ್ವಾ? ಮೂದಬೇಕು ಎಲ್ಲ ಸುಮ್ಮನೆ. ಡೋಂಟ್ ಪ್ರೊಜೆಕ್ಟ್ ಸೂಡೋ ಅರ್ಜೆನ್ಸಿ. ಧಾರವಾಡ. ಡೋಂಟ್ ವರಿ. ಎಸ್ ಕೊಡಿ. ಎಸ್ ಫ್ರೈಡೆ. ಓ ಟ್ರಾವೆಲ್ ಫ್ರಮ್ ಧಾರವಾಡ. ಧಾರವಾಡ ಇಸ್ ನಾಟ್ ಡೆನ್ವರ್ ಸರ್. ಎಸ್. ಆಲ್ ರೈಟ್. 230. ಎಸ್.
Petitioner sir, father-in-law, mother-in-law and sister-in-law. Judgment. 198.
Friday.
Thursday.
Friday. Thursday is tomorrow. We'll have it on Friday.
Thursday.
No sir. Friday. Yes.
I'm a 25-year-old.
No. Second row. Wait. Yes. Tyson?
Petitioners employed in Taiwan. This matter was listed date it was directed to be listed today. It was directed to be listed today. However, it has not come up. Lots.
Not madam.
230.
Wait. If it was date was given for today and not come. Wait.
It was given for today,
Wait,
because the charge sheet was filed and we made an application.
Oh, that you withdrew and.
Yes, ma'am.
Madam. 230.
Please.
Second row. Please wait.
My lords, the petitioner is the doctor, my lords. Offence is registered under 13B, my lords. And all the bank accounts has been freezed by the Lokaayukta, my lords. And the issues, my lords.
Lokaayukta.
Yes, my lords. There's a raid conducted, my lords, and they're issuing notice after notice, my lords. All the bank accounts, even including the children, it's freezed, my lords.
Friday.
Request for 230, my lords.
No, madam.
My lords.
Freezing of bank accounts.
The mobiles are
Friday,
also freezed by them, my lords.
Friday.
I'm requesting for tomorrow, my lords.
Friday, madam. Take that Friday.
Milord, it's a 482 petition. Recently, Milords have heard illegal mining case where I have been wrongly accused. They have invoked IPC sections. The similar case has been filed in MMDR.
What's the urgency, madam, in that?
Same refer order.
Oh, no, application.
My lord, in this matter, my lordship has stayed the matters as far as the company is concerned, my lord. Now the police are going behind the directors, my lord, and harassing them.
Move it.
My lord, please, my lord, tomorrow.
Or Friday, give it.
Your Lordship, the accused in this present case is a student, Your Lordship. Both the complainants and the accused are involved in politics. So just
Politics.
to, the Swami, running around for politics. The accused number 2 is the father of the accused number 3.
ಈಗ ಏನಾಗಿದೆ?
Accused number 3, Your Lordship, the son, just to take vengeance against the father, they arrayed him as the accused. On MBA, he's been selected for the MBA course in the University of Greenwich. January, go back, Swami. We've been
Alright,
moving the
Friday,
matter. Friday, please. Friday.
Domestic violence, trial court 60,000 ordered for maintenance, my lord. And on appeal, my lord, it has been enhanced to 120,000, even
After
attachment.
vacation.
Attachment of
After
property.
vacation.
My lord, attachment
No
of property.
adjournment. Move the vacation bench.
My lord, attachment of.
No, sir. Husband, move the vacation bench. Yes. 7A. We'll see. 7As are today. We'll see. Kodi madam. Listing of the case cannot be successful. We'll see. No. Usually charge sheet, no problem. Don't worry.
Being spoken to, my lord, interim order was subject to payment of cost, my lord, 125 CRPC cost. My lord, Lordship said, "Vidre extend agutte," but it has been vacated, my lord.
No problem. Yes.
My lord, I have already paid, my lord. It was
ನಾಳೆ
posted.
ಹಾಕಿ ಮಾಡಿ. Being spoken. ಅದು ತಗೊಳ್ಳಿ. Yes. 354A. 230. Yes. 230 ತಗೊಳ್ಳಿ. ಆಯ್ತು, ಈಗ ಸೆಕೆಂಡ್ ರೋಲ್ ಯಾರಿದ್ದಾರೆ ಕೊಡಿ. ಎಲ್ಲರೂ ಫಸ್ಟ್ ರೋ ಆಗಿರೋದೆಲ್ಲ ಹಿಂದೆ ಹೋಗ್ಬಿಡಿ. ವೈ ಆರ್ ಯು ಸ್ಟಿಲ್ ದೇರ್? No, one is enough. Go back. You move back. Allow others to move the memo. Move back. Huh? $230. ಒಂದು ನಿಮಿಷ ಒಟ್ಟಿಗೆ ಯಾಕೆ? ವಿಡ್ರಾಲ್ ಕೊಡಿ. When was it? Move the vacation bench, sir. Move the vacation bench in 311 application. Yes, next. Move the vacation bench. Yes. ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಾ? ಯಾಕೆ ತಗೊಂಡಿಲ್ಲ? ಬೇಲ್ ತಗೊಳ್ಳಿ. ಎಸ್. 420 ಏನ್ ಅರ್ಜೆನ್ಸಿ ಸರ್? ಕೊಡಿ. ಎಸ್. ಫೈವ್ ನಾಟ್ 506 ಸರ್. ಅದಕ್ಕೇನು ಅರ್ಜೆನ್ಸಿ ಸರ್? ಅದು ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರ ಅದರಲ್ಲಿ. Move the vacation bench. Yes. Move the vacation bench, sir. Yes, next. ಅದು 4 ದಿನ older he'll become ಅಷ್ಟೇ, nothing else. Yes. Move the vacation bench. Vacation bench ಇರೋದೇ ಅದಕ್ಕೆ ಮೂವ್ ಮಾಡಿ. ಮದರ್ ಇನ್ ಲಾ ಸಿಸ್ಟರ್ ಇನ್ ಲಾ ಲವ್ ಮ್ಯಾರೇಜ್ಗೆ ಏನ್ ಸಂಬಂಧ? ಪ್ರಾಪರ್ಟಿಗೂ 498ಗೂ ಏನ್ ಸಂಬಂಧ? ಸುಮ್ಮನೆ ಏನೇನೋ ಹೇಳ್ಬೇಡಿ ಸರ್. Move the vacation bench. Give up the daughter. See, husband and wife problem ಅಲ್ಲಿ is impossible to solve. ಬೇರೆ ಎಲ್ಲ ಒಳ್ಳೆ ಕೇಸ್ಗಳು ನಿಂತೋಗುತ್ತೆ. ನೀವು ವೆಕೇಶನ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ. ನೋ ಪ್ರಾಬ್ಲಮ್. ವೆಕೇಶನ್ ಬೆಂಚ್. Move the vacation bench, sir. ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ? ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಾ?
ಆಗಲ್ಲ.
Move the vacation bench. Yes. Huh? Which one? We don't know. We'll see. ಅದು ಕೊಟ್ಟಿರಿ. ಡೇಟ್ ಇದ್ರೆ ಮಾತ್ರ. Yes. Wait. Third row, don't. Wait. Yes. Extension entry ಮಾಡೋದು 230 ಹಾಕ್ಸಿ ಮೇಡಮ್. Tomorrow. Yes. ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸರ್? ನಿಮಗೆ ಅರ್ಜೆನ್ಸಿ ಆದಾಗ ನಮಗೆ ಇಲ್ಲಿ ತಗೋಬೇಕಾ? ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಮೂವ್ ಮಾಡಿ. ನಿಮ್ ಪಾಲಿಟಿಷಿಯನ್ಸ್ಗೆ ಬಂದ ತಕ್ಷಣ ತಗೊಂಡ್ಬಿಡ್ಬೇಕು ಇಲ್ಲಿ. ಎಸ್, ನಥಿಂಗ್ ಡೂಯಿಂಗ್. ಎಸ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ನಾಳೆಗೆ ಅಪಿಯರೆನ್ಸ್ ಇದೆ. 9ಗೆ
230 ತಗೊಳ್ಳಿ.
My lord,
ಯಾಕೆ ಬರ್ತಾ ಇದ್ದೀರಾ ಹಿಂದೆ? ಬಿ ಇನ್ ದ ಥರ್ಡ್ ರೋ.
my lord,
Yes.
I'm a 25-year-old tutor, my lord. My bank account has been freezed. It has been more than 6 months, my lord. The disputed amount is to,
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
my lord.
ಆಫ್ಟರ್ 2 days ಅಲ್ಲಿ ಏನಾಗಲ್ಲ ಸರ್? ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಡೋಂಟ್ ಟೇಕ್ ಇಟ್.
Petition husband and wife.
ಮೇಡಮ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಂತ ಹೇಳೋ ಮೆಮೊ ಯಾವುದೋ ತಗೋಬೇಡಿ.
Petitioner doctors.
ನೀವು ಥರ್ಡ್ ರೋಲ್ ಇದ್ದೀರಾ wait. Yes.
Reporting settlement, your lordship. May I request for tomorrow?
Yes.
Lordship seeking permission to travel abroad. Earlier, this court had traveled, given the permission to
This court
travel
had
abroad, he had
traveled
covered, came back to comply the order, your lordship. There's an emergent business need in that view. Tomorrow,
ನಾಳೆ ಹಾಕಿಬಿಡಿ.
please.
My lord, Your Honor,
Tomorrow.
OS suit pending ಇರುವಾಗಲೇ criminal trespassing charges ಹಾಕಿದ್ದಾರೆ. 70 years old ಇದ್ದಾರೆ my lord. 22
Fresh
charge
pending
ಇದೆ my lord, fresh.
ಚಾರ್ಜ್ಗೆ ಯಾವತ್ತಿದೆ?
23ನೇ ತಾರೀಕಿಗೆ charge ಇದೆ my lord.
Your Honor,
ನಾಳೆಗೆ ಹಾಕಿ.
Madam,
Your Honor, my humble submission. This is under section 14 of the Foreigners Act. He's in judicial custody for past 2 years, Your Honor. He
Why?
wants to be
Why?
for visa validity, Your Honor.
Then
So he wants to be deported back to his country, Your Honor.
Friday.
Obliged.
For reporting settlement, please, my lord.
ಯಾವತ್ ಬೇಕು?
My lord, one already case.
ಯಾವತ್ ಬೇಕು ಅಷ್ಟೇ ಕೇಳಿದ್ದು.
Today at 2:30, please. my lord.
Yes.
Petitioner.
498A, my lord, the petitioner is a judicial employee, and my lord, she is a sister-in-law, my lord, she is residing Bangalore. The family is residing in Kadur, my lord, ಅಲ್ಲಿ complaint ಮಾಡಿ.
ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಲ್ಲ?
Bail ಇದೆ, Friday ತಗೊಳ್ಳಿ sir.
ಬೇಲ್ ಬೇಡ.
Friday.
ಮುಗಿದು ವೆಕೇಶನ್.
Friday, my lord.
ಮುಗಿದು ವೆಕೇಶನ್.
13 weeks,
Threat of suspense in not 2:30.
2:30 ತಗೊಳ್ಳಿ.
See, complainant is that I am the accused and I have a criminal case against pending against me. And thereafter also my lord, this
ಏನ್ ಡೆಫಮೇಶನ್?
130.
ಮುಗಿದು ವೆಕೇಶನ್ ಬೆಂಚ್. ನೋ ನಥಿಂಗ್, ನೋ ಅಜೆನ್ಸ್. After the vacation. Yes. After the vacation.
Line ಬರ್ತೀರಿ ಉಂಟ್ಲಿ ಫಸ್ಟ್ ಲೈನ್ ಸೆಕೆಂಡ್ ಅಂಡ್ ಥರ್ಡ್ ಲೈನ್ ಬರ್ತೀರಿ.
We have what urgency in 13(1)(b)? Friday. After move the vacation bench. ನಿಮಿಷ. Next is second roll ಯಾರು ಮೂವ್ ಮಾಡಿದೀರಾ ಅದು ಹೋಗ್ಬಿಡಿ ಹಿಂದೆ. After vacation. Yes, next. ಬೇಲ್ ಇದೆಯಾ? After vacation. ಬೇಲ್ ಇದೆ ತಾನೆ? ಅಂದ್ರೆ ಕೊಡಿ. 2:30. 1 minute. Yes, madam. Yes. ಎಷ್ಟಾಯ್ತು ಮೇಡಮ್? 2:30 ಎಷ್ಟಾಯ್ತು? 429. ಯಾವ 429 offense? ಬೇಲ್ ಇದೆ ಅಲ್ವಾ? ಯಾವತ್ತಿದೆ? ಫ್ರೈಡೆ ಹಾಕಿ. 504 offense. ಅದಕ್ಕೇನ police are threatening on 504 offense. ಆಯ್ತು, ಇಸ್ಕೊಡಿ. 2:30. ನಾಳೆ ತಗೊಳ್ಳಿ. 46 ಬೇಲ್ ಇದೆ ಅಲ್ವಾ? ಯಾಕೆ ಬೇಲ್ ಇಲ್ಲ? ತಗೊಳ್ಳಿ. 86 year ಕೊಡಲ್ವಾ ಬೇಲ್? That is the reason to grant bail. 2:30 ಕೊಡಿ. Yes. 2:30. If you want it, ಇಲ್ಲ ಅಂದ್ರೆ tomorrow ಇಲ್ಲ. FR ಇದ್ರೆ ಕಂಪ್ಲೈ ಮಾಡಿ. ರೇಪ್. ಯಾಕೆ ತೊಂದರೆ ಕೊಡ್ತೀರಾ? ಎಸ್. ಮೂದು ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್. ಬೆಸ್ಟ್ ಥಿಂಗ್ ಇಸ್ ಟು ಮೂದು ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್. ವೆನ್ ಡು ಯು ವಾಂಟ್ ಸೆಟಲ್ಮೆಂಟ್? ತಗೊಳ್ಳಿ. 2:30 tomorrow. ಪೊಲೀಸ್ ತುಂಬಾ ಬೇಲ್ ತಗೊಳ್ಳಿ. ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ? ತಗೊಂಡಿದ್ದೀರಾ? ಏನ್ ಹಸ್ಬೆಂಡಾ? ತೊಂದರೆ ಇಲ್ಲ. Move the vacation bench. Move the vacation bench. ನಾನು ಕೊಡೋದು ಇಲ್ಲ ಅಷ್ಟೇ ಸುಮ್ಮನೆ.
Settlement, case and counter case, my lord, both the parties are ready to settle 323 and 354, my lord.
ಯಾವತ್ತು ಬೇಕು? Tomorrow.
ಮಲೆ
Report
petition
statement
doctors
230.
ಮಲೆ 376 pokes ಮಲೆ allegation that pregnancy terminate the
36
pregnancy
pokes.
charges ಮಲೆ
21.
started at only for
Offense ಏನು?
376 2 ಏನ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ ಡಾಕ್ಟರ್ಸ್ ಬೈ ಓನ್ಲಿ ಅಲಿಗೇಷನ್ ಪ್ರೆಗ್ನೆನ್ಸಿ ಟರ್ಮಿನೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ
ಅದೇ
allegation.
376 2 ಏನು?
ಬರಲ್ಲ ಅದರಿಂದ ಆಮೇಲೆ ಫ್ರೈಡೆ ಮಾಡಿ ಸಾಟರ್ಡೆ ಚಾರ್ಜ್
ಏನು ಅರ್ಜೆನ್ಸಿ?
ಚಾರ್ಜ್ ಫೈನಲಿ ಅಂತ ಸಾಟರ್ಡೆ
ಆಯ್ತು ನಾಳೆ
ಅಡ್ವೊಕೇಟ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಇದೆ.
ಹಾ?
ಅಡ್ವೊಕೇಟ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಇರ್ತಕ್ಕಂಥದ್ದು ಮೆಲಾಡ್ಸಿಪ್ ಆಲ್ರೆಡಿ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡೋ ಹಂತಕ್ಕೆ ಬಂದಿದೆ. ಈಗ 2 times ಕೋರ್ಟ್ ಅಲ್ಲಿಗೆ ಬಂದಿದೆ. ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ GPA ಡಾಕ್ಯುಮೆಂಟ್ ಬರಲಿ ಅಂತ ಹೇಳಿ ಕೋರ್ಟ್ ವೆಯ್ಟ್ ಮಾಡಿದ್ ಮೆಲಾಡ್ಸಿಪ್. ಪ್ಲೀಸ್ ಕೈಂಡ್ಲಿ
ಬರ್ಲಿ ಫ್ರೈಡೆ.
ಮೈಲಿ FIR number 1980 FIR number.
ಫ್ರೈಡೆ ತಗೊಳ್ಳಿ ಮಾಡಿ.
25B of
Advocate.
NDPS Act. My lord, without medical report. She is a sinister, my lord, what has
Move
happened
the
is
vacation bench.
in this-
Move the vacation.
May I request?
There is a case, ongoing case in magistrate court.
Ah.
From like she have.
Move the vacation bench madam. Move the vacation bench. Bail ಇದೆ ಅಲ್ವಾ? Move the ಅಯ್ಯೋ ಅಷ್ಟರೊಳಗೆ ಏನಾಗಲ್ಲ. Move the vacation bench. Atrocities ಇದ್ರೆ ಕೊಡಿ 230. Oh, thank you madam. Give it. Withdrawal ಹಾಕಿ madam. Move the vacation. Bail ಇದೆ ಅಲ್ವಾ? ಬರಲ್ಲ. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಕ್ಕ. ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ನೋಡಿ ಫ್ರೈಡೆಗೆ ಹಾಕಿ. Move the vacation bench. Yes. Yes. Now wait. Yes. After vacation, move the vacation bench. Move the vacation bench. Yes. Move the vacation bench. Yes. Move the vacation. Yes. Police harassment ಕೇಳಲೇಬೇಡಿ. Yes. ಕೊಡಿ. Yes. Friday. $230. Yes. What's the urgency, madam? Move the vacation bench. Yes. Atrocities Act ಕೊಡಿ. Move the vacation bench. Yes. Move the vacation bench. ಆಯ್ತು ಫ್ರೈಡೆ ಕೊಡಿ. Yes.
My lord, petitioner is a student. He wants to move abroad for the higher studies.
Go
That
abroad.
is the reason.
Yes.
My lord, he is facing problem with the
Move the
police
vacation
items.
bench. Yes.
My lord,
My lord, crime
is
number
happy-
1980
yesterday
crime
it was
number, my
posted
lord.
for
All accused
my
are
lord.
acquittal, my lord. But now slipped up ಆಗಿ ಇವಾಗ
ಹೇಳಿ.
Yes, yesterday it was posted for 230 matter, my lord. It didn't list, my lord.
ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಮೇಡಮ್. ಯಾವ್ದು ಮೇಡಮ್?
ಇಲ್ಲ.
ತಗೊಳ್ಳಿ 230 ನನಗೆ ಕೊಟ್ಟಿದ್ರಿ 230 ತಗೊಳ್ಳಿ.
my lord, crime number 1980 crime number, my lord. All accused is acquittal. But ಇವಾಗ ಚಾರ್ಜ್ ಶೀಟ್ ಸ್ಲಿಪ್ಟ್ ಅಪ್ ಆಗಿ ಇಶ್ಯೂ NBW to accuse, my lord. Petitioner aged about 80 years, my lord. 80 years, my lord. 80.
80.
So kindly issue NBW to
accused number?
accused number 3, my lord. So all accused are acquittal, my lord. 1999 ಅಲ್ಲಿ acquittal ಆಗಿದೆ. But ಇವಾಗ ಚಾರ್ಜ್ ಶೀಟ್ ಸೆಪರೇಟ್ ಆಗಿ ಇಶ್ಯೂ NBW.
230 ತಗೊಳ್ಳಿ.
Yes, my lord.
306
ಸೊ ಬೇಲ್ ಇಲ್ವಾ?
ಇಲ್ಲ ಮಂಡೇ ಇದಿದೆ ಚಾರ್ಜ್
ಬೇಲ್ ಇಲ್ವಾ? ಇದೆ ತಾನೆ.
ಮಂಡೇ ಚಾರ್ಜ್ ಇದೆ ಅದಕ್ಕೆ ಶುಕ್ರವಾರ
ಫ್ರೈಡೆಗೆ ಹಾಕಿ.
With lordship kindly. My lord, IG is personally monitoring the investigation, my lord. 13(1)(a), read with 409 and 420 IPC by Lokayukta, my lord. Since I have declined to register a kata in the name of IG.
ಫ್ರೈಡೆ
230, my lord.
ಫ್ರೈಡೆ
Second accused, my lord.
ಫ್ರೈಡೆ ತಗೊಳ್ಳಿ.
Second accused was
Friday.
granted a protection by this honorable court.
ಫ್ರೈಡೆ ಸರ್.
Fire against all other accused has been watched by the.
ಫ್ರೈಡೆ.
Article 226 and 227 money constitution. Repledge ಮಾಡಿದ್ದಾರೆ gold money.
ಅದು ವೆಕೇಶನ್ ಬೆಂಚ್ ಮೂವ್ ಮಾಡಿ ಮೇಡಮ್. ಎಸ್.
Sir, this honorable court had earlier dismissed challenging the sale notice, madam. After its dismissal.
ಸೇಲ್ ನೋಟಿಸ್ GM.
Challenge ಮಾಡಿ ತಮ್ಮ ಮುಂದೆ ಬಂದಿದ್ರು ಸ್ವಾಮಿ. This court dismissed their petition. Subsequently, I have purchased the property based on the sale notice. So criminal case is registered against.
230. Yes. ಮತ್ತೇನು? Fourth row. Yes. Give it. Why 230? What is 230 matter? What is that? So Friday. Yes. Move the vacation bench. Yes. ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ತಾನೆ. Yes. Tomorrow I don't know. We wanted at 2:30. Yes. Why? What happened? ಏನ್ allegations? Pokso. What is that? 96-year-old. ಆಯ್ತು ಕೊಡಿ. Yes. ಡೇಟ್ ಎಲ್ಲ ಬರಿ ಮಾಡಿ ತೊಗೊಳ್ಳಿ. ಮತ್ತೆ ಫಸ್ಟ್ ರೋಗ್ ಹೋಗಿ ಸೆಕೆಂಡ್ ರೋಗ್ ಹೋಗಿ ಥರ್ಡ್ ರೋಗ್ ಹೋಗಿ ಮತ್ತೆ ಫೋರ್ತ್ ರೋಗ್ ಬಂದಿದ್ದೀರಾ ಏನು? ಮೂವ್ ದಿ ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್.
Explosive Substances Act, Lord, trial is fixed on 3rd of January, Lord.
ಮೂವ್ ದಿ ವೆಕೇಶನ್ ಬೆಂಚ್. ವೆಕೇಶನ್ ಬೆಂಚ್ ಅಲ್ಲಿ 3 ಬೆಂಚ್ ಇದೆ.
Lord, charge sheet is filed for the offences
Move the
419 and 420, alleging that, my lord, the reconstituted partnership deed, my lord,
ಮೂವ್ ದಿ ವೆಕೇಶನ್ ಬೆಂಚ್.
my lord, now the arbitration proceedings are pending on the same set of allegations.
ಮೂವ್ ದಿ
My
ವೆಕೇಶನ್
lord,
ಬೆಂಚ್. ಅದ್ರಲ್ಲಿ ಏನು ಅರ್ಜಿ ಬೇಲ್ ಇಲ್ವಾ?
that
ಬೇಲ್ ಇಲ್ವಾ?
bail is there. On the very same set of
ಬೇಲ್
allegations.
ಇದೆಯಾ ಇಲ್ವಾ?
Bail is there. On the same set of allegations, my lord, prejudice will be cast to the pending arbitration proceedings. Now
ಪರವಾಗಿಲ್ಲ.
it is
Vacation
posted for
bench-
arguments, my lord.
ವೆಕೇಶನ್ ಬೆಂಚ್ ಟ್ಯೂಸ್ಡೇಗೆ ಇದೆ. Yes.
This is a matter seeking defreeze.
ಮೂವ್ ದಿ ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್.
The matter seeking defreezing of bank accounts. This is a date given matter, but it wasn't listed.
ಚೆಕ್ ಮಾಡಿ ಮೇಡಮ್. ಚತುರ್ದಶ್ ತೊಗೊಳ್ಳಿ.
On 13th, it was supposed to be listed. There was a
ಅವ್ರು ಹೇಳ್ತಿರ್ಬೇಕಾದ್ರೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಎಷ್ಟು ಸರ್ತಿ ಹೇಳ್ಬೇಕು?
date given as 13th, but due to the
Just
holiday
check.
declared by the
We'll
government,
see,
it
yes,
wasn't
yes.
listed.
ನೋಡಿ ಮೇಡಮ್.
Article,
ನೀವು ವೆಕೇಶನ್ ಬೆಂಚೇ ಮೂವ್ ಮಾಡಬೇಕು. ಎಸ್.
Article 227, Your Honor,
ಆರ್ಟಿಕಲ್
Guardians,
227.
Guardians
the
and
problem?
Courts Act, Your Honor.
227 ಇಲ್ಲಿ ಬರಲ್ಲ. ಬರೀ 482 ರೆಡ್ ಬಿ 226 ಅಷ್ಟೇ. ನೋ
My-
227.
The family court,
ಇಲ್ಲ, you go to GMFC court. Yes.
My lord, for
Not this court. Family court matters don't come here, madam.
for trolling on Facebook page, petitioners are booked under section 505 clause 2 of IPC.
Sorry.
My lord. For
230.
Friday, my lord,
230. Yes.
for Friday.
Friday ಇಲ್ಲ. ಇವತ್ತು ಬೇಕಾದ್ರೆ ಇವತ್ತು ಇಲ್ಲ. ಮೂವ್
Please, my lord, please, my lord.
ಅಷ್ಟೇ ಆಯ್ತು. ಇನ್ನೇನು?
My lord,
Yes, for number.
ಕೊಡಿ. ಫ್ರೈಡೆ ಕೊಡಿ.
identical,
ಕೊಡಿ. ಅಲ್ಲಿರೋದೇ 2 ದಿನ ಮೇಡಮ್ ಕೊಡಿ.
identical matter. This honorable court has granted interim order. This is accused number 2 and 3 filed.
ಮೂವ್ ದ ವೆಕೇಶನ್.
Friday.
ಮೂವ್ ದ ವೆಕೇಶನ್.
Lords, criminal proceedings have been initiated in a suit for money recovery. My lords, the dispute is completely civil in nature. my lords.
ವಾಟ್ಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ?
My lords,
ಹೇಳಿದ್ಯಾ?
this,
ಮೂವ್ ದ ವೆಕೇಶನ್. ಎಸ್. ನೆಕ್ಸ್ಟ್. Chamber da ಅಷ್ಟೇನಾ? This court on so and so had granted the following order. Learn the charge sheet ಆಗಿದೆಯಲ್ಲ ಇದರಲ್ಲಿ. In the case at hand, charge sheet is filed. That was what was called in question. The out of inadvertence, the order refers to further investigation. It should read as further proceedings in special case number so and so. Number. So and so. ಇದನ್ನ ಅಪ್ಲೋಡ್ ಮಾಡಿ.
My lords, serial number 118, my lords.
Wait, sir, adjournment of the matter is called. Yes.
Fresh matters number 2.
ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ ಸರ್. ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ ಸರ್. ಆನ್ ಮಾಡಿ ಸರ್.
File is misplaced.
File is misplaced.
Misplaced. And on the previous
When
hearing,
will it be replaced?
a week's time.
Week's time. Yes.
Last occasion, there was an order. My lords, if they pay the amount, whatever I paid.
ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ?
45 lakhs.
ಈಗ ವಾಪಸ್ ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಸರ್?
ಅಲ್ಲ ನಮ್ದಲ್ಲ ಅದು ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಕೊಡ್ಬೇಕು.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡ್ರೆ ವೇಕೆಟ್ ಮಾಡ್ತೇನೆ ಈಗ ಅಷ್ಟೇ.
ಅಲ್ಲ
We will discuss. You face trial, ಅವಾಗ ಸರಿ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ.
ಅಲ್ಲ, I am
No
on behalf of the accused
No
number
issues.
2,
No problem.
3 and 5, my lord.
No issues.
ಅಲ್ಲ, ನಮ್ದು ಅವ್ರದ್ದು ರಿಲೇಶನ್ಶಿಪ್ ಇಲ್ಲ.
ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ, some wrong facts have been put before your.
You put for the right facts.
I'll put for the
No
right
problem.
facts.
List the matter on 9th January for further hearing. Interim order subsisting will escape ಆಗ್ಬೇಡಿ. Interim order subsisting will continue to the next season. ನಿಮ್ದೇನು?
Idralli.
Same, yes.
What has happened now, the original documents are not with him, my lords, nor before the ICICI Bank where they have mortgaged the property. The original documents of the property is with me.
ಅವ್ರು ವಾಪಸ್ ಕೊಡದೆ ಹೋದ್ರೆ ಡಿಸ್ಮಿಸ್ ಅಷ್ಟೇ, ಸಿಂಪಲ್. ವಾಪಸ್ ಕೊಡಿ.
ಅಲ್ಲ, accused number 1 ಕೊಡ್ಬೇಕು,
ನೋಡೋಣ.
because she has taken the money.
We'll see.
We have not taken any money because I am the bona fide purchaser in this
No
transaction.
problems.
And
We'll
accused
see.
number 5 is a witness to sale deed, my lord.
ತೊಂದರೆ ಇಲ್ಲ.
Your lordship judgment is there.
Will not
From
follow
that
that.
point.
Yes. ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಿ. Yes. 45 ಲಕ್ಷ ಕೊಟ್ಟು ಇಸ್ಕೊಂಡ್ಬಿಟ್ಟು ಬೇರೆ ಯಾರಿಗೋ ಮಾಡಿ
ಅಲ್ಲ, ಅದು ಅವರು ನಾನು
ಪರವಾಗಿಲ್ಲ.
ನಾವು ಪರ್ಚೇಸ್ ಮಾಡಿ.
ಪರವಾಗಿಲ್ಲ, ನೀವೇ ತಾನೇ ಬೆನಿಫಿಷಿಯರಿ.
ಅಲ್ಲ, ಬೆನಿಫಿಷಿಯರಿ ಅಂದ್ರೆ ಐ ಆಮ್ ಬೋನಾ ಫೈಡ್ ಪರ್ಚೇಸ್. I come into the
Your
case
bona
only
fides will be tested in a trial. Don't worry.
2023 ಅಲ್ಲೇ
No problem.
ನನಗೆ ಸೇಲ್ ಮಾಡ್ತಾರೆ. 2020 she claims that in
List on 9th for the hearing.
9th.
Yes.
Much.
ಅವತ್ತು it's made clear that if no submissions are made, the interim order would stand automatically vacated.
Much.
Yes.
3.
These are offenses, my lord, 419, 420, 21 of Birds Act, lordship in this case.
Buds Act.
My lord,
Facebook post, Instagram post ಅಂತಿದೆ ಇಲ್ಲಿ.
ಅದೇ Birds Act invoke ಮಾಡಿದ್ದಾರೆ. There is no material to invoke the Birds Act.
Additional SPP.
ಅಲ್ಲ, my lord.
ಗೊತ್ತಾಯ್ತು. Interim order ಇದೆಯಲ್ಲ.
ಅಲ್ಲ, argument ಮೇಲೆ taken.
Interim order ಇದೆ ತಾನೆ.
No urgency because of my lord.
ಏನ್ ಅರ್ಜೆನ್ಸಿ?
ಅಲ್ಲ, the marriage of the petitioner was cancelled.
ಯಾವ್ದು ಇದೆ ಇದು?
ಹೌದು ಸ್ವಾಮಿ, ಅದೇನೆ. Your lordship directed on last occasion to list the matter on fresh.
Yes sir.
Please.
ಹೇಳಿ.
Lord, even though my lord, the state government has issued my lord plain SOP, they have not the SOP also my lord of the registration.
ಜಗದೀಶ್ ಇಲ್ಲ. Tomorrow in the fresh matters. Yes. ನಿಮ್ ಮದುವೆ ಯಾವತ್ತು?
Cancel.
Because of the criminal case ಕ್ಯಾನ್ಸಲ್ ಆಗೋಯ್ತಾ? ಏನ್ ಫಾರ್ಮ್ ಫಿಲ್ ಅಪ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತ?
ಅಲ್ಲ, ಗೊತ್ತಾಗಿ.
Disclaimer, no cases pending. Yes. Next.
Okay.
4.
Sunil Kumar.
In this case, my lord, 45 lakh rupees, my lord, account transfer, my lord. On the basis of
During the part of my lord.
on the basis of the,
And they have filed for civil suit for recovery
List.
of money.
List on 14th January. Interim order, 14th ಅಲ್ಲ, 15th January. Interim order subsisting will continue to the next date. Next.
5.
I represent the petitioner counsel. 306. The petitioners are neither relatives nor participated in any activity.
ಓದಿದ್ದೀರಾ? Yes. Yes sir.
The lordship may kindly see.
Who committed suicide?
One Taswini.
One ಅಂದ್ರೆ ಯಾರದು? Relationship with the complainant.
Relations, there is.
Complainant ಜೊತೆ
Complainant
relationship.
daughter. Complainant daughter committed suicide. She has not left any death note whatsoever.
What is the date of death?
Date of is 29/8/2022. She committed suicide. Marriage was, your lordship may kindly see, on 26/6/2022.
Marriage with whom?
Marriage with, he is not the accused one, Praveen.
What is the relationship of Praveen with you?
No relations. Where he didn't, as per the prosecution case.
You are accused number 1, sir.
Yes, there are only 2 accused persons.
Accused 1 and 2.
1 and 2, the husband and wife. They are the relative, they are the distant relatives of the Praveen. And he did not have the parents, since there is no parents for him, he requested to lead the rituals in the marriage ceremony. They participated in the marriage. Immediate after the marriage, she left the husband's house and she was residing with.
Husband is not the accused?
Is not the accused. Sitil mane ಮಾಡಿ ಅಂತ ಕೇಳಿದ್ರಂತೆ, deceased. ಇವರು ಮನೆ ಮಾಡ್ಲಿಲ್ವಂತೆ.
Yes sir.
My lord, 12th line, page number 22, complaint ಅಲ್ಲಿ.
Complaint ಬಿಡಿ, 31 ಗೆ ಬನ್ನಿ.
Yes. 31 charge sheet allegations, my lord.
ಅದ್ರಲ್ಲಿ ಏನಿದೆ?
ಅಲ್ಲಿ ಅವ್ರಿಗೆ ತಾಯಿ ತಂದೆ ಇಲ್ಲ ಅಂತ ಇವರೇ ಮದುವೆ ಮಾಡಿದ್ರು.
ಸರಿ.
ಮನೆ ಸಿಟಿಲ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದಾಗ ಇವರೇ ಹರಾಸ್ಮೆಂಟ್ ಮಾಡಿ.
ಅದು can that be abetment to suicide? Heard the learned senior counsel Gopal Swami appearing for the petitioner. The petitioners are accused 1 and 2 are alleged of offences punishable under section 306 of the IPC, which is abetment to suicide. A perusal at the summary of the charge sheet as obtaining in column number 17 or even the complaint would not indicate any offense, much less offenses punishable, would not indicate any ingredients, much less the ingredients under section 107 of the IPC for 107 of the IPC for it to become an offense under section 306. The petitioners are said to be the guardians of the daughter of the complainant, who the deceased, who gets married to one Prashant, one Praveen, who is not the accused. She commits suicide, and the acts of abetment to suicide falls on these petitioners, finding no allegation of goading, instigation, or instigation that is necessary for an offense to become 306 of the IPC. Permitting further proceedings could run foul of the judgment of the apex court in the case of Kamaruddin, so and so, 337, 2024 SSC online SC page 3375. Therefore, there shall be. Next.
Tomorrow, NDPS section.
Voluntary statement. Yes, Ajay.
Drugs and Cosmetics Act. The petitioner is a practicing doctor because he is qualified to
NDPS.
practice.
Drugs and cosmetics, sir.
If my lords were to
Ah,
see
again,
the
again.
list of seizures, my lords, page 27, a total of 30 drugs have been seized. But out of which, my lords, 17, my lords, are ointments and creams which do not require, my lords, any prescription. 13 are portable medicines. Then, my lords, in the complaint, there is no allegation of sale. In fact, my lords, if my lords were to peruse page 24,
Let's see, let him come. Let Jagdish come. Let's tomorrow in the fresh matters list. Next.
7.
ನೆನ್ನೆದಾ? ಅದು ಬಂದಿದೆಯಾ?
ಹೌದು, 2 ಬಂದಿದೆ.
That sheet must yes. ಈಗ ಯಾವ್ದು ಫಸ್ಟ್ ಮಾಡ್ತೀರಾ ಸರ್?
ಫಸ್ಟ್ ಹೊಸ ಮ್ಯಾಟ್ರನ್ನೇ ಫಸ್ಟ್.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಕಾಪಿ
ಪಿಟಿಷನ್ ಕಾಪಿ. ನೀವು ಮಾಡಿ ಸರ್, ಹೊಸದೇ ಮಾಡಿ. ಗಿವ್ ದಟ್ ಕಾಪಿ ಏನು ಪರವಾಗಿಲ್ಲ, ನೀವು ಸ್ಟಾರ್ಟ್ ಮಾಡಿ
ಪ್ಲೀಸ್.
Yes.
Page 52 is the complaint.
Yes. Offenses.
Page 52.
Complaint becomes a crime in page 67.
The present petitioners are 7 and 8, accused 7 and 8.
What is the challenge here?
I challenged the entire proceedings, quashing of the entire proceedings are sought for.
Where is the order of taking of cognizance?
In annexure A, please, my lord.
Where is the order of taking of
Order
cognizance?
Taking cognizance, my lord. That would be page 182. Kindly see, IO has submitted the charge sheet with enclosed documents. On going through the same, it made out prima facie ground to proceed against accused 6 and 7. Hence, by invoking 191B of CRPC, cognizance taken against accused 6 and 7 for the offences 406, 420, 465, 468, 471, 201, 120B, 34 IPC. Just please see the charge sheet submitted.
Page.
Page 157.
ಹ್ಮ್.
First, top first ಪ್ಯಾರಾದಲ್ಲಿ
ಹ್ಮ್.
ಲಾಸ್ಟ್ ಲೈನ್ಸ್ಗಳು
ಹ್ಮ್.
ಅಥವಾ ದಿನಪತ್ರಿಕೆಗಳಲ್ಲಿ ಪ್ರಕಟಣೆ ನೀಡುವ ಮೂಲಕ ಪೂರ್ವ ಮಾಹಿತಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಹೀಗಿದ್ದರೂ 20/11/14 ಸಾಕ್ಷಿ 1, ಸಾಕ್ಷಿ 2 ಇವರ ಗೈರು ಹಾಜರಿಯಲ್ಲಿ ಅಪ್ರಾಮಾಣಿಕವಾಗಿ ಮತ್ತೊಂದು ಪೂರಕ ಟ್ರಸ್ಟ್ ಡೀಡ್ ಮೂಲಕ ಅಕ್ಯೂಸ್ಡ್ 5ರಿಂದ ಅಕ್ಯೂಸ್ಡ್ 7ರವರೆಗಿನ ಆರೋಪಿತರು ಅಕ್ರಮ ಲಾಭ ಮಾಡಿಕೊಳ್ಳುವ ಉದ್ದೇಶದಿಂದ ವಿಜಯನಗರ ಎಜುಕೇಶನ್ ಟ್ರಸ್ಟಿನಲ್ಲಿ ಟ್ರಸ್ಟಿಗಳಾಗಿ ನೇಮಕವಾಗಿ ಟ್ರಸ್ಟಿನ ಎಲ್ಲ ಹಣಕಾಸಿನ ವ್ಯವಹಾರ, ಆಡಳಿತಾತ್ಮಕ ವ್ಯವಹಾರ, ಇನ್ನಿತರ ಚಟುವಟಿಕೆಗಳಲ್ಲಿ A1, A7 ವರೆಗಿನ ಆರೋಪಿತರು ಪಾಲ್ಗೊಂಡು ಸಾಕ್ಷಿ 1 ಈ ಮೊದಲು ಸದರಿ ಸಂಸ್ಥೆಯ ಟ್ರಸ್ಟಿಯಾಗಿ ನೇಮಕಗೊಂಡಿದ್ದರು. ಸಾಕ್ಷಿ 1 ಮತ್ತು 2ರವರು ವಿಜಯನಗರ ಎಜುಕೇಶನ್ ಟ್ರಸ್ಟಿಗೆ 5,60,00,000ಗಳನ್ನು ವಿವಿಧ ಸಂಸ್ಥೆಯ ಬಾಬ್ತುಗಳಿಗೆ ಖರ್ಚು ಮಾಡಿದ್ದರೂ ಸಹ A1 ರಿಂದ A7 ವರೆಗಿನ ಎಲ್ಲ ಆರೋಪಿಗಳು ಸಮಾನ ಉದ್ದೇಶದಿಂದ ಒಳಸಂಚು ರೂಪಿಸಿ ಸಾಕ್ಷಿ 1 ಮತ್ತು 2ರವರಿಗೆ ನಂಬಿಕೆ ದ್ರೋಹ ಹಾಗೂ ವಂಚನೆಯಿಂದ ಕೋಟ್ಯಾಂತರ ರೂಪಾಯಿ ಹಣವನ್ನು ಅಕ್ರಮ ಲಾಭ ಮಾಡಿಕೊಂಡು ಸಾಕ್ಷಿ 1, 2ರವರು ಆರೋಪಿತರ ಟ್ರಸ್ಟಿಗಾಗಿ ಭರಿಸಿದ್ದ 5,60,00,000ಗಳನ್ನು ಮರುಪಾವತಿ ಮಾಡದೆ ಅಪರಾಧವೆಸಗಿರುವುದು ತನಿಖೆಯಿಂದ ವ್ಯಕ್ತವಾಗುತ್ತದೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ A1 and A2ಗೆ 406, 420, 465, 468, 471, 120B and 201 read with 34 ಅಂತ ಹೇಳ್ತಾರೆ. 5 to 7 ವರೆಗೆ 420, 120B, 201.
ಇವರ ಅಕ್ಯೂಸ್ 6 and 7 ಇದರಲ್ಲಿ.
Accused 6 and 7.
ಎರಡು ಪಿಟಿಷನ್ ಅವರೇ. ಅಲ್ಲ, ಎರಡು ಪಿಟಿಷನ್ ಅವರೇನೆ.
ಅಲ್ಲ ಫಸ್ಟ್ ಪಿಟಿಷನ್ ನಲ್ಲಿ 3 and 4.
3 and all right.
1 and 2 are dead.
Now 1, 2 and 5 are dead.
1, 2 and 5 are dead.
1, 2, 5 and 6, my lord.
1, 2, 5,
5 and
6 are
6.
dead.
3, 4, 7, 8.
Now
6
3 and 4 are petitioners in the companion petition.
In the charge.
Alla, 3 and 4 are accused in the companion petition.
Yes, my lords.
And 6 and 7 in this.
In this, where the charge sheet is being challenged, 3 and 4, what they've challenged is the FIR.
That's all. I'll get back
Yes,
to you. Yes, sir. Yes.
Then it all starts with a purported memo of understanding, MOU.
Page. Page, MOU.
ಅದು ಈ ರೀತಿ ಬೌಂಡ್ ಬುಕ್
ಕೊಟ್ಟಿದ್ದಾರಾ? ಎಲ್ಲಿದೆ ಕೊಡಿ ಮೇಡಮ್. Page.
MOU starts from
Volume
page 26.
Volume 1.
ಹೌದು. Page 26 ನಲ್ಲಿ page 26. 26 or 36.
All right.
I'm sorry, it is 36.
ಆಯ್ತು ಹೇಳಿ.
Page 36. Kindly see the present complainants are shown as second party. Accused 1 to 4 are shown as first party.
So what is that you're suggesting with this?
All that I am suggesting in this is, my lord, it recites that accused 1 to 4 are running, it's a trust running some education institution.
Yes.
They wanted to start a medical college for which certain arrangements were made. They had constructed a building, but that building, they were not able to get the approval with regard to medical college and all. Therefore, they were in financial difficulty. Therefore, through a chartered accountant, the complainants were introduced. They had a discussion prior to this MOU for about 2-3 months. Thereafter, under the MOU, it is stated that a minimum of 10 to 12 crores is the liability which is to be brought in by the complainants. There are outstanding loans of which installment is to be paid. If installment is not paid, it is likely to become NPA, leading to further complications. Therefore, that amount is to be paid, and other financial investment which complainants will bring in has to be of a rate of interest which is far below what is being paid now. This is the condition.
All right.
And it also recites that, go to page 43, conditions.
So what becomes of the agreement?
Just ಅದೊಂದು ಎರಡು
ಪೂರ್ತಿ ಓದೋದ್ ಬೇಡ, ಅದರಿಂದ ಏನಾಗಿದೆ ಹೇಳಿ.
ಅದಾದ ನಂತರ complainants pay a sum of 30 lakhs, a loan which was from a private party.
You are referring to the decisions at page 43.
Conditions ಅಂತ ಹೇಳಿ ಎಲ್ಲ
consequent upon the above.
consequent discussion deliberation decided as under.
All right. Yes.
ಅದಕ್ಕೆ in gist what happened is I'll
Yes.
just 30 lakhs was paid for repayment of a private loan for which promissory note was executed. Then 1 crore 53 lakhs was the loan due to the federal bank. Complainants make that payment, for which a mortgage deed in respect of certain properties apart from promissory note is taken. There was a loan from a trust based in Kerala, to which 1.73 crore was the due, which the complainants pay, and a property measuring about 27 acres was mortgaged to that Kerala trust. That all those properties and the mortgage is assigned to complainants. Thus, complainants as on today hold every one of the property almost measuring about 28 acres of land. They hold it as mortgage. That was not one of the conditions that they will take the mortgage. But anyway, they hold it as mortgage for the amount they advanced.
Then what is the crime against you then?
In addition to it, there was an allotment of almost nearly about 4 acres of land by Karnataka Housing Board, which they get a sale deed in their name. In the meanwhile, they were invited to become, before this transfer of property, they were invited to become trustee. Accused 1 and 2 were to express their desire to resign. But before it could be brought in, the conditions started saying the amount which they have advanced will bear 16% interest. Then this transfer of all the properties, mortgage, etc. happened. With this, the further step of making them a trustee did not happen.
There lies the problem.
That is, from there it started. The first complaint itself says, I was to be given entirely, the admission process should have been handed over to the complainants. They should have made me a trustee, made 2 of them as trustees.
So it's basically a dispute between you and him with regard to becoming the trustee.
That ultimately he says all conditions put under the memorandum of understanding have been breached.
Breach of conditions of memorandum of undertaking.
Memorandum of understanding. Therefore, what he says is, I gave a complaint. In the complaint, investigation was done. A draft charge sheet was also given to him for correction, etc. Then it appears, according to them, that the matter was transferred to CCB for this thing. Then for that, matter was transferred to CCB. One of the investigating officer did not, according to them, took a biased attitude against them. Thereafter, they approached a higher authority who was good enough to send an invitation to them. That's what they have stated. All these things are stated there. Invitation to them. They were pleasantly surprised to get that invitation, and they thanked him profusely and got the charge sheet ready. It was at that stage the earlier petitions were filed. Interim order was passed in one of the petitions. In the second petition, there was no interim order. Therefore, they filed the charge sheet, which resulted in withdrawing and filing it. What I'm trying to point out is, as far as the
according to you, the crux of the allegation is on breach of memorandum of understanding.
memorandum of understanding, it involves money transaction. According to us, transfer of the property, mortgages, etc., in favor of the complainants for who came for investing was not one of the
Any
things
civil
contemplated.
suits pending?
Yes, my lord. He has filed a scheme suit. Scheme suit is filed, and that is pending. Now, kindly see the next step. It was when these things were happening, and according to accused 3 and 4, when he almost tightened his grip over the trust and its properties to such an extent, they were not even able to breathe. The accused 5 to 7 come into picture. 5 to 7 at that stage have invested money. They were taken as trustees. They are now managing the affairs. Against the accused 5 to 7, the allegation is, you were knowing that we have certain disputes between us. In spite of it, you have come and financed them, so that he is now not obliging me. Therefore, 5 to 7 are also made as accused. Initially, they were called as witnesses, and their statement under section 161 was recorded.
They were transposed as accused later.
Yes, madam. In the protest petition, this is made. Protest petition, your lordship may kindly see.
Page.
Kindly see the protest petition. It is at page 40, 76, annexure D. Now the song is different in the protest petition. Now it is.
Page, sir.
So it starts at page 76. Kindly turn to page 78. The Vijayanagar Education Trust, that is the trust of accused 1 to 4. Vijayanagar Public Trust is enjoying 100% tax exemption under section so and so, so and so. The accused have fraudulently claiming before the Honorable Trial Court and Honorable High Court that VET is a private trust and not a public trust. Accused have robbed the income tax department, central government, state government, etc. Accused have indulged in blatant and shameless money laundering, tax evasion, embezzlement without any regard to law or any fear of the income tax department. Accused have played with severely compromised upon the education of the students, which was the main objective of the trust. Accused have misused subsidized lands allotted to the trust by BDA and KHB for personal benefit.
Police B report ಹಾಕಿದ್ರು.
ಒಂದು ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರು. ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರ ಮೇಲೆ that protest petition was filed. ಅದರಲ್ಲಿ 3 ವರ್ಷ sworn statement ಗೆ ಅಂತ ಹೋಯಿತು. On one fine day, the learned judge felt sworn statement, etc. is not necessary. There is a protest petition, therefore go for further probe was the order.
ಈಗ further investigation is directed.
Further investigation was directed. Investigation, according to them, is now completed and they have
Charge sheet is.
now filed the charge sheet.
Yes. Now legal,
Let me see.
legal grounds ಏನು sir?
ಇದರಲ್ಲಿ ಪೇಜ್ 80 ಅಲ್ಲಿ ಒಂದೇ ಇದನ್ನ ತಾವು ನೋಡ್ಬಿಟ್ರೆ
180.
80.
Yes sir.
Para 3 ದಲ್ಲಿ A, accused 125 never accounted all the collection of fees and donations collected from the students of the institution run by the trust. To misappropriate the funds of the trust, they used to open joint account by one of the trustees along with one of the employee of the school who was in charge. After the MOU, according to them, was breached. They give these things. Kindly see, the only allegation as regards 5 to 7 is at page 86, para 18. The protesters submit that entire funding and induction of the complainants as trustees and the resignation of accused 1 and 2 have been witnessed by the auditor of the trust. The complainant discovered huge misappropriation of trust funds by accused 1 to 5. During the course of CCB investigation, the accused 1 to 4 have illegally, surreptitiously claimed to have inducted accused 6 to 8 as trustees who have now been handed over the management of the trust, and that accused 6 to 8 are continuing to mismanage and misappropriate the trust funds. Hence, CCB had arraigned accused 6 to 8 also in the FIR. The complainants had earlier cautioned by way of public notice as well as personally to accused number 6 not to get
This is the allegation against.
This is the allegation against.
Now, what are the legal grounds?
Legal grounds that we are canvassing is, as far as apart from, I will start with the accused 1 to 4 itself, of whom 3 and 4 are there. Essentially, the highest of the allegation is taken as true. The conditions of MOU are breached. In this sense, three of the conditions. First is, according to them, they should have been handed over the collection of fees, admission, etc., which was not done. Second, they should have been made as trustees. Though they were invited to become trustee, management was not handed over. It remained at the stage of invitation, therefore second breach. Third is, the amount of 5 crore 60 lakhs I have paid, they are not returning the amount.
So one is breach of agreement.
Breach of agreement.
The other is recovery of money.
Recovery of money.
Both of which are impermissible in law.
To our case, the person, these complainants were to bring investment at a rate much lower than what was being paid to the banks, etc. With regard to loan discharging, with regard to other investments to make it to start working, they were to bring in nearly 10 to 12 crores as recorded. They did not bring that. On the other hand, what was done was, which never was stipulated anywhere, they have got all these properties mortgaged to complainants, then to a trust formed by complainants. Thereafter, it is transferred to a third trust so that we don't have immediate recovery, etc., action against the complainants. When they did this, according to us, they breached this thing. Therefore, we did not allow them to make them a trust. Therefore, ultimately, in every one of these sense,
civil suit
it is 100% a civil action which is sought to be used as. Then, as regards the recovery of money, now that recovery of money is also stated in the protest petition, saying they are neither paying the money nor allowing them to become. We are to show our bona fides. We will pay that 5.60 crores immediately. Apart from that, if there is anything, any accounting is to be done, that would be.
You are making an offer now?
I am pointing out how it is civil. Yes, we are making an offer also. If the mortgages are discharged, we have no complaint against them. Actually, on these mortgages and other things, we had filed a complaint against them.
All right. So these are the two grounds.
Yes.
Judgment scenario. Judgment scenario.
Of course, my lord, I have brought the judgments to show they allege cheating. The ingredients which is required for teaching, cheating this thing is not available in the protest petition or in the first complaint. That is one this thing. With regard to, I don't know why those 465 etc. are quoted. I don't find any
forgery.
This thing making of a false document or of forgery, etc. Then the allegations of trust fund being misused, which will be looked after by several agencies. It is not necessary that complainant should do it.
All right. Yes, sir.
And all those mortgage deeds transfer to first one trust, next a third trust of which totally complainants are in control, are at annexure L onwards.
So basically it is recovery of money, breach of agreement, to which the Learned Senior Counsel says you cannot set the criminal law into motion.
And we also say that we are ready to repay the money.
Offer is also there. Yes.
My respectful submission, my lord, says that is a very small portion of my complaint and the charge sheet. The real substance, my lord, says crores of, I'm sorry, I'm so sorry. Lord, my respectful submission is crores of rupees of trust funds have been systematically siphoned. There is material in the charge sheet to demonstrate, lords. And if your lordship pleases, my lords, I will show 2-3 documents which are a part of the charge sheet. My only request is if your lordship will kindly take my objections in the second petition, because I have my page numbers there.
Yes.
And that shows, my lords, the involvement of not just the original trustees, but also accused number 6 and 7.
All right. Now accused 3, 4, 6 and 7 are here.
Please, my lords. It will show the involvement of all of them.
Page.
My lord, annexure R36 at page 256.
$256.
Please, my lords. R36 at page 256.
How the layout?
Respondent number 2 statement of objections, my lords.
Respondent number 3, Keystone Partners.
Lords, I am for respondent number 2.
I will be for respondent number 3, my lord. And I'm led by senior counsel.
ಕೊಟ್ಟಿದ್ದೀರಾ? Give it.
Lord, in the mail. Copy, my physical copy.
ಇದೆಯಾ ಮೇಡಮ್? Why you have not given? ಅವರು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ವಾ?
I have served, my lords.
ಕೋರ್ಟ್ಗೆ ಕೊಟ್ಟಿಲ್ವಾ? Yes. This is not there.
256, my lords.
256. All right. Tell me.
But this is part of the charge sheet. This document.
Commission of Income Tax.
Please, my lords. In this, your lordship may please, my lord, come to page 261, para 7.
The meantime, get a copy to the court. Yes.
Please, my lords, I will do. Page 261, para 7.
Violations of 13(1). Yeah.
Please, my lords. There, they admit in this paragraph that loan is taken personally, trust repays the loan. and it's not a small sum. 1.3 crore. And I will show, my lords, like this, there are multiple allegations, multiple documents where they admit that they have misused trust funds. Not para 7. On further examination, it is ascertained that the trustee is Mr. So-and-so, and with their family members, Mrs. Avita Rose Johnson and Miss Pavitra Wilking, who are not trustees, borrowed rupees 1.3 crore as mortgage loan from Standard Chartered Bank against housing site number so-and-so, vide account number dated so-and-so, and borrowed gold loan of rupees so-and-so in the name of Mrs. Clementine Johnson. However, subsequent years, the trust account shows a repayment of rupees.
Proceedings before the Commissioner of Income Tax.
Please, my lords.
What has happened after this?
My lords, they have appealed against this, but they have admitted the fact, and this is a part of the charge sheet. They admit the fact that personal loan is taken and repaid by the trust. Not at this stage, would that be sufficient for the matter to go to trial? 1.49 crore, they borrow personally, pay through the trust account. They don't say no, they don't dispute it. In fact, at that page, response of the SSC is extracted. And this is, my lords, under 131 of the Income Tax Act, admissible. They say the said loans were taken from banks, institutions have been taken by the trustees and utilized for trust purposes as there was financial need on the trust. Therefore, they don't dispute the fact that this money was taken by them from their personal bank accounts, repaid by the trust. This is, my lords, 1. Then, your lordship, my lord, please come to para 7.5 at page 263. An agreement to sell is entered into between one Girish and one of the petitioners. This Girish, my lords, to purchase the property pays about 20 lakhs. Subsequently, this agreement is cancelled. He has to personally repay the money. A DD is purchased in the name of the trust and that gentleman is repaid. This is instance number 2.
Come to the nucleus of the problem.
Notes?
Come to the nucleus of the problem.
Lord, my respectful submission is, this is the fulcrum of my allegation that there is not little, there is massive amounts of siphoning off of trust funds. And these are just few instances. And I have other documents. For instance, my lords, the wife of one of the trustees, and these are all there in my complaints. She is a full-time lecturer in St. John's Medical College. She is also taking money from the trust as a professional or so-and-so. So like this, my lords, multiple instances. Your lordship may please see, my lords, the third allegation.
No, all your allegations are based upon only upon the findings before the.
No, my lord. I am just showing the most recent.
Go to the next.
My lord, in this, all I want to show is, at the end of the order, they pay 1 crore in income tax, additional income tax, because about 5.5 crores of unaccounted cash is found. They say, I don't have account books. My lord, the first question that I ask myself is, where did 5.5 crores of money come to the trust? Why was it unaccounted? My lord, this feeds into my allegations from day one that they have been withdrawing money in cash and siphoning off those monies. And they have paid the tax. Therefore, today, they cannot run away from the fact that, my lords, they had cash money. That, your lordship, my lords, will kindly find the fact that they have paid this money is there in this very order.
Page.
Please.
You want this copy back?
No, no, my lords, it's here.
Human search is better than that.
Please, my lords. My lord, your lordship may please kindly come to page 271, para 10.2. Aure Heliro statement. They say, my lords, at the bottom, total taxable income surplus 5.87 crore, just about 10.2. And therefore, they voluntarily offer 1 crore in tax. Lord, my respectful submission is not that they should not have paid tax. My submission is, therefore,
Siphoning off of funds.
this cash was available. And now your lordship may see, my lords, what happens is they give me, lords, for a moment, let me keep aside whether I was a trustee or no.
they give me access to the books. I commission a chartered accountant to look at what is going on. He finds, my lords, systematic method of siphoning off. May I request your lordship to kindly see page 169. Idralle. Page 169. This is a report which gives details of how this siphoning off is going on.
169.
Please, my lords. Annexure R31. In this, your lordship, my lords, it begins at 169. The relevant page, my lords, starts at 202.
Yes.
Just above the table, if your lordship sees, my lords, it says, please find below the approximation of the fees that are not recorded in the books on a yearly basis. The heading, my lord, says fees income.
Why did the police file a B report?
Lords, police filed a B report saying you have filed a trust case, therefore it's a civil dispute.
So then how do you say it is not a civil dispute?
Lords, my respect.
Because of this siphoning of funds?
Lords, this is 406 straight up.
Hmm.
My lords, this is 77 lakhs. They say for every head. Then your lordship may please come kindly to the next page. The first, my lords, is 77 lakhs for 4 years.
What is the total amount of siphoning off according to you?
Lords, in this report, for the 4 years between 8 to 12.
In everything put together, how much is the amount?
Lords, I have data for these 4 years, which is about 3.2 crores in these 4 years. But in my complaint, I have given a series of properties that I say they have purchased from trust funds. In fact, my lords, the income tax department in its order says that they give loans and advances to the trust and take it back. But there is no proof of income for any one of them. Therefore, this is just a way of converting, issuing loans and advances to the trust and taking it back. But there is no income. This is second method, my lords. Third method this report identifies is they open joint bank accounts with employees. Cash is deposited
into the employee's account.
Then it gets transferred by way of check. I have produced those bank account statements.
All right.
Fourth, my lords, employed in St. John's Hospital. I have those documents I have produced.
Remuneration is taken here.
Remuneration is taken here and there. And my lords, because there are multiple actions, they have admitted that they are taking money from me. Income tax return shows.
Right. Who are you appearing for?
Number 3. For number 3.
Who is that?
She's an informant again, complaining. My lord, so far as respondent number 3 is concerned now, my lords, 2 aspects of it. The first criminal petition, what is being challenged is only an order of further investigation, for which, my lords, we have given the judgments. This is not a case where protest has been considered and then there had to be an acceptance of B report. So dehorse the protest. What the learned judge does is, he would say, I direct further investigation. That would squarely get covered by the
So the
Supreme
charge
Court.
sheet is filed after the protest petition or after the further investigation?
After further investigation, not on the protest. So all this reading of the protest petition is absolutely not relevant. Now, my lords, on the basis of a further investigation, what happened was, my lords, so far as 3 and 4 are concerned, they filed a criminal petition and there was an order of stay. So far as the other 2 accused are concerned, they filed another petition challenging the crime. No stay was granted. So investigation completed, charge sheet was filed so far as they're concerned, but 3 and 4, it remained because of this order of stay. Now, my lords, so the first petition on the ground that the order challenges only a further investigation, which in my respectful submission has been done correctly in accordance with what is being laid down by Ravi Kumar's. So first petition, we don't have a problem at all, my lords. The second petition, my lords, which now, yes, my lords, so which now they say is only a case of a mere breach of trust of an MOU. It is purely civil in nature. It does not have any criminal element.
They don't say breach of trust. There's a breach of agreement.
Breach of agreement, not even a trust.
406.
This, for this, my lords, in my statement of objections, my lords should kindly have my statement of objection, which is dated 24/9/2024.
Keystone is filed.
Please.
You filed a synopsis.
In this synopsis, Akideva? No. Well, it's only one portion. If I point out, that may be sufficient to notice, my lords.
Synopsis.
I will do that. We'll do that.
Yours.
But probably, my lords, so far as allegation is concerned, in this one aspect, I'll be able to point it out, my lords. If my lords would notice page 28R1, my lords, in my statement of objections, 24/9/2024. Please notice at page 28, my lords, what is it that has been alleged in the bullet points, my lords? Tampering and alteration of minutes book of a public charitable education trust, the very first allegation. Now, what they would do is, my lords, A1 passes away. After he is dead, my lords, his signatures are fabricated and amounts are taken out of the trust. Now, this becomes subject matter of an FSL investigation. FSL has given a report, which my lords would get at 410, page 410 of the charge sheet, that it is fabricated. So the first allegation is that of fabrication and tampering of the minutes book in relevance with A1 signatures. So positively they say it is a case of tampering, my lords. Then the other allegations in that, in the bullet points, my lords, there are about 10 allegations. Now, my lords, most important of these 10 allegations, my lords may kindly notice paragraph 15 at page 36. Now, this would make it clear how, my lords, they have gone about misusing the entire trust funds. Page 36, paragraph 15, my lords. Could I just read this?
Page 36 of the objections.
Yeah, my lords, it's in of the objections. Yes, my lords.
Yes.
30, my lords has 36, my lords.
Yes.
My lords, kindly notice this paragraph 15 to paragraph 18. Could I just point out this portion, my lords?
Yes.
Paragraph 15, my lords. Aforesaid persons had borrowed personal loans from certain banking institutions. The loans so borrowed were not for the benefit of the trust or for carrying out any activity of the trust. The loan amount so received were not utilized by the trust. Yet the personal loans utilized personally by the aforesaid persons are sought to be paid from the trust account. My lords should notice A to E. Trust account is being used to pay back their loans. Paragraph 17, my lords, the fees that is collected from the students. How the fees that is collected is used for them to purchase personal properties of house and cars. My lords should notice at paragraph 17, the houses which they have purchased, my lords, some of the properties which we gave to the investigating agency, this is out of the fees collected from the student without reflecting the same in the account of the trust. Houses, my lords should notice from Roman number 1 till Roman number 22, page 38. These are the assets that they have.
All right.
Then, my lords, please then notice paragraph 18, the property which is purchased in Kerala. Paragraph 18. Utilizing the funds of the trust, approximate value 2.5 crores. Then, my lords, paragraph 20 and 21 deals with accused 7 and accused 8. Now, my lords, the charge sheet is filed.
Yes.
It is supported by documents issued by the forensic indicating fabrication of the signature of accused number 1 who is dead, and funds have been taken away from the.
Which page is that?
My lords, 410 in the charge sheet.
Which charge sheet are you referring to?
Now, the charge sheet which they produced today. My lords, I think a spiral bound they have given. Spiral bound, eh? Volume 2.
Volume, highlight that.
It starts at 406. My lords, gets 406, my lords.
I'm at 410.
At 410, so A1, my lords, who is a deceased, his signatures are fabricated, amounts taken away from the trust.
All right.
Now, my lords, with this, if we say it is only a dispute of an MOU, may not be right, my lords. These are the 10 aspects.
Only thing is the learned senior, he mentioned 32 properties that are there in my complaint to the CCB onwards. So it is not that it is being said now.
It's all right, we'll consider. Yes, anything else?
As far as income tax and this
Those
thing is
proceedings are
concerned,
pending.
while the appeal matter is pending. With regard to trust properties being misused or taken away by some of the trustees, they have filed a suit for recovery.
That is
Scheme
pending.
suit they have filed and recovery proceeding. The allegation, other allegation of PMLA is something which will be looked after by proper agencies if at all there is anything. Not by.
Complainant.
ಅಲ್ಲಲ್ಲ ಇದು
By
predicate
the
offense.
person.
PMLA ಆಮೇಲೆ ನೋಡೋಣ.
Even
Predicate
now they don't want to
PMLA
pay
ಆಗೋಗಿದೆ.
their money.
PMLA later, my lord.
ಇನ್ನು PMLA is already in.
No, no, no.
Allala,
No,
what
they
is-
say,
ಆಗಿಲ್ಲ.
according to them, all this
Even
is
now,
under the
your
PMLA.
lordship, kindly see,
It
they are
doesn't
not ready
want
to take back their money and release the property. 28
These are
acres of
pure-
property plus 4 acres
Pure
of
offenses under
housing
the
board.
predicate offense. Now, whether they can take action under PMLA left to the ED. But now, as of now, investigation into the predicate offense has disclosed this.
That will, yes, heard reserved, yes,
Obliged.
grateful, heard ಎಲ್ಲಾರ್ದು ಹಾಕ್ಬಿಡಿ.
Lordship, I appeal for the petitioners in this matter.
Enter ಮಾಡ್ರಿ ಯಾವ್ದ್ರಲ್ಲಿದೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
Lord, respondent number 2, my lord.
On the last occasion, interim order was granted against petitioner number 2, and said it would be considered today in appearing of the respondent number 2.
Husband,
Yes, my lord.
you have appeared.
Respondent number 2, my lord. Extratal, I'll file my objection.
Learned counsel so and so undertakes to enter appearance for the respondent. List the matter after vacation. Yes, sir.
Because the interim order may be extended.
The interim order subsisting of the kind that is subsisting shall continue to the next date.
Much obliged.
Respondent number 2, Your Honor. Last time this honorable court has directed to
Pay back 28 lakhs.
Please, my lordship, out of which, my lord, now the petitioner has bought 2 lakh rupees DD.
Uh.
And my lord, the loan has been taken by the accused number 1, wherein, my lord, the petitioner is accused number 2. He has admitted his fraudulent act, therefore he has agreed to pay the full loan amount. Now also.
Who has admitted? Who has admitted?
petitioner,
Accused number 2, since petitioner has introduced the accused number 1 to the bank.
Hmm.
So now what has also happened, my lord, the national
baker?
highways,
we are ready to accept that.
pay this also, my lord.
The learned counsel for the petitioner hands over a demand draft of rupees 2 lakhs, being the part of the payment that the petitioner had to make in terms of the order dated 26/11/2024. The counsel for the respondent has accepted the same. List the matter after
My
vacation.
lord, they are ready to.
Submission.
Let
Tell him.
Now, what has happened is 28 lakh rupees is the total final amount. So out of which now 2 lakh rupees, this has to be considered in the one-time full settlement amount, my lordship.
Correct, that I will observe, yes.
That has to be.
A part
And
of the OTS is the submission of the counsel for the petitioner.
And
Learned counsel, in bank,
Bank.
ಏನು?
My lord, the accused number 1 has borrowed a loan. He's only the builder. He has cheated to the bank. Prior to that, my lord, he has sold that same flat to somebody else. The accused number 4, I think. And my lord, he has also bought a loan from another bank.
They are also accused, ಅಲ್ಲ?
Here they are not.
Petition is accused number 2 ಅಷ್ಟೇ. You proceed against everybody.
accused number 2 is the petitioner.
A petitioner, you proceed against everyone else. Now you accept that for the present. So accept for the present, subject to the outcome of the petition. The list the matter after vacation, interim order subsisting will
They
continue.
are ready to file an undertaking affidavit before this honorable
Remain
court.
also we are ready
The learned counsel for the petitioner undertakes to shall file an affidavit of undertaking with regard to the return of the entire amount by the next date of
26 lakh,
entire amount, i.e.
26 lakh. because
26 lakhs as observed in the order dated 26/11/2024 by the next date of hearing.
They have to pay entire balance. That is as the loan sanction was sanctioned 28 lakhs. That is the.
ಈಗ ನೀವು ಆರ್ಡರ್ ಏನು ಹೇಳಿದ್ದೀನಿ ಅದನ್ನು ಎಸ್
Much obliged.
ಈಗ 2 ಲಕ್ಷ ಬಂದಿದೆಯಲ್ಲ ಅದ್ರ
Number 10.
Lordship, I appear for the respondent number 2. My lordship, a kind submission, my lordship. I'm not feeling well. Kindly after vacation. The trial court date is in.
Set down for filing of charge sheet, my lord. Purely.
Filing of charge, let them file.
No, I'm sorry, for charges, charge
My
sheet has
lord-
not been challenged in this petition.
The case is in February, my lordship. Today my
Purely-
court is entirely choked. Please.
341.
Yes, ma'am.
What's the offense, sir?
It's for the offenses under 448, 341, 323 and 504. Purely this, there is civil dispute admittedly. Under
Who is the complainant?
The complainant is none other than the mother.
I'm-
of the
Here was
petitioner.
mother.
And there is a civil suit for partition and separate possession which was pending. And the subject matter of the property is schedule 1 of the civil suit in OS number 25238 of 2015. my
File
lord.
your objections, sir. Yes.
Well-
The learned counsel appearing for the second respondent submits that he seeks 2 weeks' time to file statement of objections.
Please,
The learned counsel for the petitioner submits the matter is set for framing of charges. The petitioners are accused 1 to 5. The complainant is the mother of Yaradu, first petitioner.
First petitioner.
Mother of the first petitioner and mother-in-law. Where
Oh,
Mother-in-law of the second petitioner.
mother-in-law of the second petitioner.
my lordship, one submission.
Complaint is registered on 30/11/2016. The allegation is that the allegation is for offences punishable under section 341, 448, 427, 323 and 504. The learned counsel for the petitioner submits that on the dispute with regard to the property, civil suit in
OS number 25238 of 2015 is pending.
is pending. And
What-
ಅಲ್ಲೇನ್ order ಆಗಿದೆಯಾ?
So there is an
Right, sir.
interim order of status quo.
In which the concerned court has directed maintenance of status quo.
My lordship,
So far as the possession ಯಾರಿದ್ದಾರೆ?
Possession, we are in possession.
my lordship,
learned counsel-
ಒಂದೇ ಒಂದು ಸಬ್ಮಿಷನ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
ಹೇಳಿ ಸರ್.
ದಯವಿಟ್ಟು ಅವ್ರು ಹಾಕಿರೋ OS ಸೂಟ್ ನಲ್ಲಿ ಅವ್ರು ಇದ್ದಿದ್ದ ಅಡ್ರೆಸ್ ಬೇರೆ. ಈ ಶೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಸಡನ್ ಆಗಿ ಬಂದು ನುಗ್ಬಿಟ್ಟು ನಮ್ಮನ್ನು ಓಡಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಇಲ್ಲಿ ಸೀನಿಯರ್ ಸಿಟಿಸನ್ ಇದರಲ್ಲಿ ಅವ್ರನ್ನ ವೆಕೇಟ್ ಮಾಡಿ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಯಾರನ್ನ ವೆಕೇಟ್ ಮಾಡಿ ಅಂತ?
ಇವರು ಪೆಟಿಷನರ್ ಇದ್ರಲ್ಲಿ ಬಂದಿದಾರಲ್ಲ
That is
ಅವ್ರನ್ನ
the
ವೆಕೇಟ್
subject
ಮಾಡಿ
matter
ಅಂತ
which is
ಆರ್ಡರ್
stayed by
ಆಗಿದೆ.
this court also, my lord.
ಅದು
Anyway, there are, how are you setting the criminal law into motion and all this, sir?
ಸಡನ್ ಆಗಿ ಬಂದ್ ಮನೆ ಬಿಟ್ಟು ಆಚೆ ತಳ್ಳಿದಾರೆ ವಯಸ್ಸಾಗಿರೋ.
ಅದು ಸ್ಟೇ ಆಗಿದೆಯಾ ಇಲ್ವಾ ಈಗ?
ಅದು ಇವರು ಫೈಲ್ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ. ಅದು
ಆರ್ಡರ್ ಆಗಿರೋದು ಸ್ಟೇ ಆಗಿದೆಯಾ?
ಯಾವ್ದು ಸ್ವಾಮಿ? ಅವ್ರು ಹಾಕಿರೋದನ್ನ ಅದನ್ನ ಸ್ಟೇ ಆಗಿದೆ.
ಆರ್ಡರ್ ಆಗಿರೋದು ಸ್ಟೇ ಆಗಿದೆಯಾ?
ಹೌದು ಸ್ವಾಮಿ.
All right, yes. So the offense is the one alleged under section 448 which deals with house trespass. The allegation of the complainant is that the petitioners have trespassed into the house of the complainant and have evicted a senior citizen. The order to that effect was passed by the concerned court. The coordinate MFA.
It's in WP.
The said order has been stayed by the hands of the coordinate bench of this court in so and so. ಅದು ತಗೊಳ್ಳಿ.
15565 of 2022.
So in that light, since the proceedings are pending before the coordinate bench in the said against the said order, and the suit at large is pending before the concerned court, section 448 of the IPC prima facie is not met. The other offense is the one punishable under section 341 of the IPC. For an offense under section 341, the ingredients of section 339 is necessarily to be present. The allegation does not meet the presence of those ingredients. In that light, there shall be an interim order of stay of further proceedings before the concerned court. The respondent counsel is at liberty to seek vacation of the order by filing an appropriate application along with a statement of objections. Yes.
Clear.
Next.
11. The respondent in this case.
Section 440.
Yes, I've sought for instructions. I'm yet to get the instruction.
Interim order ಇದೆಯಾ?
My lords, there are two cases.
ಕೇಳ್ತಾನೆ ಹೋದ್ರಾಗಲ್ಲ. We will protect him till then.
My lords, there are two cases. One for the one for the offences under 73 and 76 of Companies Act along with rules. One is for 447
All
of
right, when did, how
Companies
much
Act.
time you want?
Lords, a week's time, my lords.
The learned counsel Sridevi Bhosle seeks time, yet again to file statement of objections. Less the matter in the second week of January 2025. Objections, if any, by then. The respondents are restrained from precipitating the matter to the next date. Yes.
Matter is listed on 23rd before the trial.
The concerned court shall 20?
3rd of.
The concerned court shall defer its proceedings till the 23rd of January 2025. Yes. Next.
Well,
Both the
Next.
My lord, kindly have it
Just that.
tomorrow, my lord.
May I just,
ಯಾವ್ದು tomorrow?
Forest,
Serial number 2.
Why?
Forest.
Forest ಇದು.
Forest Act, my lord.
There's some
BB Patil ಯಾಕೆ?
some interpolation, my lords, my name is corrupt.
ಇಲ್ಲ, SPP ಗೆ ತಾವ್ ಹೇಳಿದ್ರಿ, Monday ಬಂದಿತ್ತು matter.
List tomorrow in the fresh matters list.
My
Let
lords,
him
my
come.
name may be deleted.
Registry to delete the name of BB Patil as appearing for the first respondent.
Deeply obliged.
ನಾಳೆ.
Because what has happened, my lords, they, at one point they say it is 1 acre 20 guntas, at the other point they say 9 acre 33.
I've already protected you.
My lords, there is no interim order, my lords.
ಅಯ್ಯೋ ಇದು ಯಾವ್ದು ಇದು BB Patil ನೋಟಿಸ್ ಆಗಿರೋದು ತಪ್ಪಿಲ್ಲ ನಿಜಕ್ಕೆ.
No interim order. If your lordships kindly
No,
see,
yes.
the FIR is registered, my lords.
Yes. Heard the learned counsel submit appearing for the petitioner. List the matter tomorrow in the fresh matters list. ಇದನ್ನ download. Yes.
Very well.
Yes. Excellent.
13.
Madam, cause this one.
For petitioner, my lords. This report awaited the merits. Awaited the merits, police.
Await, post immediately after service of notice upon the first respondent. Interim order there. To continue. Next.
14.
I am for petition, not a filing memo for withdrawal.
Thank you. Sir. Yes.
ಚಾರ್ಜ್ ಮುಂಚೆನೆ ಪ್ರೇಮ್ ಆಗಿದೆ.
ಹಾ?
ಆಮೇಲೆ ಚಾರ್ಜ್ ಮುಂಚೆನೆ ಪ್ರೇಮ್ ಆಗಿದೆ. ಆಮೇಲೆ
ಗೊತ್ತಾಯ್ತು. Because of your statement ಅವರು withdraw ಮಾಡಿದ್ದಾರೆ.
ಈಗಲೇ ಕಟ್ತೀನಿ ಸ್ವಾಮಿ. During
ಹಾ?
course of the day, ready ಇದೆ. ಈಗಲೇ ಕಟ್ತೀನಿ process memo.
311 application.
Process memo. Process
ಯಾಕೆ
ಕಟ್ಟಿಲ್ಲ.
ಕಟ್ಟಿಲ್ಲ?
ನಂಗೆ ಹುಷಾರಿತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ
ಹುಷಾರಿದ್ದಿಲ್ಲ.
ನನಗೆ ಒಂದು ವಾರದಿಂದ ಹುಷಾರಿತ್ತಿಲ್ಲ, ಅದಕ್ಕೆ ಕಟ್ಟಿ.
ಹಾ ಸರಿ. ಈಗ ಹುಷಾರಾಗಿದ್ದೀರಾ?
ಹ್ಞೂ ಸ್ವಾಮಿ, ಈಗಲೇ ಕಟ್ಟಿ.
Process ಕಟ್ಬೋದಾ ಈಗ?
ಈಗಲೇ ಕಟ್ಟಿ.
List after 2 weeks. In the event the needful is not done, the interim order would stand automatically vacated.
ಈಗಲೇ ಕಟ್ತೀನಿ.
ಈಗಲೇ
Interim
ಮಾಡಿ.
order
Subject to the aforesaid condition, interim order subsisting shall continue. Next.
ಹಚ್ಚೋಗ್ರಿ.
15.
Respondent.
No representation on behalf of the petitioner. List after vacation. Petitioner, yeah, illala. Yes, next.
17.
This ready, ಅವ್ರು ಹುಷಾರಿಲ್ಲ. After.
So I mean, at least warrant is there in both cases. At least warrant may not be issued. I will accept or not. Warrant need not be issued also.
Tag ಮಾಡ್ಬಿಡಿ madam. ಒಂದು
In two
matter.
cases. Something ಇದೆ. So warrant need not be issued here.
January.
Your lordship, warrant need not be issued. also.
Warrant hanging on the head
For
of this
both cases,
petition.
for both cases.
Sir, 1 minute, sir.
That-
Warrant hanging on these, on the head of these petitioners shall remain straight till the next date of hearing. 10th January. All
Yes,
connected
both
matters are there. Please.
The other case also, lordship.
Tag along with both, sir. Yes.
But my charges.
18.
Serial number 16.
ನೀವಿರ್ಲಿಲ್ಲ.
ಕಡೆ ಇದು.
You are outside.
Right.
Outstanding.
Sorry, my lords.
ಅಲ್ಲ ಉನ್ನಿಕೃಷ್ಣನ್ ಕರ್ಕೊಂಬನ್ನಿ, ಅವ್ರು ಹೋಗಾಗಿದೆ.
Unni was here.
ಉನ್ನಿಕೃಷ್ಣನ್ ಸರ್.
Unni
Who is Unni?
Unni Krishnan.
Yes. ಆಯ್ತು, let him come. Password.
Sorry, my lords.
Password ಆದ್ರೆ ಗೊತ್ತಲ್ಲ? Password. Yes.
Is that PMLA doctor's matter?
Oh, death certificate.
Death certificate.
Madam, where is? Oh, seriously. Let him come. Yes. ಮತ್ತೆ ಫೋನ್ ಮಾಡಿ ತೊಂದರೆ ಕೊಡ್ಬೇಡಿ. Yes. Yes. Next, 18. Password.
18.
Appear for the respondent number 2, my lords.
The offense under section 498 and 307, it's under the BNS Act. my lord.
I may be permitted to file my objections, my lord. I received my summons yesterday.
Husband,
Please, my lordship, for husband.
let him file his objections.
I
Already filed?
No, I am filing it right now, my lord.
Yes.
The lord's
Please
permit.
serve me a copy.
Learned counsel, so and so. You have already filed wakalat?
I filed wakalat yesterday. my lords.
Anil, what's your name?
Abhimanyu.
Abhimanyu, sorry. Yes. Learned counsel Abhimanyu seeks to submits that is already entered appearance for the respondent. Registry to print the name of Abhimanyu as appearing for the respondent. After vacation.
Lordship, one submission, my lordship. Before the trial court, while granting bail, she personally appeared before the court and said that the matter has been settled.
Settled now.
And the bail may be
I'll
granted.
clarify
That has been observed by the
Recorded.
trial court. ಇದೆ, ನಾನು
Page.
ತೋರಿಸಿದ್ದೇನೆ.
Page.
Kindly see, my lord, page number 39, paragraph 9.
Both of you are in Poland?
Please, my lord,
Please, my
right
lords.
after the marriage, they were in Poland.
All
And
right.
14/8/2024, they came back to
Endi
India.
page ತೋರಿಸ್ಬಿಡಿ.
Page number 39,
39.
please.
Since the
Paragraph
parties, according to the wife, matter has been settled and there is no meaning in keeping the accused in judicial custody.
If I may clarify what
If it is settled,
it is not, my lord.
why pound of flesh?
There is absolutely no proposal of any settlement also which has come from their side, my lords.
Then what is this?
I will clarify, my lords. What had happened, my lords, on the day of the arguments of the bail application, my lords, the petitioner's mother, when the incident had happened, had actually stopped the petitioner. Admittedly, he tried to stop the petitioner from assaulting the wife. Only on her request, my lords, they said, you please come down to the bail hearing, and if he comes out, there may be chances of settlement. And after that, my lords, there is absolutely nothing from their end. No side, any sort of.
Sit and sort it out. Sit and sort.
My lords, at this stage, absolutely, I've not received instructions on the
No,
settlement.
no, you
my lords.
receive. I'm not forcing you on that. If it's settleable, settle it.
Please,
I'm ready to explore, my lordship.
I mean, I'm not denying the chances of settlement.
Only exploration, no imploration.
Please.
And also, they have also assaulted me.
Attempt to murder ಆಗೋಯ್ತು.
ಇದ್ದಾರೆ.
ಅಲ್ಲ ಅದು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
ಮತ್ತೆ
ಚಪ್ಪಲಿ ಏಟು ಅಂತ ಇದೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಚಪ್ಪಲಿ ಏಟ್ ಯಾರು ಹೊಡೆದಿದ್ದು?
The
Respondent number 2.
no, the sister of the respondent.
When complaint also, counter complaint has been filed.
Anything wrong?
My lordship, at least on this ground, interim may be granted.
Every action has an equal and opposite reaction. ನೀವು ಹೊಡೆದಿದ್ದೀರ, ಅದಕ್ಕೆ ಹೊಡೆದಿದ್ದಾರೆ. Sit and settle. If it is settleable, I'll post it on 10th.
Please.
The land comes on so. Meanwhile, what?
Please, my lordship, because she has come before the court.
We'll see.
She has told.
List the matter on 10th for further, 10th on 14th for further hearing. The, ಏನಿದೆ ಈಗ? Charge sheet ಆಗಿದೆ.
No, my lordship. It's fine.
Respondent, you cooperate with the investigation.
Please, my lordship.
Respondents are restrained from taking any coercive steps or precipitating the matter till the next date of hearing. The parties shall explore the possibilities of a settlement and place the settlement, if any, before the court on the next date. Settlement. 15.
Filing a memo with regard to depositing 20% of the fine amount.
Kodi.
Before the applicant.
Abhinay. Your Abhinay's colleague.
Colleague, yes, sir.
That amount may be permitted to withdraw. Mortgage loan.
ಇಲ್ಲ ವಾಪಸ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕಳಿಸ್ಬಿಡೋಣ.
ಅದೇ
ಮ್ಯಾಟರ್ನೇ ಕಳಿಸ್ಬಿಡೋಣ. ಅಲ್ಲೇ ಯು ಫೈಲ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಬಿಫೋರ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಟು ವಿಡ್ರಾ ಇಟ್.
ಅಲ್ಲ ಅದು ಆಲ್ರೆಡಿ ಅಪೀಲ್ ಕೋರ್ಟ್ ಬಂದ್ಬಿಟ್ಟಿದೆ.
ಅದೇ ಅಪೀಲ್ ಕೋರ್ಟಿಗೆ. ದಿ ಪೆಟಿಷನರ್ ಇಸ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಕಾಲಿಂಗ್ ಇನ್ ಕ್ವೆಶ್ಚನ್ an order dated 16/10/2024 passed in criminal appeal 1175 of 2024 suspending the sentence that the petitioner that was hanging on the head of the petitioner on a condition that 20% of the amount as obtaining under section 148A is to be paid. They heard so and so. The petitioner is the accused, the respondent, complainant. 311 application da idu.
ಅಲ್ಲಿ 3 extension ಕೇಳಿದ್ವಿ, extension rejected.
The petitioner is the accused, the respondent, the complainant. The two have a transaction. The said transaction leads to an offense under section 138 of the Negotiable Instruments Act. The petitioner gets convicted of the offense. On such conviction files an appeal before the court of session in criminal appeal so and so mail. The issue in the list is not with regard to the merit of the matter. The concerned court suspends the sentence by imposing a condition that imposing a condition of payment of 20% as obtaining under section 148 of the Negotiable Instruments Act. The condition having not been able to be complied by the petitioner leads the petitioner to an application under section 311 seeking extension of time. That is rejected, and the rejection of which has driven the petitioner to this court in the subject petition. The learned counsel for the petitioner submits that he has he has an excellent case on its merit, and the imposition of 20% of the amount as 20% of the amount and making it condition precedent to suspension of a sentence runs foul of the judgment of the apex court in the case of Jambu Bandari versus so and so 2023 10 SEC page 446. Therefore, he would seek the seek the order be reconsidered at the hands of the concerned court. The petitioner has also deposited,
Yes, ma'am.
Ellie.
Before the appellate.
The petitioner, learned counsel for the petitioner submits that he has on, as on today, deposited the amount before the,
Before the trial. court.
deposit the amount of 20% as directed by the appellate court before the trial court. The learned counsel for the respondent submits that he be permitted to withdraw the said amount. It is open for the respondent to file an application before the appellate court seeking a direction for withdrawal of the said amount. The appellate court on such application shall consider the same and pass necessary orders, bearing in mind the observations made by the apex court in the case of Jambu Bandari versus so and so Supra. In the light of the deposit of the amount and the order being complied, the petition does not need any further consideration at the hands of this court. The order so and so stands quashed, or again challenge matter stands quashed. The matter is, the appellate court is at liberty to regulate its procedure.
Subject to my objections, my lord, that application.
In accordance with law ಅಂತ ಹೇಳಿದ್ದಾರೆ. Yes. ಅದು ಜಂಬ ಭಂಡಾರಿ ನೋಡ್ಬಿಟ್ಟು ಮಾಡ್ಲಿ. Next.
20.
For petitioner, my lord, MMDL action. The petitioner is the accused number 2.
Stored illegally 472 metric tons of
But the petitioner is
Stones
accused-
immediately after vacation.
Please.
Objections, if any, by the state by then. Next.
In the meantime,
No meantime.
the petitioner is accused number 2 is the owner of the land, my lord.
No, maybe, yes. Storage is in your land only. Yes,
But we have executed the rental agreement
No.
by imposing condition, my lord.
Let's see. Yes, yes. Next, after vacation.
21.
This is 420, 504 and 506 my lord. The facts of the case, my lord, 31/12/2019, there was sale agreement between the complainant and accused number.
In the meantime, yes, next.
22.
But 7A matter, the copy is served on.
7A della, I will tag along with the further hearing matters. You file your objections wherever it is not filed, when each case is called.
Lords, I have only one request. Lords, 100 of them listed on a day factually for us.
No, I'm not doing that.
Please, please.
I'm only tagging it with that. The 6 matters what I'm hearing will form the crux of the submissions. ಎಲ್ಲದರಲ್ಲೂ ಅದೇ ಇರೋದು. Then I'll individually consider 10 cases each.
Please.
On each day.
Please, Lords. Because the 6
ಅದು ಈ
matters.
subject ಇಂದ ಆಚೆ ಹೋದ್ರೆ ರೆಗ್ಯುಲೇಟ್ ಮಾಡ್ಬೋದು.
Please.
ಮಾಡಕ್ಕಾಗಲ್ಲ.
Please. Because that which my lords is saying, those 6 matters are listed at serial number 197
Yes,
today.
that thing Sandesh Chowta sir will finish it today. No other 7A matters I will hear today. They
Please.
will all be tagged with that. They will all be listed 10 each. On
Please.
facts wise, I will go on.
Please. Deeply obliged.
And those orders which I have passed in every case will be there in that case.
Please. That will be in principles of law will be common. for
Yes,
us.
common.
Obliged.
That's interim order.
What interim order?
My lord, same interim order, no charge sheet.
ಅದೇ ಆ ಆರ್ಡರ್ ಇದೆ.
Standard order, ಅದನ್ನ ಬಿಟ್ರೆ ಬೇರೆ.
ಅದು ಬಿಟ್ಟು ಬೇರೆ ಯಾವ್ದ್ರಲ್ಲಿ ಯಾವ್ದು ಮಾಡಿಲ್ಲ.
Please.
Only in cases where there is
Trial proceedings are going on. If
going
they,
on,
if
ಅದು
they
ಮಾತ್ರ
point
I
it
have
out,
said
please.
something. Yes. Yes,
Obliged.
yes.
Deeply obliged.
Tag madam. 21. ನೀವು ಇದ್ಬಿಡಿ ಎಲ್ಲದರಲ್ಲೂ ಇದು
Please,
ಮುಗಿಸ್ಬಿಡಿ.
please.
Madam. 16th. Them all on 16th. ಇದನ್ನ ಹಿಯರ್ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ ಈಗ.
Please.
We'll post others on 16th.
16th.
A further hearing tag ಮಾಡ್ತೀನಿ.
16th of January.
16th.
By that time, we'll file all the counters.
All objections, ಎಲ್ಲ pleading, get the pleadings complete by then.
Please,
Yes.
deeply obliged.
ಸಂದೇಶ್ ಸರ್ ಇವತ್ತು ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
Problem my lords pointed out, the complainants all have to be served.
True, that anyway we'll finish that. We'll see. Yes.
23.
Yes. Brother has filed complaint against.
Brother.
Yes, sir. Own brother, blood brother.
Own brother.
Yes, sir.
So what? Offense.
Offense, my lord, with
379,
PCR ಇದೆ.
PCR ಗೊತ್ತು. Offense ಏನ್ ಹೇಳಿ?
323, 324, 354.
354 sir.
447,
ಅದೆಲ್ಲ
448.
ಪರವಾಗಿಲ್ಲ. 354.
Oh, 447, 448.
ಅದೇ 354 ಅಂತ ಹೇಳಿ ನೀವು ಓದ್ತಾನೆ ಇದೆ ಬೇರೆ.
My lord, your lordship. please
CCTV footage ಇದೆ.
ಅದೇ, your lordship, please can you
yes.
see the page number 28, my lord.
Come to
number-
page 44, sir.
Page number 28, my lord. Page number
Oh,
20.
yes, one HCGP, two emergent notice.
Your lordship, please kindly see page number 28. Since 2012, the allegation started, my lord, with regard to the.
That's all right, but-
This complaint was filed, my lord, with regard to evict me from the house, my lord. Several OS cases are pending in the court, my lord.
Except 354, others we will, 380, 447, 448 ಗೆ ಮಾತ್ರ ಸ್ಟೇ ಕೊಡ್ತೀವಿ.
Except 354, my lord. No problem.
379 ಇದೆ.
379 ಓನ್ಲಿ ಕೆಳಗಡೆ ಬಂದು ಓನ್ ಸಿಸ್ಟರ್ ಮನೆಯಿಂದ ಹೊರಗಡೆ ತೆಗಿಲಿಕ್ಕೆ ಇದೆಲ್ಲ ಪ್ಲಾನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. My complaint they have not
One
entertained.
HCGP, two emergent notice, returnable, two emergent notice, except the offense under section 354. ಯಾವ್ದು 354 ಏನಾ?
ಹೌದು 354.
Except the offense under section 354A C, sorry, 354C, all other offenses shall remain stayed. Next.
24.
Here some other documents, my lord, from the party.
After vacation, yes.
Meanwhile, notice may be ordered to.
One HCGP, two ವಜಾ ಮಾಡ್ತೀನಿ. One HCGP, two emergent notice. Yes, next. Pendency of this petition will not come in the way of further proceedings. Next. ಇದು ವೆಂಕಟೇಶ್ 7 ಅದೇ.
All two has to be, notice has to be.
Emergent notice to the one BB Patil. State of
I'm already on
Karnataka.
power. Small notice is given to
Matter
me.
had come up last 3
All
days
right,
back.
emergent notice to the complainant returnable by 16th January. Tag along with that.
Same
Same
interim.
order. Other, exactly same order. Yes, next.
Oblige.
26.
Petitioners in this case, it is 171E, 188 and 133 of RPI.
In the meantime,
It's covered by the.
ಮುಗ್ಸ ಬಿಡೋಣ. ಕವರ್ಡಾ? ಇಲ್ಲ ಅಂದ್ರೆ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ. ಕಾಪಿ ಅವರು ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಆಗ್ತಾ ಗಿವ್ ಇಟ್ ಇನ್ ಅಡ್ವಾನ್ಸ್. 171 ಈಗ 171B ಇರ್ಬೇಕು ಬ್ರೈಬರಿ.
171E, my lord, in our case, the 171 states 2 persons are required. In our case.
ಉಮೇಶ್ ಶೆಟ್ಟಿಸ್ ಕೇಸ್ ದೀಕ್ಷಿತ್ ಅವ್ರದ್ದು ನೋಡಿ ಬೇಕಾದ್ರೆ ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತೀವಿ. ಪಾಸ್ವರ್ಡ್ ಎಸ್ ಪಾಸ್ವರ್ಡ್ ಮಧ್ಯಾಹ್ನ ಮುಗಿಸ್ಕೊಂಡು. ಎಸ್ ನೆಕ್ಸ್ಟ್.
27.
For petitioner, my lords, non-compliance of section 155 minutes.
Offense ಏನು ಮೇಡಮ್?
24E of Karnataka Forest Act, my lords, and section 20.
ಎಸ್ ಕಮೆಂಟ್. ಇದಕ್ಕೆ ಕವರ್ಡಾ?
Yes, my lords, page number 45, my lords.
ಇದು ನೋಡಿ.
My lord, in this case, my lord, 155 subclass 2 is only below the rank of police officers.
ಕವರ್ಡ್ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ ನೋಡಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ
I'll check.
The learned counsel for the petitioner submits that the issue in the list stands answered by the coordinate bench in criminal petition 101,990 of 2022. The counsel for the respondent, the learned HCGP would however dispute the position. Therefore, list this matter on 13th January. Till such time, further proceedings shall remain stayed. Next.
Okay.
Offenses are 420, 406, 504, 506. The entire allegation against the fact of the case is the petitioner.
498 ಯಾರು ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ?
The petitioner
Against the husband.
Yes, my lord.
Now the complainant is the husband.
Yes, my lord. Entire allegation against the husband. Husband is who is the accused number 1 in this
ಅಲ್ಲ
case.
ಸರ್, ಈಗ ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು ಸರ್?
Complaint is no. Complaint ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ ಮೇಲೆ.
ಯಾಕೆ ಗೊತ್ತಿಲ್ಲ?
ಅವ್ರು
ಇಲ್ಲಿದಾರಲ್ಲ.
ಹೇಳ್ತಾರೆ ಅವರು ನಮ್ಗೆ ಗೊತ್ತಿದ್ರು ಇಬ್ರು ಗೊತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ ಮೇಲೆ. That
So
entire.
you are the wife.
Yes, my lord.
The petitioner is the wife of.
No complaint, no FIR is produced in the.
Where is the complaint?
Not given me. ಏನಿಲ್ಲ ಇದು.
ನಿಮ್ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲಿ?
ನಮ್ದು ನಮ್ ಕಂಪ್ಲೇಂಟ್
ಅಲ್ಲ ಸರ್, ನಿಮ್ ಮೇಲಿರೋ ಕಂಪ್ಲೇಂಟ್ ಯಾವುದು?
ನಮ್ಮಲ್ಲಿ ಮೇಲೆ ಇಲ್ಲಿ ಇದೆ ಮೇಲೆ A2 ಮೇಲೆ ಪೇಜ್ ನಂಬರ್.
ನಿಮ್ ಮೇಲಿರೋ ಕಂಪ್ಲೇಂಟ್ ಯಾವ್ದು ಸರ್?
ಪೇಜ್ ನಂಬರ್ 17 ಪೇಜ್ ನಂಬರ್ 20 ಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 20
ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
ನಮ್ಗೆ
ಪೇಜ್ 20.
ಇಲ್ಲ
ಕೊಟ್ಟಿದ್ದೀವಿ
ನಾಟ್
ಇಲ್ಲ ನಾನು ಕೊಟ್ಟಿದ್ದೀವಿ ಮೇಲೆ
ಯಾವ್ದು ಕೊಟ್ಲಿ?
ಪೇಜ್ 20.
20 and 21 ಮೇಲೆ
ಕಾಪಿ. somebody is registered against the petitioner is the wife of one Yaradu Veerayya. The husband appears to have taken a lot of money from the complainant. The relationship between the husband and the wife is strained, and the wife has registered crime number 34 of 2024 against the husband for offense punishable under 498A. The counsel for the petitioner submits that the husband has now husband is accused number 1, Allah.
Yes.
The counsel for the petitioner submits that since the relationship is strained, all the allegations are now made against the wife who has nothing to do with the complainant. Based on the said statement, there shall be an interim order of stay of further investigation query petitioner till the next date of hearing. Next. On HCGP to emergent notice.
59.
Case under section 75 of the Juvenile Justice Care and Protection Act. may not be
Investigation
submitted.
paper said.
I could not secure, my lord.
I have already said.
Yes, my lord.
The learned
I think in this
HCGP
case-
seeks time, yet again to secure investigation papers list on Friday in the fresh matters list.
Please.
Yes, next. In the event the
Third.
investigation papers are not placed, the court would be constrained to grant an interim order of stay. Next.
Friday I'll secure.
Yes.
30.
On Monday, your lordship directed me to place on record the death note of the deceased,
306.
108.
108. Yes.
ಅಲ್ಲಿ death note ಇದೆ ಇದರಲ್ಲಿ.
Death note ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹಾಕಿ.
Death notice
ಹೌದು.
furnished. It is
ಹಾ.
there.
ಏನಿದೆ ಅಂದ್ರೆ ನಾನು ಬೇರೆಯವರಿಗೆ
The allegation all against this petitioner.
ಆಯ್ತಾಯ್ತು. ಹೇಳಿ.
ಅಲ್ಲ ಸರ್ ಹೇಳಿ. ಎಸ್ ಎಸ್ ಸರ್.
Kindly have a look at the death note.
ಹಾ.
13/11/24. ಅಡಿಕೆಯನ್ನು
What is the date of registration of the crime?
on 13/11/2024 is the date of suicide. On 14th,
Is the crime. What investigation for the last 1 month?
ಇದರಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ನೋಡ್ಬಿಡ್ತೀನಿ ಡೆತ್ ನೋಟ್ ಅಂತ ಅಷ್ಟೇ, ಇದೇನಿಲ್ಲ. In fact, the coordinate bench has already said, my lord, it may not amount to an offense under.
Bail ಕೊಡ್ಬೇಕಾರ?
Bail ಕೊಡುವಾಗ.
ಹಾ.
ಅಲ್ಲ, that may not be binding on your lordship.
ನನ್ನ ಸಾವಿಗೆ ಮುಖ್ಯ
Incidentally,
ಕಾರಣ ಅಡಿಕೆ
60 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಅಡಿಕೆಯನ್ನು ನನ್ನಿಂದ ಖರೀದಿ ಮಾಡಿ ಹಣವನ್ನು ಪಾವತಿಸಿರುವುದಿಲ್ಲ. ಹಣವನ್ನು ಕೇಳಲು ಹೋದಾಗ ಅವಾಚ್ಯ ಶಬ್ದದಲ್ಲಿ ಬೈದು ಕಳಿಸಿರ್ತಾರೆ. ನಾನು ಹಣವನ್ನು ಬೇರೆಯವರಿಗೆ ಪಾವತಿಸುವ ಒತ್ತಡ ಬಿದ್ದ ಕಾರಣ ನನಗೆ ಬೇರೆ ದಾರಿ ಕಾಣದೆ ಅನಿವಾರ್ಯವಾಗಿ ಸಾಯ ನಿರ್ಧಾರ ಮಾಡಿ. ಅಬೆಟ್ಮೆಂಟ್ ಏನಿದೆ?
ಎಸ್ ಸರ್. ಡೆತ್ ನೋಟೇ ಇದು.
ಡೆತ್ ನೋಟ್
ಅಷ್ಟೇ ಡೆತ್ ನೋಟ್.
ಅಷ್ಟೇ.
ನನ್ನ ಸಾವಿಗೆ ಮುಖ್ಯವಾಗಿ ಉದಯ
ಹಾ, ಹೌದು.
ಶೆಟ್ಟಿಯ ಕಾರಣ.
ಆಯ್ತು, ಅದು ಯಾಕೆಂದ್ರೆ ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ.
He was indebted to so many persons, his creditors were making a pressing demand upon him. He could not withstand the pressure, therefore he is committing suicide.
6,60,00,000 ಮೌಲ್ಯದ
100 ಕೋಟಿ ಆಗಿ
ಅಡಿಕೆಯನ್ನು ನನ್ನಿಂದ ಖರೀದಿ ಮಾಡಿ ಹಣವನ್ನು ಪಾವತಿಸಿರುವುದಿಲ್ಲ.
ಆಯ್ತು, ಅದು ಅಬೆಟ್ಮೆಂಟ್ ಆಗ್ಬೇಕಲ್ಲ. ವೇರ್ ಇಸ್ ದ ಬೇಲ್ ಆರ್ಡರ್?
Yes, I have.
ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್?
Yes, as coordinate.
ಇಲ್ಲ, ಇದೆಲ್ಲ ಅಲ್ಲಿ ಕೊಡೋದೇ ಇಲ್ಲ, ಇಲ್ಲೇ ಬರ್ಬೇಕು. ಅಲ್ಲಿ ಕೇಸ್ ಇದ್ರು ಕೊಡಲ್ಲ.
With or without this anticipatory bail order.
That's all
Had
right.
some other liability also, my lord, to discharge.
ಆಯ್ತು, ಲಯಬಿಲಿಟಿ ಇದ್ರೆ
Sir, abatement ಬೇಕು sir
When
first.
he approached the buyer, my lord, he has abused the.
that will not amount to abatement to suicide. Very difficult. Yes, heard the learned senior counsel. C.V. Nagesh appearing for the petitioner. The petitioner is alleged of offence punishable under section 108 of the
350. 108 and.
and 108
and
other
352
352 of the BNS, which is 306 and
ಹೌದು, correct.
504 other
107
107. 107?
abatement.
That is 108 is 107.
ಅಲ್ಲ, ಈಗ ಹೊಸದು BNS ಅಲ್ಲಿ ಇವ್ರು
ಅಲ್ಲ,
ಹಾಕಿದ್ದಾರೆ.
ಅದಾಯ್ತು 352 ಏನು?
352 my lord is
That I am aware.
ಏನಿಲ್ಲ ಅದರಲ್ಲಿ.
306.
306. 108 is 306, 504. Yes. So also. The
352 is
Rest-
intentional insult.
504. The petitioner and the their brother, ಅಲ್ಲ, deceased complainant ಯಾರು?
Complainant is the brother of the deceased.
The petitioner and the brother of the deceased are said to have had a financial transaction. The financial transaction leads to exchange of funds on sale of arecanet, exchange of leads to certain funds to be given by the petitioner to the deceased on sale of arecanet. On a particular day, it transpires that the petitioner has the brother of the complainant goes to the petitioner demanding money, which is denied. The complainant, the brother of the complainant, then commits suicide. The counsel for the learned senior counsel submits that the brother of the complainant had was owing money to several people and therefore had committed suicide. Though a precious life was lost, but the legal precious life is lost, this court would not ignore whether the ingredients of section 108 of the IPC, so of the BNS, is met or not. The death note is in place. The death note reads as follows. Page 7. Death note.
ಮೆಮೊ ಹಾಕ್ಬಿಟ್ಟು ಹಾಕಿದೆ
ಅದೇ ಮೆಮೊಲ ಈಗ ಓದಿದ್ರಲ್ಲ,
ಅದು ಪೇಜ್ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ.
ಪೇಜ್ ನಂಬರ್ 1.
ಇವಾಗ ಓದಿದ್ರಿ.
Still the investigation is pending.
ನನ್ನ ಸಾವಿಗೆ ಕಾರಣ ಅಡಿಕೆ so the death note reads as follows. Prima facie, the death note would indicate no instigation or goading at the hands of the petitioner for him to be instigation or goading against the petitioner. The learned counsel for the learned HCGP submits that the investigation is still pending. You cooperate with the investigation, sir?
Sure. Well, anticipatory bail condition is.
You cooperate with the investigation. Will direct no precipitative or coercive action against you for a period of
Coercive action.
for 2 weeks.
ಅಲ್ಲ, ಇದರಲ್ಲಿ anticipatory bail petition itself is allowed.
Bail ಇದೆಯಲ್ಲ ಹೆಂಗು?
ಹೌದು.
You cooperate with the stay ಮಾಡಕ್ಕೆ investigation pending ಇದೆ ಅಂತ ಅಷ್ಟೇ. Therefore, the
ಇದರಲ್ಲಿ condition is the petitioner shall cooperate with the investigation.
True, so and so. The petitioner, there shall be no coercive steps or precipitative action taken against the petitioner for a period of 4 weeks. For a period of 4 weeks, the HCGP shall place on record the records of investigation on the next date. That should protect you adequately.
ಅಲ್ಲ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಎಷ್ಟೇ ಆಗ್ಬೇಕು ಅಂತ.
ಅದು ಇನ್ನು 306 ಕೇಸಲ್ಲಿ
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಲೇಟೆಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
No, Kamaruddin I am seen, but those are all matters after trial. Supreme Court says 306 ಅಲ್ಲಿ some investigation material should be available.
ಇದು ಬಿಟ್ರೆ ಬೇರೆ ಇರೋ ಚಾನ್ಸಸ್ ಇಲ್ಲ.
We'll see whatever. ಅದಕ್ಕೆ anyway protected you, nothing will happen. Yes.
No coercive steps.
ಹೇಳಿದಿನಲ್ಲ.
ಅಲ್ಲ,
ಎರಡು
precipitative ಬೇಡ.
ಯಾಕೆ ಎಲ್ಲ ಒಂದೇ.
ಕೋಯರ್ಸಿವ್ ಸ್ಟೆಪ್ಸ್ ಅಲ್ಲ ಸರ್, ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಇದೆ, ಅವ್ರು ಏನು ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ.
Next.
The investigation has to
precipitative action against the petitioner.
Yes.
Till the next date. However, the petitioner shall abide by the condition of the anticipatory bail in cooperating with the investigation.
Please.
That's all. Yes. Next.
Your Lordship may direct the state to keep the records of the
Yes,
case.
that next time. Records of investigation, I've already said. Yes.
Your Lordship is fixing a date, man.
4 weeks ಆದ್ಮೇಲೆ I've granted this order for 4 weeks. ಅವ್ರು ನೀವೇ ಮೂವ್ ಮಾಡ್ತಿರಲ್ಲ 4 weeks ಅಲ್ಲಿ. Yes. Next.
31.
Await police report, my lords. Interim order that my lords have granted.
Granted?
Interim order is there.
Post immediately after service of notice upon the respondent.
Interim order.
Yes, next.
32.
498A 504.
Husband and in-laws. 2 petitions, 32, 33. There is no allegation against the husband and in-laws. In-laws.
ಇನ್ಯಾರ ಮೇಲೆ ಇರುತ್ತೆ?
In-laws ಏನಂತಂದ್ರೆ that they have mentally harassed ಅಂತ ಅಷ್ಟು ಬಿಟ್ರೆ ಇನ್ನೇನಿಲ್ಲ. ಹಸ್ಬೆಂಡ್ಗೆ
ನಿಮ್ ನೆನ್ನೆ ಒಂದು ಸ್ಟೇ ಕೊಟ್ಟಲ್ಲ ಯಾವ್ದು?
Yes, my lords.
ಅದು ಬೇರೆ ಮ್ಯಾಟರ್.
That's a different matter.
ಡಿಫ್ರೆಂಟ್ ಮ್ಯಾಟರ್.
Yes, my lords.
ಹೇಳಿದ್ರು ನೆನ್ನೆ.
ಅಲ್ಲ ಹಸ್ಬೆಂಡ್ ನಿನ್ನೆ ಸ್ಟೇ ಕೊಟ್ಟ.
ಅದೇ ಹೇಳಿದ್ರು similar matter.
At 5:30.
Yes. Amlad, what had happened was the complainant had thrown the in-laws out. There was a complaint filed. This was in August 2023. A senior citizen case was filed to reinstate them back to the daughter-in-law's house, their own house. Then Lord, notice was issued to an MC case by the husband. MC case was filed in September. Then there was a criminal case filed by mother-in-law that she had been assaulted by the daughter-in-law. This was in
Empowered.
October 23, reverse. And finally, she lodged the complaint in December 23.
Heard the learned senior counsel. ಎರಡು ಟ್ಯಾಗ್ ಮಾಡೋಣ.
Yes.
32 and 33 ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡಿ. Heard the learned senior counsel Vivek Reddy appearing for the petitioner. The petitioners in these cases are the husband and other family members of the husband who are alleged of offense punishable under section 498A 323 inter-alia. The learned senior counsel, taking this court through the documents appended to the petition, would seek to demonstrate that the complainant had herself assaulted the mother-in-law and the husband, against which a complaint is registered. And the second set of allegations against the daughter-in-law, that the complainant, is that she had driven the mother-in-law out of the house.
Yes.
And the mother-in-law had to knock at the doors of the assistant commissioners, invoking the provisions of the Senior Citizens Act. And in terms of an order of the assistant commissioner, the mother-in-law comes back to the. ವಾಪಸ್ ಬಂದಿಲ್ವಾ?
ಬಂದಿಲ್ಲ.
The assistant commissioner ordered for take care of the senior
They
citizen. Then
had
you
to
challenge
approach the assistant commissioner, invoking the provisions of the Maintenance and Welfare of Parents and Senior Citizens Act 2007. The MC petition idea.
MC petition.
The parties are at large before the family court in MC 164 of 2023. After all these springs the impugned complaint, and the police after investigation have filed a charge sheet. In that light, permitting further proceedings would run foul of the judgment of the apex court in the case of Payal Sharma, 2024 SCC Online SC page 3473, where the other members of the family, and the judgment of the apex court in the case of Achin Gupta versus so-and-so, insofar reported in 2024 SCC Online SC page 749, insofar as the husband is concerned. Therefore, there shall be an interim order stay.
Please.
1 HCGP, 2 emergent notice.
Please.
Yes.
The next matter is by the in-laws.
ಎರಡು ಕನೆಕ್ಟ್
ಎರಡು
ಮಾಡಿಲ್ಲ,
ಎರಡು.
ಸೇಮ್ ಆರ್ಡರ್.
Yes. Please. Oblige.
34,
354, 376 and 506, my lords.
376.
Please, my lords had granted interim order of the investigation, my lords. At page
How
112.
charge sheet could be invested despite the interim order? Yes, sir.
Charge sheet was filed on 5/10, your lordship. Stay was given on 14/10, that communication.
1410.
39, my lord.
No, 29, 26/9, I guess.
30th of.
39. ಅದು ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿದೆ.
Please,
ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ ಈಗ.
there's no interim order. My lords had posted it today, my lords, from day before.
Order granted 2-3 days after the.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡೋದು 5:10. ಇಂಟ್ರಿ ಆರ್ಡರ್ ಆನ್ 39, 5 days ಬಿಫೋರ್. ಮಧ್ಯದಲ್ಲೆಲ್ಲ ಹಾಲಿಡೇಸೇ ಇದ್ದಿದ್ದು ಬಿಡಿ. ಇಲ್ಲ ಮಧ್ಯದಲ್ಲೆಲ್ಲ ರಜಾನೇ ಇದ್ದಿದ್ದು. ನೆಕ್ಸ್ಟ್ ವರ್ಕಿಂಗ್ ಡೇ ವಾಸ್ 5th. That's why.
Please, this is.
That was the last working day.
Please. This is a case, my lords, where there's a financial transaction, my lords, post the date of incident.
The offense on 376 and
354 and 506, my lords.
350, 376, 354, 506.
Please,
How long relationship?
my lords,
She is married lady.
Married?
no, she is married to somebody else, my
He
lords.
is married.
There is some relations between the petitioner and her.
Interim order ಮುಂಚೆ ಕೊಟ್ಟಿತ್ತಲ್ವಾ?
This is an interim order granted, my lords, page 112, my lords. Annexurial.
This court at the stage of registration of the crime had granted an interim order of stay which read as follows. Page
Page 112, my lords.
112. In the teeth of the interim order, the allegation is that the charge sheet is filed The learned HCGP on instructions and verification of the records would submit that the interim order was granted on 30th September 2024, and the intervening holidays, there was no communication to the investigating officer, and the charge sheet was filed on 3rd October 2024, not 5th. Come to Annexure A, you find the seal, 3rd October 2024.
Please.
The first and second being holidays, there can be no fault found with the investigating officer filing the charge sheet. But the protection that was granted at the crime stage is to be granted to the petitioner in the facts of the case. List this matter, facts of the case. 1 HCGP, 2 emergent notice, there shall be an interim order of stay. As was granted in the crime stage, supra.
Great.
35.
35 minutes. Split charge sheet.
Idu adena.
Accusation of theft in.
Split charge sheet ge
Acquitted, A2 and A3 acquitted the electricity theft of 1998.
ಆಯ್ತು. So
Of course, 97.
which accused are you?
I am A1, but all the three are partners.
All the three are?
Partners of the firm against whom there is an
CC
allegation.
of 2015. Crime complaint ಯಾವಾಗಿದ್ದು?
97.
97.
6 lakhs is the amount.
But they say, in the evidence, they say there is no misreading of the meter. Page
Hello, why did you
139.
take just 18 years to file charge sheet? ನೆನ್ನೆ ಒಂದು ಡಿಸ್ಪೋಸ್ ಮಾಡಿದೆ. ದಿ ಓಲ್ಡೆಸ್ಟ್ ಪೆಂಡಿಂಗ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್.
Which year?
1979. It was pending because of a split charge sheet against one accused who was 22 at the time of crime, who is 70 today.
70.
Now they've arrested him today. Today, in sense, 2 days ago when I disposed it. Oldest criminal case, 1979 crime, 45 years ago. And all others are acquitted in it.
All the
Same
others are
suspect.
acquitted.
All the others are
It
acquitted.
is exactly similar situation. 21, everybody is acquitted. 2 and 3.
The petitioner heard the learned senior counsel, Vivek Reddy, appearing for the petitioner. The petitioner, along with other accused, are alleged of offences under section 394429 of the Electricity Act, along with section 379 of the IPC. The allegation is theft of electricity. Crime was registered in the year 1997. The charge sheet is filed after just 18 years of investigation in the year 2015. In the year 2021, all accused get acquitted. Since the petitioner was not available for trial, the split charge was drawn against him. The allegation against all the accused are similar, and the acquittal of other accused in the year 2021 would inure to the benefit of the petitioner. Will state. Yes, government, you want to file objections?
Please, Your Lordship.
Objections are. All right.
Could be dismissed.
Therefore, split generally be disposed. Yes, madam.
Please, Your Lordship. The para number 38 of the
Order.
On merit, they say
Page.
meter reading nalli ಯಾವುದೇ ನ್ಯೂನ್ಯತೆ
I
ಆಗಿಲ್ಲ.
got 134.
130,
Page.
139.
139.
On merit itself, the accused is, I'm sorry, PW2.
ಇದು ಕಾಪಿ paragraph ಕಾಪಿ ಮಾಡಿ ವ್ಯೂ ಆಫ್ ಮನಿ ಇದೆಯಲ್ಲ. Okay.
Para 37, Lord.
38.
38. 38 is. Yes, please. Please.
Sure.
26. Oblige.
Next.
36.
Here for the petitioner. Lord, in the check bounce complaint, petitioner is the accused.
RTF ಅಲ್ಲ ಹೇಳಿದ್ ನಾವು. But one minute.
Here for the petitioner.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement to that effect. That in the meantime, there shall be an interim order of stay for the proceedings by the petitioner till next year. Next.
7.
Offenses are 353, 504 and 506, read with
Very good.
34 of IPC.
Very good. Whom did you assaults.
No assault, no criminal force.
The
my lord.
RTO office, your lordship.
Huh?
In the RTO office.
ಏನ್ ಮಾಡಿದ್ರು RTO office ಅಲ್ಲಿ?
DL learner's license ತಗೊಳ್ಳುವಾಗ
ಏನ್ ಮಾಡಿದ್ರು?
due to
ಬೈದ್ರು
delay.
ಅಂತ ಸ್ವಾಮಿ ಇದು.
Hey,
ಬೈದ್ರು ಅಂತ ಅಲಿಗೇಷನ್ ಇರೋದು.
ಬೈದ್ರು.
ಬೈದ್ರು ಅಂತ.
ಯಾಕೆ ಬೈದ್ರಿ?
He demanded the bribe. 18-year-old boy, my lords, at the time of driving license, he demanded the bribe. Something has happened. The allegation is that I have abused the senior RTO inspector. Based on that, an FIR has been registered for 353, 504,
it
506.
is at 28.
ಯಾವಾಗ ಇದು? 2020 ಅಲ್ಲಿ?
2019.
2019.
2019.
Now it is.
No 41A notice, no, we have not even called for investigation.
353 lakh ಕೊಡ್ತಾರೆ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಎಲ್ಲ. Yes, the petitioner is before this court calling in question proceedings in CC 1193 of 2020 registered for offence punishable under section 353, 504, 506 of the IPC. The complainant is a regional transport, a senior motorway, senior IMV. The allegation is at the time, why did you use these two words? That's the problem. RTO officer use ಮಾಡ್ತಾರೆ ಅದೆಲ್ಲ. Just because you know the words, you can't use that. ಅದಕ್ಕೆ ಅವರು ಕೋಪ ಬಂದಿದೆ.
Just 18 years of age and.
ಅವಾಗ ಅದೇ ವರ್ಡ್ ಬರೋದು, ಬೇರೆ ಏನ್ ಬರೋದು. ಮೆಚುರಿಟಿ ಬಂದ್ಮೇಲೆ ಗೊತ್ತಾಗತ್ತೆ. Yes, the allegation is that the petitioner has hurled abuses against the public servant which deterred him from performing his duties for the day. The allegation, a perusal at the summary of the charge sheet would not indicate that it would meet the ingredients as necessary for an offence under section 353 in terms of the elucidation by the apex court in the case of H. Dhananjay versus Cabinet Secretary so and so. Allide, really, sorry. It's not reported, it's self-valid. H. Dhananjay versus Cabinet Secretary so and so. Even otherwise, there is no allegation of assault, nor the allegation that the petitioner stopped the public servant from performing his duties by use of criminal force, which are necessary for an offence under section 353. In the absence of those ingredients, permitting further trial against these petitioners would prima facie become an abuse of the process of the law. There shall be an interim order of stay of further proceedings till the disposal of the petition. Learned HCGP accepts notice for both the respondents.
Judgment ಕೊಡ್ತೀನಿ ಸರ್.
Next.
38.
ಅದು ತರ್ಬೇಕು ನೀವು ಅಂತ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. Why I keep saying is you also should get updated. Yes. Next.
Filing undertaking, lordship. Last week, yesterday as told.
ಏನದು?
Undertaking.
Undertaking.
Yes, please.
The counsel for the petitioner files, ಈಗ ಹಾಸ್ಟೆಲಿಂದ ಹೋದ್ರೆ ಎಲ್ಲ ಸರಿ ಹೋಗುತ್ತೆ. The counsel for the petitioner has placed an affidavit of undertaking of both the petitioners.
Yes, both
the petitioners, they would vacate the hostel premises and not cause any hindrance. Since the petitioners are students and their internal assessment examinations are ensuing, the crime would prima facie disturb or destroy the career of the petitioners. In that light, in the light of the undertaking and the undertaking, as also the fact that the ingredients of the offences are not met, albeit prima facie, I deem it appropriate to stall all investigation against these petitioners. One HCGP complaint ಬರ್ಬೇಕಲ್ಲ, ಎಲ್ಲರೂ ಮುಗಿಸ್ಬಿಡ್ಬೋದು. One HCGP, 2 emergent notice. Stay ಅಂತ ಬರೀರಿ, ಪೊಲೀಸ್ನವರು ಸ್ಟಾಲ್ ಅಂದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ. Stay of all investigation. Yes.
Please, please.
Interim order ಇಲ್ಲ ಅಂತಾರೆ ಸ್ಟಾಲ್ ಅಂದ್ರೆ.
Please, please, my lord, please.
Yes.
39.
You have the advocate for the petitioner. 11th standard boy, my lord, some class argument has happened inside the classroom. College has filed a complaint. On that basis, FIR has been registered. In the complaint, nobody is named also. My lord, the complaint is at page 17, 17.
I may be permitted to take notice for respondent number 2.
ಏನ್ ಹೊಡೆದಿದ್ದಾರಾ?
Respondent 2 is the college principal. I'm only
You're the complainant.
Yes. I'm only forwarded the complaint as per section 19 requirement of the POCSO Act.
Who has indulged in 8 and 12 of POCSO?
Lord, the allegation is that the accused has All of them are minors at that point of time. Today, the accused is 18 years old. Page 17, my lord.
All of them minors, at which school this is?
Christ College.
Ah,
11th standard student. Some argument inside the class. At page 17, in fact, the complaint is quite bland. Just says that there was some intercalation between the students. Nobody is a victim, nobody is the complainant ಅಂತ specifically ಹೇಳ್ತಾರೆ.
ಎಲ್ಲಿದೆ nobody is
ಅದು
the victim?
page 17 ಅಲ್ಲಿ I so and so the principle of
ಎಲ್ಲ
correction
ಆಯ್ತು, ಆ sentence ಎಲ್ಲಿದೆ? Nobody is the victim. nobody is-
the complaint has generalizing accusations and does not specify by name any person in particular as a victim or
No,
accused.
where is that sentence that they have said?
Here it
They
is.
have not said. Page 17 ಅಲ್ಲ?
Page 17 ಅಲ್ಲಿ
Huh.
the second last line in the first paragraph. The complaint has generalizing accusations and does
Accusations.
not specify any name by name any person in particular as a victim or accused.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ ಈಗ?
ಚಾರ್ಜ್ ಶೀಟ್ ಇಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ತದೆ.
What
Bill
investigation on this? What derogatory against a girl you have said?
But nothing has been done. I'm in fact, I am suffering mental depression and ADHD problems.
Why?
My medical records are all produced for the
File
last 2, 3
file an undertaking that you will not indulge in such things.
Certainly.
Will state tomorrow. Yes.
But why is available or not, I don't know. He may have been admitted in hospital because for quite
So
some
because
time.
of this,
And other generally ongoing
Don't
treatment.
worry.
my lord. I'll try.
they will
I'll
get
try.
it.
If
My name may be reflected,
Learned
I'll appear
counsel,
tomorrow.
Sorry,
Pratik Chandra.
Pratik Chandramouli undertakes to enter appearance for the second respondent complainant. Register to print the name of so and so as appearing for the second respondent complainant.
I'll file it. Grateful.
So that interim order will be binding, undertaking will be binding.
Certainly, man. Good behavior is, there is no problem with
That is why in the other case also I so said.
I agree.
Students will permit, but they should not indulge in such things.
Agree. Yes, great.
Yes.
40.
Appear for
But-
petitioner.
That's-
Lord, offences are, my lord, 447, 427, 504, 506, read with
Who is in
34.
possession?
My lord, now, so far as my suit scheduled property is concerned, second respondent, he himself is in possession.
Hmm.
My lord, several revenue, before the revenue courts and civil suits are, two civil suits are pending, and one CRP is pending with consideration before this.
So
are
why
full
did
court.
you trespass into his property?
Because, my lord, I am aged about, my lord, 89 years.
Like, you trespassed into his property?
ಇಲ್ಲ ಆದ್ರೂ ಏನಾಗಿದೆ ಅಂದ್ರೆ there was a dispute between
In the
fourth
meantime. Yes, 9 ವರ್ಷ ಇವ್ರು ಇವ್ರೇನ್ trespass ಮಾಡ್ತಾರೆ. Yes, next. In the meantime, state sir.
statement.
Yes, sir.
Please.
Next.
41.
138 proceeding. I have crossed, your lordship, please.
Cross that.
10/9/24, my lord.
311 application,
Yes, 311 application.
ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
ಹೌದು ಸರ್. 10/9 ಗೆ ಅವ್ರು ಕಂಪ್ಲೀಟ್ ಮಾಡಿದ್ದಾರೆ
ಹಾ.
ಎಕ್ಸಾಮಿನೇಷನ್ 10/9/24 ಗೆ.
Petitioner to serve on the council who represents the respondent in the trial proceedings and file an acknowledgement to that effect. Till the appearance of the complainant, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. Till the appearance, stay ಅಷ್ಟೇ, next date ಬೇಡ. Next.
42.
171E.
The petitioner's counsel. 171, my lord, E.
Special provision,
yes,
special
my lord.
cause.
Yes, my lord. Lord, the police have, my lord, first seized the material and, my lord, searched everything they have done, and then they sought for permission from the magistrate. Therefore, my lord,
ಯಾವತ್ತು?
the horse put behind the cart, my lord, and on that
Election time,
election time.
9/4.
T-shirt has been printed and it was in a goods tempo. It was neither distributed nor, my lord, supposed to be distributed. That is what the,
Online
even according to
transactions,
the.
payment.
In Modi once more.
But none of the people will be influenced by giving the T-shirts and everything, my lord, which is printed in somebody's name. I can understand, my lord, if it is a brand,
Anyway,
Nike or
it is-
Adidas or something.
ಯಾಕೆ ಅಡಿಡಾಸ್ ನೈಕ್?
ಅಲ್ಲ, ಅದಾದ್ರೆ ಕೊಟ್ರೆ ಇನ್ಫ್ಲುಯೆನ್ಸ್ ಆಗುತ್ತೆ.
ಎಂತದು?
ಇದು ಯಾರ್ದೋ ಹೆಸರು ಫೋಟೋ ಹಾಕಿದ T-shirt ಓನ್ಲಿ ಪಾರ್ಟಿ ಸಿಂಪಥೈಸರ್ಸ್ ಕ್ಯಾನ್ ವೇರ್ ಇಟ್. This is what the Andhra Pradesh High Court also said, right?
Yes. Heard the learned senior counsel Arun Sham appearing for the petitioner. The second respondent is the flying squad. The offences alleged are the ones punishable under section 171E and 171C. 171E deals with punishment for bribery, for which the ingredients of section 171B is necessarily to be present, which prima facie is absent in the case at hand. Even otherwise, the learned senior counsel would submit that all the actions of investigation were complete, and then the learned magistrate accords permission to register a crime for offences punishable under the offences punishable as afore quoted, which are non-cognizable. In that light, there shall be an interim order of stay of further proceedings qua this petitioner till the next date of hearing. Yes, next.
43.
Special court matter alla idu?
Special illa. Lord, earlier, the MP was made as accused in the FIR. In
That
charge sheet,
should
it
drop
dropped out.
Death.
Accused number 8, but this case, 306.
306.
Commitment to suicide. I never seen him, merely because I entered into a JDA with A1.
A12 was granted stay, your lordship, but this A8 is the agreement holder.
It's all right. How will that mean abetment to suicide, madam? Elli kodi they tag the petition along with 812. There shall be an interim order of stay. Adil kotrade ಮಾಡಿ. Next. Next.
44.
Lord's offences are under section 7 and 8 of COTPA Act. The allegation in the
E-cigarette.
How-
E-cigarette.
Hookah, Swami, hookah.
Hookah.
A raid was, my lords, this offence was done in the way back in the year 2000.
Before my judgment.
Before your lordship's judgment in the 2023. The allegation is that I have not been following certain government guidelines, and section 7 and 8 of the COTPA Act has been invoked. Section 7 and 8 of COTPA Act can only be invoked if I don't put up the warning sign. That is
Warning
what
itta? Warning idea?
ಅವ್ರು ಹೇಳಲ್ಲ ಸ್ವಾಮಿ, they only say I have violated the government restrictions ಅಂತ ಹೇಳಿ. They do not specify what is the government restriction that I have violated.
There is a ban already. Yes. Ban is upheld also.
Yes, ma'am.
They heard the learned counsel Mahesh YL appearing for, you are Mahesh, right?
Yes, ma'am.
Appearing for the petitioner. The petitioners are before this petitioners are before this
Accused
court,
number 1 and 2.
calling in question so and so proceedings registered for offence punishable under section 7 and 8 of the COTPA Act. Allide purti hakbit COTPA Act ಅಂತ ಮಾಡಿ. The learned counsel would submit that section 7 and 8 could get attracted only if the statutory warnings are not in place. That is not the finding in the summary of the charge sheet. In hammered pub idu.
Hammered Pope, HSR level.
They've not properly hammered it. Yes, so and so. What's that? So and so is not the allegation. A perusal at the summary of the charge sheet is not the allegation. In that light, there shall be an interim order of stay for the proceedings.
Deeply
Query
obliged.
petitioner to the next date of hearing. Now you are selling hookah.
No, my lords, we are not selling. It's
45.
For the petitioner, lordship. The
341.
respond number 2 was, it's in for 323 and 341, 504 and 506.
In the
lordship.
meantime, next.
State lordship.
States.
Great.
341 gain ಇದೆ ಏನು ಇಲ್ಲ. Yes. Next.
46.
And for the respondent. He
Ah.
is saying it is covered, but I want to argue, Your Lordship,
But
have
this is
it
a matter
after
where,
vacation, but it's not covered,
Not covered.
not covered.
Yes.
The Lordship's judgment,
according
yes,
to him,
please.
not covered, according to me, it is covered, but because the complaint is offense under section, under the provisions of pollution control.
There is already an interim order.
Water Act.
Options are very
Interim
clear.
order ಇದೆಯಲ್ಲ.
ಹೌದು ಇದೆ.
Interim order.
Less the matter.
ಇಲ್ಲ, interim order ಇಲ್ಲ, I'm sorry.
ಇದೆ, ಇದೆ.
ಇದೆ. I have granted.
Yeah, I'm so sorry. Yes, madam. Last time ಕೊಟ್ಟು.
ಅವರಿದ್ರು.
Grateful.
Yes, learned counsel appearing for the respondent Sampathana Shetty seeks 2 weeks' time to file his objections or make his submissions as the case would be. In that light, the interim order subsisting shall continue till the next date of hearing. Next.
And I am also filed on application, my lord, interim application with additional grounds, that would be kindly allowed.
Will allow
Not
addition-
in
ಬೇಡವಾ?
additional.
Additional
Copy
grounds.
ಇರ್ಲಿ ಬಿಡಿ.
Copy ಕೊಡ್ತೇವೆ.
Will be heard along with the main matter.
47.
Your lordship, interim order is granted. I'll take notice for all two also.
Learned HCGP accepts notice for the second respondent as well, thus completes the service of notice list after vacation. Interim order subsisting would continue to, ಇಲ್ವಾ? ಇದೆ
ಇದೆ,
ಅಂದ್ರೆ
ಇದೆ,
ಮತ್ತೆ?
interim order ಇದೆ.
ಇದೆ
Last
ಅಲ್ವಾ?
Last date interim.
Interim order subsisting will continue to the next date of hearing.
Great.
48.
It is section 7A.
ನಿಮ್ದೆ 1979
ಅಲ್ಲ, ಇದೆ.
ಕ್ರೈಮ್ ಅದ್ ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ದವ್ರು.
ಹಾ.
ಓಲ್ಡೆಸ್ಟ್ ಕ್ರೈಮ್.
This is under section 7A.
ಅದು previous intimate, if any will continue. Production ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ. After vacation ಬರ್ಲಿ. List after vacation. ಇದು notice ಆಗಿಲ್ವಾ ರೆಸ್ಪಾಂಡಿಂಗ್?
ಇಲ್ಲ. 7 8
ಸರ್ ಟ್ಯಾಗ್ ಮಾಡಿ. Yes.
interim production.
Same.
Petitioner in
Point number 2 in 49.
squabble between the landlord and tenant, my lord. On the last occasion, this honorable court had directed me to seek instructions from my client regarding payment of rent. But my client has been unable to come to office since his
Then
father.
we'll vacate the interim order.
Lord,
Lords.
if I may kindly make this submission, because his father has been in and out of the hospital due to some fluid collection in the brain. I will file the documents before this honorable court.
ಈಗ
if
rent
I
is
may
not
be given-
not paid.
My lords, I want to point out only 2 points, my lords. Lease has expired in 2023 April.
Then
One
leave it.
1.5 ವರ್ಷದಿಂದ one single rupee is not paid and squatting on the property. He's
Then
he's
you
been
are-
unsuccessful
then
in all his attempts
447.
for injunction.
What is the allegation here?
The allegation is that while I was traveling,
Hmm.
they have tried to forcibly evict me
Correct, no problem.
when my child was alone at home. A 13-year-old
The-
child was alone at home.
So now
Give me
you,
given one opportunity.
that's all
to put
right.
forth
Now you
my-
pay up or what?
But I'll seek instructions regarding the same. The
No
only reason-
instructions. This court on 3/12/2024.
Maybe kindly passed over.
One minute is
Maybe
get
take that.
around,
Grateful.
pass over.
Lords, in this petition, charge sheet has been filed, my lords. Kindly have it after vacation, my lords. I'll withdraw it and.
ಈಗ ಮಾಡಿ ಆಮೇಲೆ ಹಾಕಿ.
Because
Yes,
interim order
format.
is there in respect
Interim
of
order ಇದೆಯಾ?
petition
ಹಾಗಾದ್ರೆ
number
after
5.
vacation. Learned counsel for the petitioner submits that the during the subsistence of the interim, how did they file charge sheet? Interim order ಇರ್ಬೇಕಾದ್ರೆ?
We were not knowing that the charge sheet was filed, my lords.
ಮುಂಚೆನೆ ಹಾಕಿದ್ದೀರಾ?
Please, my
Then
lords.
you
3
withdraw it
days
now. Withdraw it now.
Please,
It's
my
your
lords.
wish.
After vacation.
List after vacation.
Grateful, my lords.
Petition in this case.
Lordship, I'm for respondent number 6, my lordship. I'm filing my wakalat along with a memo, my lordship.
ಏನು?
It's regarding the
Here was
execution of the
execution of
the NBW issued by the trial court for
There is a,
enforcement of the maintenance order.
Yes,
actually, if I may submit, there is a practical issue. He's in Jammu Kashmir. So there is ice filled everywhere. He's unable to travel
It's
here.
true, but evident, maintenance.
My lordship,
ಕೊಡ್ಲೇಬೇಕಲ್ಲ madam?
I am producing a sale deed which has been registered in the petitioner number 1, my lordship. It's not like
Ready.
I'm going to escape from the liability.
Give it.
For sure, I will settle,
Will direct attachment of your salary.
lordship.
ಒಂದ್
In
ಸ್ವಲ್ಪ
the
ಅದು-
next hearing date, I'll keep him present, my lordship.
when is he coming?
My lordship, end of, last week of Jan, my lordship. My lordship, it'll.
List the
it's-
matter on, next time, if it is not there, I'm going to direct his
My lordship, I'll have
attachment
him
of his
present.
salary towards maintenance. List the matter on January Republic Day ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ. For
Obliged,
further-
my
For
lordship.
further hearing. Yes, 29th. The learned counsel for the sixth respondent pleads that the petitioner is unable to come due to severe weather conditions in Jammu and Kashmir, and would undertake that he would come on 29th of January 2025. In the event he would not be present before, in the event he would not comply with the earlier directions, this court would be constrained to pass an order of attachment of a part of his salary towards the payment of arrears of maintenance. Yes.
52.
And pass over.
Then up tomorrow, your
ಮತ್ತೆ ಪಾಸ್ ಓವರ್
tomorrow.
ನಾಳೆ ಜಗದೀಶ್ ಬರ್ಲಿ. List tomorrow in the fresh matters list.
53.
Pay for the petitioner, man. And FIR comes to be registered and for offences
ಎನ್ನೇದು yesterday's matter.
day before yesterday, man. For offences under 406, 420 and 34, my lord. It is a purely
Gold, sir.
for non-payment of an
Yes.
invoice. Kindly see page number 27, my lord. As per their own complaint, my lord.
No,
it's-
yes.
It's clearly
No,
non-payment.
no, list after vacation. Yes, next.
My lord, kindly see page number 27, my lord.
What is?
I'll only read the relevant
Read,
portion.
read.
ಹೀಗೆ ಫಿರ್ಯಾದಿದಾರರೊಂದಿಗೆ ವಿಶ್ವಾಸದೊಂದಿಗೆ ನಡೆದುಕೊಂಡು ವಿ ಆರ್ ಉಮಾ ಮಹೇಶ್ವರಿ ಮತ್ತು ಅವರ ಗಂಡನಾದ ಸುರೇಶ್ ಪಾಂಚಾಲ್ ರವರು ದಿನಾಂಕ 9/9/2023 ರಂದು ಸಂಜೆ 7 ಗಂಟೆಗೆ ಮೇಲ್ಕಂಡ ಫಿರ್ಯಾದಿದಾರರ ಆಫೀಸ್ಗೆ ಬಂದು ಸೋನ್ಸೋ 385 ಗ್ರಾಮ್ಸ್ ಆಫ್ ಚಿನ್ನದ ಆಭರಣಗಳು ಕೊಂಡುಕೊಂಡಿರುತ್ತಾರೆ. ಹೀಗಿದ್ದು ಸೋನ್ಸೋ ಕಂಪನಿಯು ಇನ್ವಾಯ್ಸ್ ನಂಬರ್ CHS 222324 ರೈಸ್ ಮಾಡ್ತಾರೆ. ಫಾರ್ ನಾನ್ ಪೇಮೆಂಟ್ ಆಫ್ ದಿ ಇನ್ವಾಯ್ಸ್ ಆಫ್ಟರ್ 9 months ಆಫ್ ದಟ್ ಅಲೆಜೆಡ್ ಇನ್ವಾಯ್ಸ್ ಡೇಟ್, my lord, he will file a complaint.
All right, after vacation. I've seen that. Yes, next.
My lord, it's
Gold ತಗೊಂಡ್ಬಿಟ್ಟು ದುಡ್ಡು ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ?
ಅಲ್ಲ, gold after, my lord, it's an invoice transaction, my lord. It's a purely commercial transaction, and that too, my lord,
No, invoice transaction is not that. ಕೊಡಿ.
my lord, after 9 months, the complaint comes to be registered, my lord. On the same
And
date, FIR also
where
is
have you,
registered.
where is the transfer of money?
My lord, transfer of money illa. It is a fabricated invoice is my
List after vacation. Next.
54.
For the respondent.
My lord, appearing for petitioner, kindly pass over the matter. my lord.
Pass over
The files directed to secure records, your lordship.
list immediately after vacation. Yes, next.
55.
Petition of lords. Now, my lords, we have received a statement of objections.
Box-based technology.
I have filed an objection today morning. I have sent a copy also to them.
All right. Objection copy.
Immediately after vacation, lord.
List on 6th January.
Please,
Yes.
apply.
Next.
56.
7A matter. Trap.
7A. Tag, same.
Trap is not concluded.
So what?
Failed trap, my lord.
So what?
But there is no interim order, my lord, your lordship may.
ಅದೇ ಸೇಮ್ ಏನಿದು?
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ರಿ
Twice.
Tag. Yes.
ಅಲ್ಲ, trial court will proceed, my lord.
If the trial court proceeds, you move the matter.
My lord, but I have produced the order sheet, my lord, for
Next date ಯಾವತ್ತು?
but next date is, my lord, 22/11 ಗಿತ್ತು.
ಕೇಳ್ಕೊಂಬಿಟ್ಟು ಹೇಳಿ.
On that day, my lord.
ಏನಾಗಿದೆ ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ.
But
ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ.
Please.
For the end of the day ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ.
Please.
Next. BB Patil is directed to accept notice for the respondent. ಅದೆಲ್ಲ ಮಾಡಿ.
Please.
Objections, if any, list the matter on 16 January for the
Please.
hearing. ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ.
Oblige.
57.
Please, my lord.
In this
There is
matter,
accused number 2, Lord, offenses under
other two
406.
petitions, my lord, stay is also vacated, my lord, connected matters.
ಓ ಇದು ಅದು ಎಸ್ ಕೊಡಿ.
WP
my lord.
number 60.
Stay ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟೇ ಇಲ್ವಲ್ಲ ವೆಕೆಟ್
ಅಲ್ಲ,
ಮಾಡಲ್ಲ.
ಇದರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ. ಇನ್ನೆರಡು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಸ್ಟೇ ಕೊಟ್ಟು ಅದು ವೇಕೇಟ್ ಆಗಿದೆ.
ಆಮೇಲೆ
I just take your lordship to my lord, column number 10
ಇದು
of
ಡೇ
that.
ಬಿಫೋರ್ ಎಸ್ಟರ್ಡೇ ಮ್ಯಾಟರ್ ಅಲ್ವಾ?
ಹೌದು.
ಹೌದು.
Section 9 of KPID, my lord. Lord, there should be some prima facie material, my lord. Coordinate bench have held, my lord. May I
ಇನ್ನೆರಡು ಮ್ಯಾಟರ್ ಯಾವ್ದು?
pass on?
ಸೇಮ್ ಮ್ಯಾಟರ್, ಮೈ ಲಾರ್ಡ್.
Kindly, my lord.
6059 of 24 and WP number 19552
Co-accused,
of 24.
Co-accused.
Co-accused.
Lord, I'm only an employee there.
It's all right. Co-accused.
The A2 in this petition.
All right.
He is also a.
Kindly, my lord.
To the share bar.
List after
Yeah,
vacation.
my lord, I'll just,
No,
yes.
yes.
My lord,
Next.
clearly held, my lord, without any allegation made, just mentioning my name, my lord. They have filed they have registered an FIR, my lord.
List on 7th
Yes, my-
January.
Kindly take on record, my lord.
The learned counsel for the petitioner seeks to place reliance upon the judgment of the coordinate bench to buttress his submission, which is submission that he has nothing to do with the allegations, as it is only against the other. ಇದು KPID ನಾ?
ಹೌದು, KP, exact, my lord, identical facts, my lord.
Who is the complainant?
Complainant is an investor.
The complainants are always investors. Who are they? You are accused number?
I'm accused number 2. I'm
Other
an
accused?
employee under accused number 1, who is the owner, my lord.
Employee ಮೇಲೆ ಮತ್ತೆ?
In those writ petitions, accused number 1 and accused number 3.
3 ಯಾರು ಅದರಲ್ಲಿ?
3 is also shareholder. Shareholder ಅಲ್ಲ.
You are a
Investor,
shareholder?
investors.
I'm just an employee there. ಸ್ನೇಹಿತರು ಅಂತ ಹೇಳ್ತಾರೆ ಇದರಲ್ಲಿ. Even in the complaint governments, they say owner and his friend.
So, which is disputed by the learned counsel, learned HCGP. Therefore, list this matter on 7th January. Till such time, the respondent shall not. Charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಆಗಿದೆ.
ಇಲ್ಲ.
Respondent shall not take any coercive steps. Quay the petitioner. Yes, next. You can tell your client. ಸ್ವಲ್ಪ entry ಮಾಡ್ರಿ. Yes. 7A?
Disproportionate assets.
EA.
No check
Objections
period.
ಹಾಕಿದ್ದೀರಾ?
No, my lords.
ಹಾಕ್ಬಿಡಿ.
Served recently, I'll have to file a counter.
So and so.
No check period.
I'll file a counter.
File the count.
File a-
Yes, list the matter on same day ಕೊಡಿ madam. ಅಲ್ಲ same day ಬೇಡ. List the matter on 16th ಅದು 23rd ಕೊಡಿ. List the matter on 23rd for further hearing. Objections if any, because I have already passed those orders.
Please.
Further hearing. The
Objection.
objections if any by then. Next.
No, dear, summons has been issued to me without a predicate offense, my lord. Predicate offense, whichever was there, my lord. Now, they refer to only one predicate offense because I've already cooperated with investigation. Petition number 1 goes there, visits the ED office, cooperates with investigation, gives all the papers, whatever documents are asked, my lord. That was on 4/6/2024 is the first summons which was issued to me. On 18/6/2024, petition number 1 goes there, cooperates.
Predicate offense ಇಲ್ವಾ ಏನು?
Ilva, there's nothing, my lord, because
ಪಾಸ್ ಆಗಿದೆಯಾ ಇಲ್ವಾ?
my lord, there was an offense against my mother, which was already, she passed away in 2017.
No, those
Abated in
proceeds
2000
are with you now.
Abated in 2018. After 2018, nothing is taken, my lord. Thereafter, my lord, the only issue here.
Lord, the facts are that the three petitioners' mother made a claim for payment of compensation by KDB when the land was acquired by making a false statement that the documents which were mortgaged with Canara Bank is also one of the complainant, that it is lost. So the criminal activity was making that false statement that I have lost the paper.
No, the proceeds came out of that false statement.
Out of that false statement, and that proceeds
Compensation.
which was with the mother,
16 crores.
16 crores,
Yeah.
about 16.5 crore. That proceeds of crime which she has distributed among the children who are the petitioners. Now, my lord, it is a fact that she passed away and the proceedings against her has abated. Under these circumstances, section 8, subsection 7 would apply. Please have a look at PML.
File your objections, sir.
ಅಲ್ಲ ಅದೊಂದು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬಿಡೋದು. Please have a look at subsection 7.
ಕೊಡಿ PML ಅದು 2002 act.
There is a clear provision made in law.
Alternative remedy.
Allah, please have a look at subsection 7 of section 8.
Subsection.
Where the trial under this act cannot be conducted by reason of the death of the accused, or the accused being declared a proclaimed offender, or for any other reason, or having commenced but not concluded, the special court shall, on an application moved by the director or a person claiming to be entitled to possession of a property in respect of which an order has been passed under subsection 3 of section 8, pass appropriate order regarding confiscation or release of the property, as the case may be, involved in the offense of money laundering after having regard to the material before it. So this is not a case where the predicate offense is quashed. Because of the death of the accused, we cannot consider, but we can proceed against the property. He is seeking quashing of the ECIR. How is it permissible? I want to proceed with the confiscation of the property. So ECR cannot be quashed. And as far as the summons is concerned, the petitioners have to just appear and give their statement.
You've already given.
I have appeared.
Ah,
my lord.
already
Petition
given.
number
What is
1
the fear then?
appears
What is the
on
fear then?
18/6/2024. I appear. Thereafter, my lord, 3 months later, my wife and my brother are then summoned.
Yes.
So
My lord, now here the issue is this, my lord.
It is only to get
you are the
information.
beneficiary of 16.5.
I am not, my lord. That's exactly my case, my lord. Insofar as
What happened to the 16.5 crores?
16.5 crores, in fact, whatever, now this, my lord, the entire issue is with regard to what Canara Bank is supposed to get. Canara Bank is supposed to get 43 crores. Canara Bank has already got the 43 crores.
So how much have you got, sir?
My lord, for me, as far as I am concerned, my lord, I'll have to verify that record. If anything is come, first of all. Nothing, because my lord, I was one of the witnesses in that very same case against my mother.
Against your mother?
My lord, I was one of the witnesses.
So your statement was mother has fabricated?
I have not said anything, my lord. Nobody knew about it because this never showed up in the EC as well, my lord. My father mortgages the property. It is not my mother's property also. It is not my property also. My father mortgages the property. Not shown in the EC at all.
Maze of facts. You cooperate with the investigation.
Yes, my lord,
I would- my lord,
ECIR
no
cannot be
court
challenged
may be
because of
taken.
8.7. ECIR cannot be challenged.
No coercive action because as of, my lord,
No,
taking a
how
cue from
could-
my lord's
if we-
judgment,
if
my
we
lord,
find some material, even according to Vijay Madan Lal, we can proceed. If we find something.
because today,
As on
there
today,
is
we have
no-
not found anything.
there
But
is
if we
no
find
predicate
something.
offense today. There is nothing because 2018
There
and
cannot
that they
be
keep
answer.
quiet. They don't do anything. Then, my lord, the bank recovers the entire 44 crores. After that, only ED comes in. After recovery.
Solid, whatever amount you have got and whatever documents you have.
But
got,
if there
please
is
give it.
anything, Manoj, I've cooperated. I will also cooperate, but no coercive action to be taken.
We will dispose this saying that you cooperate with the investigation, reserving your liberty to knock at
Yes,
the doors of the
Manoj,
appropriate
again,
forum.
no
Yes,
coercive action to be
No,
taken.
no, how is it
basically
possible?
whatever. Because if
Coercive action,
coercive
test
action,
ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ coercive ಹೆಂಗೆ? If we find some material, even Vijay Madan Lal says, if we find some material during the course of investigation, then we can proceed.
You can proceed. no
Yes,
problem.
if
You-
we find.
If you find anything, definitely. Not proceeding is not what he is asking. Arrest ಮಾಡಬಾರ್ದು ಅಂತ.
at least
ಅಲ್ಲ
some
ಇವಾಗಲ್ಲ
protection.
Milord, that cannot operate permanently against me.
No, if you find anything incriminating against him, you can definitely proceed.
Yes,
And he does not cooperate only then.
yes.
My lord, if that is the case, my lord, my lords may keep it pending. If that is the case, if they were to issue a notice to me or summons to me, I will go and cooperate because after the 18-9 notice, nothing has been issued to me. It's only, my lord, there is a threat of arrest which is looming on my head every single time then. Every single day I'm just thinking, my lord, when
Let
will
him
they
appear then.
Let him
I'll
appear.
appear.
Let him
My lords may keep it
We'll
pending
keep it,
then.
yes.
Yes, it may be kept pending. Let him
Yes,
appear.
yes. Heard the learned counsel Siddharth Suman and the learned additional solicitor general of India, Shri Arvind Kamath. The learned solicitor, additional solicitor general of India would take this court through sections 8, 7 to prima facie demonstrate that the hands of the enforcement directorate cannot be tied merely because the mother of the petitioners is no more. The beneficiary of 16.5 crores of compensation on an alleged forged document was the mother, and the mother has now transferred the amounts to these petitioners, and therefore the proceeds of crime has percolated into the coffers of the petitioners. He would submit that they are entitled to investigate into the matter and the petitioner should cooperate with the investigation. The learned counsel for the petitioner undertakes to cooperate with the investigation. His apprehension is that they should not be arrested in the garb of investigation. To alleviate the said apprehension, I deem it appropriate to direct that the petitioner shall cooperate with the investigation, and the investigation will continue for the purpose of getting to know as to where the proceeds of crime are at the hands of the enforcement directorate. But in the garb of investigation, unless situation warrants, I mean the petitioner not cooperating with the investigation, no coercive steps will be taken against the petitioner. That's it. Yes.
My lords may fix the date also, my lord.
Yeah, list on 23rd for further hearing.
Please.
Yes.
Oblige.
Complaint before this honorable court, my lord. No notice has been issued to file alleged
Yes,
charge.
sir.
Additional charge sheet is filed.
ನಮ್ಗೆ ಕರ್ದೇ ಇಲ್ಲ.
ಅಲ್ಲ ಇವರು ಕರೀದೆ
ಕೇಸ್ ಹಾಕಿದ್ಮೇಲೆ ಇಲ್ಲಿ ಕೇಸ್ ಹಾಕಿದ್ಮೇಲೆ ಅಡಿಷನಲ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರೆ.
490, you are the wife.
Yes, complainant.
ಅದೇ ಕಂಪ್ಲೇಂಟ್
Yes, my lord.
Without taking their statements.
Yes, my lord.
ಹೌದು. Well, where is the material for further investigation? Produce it.
Please, your lord.
ಕೊಡಿ ಇಲ್ಲಿ ಅದು. ಇದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. List tomorrow in the fresh matters list. Next.
Remand is
Yeah.
remand ಇದೆ after vacation.
ಏನಿದು? After vacation.
After vacation.
At the learned senior counsel, Sri Vinagesh appearing for the petition, learned counsel P. Prasanna Kumar seeks 2 weeks' time to file statement of objections or make submissions as the case would be. List after 2 weeks, interim order subsisting would continue till the next date of hearing.
62.
ಏನೇ ಬೇರೆ ಕೇಸಸ್ ಏನಿಲ್ವಾ?
My lords, this matter had come up earlier.
I know, sir.
My lords, kindly notice the order of the Supreme Court for a minute, my lords.
Page.
My lords, it's at page 69, my lords. 69. What is prohibited under this order, my lords? Relevant portion, page 70. Prayer in terms of para A is granted, transferring alienation of any property. This is prohibited. Now, subject matter of this crime
This is tagged with a few other cases where Lodha committee.
Lodha committee. So Lodha committee, my lords, when the matter goes there, there should not be any sale of any property.
Pipin sir ಇಲ್ಲ ಇದಾರೆ, ಅವರೇ ಅಪಿಯರ್ ಆಗ್ತಿರೋದ್ರಲ್ಲ. Which are those further hearing ಇದೆಯಲ್ಲ ಅದು? We'll tag this also along with that.
See, they're protected, my lords,
They are protected by what?
by an interim
No
order.
coercive steps.
Interim order.
Are there no coercive steps? Tag the petition.
They stay of.
They have further proceedings.
My lord, only coercive steps, my lord, because
That's
still, yes, my lord.
Supreme Court says that's enough.
And he is accused number 2 and he was a police officer.
No, my
Yeah,
lords.
Yura,
Yeah, accused number 2.
you're a
Unlike
police
the-
officer.
Kumar.
Yeah, my lords, accused number 2 without being part of the transaction. Their whole case is, there's an agreement of sale.
Okay, those will tag along with those.
Yes,
I'll collect
Pin
some
sir,
more
ಅದಕ್ಕೆ numbers ಕೊಡಿ.
documents also.
Yes, so one HCGP, two emergent, ಎರಡು ನೀವೇನಾ complainant ಯಾರು?
Yes.
Two emergent notice. This court has in identical cases
One
arising out of the transactions that have happened pursuant to the observations of Justice Lodha Committee is being heard, and they are is being heard in the following cases. Tag this petition along with so and so. In the light of the protective orders passed in those petitions, there shall be the same protective orders that are operating in the said case to become operational in the case at hand as well. Yes.
Obliged.
only coercive steps.
ಅದೇ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ. Yes.
Obliged.
63.
Kanti,
Total
it is
17.
forgotten in this court, is it?
Total 17.
17, oh, GM,
That's
is in GM, yes, sir.
Petitioner number 3, my lords, has sought for permission to travel, my lords. In that effect, my lords, I'm filing an affidavit.
ಎಲ್ಲಿದೆ?
Now,
ಅವ್ರಿಗೆ ಮುಂಚೆನೆ ಕೊಡ್ಬೇಕು ತಾನೆ? Will permit? Yes. Heard the learned counsel appearing for the petitioner and the respondent. The petitioner is embroiled in the impugned crime. In stay ಇದೆಯಲ್ಲಿ?
Please, my lords.
Still, this court has by an order dated 25/11/2024 stayed all further proceedings qua these petitioners. Now, the first petition, all petitioners are what?
No, my lords, only petitioner
The
number.
first petitioner accused number,
No, my lords, but insofar as petitioner number 3 only,
who is that?
brother of the accused number 1.
Petition number 3. The petitioner number 3, who is the brother of accused number 1, is now wanting to travel beyond the shores of this nation and has filed an affidavit seeking permission for such travel. The affidavit reads as follows. When are you coming back?
31st of March, my lords.
The learned counsel, the affidavit reads that the petitioner would travel to Qatar and come back on 31/3/2025. The learned DSGI on instructions has no objection to permit the petitioner to travel. In that light, the petitioner be passport ಇದೆ.
Let's.
ನಿಮ್ಮ ಹತ್ರನೇ ಇದೆಯಾ?
Passport is.
ಹಾ, ಸರಿ. The petitioner shall be permitted to travel between the, when are you leaving?
Let's immediately, my lords, after.
Permitted to travel, ಇದು will give you from Friday.
Please.
Permitted to travel Friday date ಹಾಕಿ madam. Up to 31/3/2025, the petitioner shall abide by the undertaking failing which the coercive arm of law can be unleashed against the petitioner. Yes. List after vacation.
64.
For petition, my lord.
We'll continue to, there is a meeting at.
Please.
Serial number 67, my lord. Lords, the appearance of the accused
Madam,
deferred.
adjournment ಯಾರಿಗಾರು ಬೇಕಾದ್ರೆ ಹೇಳ್ಬಿಡಿ.
My lord, one submission,
Adjournment ಬೇಕು ಅಂದ್ರೆ.
one submission, my lord. Matter has been settled, my lord. 149, my lord. Parties are.
ಅಲ್ಲ, every time I see this, the councils, 1:30 ಎದ್ದು ಹೋಗ್ಬೇಕಾದ್ರೆ ಪಾರ್ಟೀಸ್ ಆರ್ ಪ್ರೆಸೆಂಟ್ ಅಂದ್ರೆ ಅವ್ರು ಪೆಸ್ಟರ್ ಮಾಡ್ತಾ ಇರ್ತಾರ, 1:15 ಒಳಗೆ ಕಳಿಸ್ಬಿಡಿ ನಮ್ಮನ್ನ ಅಂತ. ಮತ್ತೆ ಇರಿ ಸೆಟಲ್ಮೆಂಟ್ ಅಂದ್ರೆ ವೇಟ್. It's settlement of an offense. It's not that you're doing any meherbani here. Every time at 1:30 parties are present. Ask them to have lunch and come at 5 o'clock. Yes, there should be some limit in settlements. ದಿನ 1:15 parties are present, ಈಗ ತಗೊಂಡ್ಬಿಡ್ಬೇಕು ಅಂತ. I'm seeing this pattern for a long time. This is incorrect. Yes.
Can I make one request? Not the offense under the Employees Provident Fund Act, amount is paid to a wrong account. Amount is paid. Not directors of not Amazon are being called.
Amazon.
By registering in FIR for the offense on 424/06, it is actually an offense under EPF Act. Not we will cooperate with the investigation. Not my request, Your Lordship.
ನಾಳೆ
Please.
ನಾಳೆ ತಗೊಳ್ಳಿ.
Your Lordship, one submission.
Yes.
The petitioner is ADGP. This complaint is come in the way of his promotion. Kindly have it on tomorrow, my lordship.
What promotion ಗೂ ಇಲ್ಲಿಗೂ ಏನು ಸಂಬಂಧ ಮೇಡಮ್?
Some complaint.
ಆಯ್ತು ಕೊಡೋದು ಕೊಡಿ. Day after tomorrow, Friday.
Much obliged.
Hmm. 23/1 sir. 23/12. ನೋಡೋಣ ಮಧ್ಯಾಹ್ನ. Wait, we'll see. Date ಕೇಳಿ ಅಲ್ಲಿ.
Your Lordship.
Adjournment ಯಾವ್ದಾರು ಬೇಕಾದ್ರೆ ಹೇಳಿ.
Your Lordship, serial number 160. I am for the R2. I am not keeping well, Your Lordship. The document.
Just make a note.
160 for R2.
Other side advocate, my lord, is not available today.
ಏನು ಸರ್? Serial number?
16, my lord.
16 sir.
16.
ಏನಾಯ್ತು 16ಗೆ?
So,
ಇಲ್ಲೇ ಇದಾರಲ್ಲ. Yes madam. He did not come out.
kindly have it tomorrow.
ಅರೆ no, you told me some reason. Then you're telling us not come.
My lord, serial number.
Kindly have it tomorrow.
Huh?
Kindly have it tomorrow.
ನಾಳೆ ಆಯ್ತು. Tomorrow, ask him to come tomorrow. Why he is not coming tomorrow?
My lord, serial number 141.
This tomorrow, ask him to come, madam. Yes.
My lord, serial number 141. Kindly have it after.
ಅದೆಲ್ಲ ಕೇಳಿ, whatever. Yes, madam.
167.
ಏನದು?
Lordship, that's 7A matters only. Last
Ah.
time we had mentioned the urgency because despite your lordship's
ಇಲ್ಲ, ಇವತ್ತು
interim
hear
order, they
ಮಾಡ್ತೀನಿ
were.
madam. I'll hear it and
160.
finish it today.
Please.
Yes, Sandesh sir also I have told. Yes. But complainants are not served in those cases. I have granted interim orders.
Please.
But unless complainants are not served, wherever complaints are served, we'll hear them.
Please.
That serial number 124, my lord. Seeking adjournment, my lord. I am for a respondent. Copy not, sir.
Permission for travel tomorrow, my lords.
Good, tomorrow.
OE corporation matters are listed tomorrow. Along with that, it may.
Give it. ನೀವು ಮೆಮೊ ಅಂದ್ರೆ ಚೀಟಿ ತಗೊಂಡ್ಬಂದಿದ್ದೀರಾ?
ಇಲ್ಲ.
Examination.
But yesterday one writ petition was listed, my lord, 34098. My lords have granted interim order as granted in the earlier petition, my lord.
ಏನಾಗಿದೆ?
One line ಅಲ್ಲಿ ಹೋಗಿದೆ. That is service. My lord, in the
ನೋಡೋಣ ಹಾಕೋಣ. Friday being spoken to.
My lord, in my matter also, my lord, today's matter is listed. Lords, one.
ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಲ್ವಾ? ಹಾಗಾದ್ರೆ ಇರಿ.
Small submission.
My lord,
My lord, PMLA case, my lords. PMLA case, it was allowed by this honorable court on 16/12, my lords. The order has not yet been released.
ಪರವಾಗಿಲ್ಲ
and,
ಬಿಡಿ, ಇರ್ಲಿ. Yes.
The trial court has posted it for final arguments in
No
the connected
problem.
case tomorrow, my lords.
my lord,
We'll try to release
My lord,
it tomorrow morning at 10:30. 16/12 ಅಂದ್ರೆ 4 days back.
4 days back.
Yes, sir. ಆಮೇಲೆ.
My lord,
Covered by judgment.
my lord, I was, my lord,
One
I was,
minute, sir. This is saying, yes,
Covered by judgment, your lordship.
after vacation.
With your lordship's permission.
After vacation ಮೆಮೊ ತಗೊಂಡು.
Tomorrow, matter stay ಆಗಿದೆ lower court ನಲ್ಲಿ.
ಸ್ಟೇ ಆಗಿದೆಯಾ? ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ಅಂದ್ರೆ ನೀವು ಕಂಪ್ಲೇಂಟ್ ಈಗ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ ಯಾರಿಗೆ?
Accused, your lordship.
ಸರಿ, ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಎಸ್.
With your lordship's permission, one matter
ಆಫ್ಟರ್ ಮೆಮೊ ಕೊಡ್ಬೇಡಿ.
one matter for admission tomorrow, my lords. Matter is filed in November
ಫ್ರೆಶ್
2000.
ಮ್ಯಾಟರ್ ಸರ್.
Admission, fresh matter, my lords.
ಕೊಡಿ.
It's fresh matter, my lords.
ಗಿವ್ ಇಟ್.
Tomorrow.
ಅದು ಗೊತ್ತಿಲ್ಲ, ಅವ್ರು ಬರ್ಲೇಬೇಕು ನಾಳೆ. ಅವ್ರಿಗೆ ಲೆಟ್ ದೆಮ್ ವರ್ಕ್ ಓದ್ಬೋದು. ಬರ್ತಾ ಇಲ್ಲ ಯಾಕೆ? ಮನೆಯಲ್ಲೂ ಮಾಡಕ್ ಹೇಳಿ. 6 ಗಂಟೆ ಒಳಗೆ ಬರುತ್ತೆ ಅಂದ್ರೆ ಯಾವಾಗ ಬರುತ್ತೆ ಬರಲಿ. ಮೇಡಮ್ 1 minute, there is some problem with the plan. ಸಿಸ್ಟಮ್ ಪ್ರಾಬ್ಲಮ್ ಅಂತ ಡೋಂಟ್ 38 ಮೆಮೊ ತಗೊಂಡಿದ್ದೀನಿ. 38 ಬರಲೇಬೇಕು. ನೀವು ಆನ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ಕೈಯಲ್ಲಿ ಬರೀರಿ. No, ಅದು you get it sorted. Which are moved at 2:30 should come at 2:30. Even if it is 6 o'clock ಪರವಾಗಿಲ್ಲ, do it and get it. whatever 6 ಗಂಟೆ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ, ಬರ್ಬೇಕದು. ನೀವು ಸಿಸ್ಟಮ್ ಸರಿ ಇಲ್ಲ ಅದಿಲ್ಲ. No, whatever it is. Yes.
For tomorrow, my lords, fresh matter.
ಕೊಡಿ.
My lord, your lordship had passed for interim order on 12/12, my lord. There's a small correction in that.
ಏನು?
ಅದು CC number 553.
ಅಷ್ಟೇನಾ?
CC number.
ಅದು ಚೇಂಬರ್ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ. ಅದು
I just give it.
ನಂಬರ್ ಕೊಡಿ. ಎಸ್. ಅದಕ್ಕೆಲ್ಲ ಮತ್ತೆ ಕೋರ್ಟ್ ಮುಂದೆ
ಅಲ್ಲ,
list
ಅದಕ್ಕೆ
ಆಗೋದೆಲ್ಲ
that's only one number. One matter is listed at 2:30. Court may kindly recollect, it was understood it will be taken up at 2:30. I was asked to make it.
ಈಗ ತಗೊಂಡ್ಬಿಡಲ್ವಾ? ಒಂದು ನಿಮಿಷ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮುಗಿಸ್ತೀನಿ. ಮೆನಿ ಆಟ್ ವೇಟಿಂಗ್. ಎಸ್.
Subnet print is also here.
ಆಲ್ ರೈಟ್.
my lord, I was,
Both of us are ready.
my lord, I was also promised the same thing, my lord, on the last date of hearing, that
As
my
what,
matter
sir?
will be heard at 2:30.
If the many matters at 2:30, we will see.
My lord,
Yes.
the urgency is that my visa is expiring at the end of this month and a seal cover has also come, my lord.
No
So it is
problem.
a very simple matter. It
Let's
will be
see.
finished.
No matter is
The
simple.
serial
sir.
number is
Yes.
106, my lord. It may not
No
come up at
problem.
all.
You move the vacation bench, sir. No problem. I'll give you liberty to move the vacation bench. Yes, though that matter cannot be posted before the vacation bench because it's special court matter. Your matter can go before the vacation bench. Move the vacation bench. Yes.
Back at 3 o'clock.
Fresh matter ಮುಗಿಸ್ಬಿಟ್ಟು ತಗೊಂತೀನಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಆರ್ಡರ್ಸ್ ಏನಿದೆ ನೋಡ್ಕೊಂಡು. ಅಡ್ಮಿಷನ್ ಐ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಎನಿ ಮ್ಯಾಟರ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇದು ಆರ್ಡರ್ಸ್ ಮುಗಿದ ತಕ್ಷಣ ಐ ಟೇಕ್ ಇಟ್. ಎಸ್. ಎಸ್.
List continued. 64.
Lord, this is a matter where the state had given an undertaking.
Why are you on VC, Arun?
My lord, had viral infection. So
Viral infection.
please, that's why, in fact, my throat is also not doing good.
Interim order ಇದೆಯಲ್ಲ?
But the interim order is there, but there is an undertaking by the state with respect to circular 41A.
Oh, this matter, yes, sir.
Additional SPP. Time, pay for time.
Dispose ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ.
Please, the impugned order should go, and the
Ali,
state
impugned
undertaking
order will
was there because, ಏನಂದ್ರೆ earlier there was an undertaking that like their
Tomorrow
circular
the
would
fresh
be.
matters list. Yes, next.
Please, madam, please.
65.
The petition has been exonerated in the department inquiry.
Learned
And it's
counsel
also
B.B.
failed.
Patil is directed. ಆಗಿದೆಯಲ್ಲ?
It's already agide.
Objections haki. List on 16 January.
Trial is begun. Trial ನಾಳೆ
ಏನ್ ಟ್ರಯಲ್ ಇದೆ?
Trial
Offense ಏನು?
7A. Failed trap.
Failed trap ಅಲ್ಲಿ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿಗೂ ಟ್ರ್ಯಾಪ್ಗೂ ಏನ್ ಸರ್ ಸಂಬಂಧ?
After the failed trap, department
ಸರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿಗೂ ಟ್ರ್ಯಾಪ್ಗೂ ಏನ್ ಸಂಬಂಧ ಹೇಳಿ?
based on the FIR of the Lokayukta, the IACB, they conducted the department
ಏನ್ ಮಾಡಿದ್ರು?
and detailed.
How did they determine demand and acceptance there?
They examined the complaint, shadow witness.
Same. Same
Shadow
witnesses.
witness. Same.
What's your name? Imesre.
Prithvikiran.
Ah.
Annexure C.
Yes.
Retired judge, retired judge
what?
appointed, and then.
So what?
No, my submission is a detailed inquiry, a complainant, shadow witness was also examined.
Where is the comparative statement made by
I'm
you?
in the petition I have mentioned.
Where is the comparative statement? Iday witness mention alla. Where is the
In the
chart?
page 6.
Prepare a chart.
I put in the.
Where is the chart?
Page 6.
Ishtena. What are the documents examined?
There are total 50.
Where are the documents, comparative documents?
Annexure C.
No, in the chart.
Chart ಅಲ್ಲಿ. I mean, it's.
In the chart. Chart ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಒಂದ್ ನಾಳೆಗೆ.
But tomorrow is the trial.
ಪರವಾಗಿಲ್ಲ ಏನು ಚಾರ್ಟ್ ಮಾಡ್ಕೊಂಡು
Kindly interim.
ಚಾರ್ಟ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ನಾಳೆಗೆ.
None.
Tomorrow fresh matters list. Prepare a chart. Witnesses same, IO same, documents same, everything same. Yes.
66.
ಏನಿದು?
I'm for respondent.
The
Connected matter.
employee of Lord BWSSB
ಅದೇ ಇದು digging.
digging.
Connected matter ನಾಳೆಗಿದೆ ಸ್ವಾಮಿ, ಅದು ಕೌನ್ಸಿಲ್ ಇಲ್ಲ ಅದು.
Take the petition along with sounds tomorrow. Number ಕೊಡಿ.
23465 of please.
CT.
CT ಕೊಡಿ.
Yes. Next.
67.
Please, my lords, I appear for the petition. My lords, this is a matter, my lords, the predicate offense is stayed by your lordships, as could be seen from page 24, my lords.
Yes, madam.
My lord, day before yesterday, we had sought time for 10 days to file our objections for the same matter, my lord.
But I have deferred the proceedings by the summons.
My lords, that is, I have seen, my lords, but ಅಲ್ಲಿ order ಅಲ್ಲಿ ಏನಾಗಿದೆ, respondent ಅಂತ ಆಗಿದೆ, that should be before the special court. And the special court matter is listed today and passed over, my lords. Order sheet is also not uploaded online.
The learned counsel M. Unnikrishnan will print his name only. M. Unnikrishnan seeks had sought 10 days time on 16/12/2024 to file statement of objections. This court had directed deferment of the issue of summons. But the learned
Summons issue ಆಗಿದೆ, accused number 1 and 2 appearance is deferred before the special court.
that is to be deferred. Alva.
Please, my lord.
So therefore, the appearance of the accused number 1 and 2 till the statement of objections are filed by the respondent enforcement directorate before the concerned, there shall be deferment of the appearance of the accused number 1 and 2 before the concerned court till the statement of objections are filed by the respondent.
My lords, in
Yes.
the meantime, my lords, there is an error. Last time, it is mentioned as respondent. The respondent is the enforcement director. In the order
Concerned
sheet.
court ಅಂತ ಹೇಳಿದಿನ ಅಲ್ಲಿಗೆ.
ಇಲ್ಲ, ಅದು respondent ಆಗಿದೆ, I just verified.
What do you want, sir?
That has to be special court, my lords, otherwise the special court
No,
will not.
special court is to defer the proceedings or who, your summons ಯಾರಿಗೆ ಕೊಟ್ಟಿರೋದು?
Summons is issued by the special court in special CC 2253 of
Inquiry, madam.
2024.
The learned counsel for the petitioner submits that the predicate offense has been stayed at the hands of the coordinate bench of this court. Despite the stay, now the allegation is that the concerned court is proceeding against these petitioners and have issued summons seeking their appearance. And the matter is listed today. The matter is listed today for the appearance of the petitioners. In the light of the stay granted by the coordinate bench in the predicate offense, the concerned court hearing the offenses under the PMLA shall defer its proceedings till the statement of objections are filed by the respondent enforcement directorate. Ordered, yes, directorate, sir. Yes.
Please, my lords. May I request for hand delivery, my lords?
No, we'll see, yes. Tell the court.
Please, my lords, I'll inform.
Next.
68.
Here for the petitioner, my lords. Inter of charge. That's case number 1 to 5, my lords, have.
Stay ಇದೆಯಲ್ಲ?
No, my lords. 1 to 5.
1 to 5 acquitted, ah?
Please, my lords, they have faced
The
trial and
petitioner
they
is
are
before this, you are accused number?
acquitted. 7, my lords.
The petitioner is accused number 7
Lords,
in a split up.
So far as accused number 6, my lord, your lordship have quashed the proceedings.
Time ellide, sir. Yes. The petitioner is accused number 7. Accused number 1 to 5 have, accused number 1 to 5 have all been acquitted of the offences. In so far as accused number 6 is concerned, the learned counsel for the petitioner submits that the proceedings have been quashed. Order kodi.
Criminal, my lord, it's annexure F, my lords, volume 2.
Volume 2. Volume 2. Page heli sir, volume 12.
456 to 471.
Volume 2.
Please.
In that light, we'll quash this also. In the light of the reasons, the petitioner accused number 6,
Please, my lord.
accused number 6 and the accused number 5 had common allegations or overtax against them. In the light of quashment, in the light of the acquittal of accused number 1 to 5 and the quashment of proceedings by accused number 6, I deem it appropriate to follow the same and quash the proceedings by the accused number 7, the present petitioner. Adu page ಬರ್ಕೊಂಡ್ರೆ page yes. ಅದನ್ನ copy paste ಮಾಡಿ allowed quashed. Next.
69.
I appear, my lord, for the petition. Offense under section 468 and 471, my lord. Lordship, may I kindly turn to page 69, my lord, the cognizance which has been taken. 69.
69.
61, sorry, my lord, 61. Annexure D, my lord, page 60. No reasons have been assigned, my lord.
Only the
No-
cognizance order.
My lord, annexure D, page 61.
Heard the learned counsel, Bipin Hegde appearing for the petitioner. The petitioner is before this court calling, ಯಾವಾಗಿಂದು ಸರ್ ಇದು?
My lord, 2007.
ಇವಾಗ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? 8 ವರ್ಷ ಆದ್ಮೇಲೆ.
ಈಗ
What is the stage?
Evidence.
evidence, now, my
Charge
lord, summons
frame
have been issued. Charge has been framed. My lord, on merits also, my lord, if I may
Oh,
submit.
no, sir. Charge frame ಆದ್ಮೇಲೆ I will not interfere.
My lord, Supreme Court has said, my lord,
After vacation, take chance after vacation.
ಅಲ್ಲ, ಈಗ 22nd ಗೆ,
I
21st
can't go against my orders that I have passed day in and day out. The charge is frame ಆದ್ಮೇಲೆ I will not entertain.
Not the very fact that, my lord, the cognizance is taken, my lord, without application
Cognizance
of
in
mine.
2017, what were you doing for 7 years, sir?
My lord, otherwise also merits, my lord, I may.
Otherwise, after vacation.
My lord, on merit,
That's frame
only,
ಆದ್ಮೇಲೆ interfere
I'll just submit, my lord. Only allegation is that, my lord, that the NOC letter which has been issued by the,
Sir, allegation may be frivolous. You have let the charges to be framed and it is in 2017, cognizance is taken, 8 years have passed by, trial is on.
my lord, trial, my lord, now summons have been issued, my lord, now trial is, at that stage, my lord, the
Oh,
matter
no,
is, therefore,
I
my
will
lord,
not- ಅದಕ್ಕೆ take chance
my lord,
after vacation.
21st ಇದೆ, summons issue, evidence start ಆಗ್ಬಿಡುತ್ತೆ.
ಪರವಾಗಿಲ್ಲ. Take
I
chance.
will be in
after-
a worse position, my lord,
No, sir.
than I am today.
Take chance after vacation. Charge frame ಆದ್ಮೇಲೆ I will not interfere. I have not interfered in any case.
ಅಲ್ಲ, my lord, trial.
No,
Sorry,
sir.
the Lord
In
gives, my lord,
cases
Anjaneyulu
where, in
Reddy's
cases
case, my
where
lord,
in-laws had nothing against them in 498, I have not interfered.
my lord, in the trial stage also, my lord, this honorable court has interfered on the same ground, my
No,
lord.
ಅದು after vacation ತಗೊಳ್ಳಿ. Yes.
70.
Yes.
Case and counter case, my lords. Now, what happens is investigation takes place by the same agency,
Same investigating officer.
same investigating officer,
Hmm.
but post that, my lords, it goes to two different courts. So then we have filed an
210.
application. I'm sorry, my
Under
lords.
210.
No, because one case, the other case, they invoke POCSO, so it goes before the special court, and this remains before the other court. So we filed an application under 407, my lords, before the coordinate bench,
Hmm.
and there's an order of stay insofar as the other matter is concerned.
Hmm.
Now, in this particular case,
We'll
what-
post the matter also before the same court. 407 court. Number ಕೊಡಿ.
probably that may have to come before my lords.
Let's see.
Because
Number
the
ಕೊಡಿ.
seniority.
Give the number.
And my lords, what we have sought here as a prayer is for further investigation by the CBI, my lords. That's a.
CBI?
Yes, my
Why,
lords. The
sir?
reason, my lords, the reason is, in this incident that takes place, my lords, my complaint is first in point of time, FIR gets registered. Allegation is, my lords, I am assaulted by a talwar. Now, what they would do is, my lords, they, in the charge sheet, show a further statement
No,
of mine.
this is by the complainant.
Yes, my lords.
Then we'll have to hear the respondent. Yes. They heard the learned senior counsel Sandesh Chowta appearing for the petitioner. The learned HCGP is directed to accept notice. Who are these accused need not be heard. Why have you made them parties? Further investigation ಬೇಕಾಗಿಲ್ಲ. Learned HCGP is directed to accept notice for the respondent. go through the papers and make his submission. What's the next date?
My lords, it's for here before charge. It's posted on.
Tag this petition along with the criminal petition 12816 of 2024. List them both on 7th January.
Could there be a deferment of the charge, my lords?
In the light of the interim order subsisting in the counter case, in criminal petition 12816 of 2024, the concerned court shall defer its action of framing of charges, comma, if any, till the next date of hearing.
Right.
Yes, next.
71.
Petitioner, my lord. My lord, the petitioner is the worker in the bar of the accused number 3.
Bar.
My lord, bar, my lord. Accused number 3 petition, my lord, came to be allowed, my lord, by this honorable court. in Annexure D,
Excise Act.
Excise Act, my lord. Section 54 of Karnataka.
New
has not been
employee,
fo-
yeah?
He was selling the liquor.
No,
Who was
it's the
selling?
worker, my lord. The
This
petitioner
petitioner.
herein, my lord, the present petitioner is the worker here. My lord, they only state, my lord, in the charge sheet,
A1.
my lord, at page
Charge sheet ಅಲ್ಲಿ ತೋರ್ಸಿ.
23, may kindly be seen, my lord.
ಹಾ.
ದಿನಾಂಕ 29/11 ಸಂಜೆ 4, the operative portion, my lord, is
ನಿಮ್ಮ ಹೆಸರೇನು? ಉಮೇಶ್.
ಉಮೇಶ್ ಮೈಲ ತನ್ನ ಹೆಸರು ಉಮೇಶ್ BN ಚಿಕ್ಕೇಗೌಡ ಎಂದು ಹೇಳಲಾಗಿ
ಹ್ಮ್.
ವೆಂಡರ್ ಆಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವುದಾಗಿ ಹಾಗೂ ಆತನು ಸೋ ಅಂಡ್ ಸೋ ನಂತರ ಇಲಾಖೆ ನೀಡಿದ ನೌಕರ ನಾಮವನ್ನು
Page 42 covered, madam. Same order, page 42.
ಗ್ರೇಟ್ಫುಲ್.
72.
ಬಾರ್ ಅಲ್ಲಿರೋ ಸಪ್ಲೈಯರ್ಸ್ ಎಲ್ಲ ತೊಂದರೆ ಕೊಡ್ತೀರಿ. Yes.
Offense under 323, 504 and 354.
354, madam.
All are family members and
So 354 ಆಗ್ಬಾರ್ದು ಅಂತನಾ? ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಆದ್ರೆ
disputes between them. my lord,
ಸಿವಿಲ್
parties-
ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ರೆ 354 ಇರಬಾರ್ದು ಅಂತನಾ?
And in the complaint also, she stated that,
ಹ್ಮ್.
I read the complaint, my lord.
ಹ್ಮ್.
ನಾನು ಮೇಲಿನ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದು ಕೃಷಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. ನಾನು ಅವಿವಾಹಿತೆಯಾಗಿರುತ್ತೇನೆ. ಈ ಮೇಲಿನ ಮನೆಯ ಅವಿವಾಹಿತವಾಗಿರುವ ನನ್ನ ತಮ್ಮ ಸದಾಶಿವರಯ್ಯ ಅವರು
Where
ವಾಸವಾಗಿರುತ್ತಾರೆ.
is the own certificate? ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ?
Yes, my lord.
ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ
ಅಲ್ಲಿ secure ಮಾಡಿ.
ವಾಟ್ ವಿಲ್ ಸೆಕ್ಯೂರ್? ಚಾರ್ಜ್ ಶೀಟ್ ಜೊತೆ ಇಲ್ಲದೆ ಇರೋದು ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ಈಗ?
ಅಲ್ಲ ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
Yes, secure the records.
I have the own
Why
certificate,
have you
my
not
lord.
appended it? ಕೊಡಿ ಇಲ್ಲಿ. ಪ್ರೊಡ್ಯೂಸ್ ಯಾಕೆ ಮಾಡಿಲ್ಲ? What is the civil suit? 354 ಏನಿಲ್ಲ.
Partitions
ಏನು ಇಲ್ಲ.
pending, my lord.
The petitioners are before this court. Petitioners ಇದೇನು? One
And my
ಕೆಳಗಡೆ
lord,
2
one
ಮಧ್ಯ ಮೇಲ್ 3.
Allegation against
ಇಲ್ಲ,
under
ಯಾಕೆ?
354 allegation is only on,
All right. Accused 3 to 1 ಯಾಕೆ 1 to 3 ಮಾಡಿಲ್ಲ? ಅದು ಯಾಕೆ ಉಲ್ಟಾ? Yes, anyway, the petitioners are accused 1, 2, 3.
354 allegation
are,
is against only petitioner number 2, my lordship.
ಆಯ್ತಾ?
Yes.
Yes. The petitioners are accused 1, 2 and 3 are knocking at the doors of this court, calling in question proceedings in CC 443 of 2024 registered for offences punishable under section so and so. A perusal at the summary of the charge sheet would indicate that the allegations leveled against these petitioners is as a counterblast to the civil suit instituted by the third petitioner in OS 64 of 2022. There is not even an iota of allegation that would touch upon the ingredients of section 354A. Therefore, there shall be an interim order of stay of further proceedings qua these petitioners till the disposal of the petition. 1 HCGP, 2 emergent notice. ಅದಕ್ಕೆ ಸುಮ್ಮನೆ ಇದ್ಬಿಡಿ ಮೇಡಮ್. Next.
23.
23 APF for the petitioners, my lord. Lord, challenging the charge sheet, my lord, 498A and 504. Petitioners are, my lord, husband and mother-in-law.
Husband,
My lord, here, jurisdiction as per your lordship, may kindly see the complaint. My lord, marriage took place in Mumbai, my lord. After that, they went to UK immediately. No part of time, my lord, they lived in Kundapur. But however, my lord, after coming to India, she registered a complaint in Kundapur. And in the complaint, in page 90, may kindly be seen.
in the meantime, yes.
Right.
ಯಾರ ಮೇಲೂ ಏನೂ ಇಲ್ಲ.
ಇಲ್ಲ, ಅದರಲ್ಲಿ
ಹಸ್ಬೆಂಡ್ ಮೇಲೆ ಇದೆಯಾ? ಏನಿದೆ?
ಇಲ್ಲ,
ಸಂಶಯ ದೈಹಿಕ
charge sheet
ಹಿಂಸೆ.
ಅಷ್ಟೇ.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ ನಾನು.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಅಂತ.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆಯಾ?
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಲ್ಲ ಅಂತ
ಆಯ್ತಾಯ್ತು. Next.
My lord, that PPE kit matter, my lords. My lords are directed the government.
ಇವತ್ತು is not there. Pass over. SPP ಬರ್ತಾರಂತೆ. ಆಯ್ತು, pass over. Pass over ಆಗಲ್ಲ, ನಾಳೆ ಬೆಳಗ್ಗೆ ಬರಕ್ಕೆ ಹೇಳಿ. This tomorrow in the fresh matters list.
Interim order may be extended.
Interim order subsisting will continue to the next date of hearing. Huh? Going, ask him to come and go. Yes. ನೋಡೋಣ. Yes. Additional SPP ಬರಲಿ ನಾಳೆ. Next.
25. Sorry,
Seeking-
75.
Seeking to quash order of proclamation, my lord. This is insofar as accused number 4, my lord. Against accused number 5, lordship has quashed the order of proclamation.
Number, page.
Page 51, my lord, annexure F, my lord. Very same CC number, accused number 5, my lord.
Your accused number?
4, my lord, 4.
Yes. Page 51 disposed. Page 51 accused number 5. 5 ಅಲ್ಲ?
This is 4, that was 5, my lord.
Accused number 5 ಅದು, ಇದು accused number 4. Same order. Yes, next.
76.
Offences alleged under section 188 IPC and section 51B of the Disaster Management Act. Petitioners are advocates. They
against him?
participated in the protest. Hello?
Why against him?
Hello?
Why
They
against
participated
this
in the
petitioner?
protest.
Huh?
They participated in the protest. The petitioners are all advocates.
I know. Let it lift and go to protest.
It's covered by my lord's.
ಎಲ್ಲರೂ
judgments.
ಇದ್ದಾರೆ?
My lord?
All of them are here? Huh? Give it. What against these people? 353
ಅದೇ
ಹಾಕೊಂಡಿದ್ದೀರಾ?
30 days
ಏನ್
time
30 days notice ಕೊಟ್ಟಿಲ್ಲ 51B
ನೋಟಿಸ್
ಪ್ರಕಾರ?
ಕೊಟ್ಟಿದೆ, ಬಟ್ 30 days ಟೈಮ್ ಕೊಟ್ಟಿಲ್ಲ.
ಮಾರನೇ
ಮುಂಚೆನೆ
ಕೊಡ್ತೀರಾ? 30 days
ಮುಂಚೆನೆ
crime
PCR
register
register.
ಮಾಡಿದ್ದೀರಾ? ಇದ್ರಲ್ಲೂ ಅಷ್ಟೇನೆ, ಅದೇ ಮಾಡ್ರಿ.
Yes.
Yes. What do we do?
It's covered, my lord.
Yes. Disposed. ಎರಡು. The petitioner, ಹೇಳ್ಬಿಡ್ತೀನಿ. The petitioners, advocates are before this court calling in question proceedings in CC 1383 of 2021 registered for offense punishable under section 51B of the Disaster Management Act. ಅದೊಂದೇನಾ? And section 188 of the IPC. The learned counsel appearing for the petitioner Shruti Changati would submit that the issue in the list stands answered by the judgments rendered by this court in so and so, along with so and so, Shruti Changati along with so and so. The learned, both the learned counsel would submit that the issue in the list stands answered by the judgment rendered by this court qua interpretation of section 51B of the Disaster Management Act. According to the learned counsels, the issue, all the issues that are projected in the case at hand are answered by this court in the aforesaid judgments. This court has held as follows. ಎರಡನ್ನು court ಮಾಡ್ಬಿಟ್ಟು allowed cost. Yes. Instant justice. Yes. Orders ಮುಗಿಸ್ಬಿಟ್ಟು ಅವ್ರನ್ನ ಕರೀತೀನಿ.
Is that Steel Hypermart Private Limited matter?
ಎಲ್ಲ after vacation.
Alla, my lords, here.
Today
we
no
need-
time.
My lords, protection because Supreme Court. has
What protection, sir?
Protected us for 30 days. My lords quashed this matter. Matter went up to the Supreme Court. Supreme Court set aside our, my lord's order with liberty for us to file additional pleadings and the matter to be heard.
You are the complainant.
My lords, no, I'm the accused. I'm the accused. Kindly notice this
Complainant
order.
had challenged it.
Yes, my lords, they challenged it. My lords had quashed it on the ground that without being declared as a willful defaulter and fraudulent borrower, the criminal proceeding was going on, which is bad. But then Supreme Court says that was not pleaded in the pleadings, and saying so in paragraph 9, my lords, Supreme Court order, the liberty which is granted.
You appeared there?
My lords?
You appeared
No,
there?
no, not.
No, because you submit here Allah. Legal questions need not be pleaded. And how did you go and plead it there?
I wasn't there.
Then?
Anyway, my lords, kindly notice the liberty, my lords, paragraph 9 only. So impugned order is
And how can
quashed.
you support this pleading?
I'm sorry, my lords.
How can you support this pleading now?
No, my lords, liberty granted for us to file the pleadings, my lords, additional
All right,
pleadings.
you file it.
that we are filing it,
This
but
court,
potentially,
anyway, it
my
should
lords.
come before me only. Criminal case ಇದು.
ಹೌದು.
All right, so and so. This court had by an order dated 10th January, what's the date?
2nd August
2nd
20
August 2023,
2022, my lords.
22, quashed the proceedings against the accused, against which the complainant Indian Bank had approached the apex court. The apex court, by its order dated 5th
5/12.
December 2024, while setting aside the order passed by this court, directs further documents to be placed on record by the complainant or the accused as the case would be, and a fresh consideration at the hands of this court. In 30 days time,
30 days time, which is granted at paragraph 10.
the apex court, while disposing the
Paragraph 10,
appeal,
ma'am.
has observed as follows. Shall not be,
And throughout we had an interim
the
order.
petitioners, the accused, were directed not to be arrested for a period of 1 month from the date of the order, i.e. 5th December 2024, subject to the condition that they would cooperate with the investigation. The liberty was granted to this court to pass necessary orders in accordance with law. Therefore, the direction of the apex court not to arrest the petitioners shall continue till the next date of hearing.
In the main matter, throughout there was an order of stay by this court, and Supreme Court did not disturb that even when the SLP was filed.
That's
My
all
lords,
right. That's all. The order itself is disturbed. Where is the interim order? Yes,
my lords, 3 applications where notice can be ordered, we will serve it on.
that I will do. Learned, ನೀವಿದ್ದೀರಲ್ಲ? CBI. Yes.
First application is for additional pleading, my lords.
Sir, 1 minute. On all applications, we will issue notice.
Yes, my lords.
Notice on all applications. Learned Counsel P. Prasanna Kumar is directed to accept notice for the first respondent on the application so filed after the order passed by the apex court, and emergent notice to the ಅವಾಗ ಯಾರು appear ಆಗಿದ್ರು? Indian Bank ಗೆ ಯಾರು
My lords, AG was then appearing for the bank.
Indian Bank.
ಹೌದು. ಈ
He
matter-
was then appearing.
ಈ
Correct,
matter.
correct. So and so, the petitioner, the counsel on record is at liberty to serve on any panel counsel representing the respondent bank. All the applications that are filed after the order passed by the apex court. List the matter on 16th January
Obliged.
for further hearing. Yes.
78.
Behalf of the petitioner.
I appear for the respondent here.
After vacation, yes.
Lordship, there's one prayer I have to point out, your lordship. May I take your lordship to page 19 of their petition, your lordship?
Yeah, what is the matter?
Prayer is.
Although his husband and wife, after vacation, yes.
Lordship, one submission, your lordship. Trial court, appeal nalli, the same order they have challenged, which is pending before the sessions court. And the prayer here made before your lordship is also for the same order.
No, my
So
lords.
there are 2 prayers before 2 different courts. May I
No,
request you?
Now everything is all right before the trial court?
Trial court, your lordship, they are
La-
precipitating matter over there. Their prayer is same
Last
before
time you
both
had
the
some
courts.
allegations.
ಅಲ್ಲಿ ಇವತ್ತು ಹೇಳಿದ್ದಾರೆ, I made allegation about the court ಅಂತ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, so. So it's going on. I did not
All
make
right,
any
list
allegation.
after vacation, yes.
Highly obliged.
Interim order may kind.
Interim order subsisting will continue to the next date.
ಅಲ್ಲಿ ಡೆಫರ್ ಮಾಡಿದ್ರೆ ಒಳ್ಳೆದಾಗ.
Whatever, yes.
ಅಲ್ಲ ಅದು ಆರ್ಡರ್ ಆಗಿಲ್ಲ lordship. There is no.
ಈಗ ಏನ್ interim order is continue.
Interim order is for payment of interim.
Whatever interim order is there, that will continue.
Yes, your lordship, but ಅಲ್ಲಿ matter same ಅದ್ರ ಮೇಲೆ argue ಮಾಡ್ತಾ ಇದ್ದಾರೆ. So prayer is same in both the courts.
Madam, now I
They
have
are-
no time to resolve the dispute between husband and wife
No, your lordship.
after
I'm only
vacation.
requesting
Yes.
lordship to kindly defer the proceedings in criminal appeal 334. ಅಷ್ಟೇ your lordship. That's all I'm requesting.
Same submissions you are making,
Yes,
same
your
thing is challenged there.
I have challenged, my lords, the refusal to grant me an interim order in the appeal over before this honorable court.
Then
Then my-
let that wait further orders from this court.
My lords, it's only so far as the interim order is concerned, my lords, that I had sought for stay. That, my lord, this honorable court granted me the stay and then modified the stay also of 50,000 rupees. My lords, there so far as the merits of the.
So that's
trial
not before this court.
That is not before this
All right.
court.
List after
Prayer,
vacation.
prayer, your lordship. One, ಈಗ್ಲೂ ಅವ್ರು ಹೆಂಗ್ ಸುಳ್ಳು ಹೇಳ್ತಿದಾರೆ lordship. Prayer, your lordship. Prayer says to quash the order dated 22/23.
What is that?
That is the main order which was passed by MMTC court.
What is that
Granting
order?
interim order.
What is
interim-
that?
Interim
Maintenance.
ಮೇಂಟೆನೆನ್ಸ್ ಅದನ್ನೇ ಅಪೀಲ್ ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು.
ವಾಶ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ
ಆಯ್ತು.
ಸ್ಟೇ ಕೇಳಿದ್ರು, ಸ್ಟೇ ಆಗ್ಲಿಲ್ಲ ಅಲ್ಲಿ. ಸ್ಟೇ ಆರ್ಡರ್ ನ ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು, ಜೊತೆಗೆ ದೇ ಆರ್ ಆಸ್ಕಿಂಗ್ ಫಾರ್ ಕ್ವಾಶಿಂಗ್ ಆಫ್ ದಟ್ ಆರ್ಡರ್ ಆಲ್ಸೋ.
ಈಗ
22
ಅಮಿತ್, you want proceedings pending here or before the appellate court?
Appellate court, my lord.
ಅದನ್ನ ಅಲ್ಲೇ ಹೋಗಿ ಅಲ್ಲೇ ಮಾಡಿ.
ಅಲ್ಲೇ ಇದೀವಿ,
We'll close
my
this.
I only came here, my lord.
We'll close this.
Yes,
Yes, my lord.
ಟೈಮ್ ಇಲ್ಲ ಅಂದ್ರೆ ಏನಾರು ಒಂದು ಆಗೇ ಆಗುತ್ತೆ. Husband wife. Yes.
I apologize, Lord. Two prayers
But
and
madam,
two
the petitioner is before this court calling in question the order date so and so. This court from time to time has passed certain orders. The learned counsel for the petitioner submits that the orders have been complied with by depositing
Yes,
certain
ma'am.
amount. The learned counsel appearing for the respondent Abhinaya K would submit that very same relief is sought before the appellate court and the appellate court is seized of the matter. The having challenged the same order before the appellate court, the petitioners could not have presented the present petition twice over challenging the same order. The learned counsel for the petitioner submits that he would work out his remedies before the appellate court and both the parties would seek closure of these proceedings with the interim order being complied as observed in the order dated 14/10/2024. Both the parties are at liberty to urge their respective contentions before the appellate court, ordered accordingly. Yes. ಬಿಡ್ಲೇ ಇಲ್ಲಲ್ಲ. Yes.
79.
And the petition in this case, not the, your lordship requires the proceedings against section number 2 in this case. The order is placed at page number 335.
ಏನ್ ಸ್ಪ್ಲಿಟ್ ಇದು?
Right?
ಸ್ಪ್ಲಿಟ್
ಅಲ್ಲ ಸ್ವಾಮಿ.
ಬೇರೆ crime.
ಬೇರೆ ಕ್ರೈಮ್
The accused.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಇಂಟರ್ order ಇದೆಯಾ?
Entry order is, but
Just after vacation, interim order subsisting.
submission, one
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಸ್ಟೇ ಏನು?
Minute.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಸ್ಟೇ ಏನು ಐ ಹಾಕಿದ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಸ್ಟೇ?
earlier the extension of the accusation.
ಸರಿ, ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ interim order
One thing.
granted earlier stands extended till the next date of hearing.
Petitioner wants to go to abroad for a job, my lord. He has got job and so he has. also
Immediately
got
after
visa.
vacation.
He has got visa already, my lord. He has to go.
ಎಲ್ಲಿದೆ visa?
20th, I produced along with the memo, my lord.
ಯಾವ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು?
Dubai, my lord. He got
ದುಬೈಯಲ್ಲಿ
job.
ಜಾಬಾ?
Yes, madam.
ಕೊಡಿ, ಪೇಪರ್ ಕೊಡಿ ಮೇಡಮ್.
Along with memo for posting, I have placed, my lord. 20th is the journey date, my lord.
ಮೆಮೋ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್.
Yes, my lord. Yesterday I moved, my lord.
File an
Along with that,
affidavit.
I have produced, my lord.
ಫೈಲ್ ಅನ್ ಅಫಿಡವಿಟ್ ಆಫ್ ದ ಪಾರ್ಟಿ. ಇಲ್ಲದ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಹೆಂಗೋ ಇದೆ, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಗ್ತೀನಿ.
But he has to, 20th is the date. my
ಎಲ್ಲಿದ್ದಾರೆ?
journey date,
ವೆರ್
my
ಇಸ್ ದಿ?
lord. He's in Bangalore, my lord.
Get an affidavit of him tomorrow along with the visa and memo ಜೊತೆ ಹಾಕ್ಬೇಡಿ. List tomorrow in the fresh matters list.
Obliged.
Yes, next.
80.
Withdrawal in
81.
terms of. ಏನೋ ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರಲ್ಲ ಏನಿದು?
ಇದು ಬೆಳಿಗ್ಗೆ ಮೆನ್ಷನ್
ಇದಲ್ವಾ? ಹೇಳಿ.
ಮ್ಯಾಟರ್ ಆಫ್ ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಮೆಲಾಟ್
ನೋಟಿಸ್ ಆಗಿದೆ ಅಲ್ವಾ?
ನೋಟಿಸ್ ಆಗಿದೆ.
ಮತ್ತೆ ಯಾಕೆ ಬಂತು ಮತ್ತೆ?
ನಾವು ಮೆಲಾಟ್ ದಿ ಸೆಕ್ಷನ್ಸ್ ದಟ್ ಆರ್
4/24 ನೋಟಿಸ್ ಆಗಿರೋದು, ಇನ್ನೂ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿಲ್ಲ.
ತಗೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಮತ್ತೆ ಸಿ ಫರ್ನಿಶಿಂಗ್ ಆಫ್ PF ಫಾರ್ ದಿ ಫಸ್ಟ್ ಟೈಮ್ ಯಾವತ್ತು?
ಇವತ್ತು ತಗೊಂಡಿದ್ದೀನಿ.
ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ನಾವು ಮೆಲಾಟ್
ನೋ ಸರ್.
ಅಲ್ಲ, ಮ್ಯಾಟರ್ ಇಸ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಆರ್ಡರ್ಸ್.
4/1/2024 is the order issuing notice and you have not taken steps for 12 months. You can't project urgency.
ನಾವು ಮೆಲಾಟ್ ಮ್ಯಾಟರ್ ಇಸ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಆರ್ಡರ್ಸ್ ಆನ್ ಹಿಯರ್ ಬಿಫೋರ್ ಚಾರ್ಜ್. ಕೈಂಡ್ಲಿ
Not at all. Yes.
ಕೈಂಡ್ಲಿ ಮೆಲಾಟ್.
No, sir. Move the vacation bench. This attitude, ಸುಮ್ನೆ ನೋಟಿಸ್ ಆದ ತಕ್ಷಣ ಸುಮ್ನೆ ಇದ್ಬಿಡೋದು ನಿಲ್ಲಿಸ್ಬೇಕು.
ಅಲ್ಲ, ಕೈಂಡ್ಲಿ ಮೆಲಾಟ್.
No, sir. 1 ವರ್ಷ you have kept quiet. Today you have taken steps.
24th
this
year
is-
before charge ಮೇಲೆ ಆರ್ಡರ್ಸ್.
Whatever, sir. You should have been diligent. What is this?
ಅಲ್ಲ,
1 ವರ್ಷ
354
ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳಲ್ಲ. And today
Extremely sorry.
ಬೆಳಗ್ಗೆ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಂತ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡು ಅರ್ಜೆನ್ಸಿ.
354 has been invoked against me, my lord.
Whatever is invoked. Yes.
ಅಲ್ಲ, in the entire complaint, my lord, there is no allegation
Yes,
against
after
me there.
vacation. Yes, yes.
My lord, for tomorrow, my lord.
There's no, sir.
82.
This
Kindly, my lord.
attitude is incorrect.
No, no,
Absolutely.
I
incorrect.
apologize, my lord. I should have taken
No,
steps.
nothing doing, sir. 12 months you have kept quiet. And not to pay process. First time, ಏನೋ FPF ಆದ್ರೆ ಒಂದ್ಸರಿ ಕಟ್ಟಿ ಬಾಗಿಲ್ಲ ಅಂತಂದು ಬೇರೆ ಮಾತು. ಫಸ್ಟ್ ಟೈಮ್ ಕಟ್ಟಕ್ಕೆ 12 ತಿಂಗಳು ತಗೊಂಡಿದ್ದೀರಾ, ಇವತ್ತು ಅರ್ಜೆನ್ಸಿ.
Kindly, matter
No,
is
sir.
posted for year before.
No, let be. Argue, sir. Here before charge ತಾನೆ.
On Friday, my lord.
If you knew the seriousness, you should have posted it.
At least on Friday, my
No,
lord.
sir. Move the vacation bench. This is incorrect, Sadan.
I'm sorry.
Very bad.
There's some
And
urgency,
not
otherwise,
expected-
otherwise. I
Not
wouldn't have trouble.
expected from you. What is
Alala,
this?
I know, I wouldn't have trouble this.
What
quick,
is
my
this,
lord.
sir?
Kindly, my lord.
Nothing.
ಅಲ್ಲ
Yes,
354 ಇದೆ my lord. Yes, sir.
ಏನಾಗುತ್ತೆ?
ಅಲ್ಲ here before charge ಅಲ್ಲ orders ಗೆ ಅಂತ ಇದೆ. This sword hanging on my head, my lord. Otherwise I would have.
You should have known that this sword will
No,
pop
I deeply
if you don't
apologize, my
take
lord.
steps.
My lord, it's my mistake, my lord. Kindly, my lord. One opportunity may be
List
given.
on Friday. Yes.
All right, great.
82.
For the petition. Let's,
Post immediately after service of notice upon, sorry, 82. Yes, sir.
let's, offenses are 406, 409, and 420, my lord. Petition by accused number 16, my lord. The petition filed by accused number 17 and accused number 5 have been stayed by this honorable court, my lord.
Sorry. Tag the petition along with zones.
Annexed D is the petition
Page,
filed by
page.
64, my lord.
Yes,
It's
tag along with zones.
Plus,
Same one.
producing the memo, my lords, along with the entry order details of the other petition, my lords, which was recently filed and. which was
Tag
stayed.
along with everything. ಅದ್ರಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ ಒಂದರದ ಕಾಪಿ
ಅಲ್ಲ ಬ್ಯಾಂಕ್ ಎಂಪ್ಲಾಯ್ ಈಸ್ ದ ಮೇನ್ ಅಕ್ಯೂಸ್ ಮೇಡಮ್ ಬ್ಯಾಂಕ್ ಎಂಪ್ಲಾಯ್
ಕೊಡಿ ಇಲ್ಲಿ.
ಈಸ್ ದ ಮೇನ್ ಅಕ್ಯೂಸ್
ಅವರೆಲ್ಲ
serious allegation
accused
against-
number
16, my lord.
16.
You are 16.
Kindly, page number 24 ಮೇಲೆ ಕಾರ್ತಿಕ್ ಪಾತಿವಾಡ ಎಲ್ಲ ಪೇಜ್ ಅಲ್ಲೂ ಇವ್ರದೇ ಮೈನ್
ಅವ್ರ ಹೆಸರೇ ಇದೆಯಾ?
He was
Quite popular.
ಈಚ್ ಅಂಡ್ ಎವ್ರಿ
He was the field
Accused
officer,
role-
my lords, whose duty was to
What
verify.
operator?
Field officer, my lords, whose duty was to verify the property and the documents. my
1
lords.
minute. sir.
in the page number 24.
ಇದು ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟಿದೆ ಗೊತ್ತಾಗಿದೆ.
Yes,
ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ, my lords, fresh matter.
ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
No, my lords, it's coming up for the first time.
Tomorrow in the fresh matters.
Please.
Venkatesh, 7A. Post immediately after service if notice upon the respondent, tag with zones. Further ಇದೆಲ್ಲ madam.
Entry order may be extended.
ಇದೆ ಅಲ್ವಾ? Entry mode extend.
84.
Petitioner, my lordship, in this
Office objection.
tomorrow.
Tomorrow. Complaint.
ಇದರಲ್ಲಿ
ಬೇಗ
allegation
ಹೇಳಿದ್ರೆ
itself, the allegation complaint itself.
504, 506.
ಹೌದು ಸ್ವಾಮಿ, ಮರಗಳನ್ನ ಕಟ್ ಮಾಡಿ ನಾನು ಆಸಿಡ್ ಹಾಕ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಆಸಿಡ್ ಹಾಕ್ಬಿಟ್ರ?
ಮರಗಳಿಗೆ ಆಸಿಡ್ ಹಾಕ್ತೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಅಲಿಗೇಷನ್ ಇರೋ ಸರ್. ಬಟ್ ಮಾಜರ್ ರಿಪೋರ್ಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಶೋಸ್ ದಟ್ ಆಸಿಡ್ ಏನು ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿ. ಲೇಟರ್ ಆನ್ ನಂದೊಂದು ಕೌಂಟರ್ ಕಂಪ್ಲೇಂಟ್ ಗೆ ಟು ಓವರ್ಕಮ್ ಅವರು ಅಟ್ರಾಸಿಟಿ ಸೆಕ್ಷನ್ಸ್ ನ ಇನ್ವೋಕ್ ಮಾಡ್ತಾರೆ. ಹೌದು ಸ್ವಾಮಿ, ಕಂಪ್ಲೇಂಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಅವರು ಮರಗಳಿಗೆ ಬಂದು ಕತ್ತರಿಸಿ ಆಸಿಡ್ ಹಾಕೋದು ಅಂತ ಅಷ್ಟೇ ಇದೆ ಸ್ವಾಮಿ. ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್. ಲೇಟರ್ ಡೆವಲಪ್ಮೆಂಟ್ ಇಟ್ ಶೋಸ್ ದಟ್ ಅವರು ಕ್ಯಾಶ್ ನನ್ ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ಬಿಟ್ಟು ಆಫ್ಟರ್ 1 week ಆದ್ಮೇಲೆ ಅದನ್ನ ಅಲಿಗೇಷನ್ ಇಂಟ್ರೊಡ್ಯೂಸ್
ಪೇಜ್ ನಂಬರ್ 31 ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಇದೆ ಕ್ಲಿಯರ್ ಆಗಿ ಜಾತಿ ಹೆಸರು ಪಬ್ಲಿಕ್ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಇನ್ ಪಬ್ಲಿಕ್ ಯು ಅಬ್ಯೂಸ್ ದಿ ಕಂಪ್ಲೇಂಟ್.
ಸ್ವಾಮಿ ಪೇಜ್ ನಂಬರ್
31 ಅಲ್ಲಿ ಡೇಟ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ.
ಸ್ವಾಮಿ ನಿಮ್ಮ ಕೆಟ್ಟ ಜಾತಿ ನಾಡ ಅಂತ ಅದ್ ಲೇಟರ್ ಆನ್ ಮತ್ತೆ
ಏನೇನೋ
ಮಾಡ್ತಾರೆ.
ಕೋರ್ಟ್ ಅಲ್ವಾ ಹೇಳ್ಬೇಕಾರೆ ಹೇಳ್ಬಾರ್ದು. ಓದಿ ಅಂತ ಹೇಳ್ಬೇಕು, ನಾವು ಓದ್ತೀನಿ. You should not utter those words here. List tomorrow in the fresh matters list. Office objections overruled, fresh matters. ಅದೆಲ್ಲ ಇರೋದನ್ನ ಓದ್ಬಾರ್ದು, ಹಂಗೆ ಇಟ್ಕೋಬೇಕು. ನಾಳೆ
85. There is no petition. Offense under section,
post immediately after service of notice upon the respondent.
my lord,
Case and
may I
counter
request
case.
for, please, my lord, it's a case and counter case, but may I request interim order for accused number 2? As my lord, he's 74 years old, my lord, and also he has assaulted with the hands, my lordship. As per the complaint government itself, my lord, it discloses that, my lord, the allegation is that, my lord, ಕೈಯಿಂದನೇ ಹೊಡೆದಿದ್ದು. I may be permitted to read.
ನಾನೇ ನೋಟಿಸ್ ಮಾಡ್ರಿ. Post immediately after service of
My
notice
lordship,
upon
I
the
request
respondent.
for accused number 2,
No,
my
madam.
lordship.
Yes, next. ಅವಾಗ ಕೊಟ್ಟಿಲ್ದೇ ಇರೋದು ಇವಾಗ ಕೊಡ್ತೀನಿ. Yes, next.
86.
Appear for the respondent, 7A case, your lordship.
Same tag. BB Patil
I have
directed.
Copy served.
Sir, ಪರವಾಗಿಲ್ಲ. ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ.
ಇಲ್ಲ ಕೊಟ್ಟಿದ್ದೆ 2 ಕಾಪಿ.
ಇನ್ನೊಂದು ಕೊಡಿ. 7A ಸರ್, ದುಡ್ಡು ತಗೊಂಡಿರೋದು ಅದೇ ಕಾಪಿ ಕೊಡಿ.
ತಗೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಪರವಾಗಿಲ್ಲ.
ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಇಲ್ಲ. ಕ್ವಶನ್ ಆಫ್ ಅಕ್ಸೆಪ್ಟ್.
ಡಿಮಾಂಡ್ ಮಾಡಿದಿರಲ್ಲ.
ಅಲ್ಲ ಡಿಮ್ಯಾಂಡ್ ಇಲ್ಲ, ವಾಯ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದ್ರು.
ಮತ್ತೆ ವಾಯ್ಸ್ ಅಲ್ಲಿ ಡಿಮಾಂಡ್ ಆದ್ಮೇಲೆ ಕಾಪಿ ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ.
ಕಾಪಿ ಕೊಡಕ್ ಒದ್ದಾಡ್ತಿದಲ್ಲ.
ಕಾಪಿ ಕೊಟ್ಟಿದೆ.
ಡಿಮಾಂಡ್ ಅಂಡ್ ಆಕ್ಸೆಪ್ಟೆನ್ಸ್ ಅಲ್ಲಿ.
ಇಲ್ಲ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಇಲ್ಲ.
The petitioner shall serve 4 sets of papers upon the counsel for the respondent BB Patil forthwith. Yes, next.
ಎಲ್ಲ 2 ಸೆಟ್ ಕೊಟ್ಟಿದೆ.
ಇನ್ನೊಂದು 4 ಕೊಡಿ. 4 sets of papers. ಕಾಪಿ ಕೊಡಕ್ ಹೊಡೆದಾಡ್ತಿ.
ಕೊಟ್ಟಿದೆ. ಕಾಪಿ ಸರ್ವ್.
Yes, ಆಮೇಲೆ objections if any by the next date. Yes. ಡೇಟ್ ಟ್ಯಾಗ್ ಅಷ್ಟೇ. Date tag, ಬೇರೆ ಏನು ಬರೀಬೇಡಿ.
87.
Post immediately after service of notice upon the respondent. Interim order subsisting will continue.
ಸ್ವಾಮಿ ಇದು ನಿನ್ನೆ ಬಂದಿದೆ ನಮಗೆ.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟಾ?
ಹೌದು, ಸೋಹನ್ ಕುಮಾರ್.
ಹಾ.
ನಾನು 169 ಪೇಜ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇಲ್ಲಿರೋದೇ 50 ಪೇಜು ಸ್ವಾಮಿ. ನಮ್ಗೆ
Copy.
ವಕೀಲರನ್ನ
ಕಾಪಿ
ನೇಮಿಸ್ಕೊಳ್ಳೋಕೆ
ಕೊಡಿ.
ಸ್ವಲ್ಪ ಕಾಲಾವಕಾಶ.
Copy ಕೊಡ್ತೀನಿ. The respondent has appeared in person, seeks 2 weeks time to engage the service of a counsel. He would submit that the entire set of papers are not received by him. Therefore, counsel for the petitioner shall serve entire set of criminal petition papers upon the complainant forthwith, lest the matter in the first week of January. They have engage ಮಾಡ್ತಿರಲ್ಲ advocate.
ಅಡ್ವೊಕೇಟ್ ನಾವು
Just in the first week of January 2025.
2025.
Rajshekar,
On 16/4/2024.
post immediately after service of notice upon the respondent, interim order continue ಮಾಡಿ.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
ಇಲ್ದರೆ ಅದನ್ನೇ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. Next, yes.
I make one request.
Oh, sir. Yes.
89.
354 ಇದೆ ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ.
ಕೆನೆ ಕೊಟ್ಟಿಲ್ಲ. Yes, ಈಗ ನೋಟಿಸ್ ಹೋಗಿ ಬಂದಿಲ್ಲಲ್ಲ ಇನ್ನು.
I make only one
Oh,
request.
sir. Yes.
On 16/4/2024 I file a suit. Then an
ಪರವಾಗಿಲ್ಲ
injunction
sir.
order. 20th they
ಅದ್ರಲ್ಲಿ
appoint-
allegations ಇದೆ ಅಂತಾನೆ ಮಾಡಿಲ್ಲ. Yes, next.
89.
seek for a date.
Immediately after service of notice. Yes, next.
Plea urgency, my lords, your lordships had
Post immediately after service of notice upon.
His private employment, my lords, and his marriage. my lords.
Filed my wakalat yesterday.
Learned counsel so
See, to
and
the
so.
extent of committal, my lords, 304 and
Learned
304.
counsel so and so undertakes to enter appearance for the respondent. 304 ಏನು?
Yes, my lords, 304 is invoked, but I think it will be 304A, my lord. It has to come down to 304A. That's only
ಏನು?
to that extent
Who
committal.
died? Who are you?
My lords, I was the driver of the vehicle, my lords.
Yes, after vacation.
My lords,
Next.
my lords, only urgency is, my lords.
No urgency. You are a driver of the vehicles. Yes.
My lords,
Who, I'll tell you one thing. You are a driver of the vehicle. Who else can be attributed negligence still? Who else can?
my lords,
Compensation
therefore,
apart.
304A is
Alla,
applicable.
compensation apart. Death is caused due to the rash and negligent act of yours. Who driver ಅಲ್ಲದೆ ಬೇರೆ ಯಾರು ಪಕ್ಕದಲ್ಲಿ ಕೂತಿರೋ ಪ್ಯಾಸೆಂಜರ್ ಮೇಲೆ ಯಾಕಾಗುತ್ತೆ?
304 ಬರಲ್ಲ
ಮತ್ತೆ?
ಅದಕ್ಕೆ 304 two part.
ನೋಡ್, we'll see.
Only
Yes.
to that extent because my lords, his marriage is
We'll
fixed. Only to the extent
ಅಂದ್ರೆ
of
304A ಆದ್ರೆ you will get married, 304 ಆದ್ರೆ nobody will give you in marriage, is it?
my lords, his private employment.
ಅಲ್ಲ
my lords,
304A ಇದ್ರೆ ಮ್ಯಾರೇಜ್ ಬಾಗತ್ತಾ?
The offense under 304 punishment is
What
there. His
submission,
private employment is also under.
304A ಆದ್ರೆ private employment is
But
not
it's
under
only
stake.
for 2 years. my lords. There, my lords, it's more.
Yes.
Only.
ಆಲ್ಕೋಹಾಲ್ ಲೆವೆಲ್ ಇಸ್ ಲಿಮಿಟ್ ಅದೊಂದು ಹಾಕೇ ಇಲ್ಲ ಅವ್ರ ಚಾರ್ಜ್ ಶೀಟ್.
ಎಷ್ಟಿದೆ ಸರ್?
ಆಲ್ಮೋಸ್ಟ್ 113 mg per 100
I have
ml.
produced the charge sheet itself, but the medical report of that alcohol test is not available in the charge sheet. That's the only case, my lords,
It's
that
better you don't get married.
I mean, your lord,
Yes.
if your lord.
ಈ ತರ ಆಲ್ಕೋಹಾಲ್ ಇದ್ರೆ
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಇಲ್ಲ.
ಏನ್ ಅದ್ರಲ್ಲಿ
Medical
ಇಲ್ಲ?
report is not there. That is the, in the last sentence of the charge sheet, that observation.
What sentence?
FSL
Drunken
report
driving,
is there.
drunken driving,
Drunken drive.
at 113%.
113
14 mg of alcohol in 1 ounce of blood.
140 at
Please.
least, not
140 mg in 1 ounce.
141.44 mg.
That report was not available. Very well. Your lordship feel that it.
Feel ಅಲ್ಲ.
That
You, I
it's
need
not
not,
available.
I
It-
need
that
not-
FSL
you
report
need
is
not say
available.
lordship feel that.
No, my lord. That FSL report is not available in the charge sheet.
No,
It
it's
is
the.
available. I have it.
Very. In the certified copy that I have produced. they did not
ಅದಕ್ಕೆ
give it.
even before that alcohol thing he told, driver ಅಲ್ಲದೆ ಬೇರೆ ಯಾರ ಮೇಲೆ ಹಾಕಕ್ ಸಾಧ್ಯ?
That's right. That's why only to the
And now
extent
that
of
140%,
from 304 to 304A is all that I was seeking. Very well, after vacation.
sir,
See,
304A ಬರಕ್ಕೆ some
if
act
there
of
was-
yours,
Yes,
intent to cause death is 304. 304A is unintended death.
please,
We'll see.
very well. Only to that extent I was.
ಸ್ವಯಂಕೃತ ಅಪರಾಧ, ಏನು ಮಾಡಕ್ಕ? Yes.
Please,
Excise department blame ಮಾಡಿ.
90.
So, my lord, section 7A for the exonerated departmental proceedings. It's a 7A case, your lordship.
7A, sir, yes. List on 16th.
My lord,
AV
three-
Patil is directed to accept same. ಆಗಿದೆ notice?
Copy has been served, my lords. Interim order may be granted. Trial court is proceeding with the matter, my lords.
No, charge sheet ಆಗಿದೆ, no entry matters.
Charge sheet has been filed. my lords.
No problem. Latest list on 16th along with connected cases.
The proceeding, trial court is
Let it
proceeding to frame
proceed.
the charge.
Yes, nothing is going to happen.
Maybe deferred until the hearing.
Defer ಮಾಡಿದೆವು ಬೇರೆದ್ರಲ್ಲಿ.
ಹೌದು ಬೇರೆ
ಯಾವ್ದ್ರಲ್ಲಿ ಮಾಡಿದೆ?
Exonerate
ಎಲ್ಲಿ
ಮಾಡ್ಬೇಕು. This is
ಮುಜಾಸ್
exonerate.
Please, my lordship.
ಡೆಫರ್ ಮಾಡಿದೆ ಬೇರೆದ್ರಲ್ಲಿ?
Matter is framing of charge till the next date, my lordship.
The concerned court shall defer framing of charges till the next date. List on 16th. Venkatesh,
7M.
same tag, same order. Post immediately after service of notice upon the respondent. Intermort ಇದೆ. Ravi Shankar,
498A.
office objections.
ಅದು page 46 has
ಆಯ್ತು,
been
ಏನು ಯಾರು petitioners ಯಾರು?
husband, brother-in-law, so and so, mother-in. Husband, I am drawing an exception because it's a second marriage for her, first marriage for him.
So exceptional husband.
No, I'll say.
Then
12,50,000 she has been taken as a permanent alimony from the first wife.
she did not give it to you.
No. Page 54 alli, there is already complaint is prior 1 month it has been filed. No allegations. NCR been issued, page 56. After 1 month, another complaint is been filed on the ground of filing of my divorce.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ತೊಂದರೆ ಇಲ್ಲ.
But
12.5 lakhs ಕೇಳಿರ್ತೀರ ನೀವು ಅದಕ್ಕೆ?
ನಾನೇನ್ ಕೇಳಿಲ್ಲ. First husband, she has taken. After taking 12.5 lakhs, but she changes her name, marries me.
Changes her name?
Yes. That is from Rachana to Sudisha.
Oh.
That has been hidden. Marriage agilla ಅಂತ ಹೇಳಿ that she marries me. Thereafter Millet files a complaint one after the another. Within 1 month, 2 complaints are filed. In the first complaint, though there is no allegation. In the second complaint, Millet husband is also drawn. That is my I am seeking
Yes.
exception.
Office objections overruled. 1 HCGP to emergent notice in the meantime. Please. Next.
93.
So appear for the
Post
petitioner.
immediately after service of notice, same intermort extended. Next.
Appear for the respondent.
Tag along with. Complainant, huh?
4.
ನೀವು complainant ಈಗ?
I'm for the second respondent. I'm file.
Okay, ಹೇಳಿ. Learned counsel so and so enters appearance
For the second respondent here.
enters appearance for the second respondent, registry to print the name of so and so is appearing for the second respondent.
93.
Milord,
1 minute. Thus service of notice stands complete. List the matter on 16th. Next.
Interim order.
That will continue.
94.
Milord, petitioner by me, Milord, 407 petition.
Post immediately after service of notice upon the respondent. Next.
Date may be fixed in the first week of January, Milord, because
List
in the
first week of
matter,
January. Next. Yes.
Milord, one submission, Milord, one submission, Milord. In this matter, Milord, the second respondent is residing in Bangalore and working in Bangalore, but the alleged complaint has lodged in the at Chitradurga.
ಅಂದ್ಬಿಟ್ಟು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೋಗ್ತಾ ಇದ್ದೀರಲ್ಲ, ಆಮೇಲೆ post immediately after service of notice upon the respondent. Yes, next.
Appealing for petitioner, Millet. Offense under section 498
Much
and
better.
504.
Maintainability ಯಾಕೆ? ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಏನು?
ಅದು ಫಸ್ಟ್ FIR ಚಾಲೆಂಜ್ ಮಾಡಿದೆ, ಅದು ಲಿಸ್ಟ್ ಆಗಕ್ ಮುಂಚೆ FIR ಇದಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಲಿಸ್ಟ್? ನಂಬರ್ ಕೊಡಿ ಅದು.
Memo, I am filing memo.
ಮೆಮೋ ಫಾರ್ ವಾಟ್?
Memo for withdrawal of that petition.
ಲಿಸ್ಟ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ಅದು FIR ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೆ. ಅದು FIR ಪೆಂಡಿಂಗ್ ಇರ್ಬೇಕಾದ್ರೆ ಕೇಸ್ ಬರಕ್ ಮುಂಚೆನೆ
ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ?
ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
ಮತ್ ಮೆಮೋ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿಲ್ದೇ ಇರೋಕೆ ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಕೊಡಿ, ನಾಳೆ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ತೀವಿ, ಕೊಡಿ.
Please.
ಎಸ್. ನೆಕ್ಸ್ಟ್. ಯಾರು ಹಸ್ಬೆಂಡ್ ಇದಾರಾ?
Husband ಇದ್ದಾರೆ. Petitioner number 1 is the husband. Petitioner number 2 is mother. Petitioner number 3 is the sister of petitioner's
ಆಯ್ತು
mother.
ಒಂದ್ ನಿಮಿಷ. ಇನ್ನು ತುಂಬಾ ಜನ ಇದ್ದಾರೆ, ಆಮೇಲೆ
ಇಲ್ಲ,
ಸಾಯಂಕಾಲ ಆಗುತ್ತೆ.
4 ಜನ. Petitioner number 2 is mother, Mela.
ಒಂದ್ ನಿಮಿಷ ಸರ್.
Please, ma'am. ಮದುವೆ ಆಗಿ 15 ದಿನಕ್ಕೇನೆ ಬೇರೆ ಮನೆ ಮಾಡ್ಬೇಕು.
ಪರವಾಗಿಲ್ಲ, ನಿಮಿಷ. Yes. 1 HCGP 2 emergent notice. A perusal at the summary of the charge sheet would not indicate the offences necessary to become the ingredients necessary to become the offense under section 498A, que petitioners 2, 3 and 4. Therefore, there shall be an interim order of stay, que 2, 3 and 4. Emergent notice to the respondent. Next.
96.
Counsel submission.
I'm for the petitioner, my lord. My lord, counsel submission is with regard to the respondent number.
Matter.
Yes, my lord. My lord.
406, 417, 420.
Petitioner is an accused number 1, my lord.
Ah.
He is a former president in the sports club.
Allegation is misappropriation of
Yes, my lord.
1 crore.
Yes, my lordship, accused number 4 is a manager, my lord, who is looking after the day-to-day affairs and the financial accounts, my lord.
One,
My lord,
will you
he,
take a chance in the vacation bench?
my lord, he already admitted the,
Where is the admission?
my lord, in running page number 25, my lord,
Where is the admission?
document number 3, my lord.
ಅಲ್ಲೇ ಇದ್ದೀನಿ.
Yes, my lord. After that, my lord, document number 4, running page number 28, my lord, he issued a check of 10 lakh and 14 lakh, my lord.
10 lakh, 14 lakhs will not become 1 crore.
My lord, he in running page number 25, document number
When,
3, my
when
lord.
did you come out as president?
My lord, my period is, my lord, 2019 to 23.
Correct ಆಗಿ ಅದೇ period ಗೆ ಆಗಿರೋದೆಲ್ಲ.
My lord, in manager, my lord, agreed that, my lord, he misappropriate the
Let's see,
but it's not 1 crore, my lord. He gave
50,
an
54
explanation.
lakhs and
My lord, he gave an explanation, my lord, there is some mistakes in the accounts. He gave detailed explanation in document number 3, my lord. Running page number 25.
The allegation is
ಹ್ಮ್
because the Siddhartha Sports Club.
ಗೊತ್ತಾಯ್ತು, ಸಿದ್ಧಾರ್ಥ ಸ್ಪೋರ್ಟ್ಸ್ ಕ್ಲಬ್ ಕ್ಲೋಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಹಿಂಗೇನೆ. ಎಲ್ಲ
ಹೊಡೆದ್ಮೇಲೆ
siphoned off.
My lord, he is ready to give the, my lord, misappropriated amount.
How
my lord.
much?
My lord, 54 lakhs, my lord.
ನೀವು
Allah, accused number 4, my lord, the manager.
will see, yes. What notice or will take chance in the vacation?
My lord, meanwhile, my lord,
Yes.
my lord, accused number.
Not in misappropriation.
I am the,
ಬರೀ 10 ಲಕ್ಷ ಮೇಡಮ್ ಇರೋದಲ್ಲಿ.
my lord,
ವೇರ್ ಇಸ್ ಇಸ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ದಟ್ 54 ಲಕ್ಷನ ಕೊಡ್ತೀನಿ ಅಂತ.
Allah, my lord, he gave the apology letter also, my lord. And
ಎಲ್ಲಿದೆ?
he is ready to pay the,
ಎಲ್ಲಿದೆ? You are ready to tell that he is ready, but where is he ready?
my lord, in our case, my lord, we also.
ಮೇಡಮ್ ಅವ್ರದ್ದು ಎಲ್ಲಿದೆ? ರೆಡಿ ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಎಲ್ಲಿದೆ?
My lord, he issued a check of rupees 10 lakh.
10 ಲಕ್ಷಕ್ಕೆ 54 ಲಕ್ಷ ಒಂದೇನಾ ಮೇಡಮ್?
My lord,
ಹ್ಮ್
because the manager, my lord, he misappropriate the fund, my lord.
Let's
I am the
tomorrow
president, my lord.
tomorrow in the fresh matters list.
Please, my lord. Much obliged, my lord.
But don't get your senior now. You come tomorrow. Yes.
Please, my lord.
Next.
Much obliged.
97.
Bring for the petition.
My lord, in this case, I take notice for second respondent, my lord.
498A.
Yes, the matrimonial disputes, my lord, have been settled. In fact, 3 years ಆಯ್ತು.
Settled
Divorce ಆಗಿದೆ.
ಆಯ್ತು.
My client has received the
settlement
maintenance amount also, my lord.
All right.
I am filing my wakalat and also
The
affidavit.
Learned counsel so and so.
Both are present, my lord.
Letters appearance for the respondent registry to print the name of so and so is appearing for the respondent. The learned counsel for the petitioner and the respondent would submit that the dispute between the two have been resolved
Please.
3 years ago. And
Allala,
have been
3 years
resolved now.
dispute is resolved.
Sorry.
Sorry, my lord.
Resolved now. And have drawn up certain and have filed a joint affidavit to that effect along with an application seeking compounding of the offense. So and so, 498A. Yes.
Please,
Yes.
much obliged.
Order sheet signatures.
Please.
Next.
98.
Appear for the petitioner, my lord. 153 offense, my lord. Without any sanction, my lord, the magistrate is taking cognizance of the offenses.
Office. 1 HCGP 2 emergent notice in the meantime. Next.
As may I be.
Office objections overruled. Next.
As may be permitted to place your lordship's judgment on that.
ಏನ್ ಇವಾಗಲೇ ಕ್ವಶನ್ ಮಾಡ್ಬೇಕಾ? ಸ್ಟೇ ಮಾಡಿದ್ದೀನಿ. Yes. Next.
59.
For petitioner. The office objection has been overruled on 13th, my lord. This is the petition challenging the order passed. 391 application, my lord. 2 cases, my lord, on same alleged single liability, but filed one against the principal borrower and another case against the personal guarantor. my lord.
Yes, sir. ಸ್ಟೇ ಮಾಡಿರುವ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿರ್ತೀನಿ.
ಇಲ್ಲ, no,
ಬೇಡವಾ?
after vacation.
Why?
3
2 cases ಇದೆ. You go again. You are the borrower.
I am the
Guarantor.
principal guarantor.
391 CRPC application reject ಆಗಿರೋದು. They have come upon that application.
All right. List after
My
vacation.
lord, 23rd, the
After
matter is
vacation.
posted for arguments.
List on Friday and Monday. Yes, next.
100.
For the petitioner, my lord.
2 weeks to
Steps
do,
taken.
2 weeks to do the needful entry order.
Needful done, my lord.
Learned counsel submits needful has been done. Office to verify. Yes, next.
Please, my lord.
101.
Yes, please, my lord. In this matter, please, my lord, R2 R12 is the husband of the deceased, please, my lord. It's a police sub-inspector. In the,
ಈಗ ಏನಾಗ್ಬೇಕು ಈಗ?
that, my lord, in this matter, convenience compilation has been filed.
Today it's not convenient to hear, sir.
All right, please.
List the matter on
Any other date may kindly
16
be fixed.
January. Interim order subsisting would continue to the next date of hearing. Further hearing ಅಂತ already ಇದೆ madam. List the for
Apply.
further hearing. Yes, next. 102, post immediately after service of notice
And for
upon
the
the respondent.
petitioners, your lordships, kindly extend the interim order.
Where
because
is the
it's-
file?
File is here, your
Ah,
lordship.
yes. So it's post immediately after service of notice, I will, next.
Then
Latif,
three.
ಯಾರಿಗೆ?
7A.
Yes, next.
And three.
Appeal for petition.
Post immediately after service of notice, I will, next.
Then four.
Same order.
For the respondent.
So seven, ಇದು 7A. Yes, tag.
with my lords 167, serial number 167, tag.
Wait, sir. Yes, tag ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
Please.
Next. Same, ಅದು tag ಮಾಡಿ. 105,
Then five.
7A, my lord.
7A.
same.
It's interim order extension for further hearing.
And then six.
ಅವ್ರು ಹೋದ್ರು ಅನ್ಸುತ್ತೆ ಬಿಡಿ. Yes. List after vacation. ಇಲ್ಲ ಯಾವತ್ತು ಹಾಕೋಣ?
This your lordship inform that it be posted for orders.
Further hearing ಹಾಕ್ಲಾ?
Further hearing.
Yes, list on 13th, sorry, 15th January, 16th January. Yes, for further hearing. Next. 7A,
107.
7A,
7A, my lord.
7A.
Interim order, my lord.
ಏನಿದೆ ಅದಕ್ಕಂటే ನೀವು ಹೇಳಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಲ್ಲ. ಸೇಮ್
And
7.
eight.
Same 7A, your lordship.
Nine.
109. This objection may be overruled, my lord.
ಏನ್ ಹೇಳಿ?
It's a DA
This
case.
objection up to date.
7A
DA.
DA case, your lordship.
13
Yes.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
Order sheet generate ಆಗಿಲ್ಲ.
ಸರಿ ಬಿಡಿ.
Office objection may be overruled.
Tagged along with office objections overruled. BB Patil is directed to accept notice for the respondent ಇದ್ರಲ್ಲಿ DA ಅಂದ್ರೆ ಅವರೇ ಇರೋದು. ಕಂಪ್ಲೇಂಟ್ ಇದಾರಲ್ಲ?
Government, status.
ಸ್ಟೇಟ್ ಅಲ್ವಾ? ಎಸ್ ನೋಡ್ಸ್.
Yes.
ಇಬ್ರು ನೀವೇನಾ?
Yes, your lordship.
Learned Counsel BB Patil is directed to accept notice for the respondents. Same if not filed. Charge sheet, yes, next. 23rd.
Interim order ಇದೆ sir.
ಇದೆಯಾ ಆಲ್ರೆಡಿ? ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Next.
Then ten.
Lord, I appear for the petition, my lord. Page 58, my lord, is a complaint which was given by us petitioner.
ಏನಿದು?
My lord, for extortion, my lord, on section 420.
Extortion.
My lord, he had a relationship with this lady who is much younger to her. Now, my lord, she has taken some photographs.
List tomorrow in the fresh matters list. ಸ್ವಲ್ಪ ಡೀಟೇಲ್ ರೀಡಿಂಗ್ ಮಾಡಿ. ಇದು ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬಂದ್ರೆ ಸಿಗಲ್ಲ ಕೈಗೆ ಅದು. ಡೋಂಟ್ ಕಾಲ್ ಎನಿ ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ಮೇಡಮ್. 111 ಏನಿದು?
Petitioner, my lord.
ಆಗಿದೆ lordship.
Interim order to be extended.
List after vacation, interim order extended. Call that ಇವ್ರದ್ದು.
Sir. 112, my lord, sir.
ಏನು?
Madam,
That's in a.
my lord, the predicate offense has been stayed, my lords, in that person to which they have, under the PML Act, they have sought to file the case, my lord. In fact, covered by your lordship's judgment, once the predicate offense has been stayed, it was supposed to be listed on Monday, it went to Justice Court Hall number 9, again we got it listed before your lordship.
ಇದೇನು ಟ್ಯಾಗ್ ಎಲ್ಲ ಆಗಿದೆ?
Yes, my lord, it got tagged along with the service matter, but because of which.
We'll take it tomorrow in the fresh matters.
Can I request day after tomorrow?
No, tomorrow. Yes.
No, please.
You're not there?
I'll do it online.
Oh, no problem.
Please.
List tomorrow in the fresh matters list. Yes. Madam, ask Kunni Krishnan to come tomorrow and not go out of the court for anything. Yes. Yes.
Your lordship. Your lordship. Sorry to mention this out of turn. Item 134, your lordship, was supposed to be listed in the fresh matters list.
ಏನು ಒಂದ್ಸರಿ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
No notice, your lordship.
ಅದು ನೋಡೋಣ ಆಮೇಲೆ. Matters which are not, we'll take that parted matter. Yes.
List number two.
That's.
Yes, sir.
That's.
No, admission ಯಾವ್ದು ಕೇಳಬೇಡಿ.
No, my lord, serial number 171, please, no. It was listed on 27th of November. There was an interim order, but on that day it did not reach. So interim order is
ಎಕ್ಸ್ಟೆಂಡ್
not.
ಆಗ್ಬೇಕು ತಾನೆ ಆಗುತ್ತೆ.
Extend ಆಗಬೇಕಷ್ಟೇ.
ಎಲ್ಲ ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
On that day it was not.
ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಗ್ರಾಂಟೆಡ್ ಅರ್ಲಿಯರ್ ಅಂತಾನೆ ಹೇಳ್ತೀನಿ.
ಬರೀ ಅಡ್ಜರ್ನ್ ಅಂತ.
ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ಪಾಸ್ ಓವರ್ ಆಮೇಲೆ ಕಮ್ at 5 o'clock. Yes. 5 or even 6 o'clock. You can come at 6 o'clock also. Yes. Yes, sir.
Maybe. Wait for the.
Yes.
Tell a synopsis. Sandeep. Where is the synopsis list of authorities? I will not hear the matter if you have not done that. Last time did I not ask you? What is this? Sorry?
Of submissions, we wanted to place.
No, whatever, on the basis of submissions, Allah, you don't know what are the arguments? Yes, sir. You can remark.
Sorry for the.
No, the advocates on record should do it. Last time ಹೇಳಿದೀನಿ.
ಹೌದು ಹೇಳಿದ್ರಿ. But just to recapitulate the submissions which I made the other day in just 2 or 3 sentences. Well, I invited my lord's kind attention to section 73 of the code.
Warrant. I remember that.
It is that has necessitated the petitioner, my lord, to invoke my lord's jurisdiction under section 438 of the CRPC. On 12/12, he was required to be present before the IO.
No, I mean hearing on merits.
Merits. But I also drew my lord's kind attention to the conduct of the first informant in the case, that is the mother of the alleged victim. 56 cases and 56 petitions against anybody and everybody who is known to her. But the offense was on 2/12/2024. Well, for the first time, the complaint is filed on 14th of March 2024. That is nearly 1.5 months later to the date of the incident. Well, that is how I submitted to lordship. Well, I also invited my lord's kind attention that no doubt the statement of the victim is there. The victim would certainly state that she came to be touched by the petitioner inappropriately. It is certainly there. That is the allegation. That allegation, my lord, has resulted in the registration of the crime against the petitioner under section 364 capital A, as well as of the IPC, as well as one under section 8 of the POCSO. Lord, I would like to request your lordship to kindly have a cursory look at section 2H of the CRPC for a second. That is investigation.
Yes.
Well, the object of investigation as mandated under section 2H is to collect evidence under the provisions of the code. Well, collection of evidence by the investigator is not either in support of the case of the complainant informant or in support of the defense of the accused. I'm sure your lordship would certainly agree with me on that issue. Well, the allegations that are made by the complainant in the complaint as the informant to the police on the basis of which the crime came to be registered is virtually put in test by the investigator during the course of the investigation. Whether is it true or false, is it acceptable or unacceptable? Well, that is the object or the purpose of investigation as mandated under section 2H of the CRPC. Well, your lordship, I recall to your lordship's memory, I submitted to your lordship right under the public gaze, this offense is said to have been committed. That is how, my lord, I made my submission. But according to the prosecution, operators and witnesses are examined in the course of the investigation of the crime, who are the one said to have witnessed this incident of inappropriate touch by the petitioner upon the victim. May I just request your lordship to kindly turn to my compilation, which I have given, convenience compilation of the statements of witnesses, which I have given. My lord, the offence is said to have taken place in the residential premises of the accused petitioner. Would your lordship kindly turn to page 31 of my convenience compilation, which I have filed. He is the first witness who was present or the place where the incident is said to have taken place, and at a point of time when the offence alleged against the petitioner is committed. This is the
Yes.
first statement of the witness. Kindly turn to page 31. That is Manoj. My lord, he is CW 13.
Yes.
My lord, would your lordship kindly turn to the last paragraph at page 31, at the bottom. ದಿನಾಂಕ 2/2/2024 ನಾನು ದೈನಂದಿನ ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾಗಿದ್ದೇನು. ಬೆಳಗ್ಗೆ ಸುಮಾರು 10:45 ಗಂಟೆಯಲ್ಲಿ ಸೋಂಡ್ಸೋರು ರೂಮಿನಿಂದ ಡೈನಿಂಗ್ ಟೇಬಲ್ಗೆ ಬಂದರು. ಆಗ ನಾನು ಅವರಿಗೆ ತಿಂಡಿಯನ್ನು ಕೊಟ್ಟಿರುತ್ತೇನೆ. My lord, I am taking your lordship to the statement because I have questioned the legality and correctness of the order of process, and I have also sought for the quashing of the entire charge sheet. That is why, my lord, I am taking your lordship here and there to the statement of the witnesses. ತಿಂಡಿ ಟೀ ಕುಡಿದು ಹಾಲ್ನಲ್ಲಿ ಕುಳಿತುಕೊಂಡರು. ನಾನು ನನ್ನ ಕೆಲಸವನ್ನು ಮಾಡುತ್ತಾ ಇದ್ದು ಸ್ವಲ್ಪ ಸಮಯದಲ್ಲಿ ಬೆಲ್ ಮಾಡಿದರು. ಆಗ ನಾನು ಹಾಲ್ಗೆ ಹೋಗಿ ನೋಡಿದಾಗ ಅಲ್ಲಿ 3 ಜನ ಗೆಸ್ಟ್ ಇದ್ದರು. ಅದರಲ್ಲಿ ಒಂದು ಗಂಡಸು, ಒಂದು ಹೆಂಗಸು, ಇನ್ನೊಬ್ಬ ಹುಡುಗಿ ಇದ್ದರು. ಅವರುಗಳು ಸೋಫಾ ಮೇಲೆ ಕುಳಿತುಕೊಂಡಿದ್ದರು. ಆಗ ಸಮಯ ಸುಮಾರು 11:30 11:45 ಗಂಟೆ ಸಮಯವಾಗಿತ್ತು. ಆಗ ಪಿಟಿಷನರ್ ನನಗೆ ಇವರಿಗೆ ಟೀ ತೆಗೆದುಕೊಂಡು ಬಾ ಎಂದರು. ನಾನು ಆಯಿತು ಎಂದು 3 ಜನಕ್ಕೆ ಟೀ ತೆಗೆದುಕೊಂಡು ಹೋಗಿ ಕೊಟ್ಟನು. ಅವರುಗಳು ಸುಮಾರು ಅರ್ಧ ಗಂಟೆಯವರೆಗೂ ಮಾತನಾಡುತ್ತಾ ಇದ್ದರು. ಅವರುಗಳು ಎದ್ದು ಹೋದ ನಂತರ ನಾನು ಟೀ ಕಪ್ಪುಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋಗಿ ಸಿಂಕಿನಲ್ಲಿ ತೊಳೆಯಲು ಇಟ್ಟೆನು. ಯಾರಾದರೂ ವಿಸಿಟರ್ಸ್ ಬಂದಾಗ ದೊಡ್ಡವರು ಟೀ ಕಾಫಿ ಕೊಡು ಎಂದು ತಿಳಿಸಿದರೆ ನಾನು ಅಥವಾ ಹನುಮಂತು ಯಾರಾದರೂ ಒಬ್ಬರು ಬಂದು ವಿಸಿಟರ್ಸ್ಗೆ ಟೀ ಮತ್ತು ಕಾಫಿಯನ್ನು ಕೊಡುತ್ತೇವೆ. ಕೈಂಡ್ಲಿ ಸ್ಕಿಪ್ ದಿ ರೆಸ್ಟ್ ಆಫ್ ದಿ ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ದೇರ್. Now kindly go to page 33. This would be very, very important. Actually, this is nothing but the further statement of the witness in the form of questionnaire and the answer which the witness would give to the investigator. It commences from page 33. May I request your lordship to kindly go to page 34.
Yes.
Question number 10. ಮಮತಾ ಸಿಂಗ್ ರವರ ಮಗಳು ಹಾಲಿನಲ್ಲಿ ಅಲ್ಲದೆ ಮನೆಯ ಬೇರೆ ಯಾವುದಾದರೂ ಕೋಣೆಗೆ ಟೀ ಕಪ್ ತೆಗೆದು ಅಥವಾ ರೂಮ್ಗೆ ಆ ದಿನ ಯಾರೊಟ್ಟಿಗಾದರೂ ಹೋಗಿದ್ದಾರಾ? 34 ಮೇಲೆ.
I am there.
Your lordship, I am sorry.
Yes.
ಮಮತಾ ಸಿಂಗ್ ರವರು ಮತ್ತು ಅವರ ಮಗಳು ಆ ದಿನ ಹಾಲ್ ಬಿಟ್ಟರೆ ಮನೆಯ ಒಳಗಿನ ಯಾವುದೇ ಕೋಣೆಗಳಿಗೆ ಹೋಗಿರುವುದಿಲ್ಲ. ಮಮತಾ ಸಿಂಗ್ ಮತ್ತು ಅವರ ಮಗಳು ಮತ್ತು ಶಿವಾನಂದ ತಗಡೂರವರು ಇವರೆಲ್ಲರೂ ಹಾಲಿನಲ್ಲಿ ಬಂದು ಕುಳಿತು ಸಮಯದಿಂದ ಹೋಗುವವರೆಗೂ ನಾನು ಕಣ್ಣಳತೆಯ ದೂರದಲ್ಲಿ ಇದ್ದು ನೋಡಿರುತ್ತೇನೆ. ಈ 3 ಜನ ಹಾಲ್ ಬಿಟ್ಟು ಮನೆಯ ಒಳಗಿನ ಯಾವುದೇ ಕೋಣೆಗಳಿಗೆ ಹೋಗಿರುವುದಿಲ್ಲ. ಸಾಹೇಬರಿಗೆ 82 ವರ್ಷ ವಯಸ್ಸಾಗಿದ್ದು ಅವರಿಗೆ ಕೈಗಳು ತುಂಬ ನಡುಗುತ್ತದೆ. ಅವರಿಗೆ ಲೈಟ್ ಅಂಡ್ ಫ್ಯಾನ್ ಸ್ವಿಚ್ಗಳೆಲ್ಲ ಡೈನಿಂಗ್ ಹಾಲ್ ಅಥವಾ ಇರುವುದಕ್ಕೆ ಜಾಗಕ್ಕೆ ಕೋಣೆಗೆ ಹೋಗಬೇಕಾದಲ್ಲಿ ನನಗೆ ಮೊದಲಿಗೆ ಕರೆದು ಲೈಟ್ ಮತ್ತು ಫ್ಯಾನ್ಗಳನ್ನು ಹಾಕುವಂತೆ ಹೇಳುತ್ತಾರೆ. ಆ ದಿನ ನನಗೆ ಯಾವುದೇ ಕೋಣೆಯ ಮೀಟಿಂಗ್ ಹಾಲ್, ಡೈನಿಂಗ್ ಹಾಲ್, ಲೈಟು, ಫ್ಯಾನುಗಳನ್ನು ಹಾಕಲು ಹೇಳುವುದಿಲ್ಲ. ಮತ್ತು ಸಾಹೇಬರು ವಯಸ್ಸಾದ್ದರಿಂದ ಅಂಗರಕ್ಷಕರು ಯಾವಾಗಲೂ ಸಾಹೇಬರು ಯಾವ ಕೋಣೆಗೆ ಹೋದರೂ ಅವರ ಕಣ್ಣಳತೆಯಲ್ಲಿಯೇ ಇರುತ್ತಾರೆ. ಹೀಗಾಗಿ ಆ ದಿನ ಸಾಹೇಬರು ಮಮತಾ ಸಿಂಗ್ ಅವರ ಮಗಳನ್ನು ಡೈನಿಂಗ್ ಹಾಲ್ ಬಿಟ್ಟು ಇನ್ಯಾವ ಕೋಣೆಗೂ ಸಹ ಕರೆದುಕೊಂಡು ಹೋಗಿರುವುದಿಲ್ಲ. ಅಂದು ಮಮತಾ ಸಿಂಗ್ ಮತ್ತು ಅವರ ಮಗಳನ್ನು ಹಾಲಿನಲ್ಲಿ ಮಾತನಾಡಿಸಿ ಕಳಿಸಿರುತ್ತಾರೆ. Question number 11.
Hmm.
My lord, your lordship may recall to your lordship's memory, I submitted to your lordship the other day that this incident of inappropriate touch does not take place in the hall. According to the prosecution, this victim was led to a room that is attached to the hall, and thereafter it came to be bolted from inside, and it was at that point of time this inappropriate touch is said to have been made by the petitioner upon the person of the victim. Now, kindly go to question number 11 now. ನೀವು ಮಮತಾ ಸಿಂಗ್ ಮತ್ತು ಅವರ ಮಗಳು ಸೋ ಮನೆಗೆ ಬಂದು ಹೋಗುವವರೆಗೂ ನೀವು ಎಲ್ಲಿದ್ದೀರಿ, ಅವರು ಮಾತನಾಡುವುದನ್ನು ನೀವು ನೋಡಿದ್ದೀರಾ? ಮಮತಾ ಸಿಂಗ್ ರವರು ಮತ್ತು ಅವರ ಮಗಳು ಆ ದಿನ ಬಂದು ಹೋಗುವವರೆಗೂ ಅವರ ಕಣ್ಣಳತೆಯಲ್ಲಿಯೇ ಇದೆ. ಸಾಹೇಬರು ಬೆಲ್ ಮಾಡಿದಾಗ ಹಾಲ್ಗೆ ಸಾಹೇಬರು ಮುಂದೆ ಹೋದಾಗ ಎಲ್ಲರಿಗೂ ಟೀ ತರಲು ತಿಳಿಸಿದ್ದರು. ಟೀ ತಂದು ಕೊಟ್ಟು ಹಾಲ್ಗೆ ಹೊಂದಿಕೊಂಡಿರುವ ಪ್ಯಾಸೇಜ್ನಲ್ಲಿಯೇ ನಿಂತಿದ್ದೆ. ಮಮತಾ ಸಿಂಗ್ ರವರ ಮಗಳು ಹೋದ ನಂತರ ಟೀ ಕಪ್ಪುಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಬಂದೆ. ನಂತರ ಶಿವಾನಂದ ತಗಡೂರವರು ಇನ್ವಿಟೇಷನ್ ಕೊಡುತ್ತಾ ಇದ್ದರು. ಕೈಂಡ್ಲಿ ಪಾಸ್ ಫಾರ್ ಅ ಮಿನಿಟ್ ಅಂಡ್ ಮಾರ್ಕ್ ದಿಸ್ ಮೈ ಲಾರ್ಡ್. ಶಿವಾನಂದ ತಗಡೂರವರು, my lord, even in question number 10, your lordship would get in the third line, ಮಮತಾ ಸಿಂಗ್ ಅವರು ಮತ್ತು ಅವರ ಮಗಳು ಆ ದಿನ ಹಾಲ್ ಬಿಟ್ಟರೆ ಮನೆಯ ಒಳಗಿನ ಯಾವುದೇ ಕೋಣೆಗಳಿಗೆ ಹೋಗಿರುವುದಿಲ್ಲ. ಮಮತಾ ಸಿಂಗ್ ಮತ್ತು ಅವರ ಮಗಳು ಮತ್ತು ಶಿವಾನಂದ ತಗಡೂರವರು ಇವರೆಲ್ಲರೂ ಸಹ ಹಾಲಿನಲ್ಲಿ ಬಲ್ತು ಕುಳಿತಿದ್ದರು. My lord, he would clearly, categorically makes a mention of the presence of one Shivananda Tagadur, not only while answering question number 10, but also while answering question number 11. Well, this Shivananda Tagadur is none other than the president of the Working Journalists Association, who had come there on that day at that point of time for the purpose of extending an invitation to the petitioner. But I shall deal with it little later. Kindly mark this, about the presence of Shivananda Tagadur. ಅವರು ಹೊರಡಲು ನಿಂತ ಸಮಯಕ್ಕೆ ಪರಮಶಿವಯ್ಯನವರು ಸಹ ಬಂದರು. Another witness enters into that place. ಅವರ ಜೊತೆ 2-3 ಜನ ಬಂದಿದ್ದರು. ಸಾಹೇಬರು ಬೆಲ್ ಅವರಿಗೂ ಸಹ ಟೀ ಕೊಡಲು ಹೇಳಿದರು. ಅವರಿಗೂ ಸಹ ಟೀ ಕೊಟ್ಟು ಹಾಲಿಗೆ ಹೊಂದಿಕೊಂಡಿರುವ ಪ್ಯಾಸೇಜ್ನಲ್ಲಿ ನಿಂತೆ. ಅವರು ಹೋದ ನಂತರ ಟೀ ಕಪ್ ತೆಗೆದುಕೊಂಡು ಹೋಗುವ ಮತ್ತೆ ಮಮತಾ ಸಿಂಗ್ ರವರ ಮಗಳು ಮತ್ತು ಹಾಲ್ ಒಳಗೆ ಬಂದಿದ್ದು ಮತ್ತು ಟೀ ಕಪ್ ಇಟ್ಟು ಕಣ್ಣಳತೆಯಿಂದ ದೂರದಲ್ಲಿ ನಿಂತಿದ್ದಾಗ ಮತ್ತು ಮಮತಾ ಸಿಂಗ್ ರವರು ಸಿಟ್ಟೆಂದು ಹೇಳಿದ್ದು ಕೇಳಿಸಿತು. ನಂತರ ಮಮತಾ ಸಿಂಗ್ ಮತ್ತು ಅವರ ಮಗಳು ಮಾತನಾಡಿ ಹೋದರು. ನಾವು ಕೈಂಡ್ಲಿ ಕೊಟ್ಟು ಕ್ವಶನ್ ನಂಬರ್ 12. ಮಮತಾ ಸಿಂಗ್ ಮತ್ತು ಅವರ ಮಗಳು ಸುಮಾರು ಎಷ್ಟು ಗಂಟೆಗೆ ಪಿಟಿಷನರ್ ಮನೆಯಿಂದ ಹೊರಟರು? ಅವರು ಹೋದ ನಂತರ ಬೇರೆ ಯಾರಾದರೂ ಅವರ ಮನೆಗೆ ಬಂದಿದ್ದಾರಾ? ಮಮತಾ ಸಿಂಗ್ ಮತ್ತು ಅವರ ಮಗಳು ಅಂದು ಮೊದಲ ಬಾರಿಗೆ ಬಂದಾಗ 11:15 ಗಂಟೆ ಸಮಯವಾಗಿತ್ತು. ಸುಮಾರು 30 ನಿಮಿಷ ಇದ್ದು ನಂತರ ಅಲ್ಲಿಯೇ ಇದ್ದ ಶಿವಾನಂದ ತಗಡೂರವರು ಇನ್ವಿಟೇಷನ್ ಕೊಟ್ಟು ಹೊರಡುವಾಗ ಪರಮಶಿವಯ್ಯನವರು 2-3 ಜೊತೆ ಬಂದಿದ್ದರು. ನಂತರ ಪರಮಶಿವಯ್ಯ ಹೊರಗೆ ಹೋದಾಗ ಮತ್ತು ಮಮತಾ ಸಿಂಗ್ ಮತ್ತು ಅವರ ಮಗಳು ಬಂದರು. ಸುಮಾರು 15 ನಿಮಿಷ ಮಾತನಾಡಿಕೊಂಡು ಅವರು ಸಹ ಹೋದರು. ಈ ಮಧ್ಯೆ ಡಾಕ್ಟರ್ ನೀರಜ್ ಸಾಹೇಬರಿಗೆ ಇಂಜೆಕ್ಷನ್ ಕೊಡಲು ಬಂದಿದ್ದರು. ಅವರನ್ನು ಹಾಲಿಗೆ ಹೊಂದಿಕೊಂಡಿರುವ ಪ್ಯಾಸೆಯಲ್ಲಿ ಕೂರಿಸಿದೆ. ಮಮತಾ ಸಿಂಗ್ ಮತ್ತು ಅವರ ಮಗಳು ಶಿವಾನಂದ ತಗಡೂರ್, ಪರಮಶಿವಯ್ಯ ಅವರ ಜೊತೆ ಬಂದಿದ್ದವರು ಹಾಲಿನಲ್ಲಿ ಭೇಟಿ ಮಾಡಿದ್ದರು. ಬಟ್ ನಾವು ಕೈಂಡ್ಲಿ ರೀಡ್ ದಿಸ್ ಎಂಡ್. ಮಮತಾ ಸಿಂಗ್ ಮತ್ತು ಅವರ ಮಗಳು ಮತ್ತೆ ಏನಾದರೂ ಆ ದಿನ ಅರ್ಜಿದಾರರ ಮನೆಗೆ ಸುಮಾರು ಎಷ್ಟು ಸಮಯ ಅಲ್ಲಿದ್ದರು, ಹಾಲು ಬಂದಿದ್ರು?
Statement of the victim is recorded.
Yes, my lord.
Where is that?
Yes, that your lordship, I have produced it. Well, I submitted to your lordship in a nutshell in one sentence. Yes, she would say that.
She has said so.
She has said it. Well, that is put to the test. That is how I said it. The investigator would record the statements of 6 persons who were there on that day. Each one, every one of them would say in one voice, in unequivocal terms, nothing happened on that day. Well, if
164 statement.
All right.
208.
Unkilled. I'll take it. Yes.
Well, if the statement of the witness alone is to be taken to its face value as gospel truth, it is no investigation at all. The investigator need not record anyone else's statement, nor collect any other documentary or any other evidence whatsoever, and proceed to file a charge sheet. Accept it and be done with it. That is not investigation. That is how, my lord, I submitted to your lordship in the beginning of my submissions, that investigation is collection of evidence. Evidence means it may inure to the benefit of the prosecution or it may inure to the benefit of the defense. But that is how, my lord, I submitted to your lordship. Now kindly see this. ಮಮತಾ ಸಿಂಗ್ ಅವರು ಒಟ್ಟು 2 ಬಾರಿ ಬಂದಿದ್ದರು. ಮೊದಲಿಗೆ 11:15 ನಂತರ ಬಂದಿದ್ದರು. ಬಂದು ಸಾಹೇಬರ ಬಳಿ ಮಾತನಾಡಿ ಟೀ ಕುಡಿದು ಹೋದರು. ನಂತರ ಶಿವಾನಂದ ತಗಳೂನವರು ಮಾತನಾಡಿ ಇನ್ವಿಟೇಷನ್ ಸಾಹೇಬರಿಗೆ ನೀಡಿ ಹೋದರು. ಸಮಯಕ್ಕೆ ಪರಮಶಿವೇಂದ್ರ ಎಕ್ಸೆಟ್ರಾ ಅವರು ಬಂದರು. ನೋ ಮೈ ಲಾರ್ಡ್, ಕೈಂಡ್ಲಿ ಗೋ ಟು page 39. Last question. And I think I took your lordship to question number 10, continuation at page 35. I don't know. I forgot.
ಮುಂದುವರೆದಿದೆ ನೋಡಿದೆ.
ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ ಸಾಹೇಬರು ವಯಸ್ಸಾದ್ರಿಂದ ಅಂಗರಕ್ಷಕರು ಯಾವಾಗಲೂ ಎಕ್ಸೆಟ್ರಾ ಸಾಹೇಬರು ಮಮತಾ ಮಗಳನ್ನು ಹಾಲ್ ಬಿಟ್ಟು, ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ ದಿಸ್, ಹಾಲ್ ಬಿಟ್ಟು ಇನ್ಯಾವ ಕೋಣೆಗೂ ಕರೆದುಕೊಂಡು ಹೋಗಿರುವುದಿಲ್ಲ. ಕ್ವಶನ್ ನಂಬರ್ 10 is the answer. ಅಂದು ಮಮತಾ ಸಿಂಗ್ ಮತ್ತು ಅವರ ಮಗಳನ್ನು ಹಾಲಿನಲ್ಲೇ ಮಾತನಾಡಿಸಿ ಕಳುಹಿಸಿಕೊಡಲಾಗಿತ್ತು. Well, that was the evidence of this witness. This statement is recorded by the investigator. It is the evidence that is brought on record in the case in the form of statement of Manoj, presumably in support of the case of the prosecution.
These are statements recorded by the IO.
IO, my lord. I shall take your lordship one statement after the other.
Yes.
Now kindly go to the statement of CW12, Anandaradya.
Now charge sheet is filed.
Charge sheet is filed.
How does this statement?
It has not been referred to at all. In fact, your lordship, I recall to your lordship's memory, I invited my lord's kind attention the other day to the order of cognizance and issuance of process. Nothing. Perus. But one statement after the other statement I shall show to your lordship now. But unfortunately, this witness CW13 Manoj would speak about the presence of the president of the Working Journalists Association who had gone there on that day at that time for the purpose of extending the invitation to the petitioner. He was present all through. It is only after these two, mother and daughter, leaving the place.
These are 161 statements.
Yes, my lord. These are all 161 statements with the investigator would record. But the Special Investigating Agency, CID.
That's all right. The victim statement is recorded on a higher pedestal before the court under 164.
Well, it is at par with 161 statement.
It's
Beyond that,
little
beyond that,
higher pedestal, little higher pedestal.
What the Supreme Court has
But
said,
when you pit 161 against
in a
164,
higher pedestal, your lordship.
No. when you pit 161 against 164, what would prevail? None or some?
Well, your lordship may take it, it prevails. I am making a submission, my lord, 161 prevails. I am not for a moment saying, my lord, there are contradictions between 161 statement and 164 statement. My respectful submission to your lordship is that they are at par with each other. The only object or the purpose for which the statement recorded in section 164 could be made use of is for the purpose of prosecution of the person who has made the statement under section 164 for perjury in the event of that witness or the person who made the statement not towing the line that is suggested to him or her by the prosecution. That's it. But I am making a submission, proceed with an assumption that the victim has made such a statement. Well, that statement is put into test by the investigator and he would collect evidence where it is true or false, where it is acceptable or unacceptable. If my lord were to read the statement of Manoj, CW13.
These are statement recorded by the IO.
Yes.
Question and answers by the IO. Should it not be tested in evidence before in the trial, whether they are correct or not? Because there is victim statement under 164 saying that this incident has happened. These people say the incident has not happened. If you
But this has remained on record as unrebutted evidence. at this point of time.
Unrebutted evidence where? Trial
No,
ಆಗಿಲ್ವಲ್ಲ?
at this point of time, either for the purpose of framing charges.
The
how
charges
are to
are-
read the
charges-
state-
charges are framed, not yet.
ಇಲ್ಲ ಅಲ್ಲ ನಾನು ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತಂದ್ರೆ either for the purpose of framing charges or for the purpose of taking cognizance of the offense and ordering process against the
Taking
accused.
cognizance of the offense, the court ought to have noticed everything and
It has not noticed.
recorded and taken cognizance. But that is one thing to say. It is another thing that a court exercising jurisdiction under 482 would look into these statements and ignore the statement of the victim under 164. Believe these statements
But
under
what-
161.
No.
And
The
enter into
combined
an
reading is
opinion.
necessary.
The combined reading is
A
necessary.
combined reading is one statement of the victim. As against that, well, this is also a statement. As against that, my lord, the statements of half a dozen witnesses.
No, it may outweigh, that's a different thing, but they are recorded in different provisions of law before different persons.
So-
One is before the IO, one is before the magistrate.
So a solitary statement, that is put into test, my lord. That is investigation. Otherwise, where is the question of investigation at all?
Where it is to be decided in a trial.
No, certainly not.
How
But
can I
this
inform you to
is,
say whatever
no, I am
this
developing.
person who has said accused number, CW 12, before the investigating officer is correct, what the victim has said is wrong, I'll take it as gospel truth.
But what I am submitting to your lordship is accept all the statements to its face value as true at this point of time as unrebutted evidence for the purpose of taking cognizance and issuance of process.
Cognizance issuance of process, yes, it should bear application of.
Should we not advert to all these things?
That, but washing the entire proceedings
No,
of
no,
the complaint or either.
My lord, for the purpose of setting at naught, my lord, the order of cognizance and issuance of process.
That's all right.
No. The other day, I invited my lord's attention to the entire order which can be passed by the learned judge and my lord commencing from
That I may consider,
GHCL.
but taking this statement as correct and quashing the entire proceedings,
How does I say it is wrong?
it should be put to, how do you say the victim statement is wrong?
Quite right. That is actually, my lord.
This is why.
There are half a dozen statements against one solitary statement. Then where is the question of investigation then?
Sir,
What is
Half a
investigation?
dozen statements of others.
How?
A statement of the victim who has suffered that.
That alone is sufficient?
No, it's a trial. It's a matter of trial for,
My lord,
for quashing, that is not, sir.
that is exactly my submission, my lord. If the evidence that is collected by the investigator, that is also brought on record in the case, on which statements or on whose statements the investigator is placing reliance and the prosecution is placing reliance, is in total contradiction or would indicate that what the victim has said cannot be accepted, but the proceedings have got to be quashed. That is the law laid down by the Supreme Court. I shall place those judgments, my lord, for my lord's kind consideration.
Alright.
After taking your lordship to one statement after the other, not one, half a dozen. Well, now the next statement is, kindly go to the statement of Ananda Aradhya, TW 12, which my lord gets at page 24. My lord, if a solitary statement of the victim could be accepted to its face value as true for the purpose of issuance of process, my lord, where is the question of investigation then?
Issuance of process is one thing. Quashing the entire proceedings is another thing. Quashing the entire proceedings relying on these statements under 482, I'm afraid.
My lord, if the statements, we don't say it is statements, I would say, my lord, this is the evidence which the investigator has collected.
Investigator has
If that
collected-
evidence,
It is not the evidence before the court.
my lord,
The evidence which the investigator has collected. it
this is
the
also,
evidence
this is
which
also, my lord, not in evidence before the court.
That is,
What the
nothing
victim
is
has said.
evidence. Victim is
What the victim has said is also not
not
evidence.
before, I am
My
not
lord,
saying.
evidence commences only after
God,
framing of
I am
charges.
Correct. All these statements are to be put after the framing of charges. 164 statement is not gospel truth. 161 statement is not gospel truth. We will be statements versus statements, but that has to be tried. Now, quashing the entire proceedings based upon 161 and 164 is not available is my prima facie view, unless you convince me otherwise.
I will do it. I
Yes.
will certainly.
That's what is running in my mind.
No, having understood your lordship's
Yes. that's
mind, my lord, I will certainly satisfy your lordships. First, I shall take your lordship to the evidence.
Cognizance order, yes, it is unreasoned, absolutely. That last time you showed.
No, I
that
said I don't want my lord, that order to be set at naught and the matter to be remitted back for fresh consideration at the hands of the trial court. No, that is how, my lord, I submitted.
So you should
My
not,
endeavor before your lordship is
you
for the
should now
quashing.
convince me as to how
I'll do.
I can, relying on these statements of 161 and 164, set the entire thing at naught.
I will do it. I shall do it. If that is a doubt which my lord has been entertaining, I shall certainly try my best to satisfy.
ಒಂದು ಜಡ್ಮೆಂಟ್ ಕೊಟ್ಬಿಡಿ.
ಕೊಡ್ತೀನಿ.
161 ಸ್ಟೇಟ್ಮೆಂಟ್ 164 ರಿಲೈ ಆಗಿ ಕ್ವಾಶ್ ಮಾಡಬಹುದು.
ಕೊಡ್ತೀನಿ.
Without putting them on trial. See, there are many cases frivolous. This is a case of POCSO.
Really?
The victim under 164 says, yes, there has been inappropriate touch. But we are not concerned about the age, whether he can or not or whatever. It is only a touch here.
But if the evidence brought on record in the case indicate that the victim was not taken to the place of offense at all.
No, those.
Well, kindly imagine the situation. The offense is said to have taken place, but in the room, which came to be bolted from inside after taking the victim to the room. But the evidence on record do demonstrably indicate that the victim was not taken to the place of offense at all.
Evidence by whom?
Evidence by the witnesses
By
whom the investigator
witnesses.
examined.
Witnesses. Should not those witnesses be cross-examined?
But she should also be
How-
cross-examined.
Yes, very
then.
much.
She should also be
She should also be
No, no,
cross-examined.
here my lord, kindly see, if that is the gospel truth, this would indicate that what she is saying is wholly incorrect and it is not true at all.
Either of the thing becomes gospel truth unless they are put in evidence and tried.
Then in
before
no
the court.
case, my lord, the proceedings could be quashed.
No, not on the basis of statements. Sir, there are scores of cases which I quash every day. The moment we see it, it's a frivolous case. Civil cases given a color of crime, then promise of marriage entering it, then rape. All these cases straight away we quash. Here there is a victim under 160, it's a POCSO case. Victim under 164 comes and deposes, comes and tells the magistrate that he has touched me.
That is sufficient for issuance of process?
Process
Well,
ಹೇಳಿ.
when
You
the-
are- if you are
plenty
restricting
of
your sub-
evidence is-
Sir,
when the
if you are
plenty of evidence
restricting
is
your sub-
available on record in the
If
case.
you are restricting your submission to issuance of process, fine. But if you want quashment of the entire proceedings, I told you I'm afraid. Yes.
No. But, we will examine, certainly I will examine it
If
and.
you should strengthen the submission with lot of judgments.
Certainly,
Yes,
I will. say.
that you will do, sir. But
Certainly I will.
what is running in my mind ಅಂತ ಹೇಳಿ.
Certainly, my lord, I am here to clarify your lordships or explain your lordship's doubt to my advantage. No, my lord, kindly go to now. Cerebral, Anandaradya, each and every witness.
Who are all? Who are they all?
Well, I submitted to lordship one person who had come there to extend the invitation, who is none other than the president of the Working Journalists Association.
He also tenders evidence.
But let me tell your lordship one thing. Your lordship, I recall to your lordship's memory in the application which came to be filed by the investigator before the magistrate, seeking for an order under section 73 of the code.
Yes.
He would make a mention of he having recorded the statement of
That Tavdur.
Tagadur. Well, my lord, I think I need
Yeah,
not
that
take your
last time
lordship,
ತೋರ್ಸಿದೆ.
lordship very caught your unfair investigation. I am just inviting my lord's attention. This Tagadur statement is recorded. That is how the investigator would say. Kindly secure the record of the case. Tagadur statement is not brought on record in the case at all. Number one. Number two, this Tagadur has not even been cited as a witness in the charge sheet. Why? Because my lord posed a question to me, who is he? What is his status and all that?
No, is he given evidence, has he given evidence before the IO?
Yes, my lord.
Statement in your favor or against you?
I don't know. How do I know?
ಅಲ್ಲ ಇಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಇಲ್ವಾ ಈಗ?
ಹಾಗೆ ಇಲ್ಲ, ಅವ್ನು ವಿಟ್ನೆಸ್ ಮಾಡಿಲ್ಲ. Lord, may I just request your lordship to kindly turn to page 125. ಅಲ್ಲ ಇದೆಲ್ಲ ಅನ್ಯಾಯ.
ನಿಜ.
ಮಾಡ್ಲಿ.
ಬಟ್
ಅಲ್ಲ ಅವನು ಏನ್ ಹೇಳಿದಾನೆ ಮಾಡಿದಾನೆ ತಾವು ನೋಡ್ಲಿ.
ತೀರ್ಮಾನ ಆಗ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ ತಾವು ನೋಡ್ಲಿ, ನಂದೇನ್ ತೊಂದರೆ ಇಲ್ಲ. May I request your lordship to kindly turn to.
Now these statements of witnesses.
ಎಲ್ಲರೂ
ಅಲ್ಲ.
ಎಲ್ಲರೂ ಒಂದೊಂದಾಗಿ ತೋರಿಸ್ತೀನಿ ಯಾರ್ಯಾರ್ದಿಲ್ಲ ಅಂತ.
Are there any independent witnesses?
Yes, my lord, they are all independent witnesses.
ಅಲ್ಲ ಇವ್ರು ಯಾರೋ ಮನೇಲಿ ಕೆಲಸ ಮಾಡೋರು ಅಂತ ಹೇಳಿದ್ರೆ.
I'm sorry.
CW12 is the one who is working in the house.
ಹೌದು.
ಹಾ.
Next 12 ಗನ್ಮನ್.
ಗನ್ಮ್ಯಾನ್. ಆಮೇಲೆ ಅದರ್ ದನ್ ದಟ್ ಬೇರೆ ಯಾರಾದ್ರು?
ತಗಡೂರು.
ಅದು ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರಿ?
ಮಾಡಿದ್ದಾರೆ.
Not a part of the charge sheet. Not a part of the charge sheet.
They have recorded the statement of Tagadur May I request your lordship to kindly go to page 123 for a second. Kindly go to page 125. Why did they suppress this?
ದಿನಾಂಕ 6/4/24.
ಹೌದು.
ಹಾ
6/4/24 ಸಾಕ್ಷಿದಾರದ ಶಿವಾನಂದ ತಗಡೂರ್ ಮಹೇಶ್ ಕುಮಾರ್ ಅವರನ್ನು ವಿಚಾರಣೆ ಮಾಡಿ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತದೆ. They have recorded the statement. That statement which they have recorded does not form part of the record of the case at all.
It formed a part of the 73 application.
He forms part of the 73 application. He does not figure as a prosecution witness. Mahesh Kumar also does not figure as a prosecution witness. His statement is also not brought on record in the case. Why? Probably this would answer your lordship's doubt. Who are the other independent witnesses who were there? Your lordship may secure the record. Have a look at it.
No, records will be secured, that's all right. Charge sheet file ಮಾಡಿದಾರಲ್ಲ, charge sheet material ಎಲ್ಲಿದೆ?
Charge sheet ಹಾಕಿದ್ದಾರೆ. I don't know whether
ಎಲ್ಲ ಹಾಕಿದಿರಲ್ಲ?
Entire charge, all the volumes, sir.
ಏನು ತಗಡೂರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಓದ್ಬಿಡ್ಲಿ ನೋಡೋಣ.
ಅಲ್ಲ ಅದಿಲ್ಲ, ಬೇರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಅದು ಸರಿ.
ಏನೇನಿದೆ ಎಲ್ಲ ಇದೆ ಅಂತ.
ಅಲ್ಲ ಇದೆಲ್ಲ ಬಿಟ್ಬಿಟ್ಟು ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ ಇದು.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ ಇದು.
Yes sir.
Well, now
ಅಲ್ಲ ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಕೊಟ್ಟಿದ್ಯಾ ಅಂತ ಜಸ್ಟ್
ಅದು ಗೊತ್ತಿಲ್ಲ. ಇದು 2 ವಾಲ್ಯೂಮ್ ಇದೆ, ಅದೇನಾ ಇದು? Is this the one?
ನಾವು ಕೊಟ್ಟಿರೋದು.
ಮತ್ತೆ ನಮ್ಮ ಕೋರ್ಟ್ ಕೊಟ್ಟೇ ಇಲ್ಲ.
ಸರ್ ಅದಲ್ಲ ಸಾಹೇಬ್ರು ಕೇಳ್ತಾ ಇರೋದು.
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಕಂಪ್ಲೀಟ್ ಮೆಟೀರಿಯಲ್
ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲ ಸರ್.
ಅಲ್ಲ ಸ್ಟೇಟ್ಮೆಂಟ್
ಕೊಡಿ ಫಾರ್ ಎ ಸೆಕೆಂಡ್ ನೋಡೋಣ.
6/4/24 ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆಯಾ?
ಕೊಡಿ.
ತೌಡೂರ್ದು
ಕೊಡಿ, ದಯಮಾಡಿ ಕೊಡಿ.
ನೀವು ಮುಂದುವರಿಸಿ.
ಅಲ್ಲ ಅವ್ರು ಬಹಳ
ಕೊಡ್ಲಿ, ನೀವು
ಮುಂದುವರಿಸ್ಕೊಂಡ್ರು ಪರವಾಗಿಲ್ಲ, ನನಗೇನು ತೊಂದರೆ ಇಲ್ಲ.
ಅಲ್ಲ ಪರವಾಗಿಲ್ಲ, ನೀವು ಮುಂದುವರಿಸ್ತಾರೆ, ನಾನು ತಗೊಂತೀನಿ. ಎಸ್ ಸರ್.
So my lord, independent statements of independent witnesses. I read to your lordship the statement of Manoj. That would indicate, my lord, the presence of Tagore on that day at that time. He is the one who would leave the place sometime after the mother and the daughter left the place. Certainly he would have been the best witness, the prosecution. It is on his statement also the prosecution has got to place reliance. That is the investigation. Why did they suppress it? But in the charge sheet that is given to me, the copy of the charge sheet that is given to me, his statement does not find a place at all. Your lordship may take it from me. Number one. Number two, he is not even cited as a witness on behalf of the prosecution. Now kindly go to the next statement. That is Ananda Radhya, who is examined as CW 12.
Who is he?
I shall take your lordship. But page 24.
Who is he?
He is a CAR constable.
Constable attached to the
CAR. ಹೌದು. ಈ ಸರ್ಕಾರದವ್ರು, ನಮ್ಮ ಸರ್ಕಾರದ ಅಲ್ಲ. ಈ ಸರ್ಕಾರದವ್ರನ್ನ ಡೆಪ್ಯೂಟ್ ಮಾಡೋದು ಅವರು. For my security, the present dispensation has deputed him. He is a policeman attached to the police department of the state of Karnataka. He was the one who was deputed for my security. May I request your lordship to kindly go to page 25 for a second.
How was he inside the house? How was he inside the house?
Security. ನಮ್ ಜೊತೆನೆ ಇರ್ಲೇಬೇಕು ಅವ್ನು, ಬೇರೆ ಯಾರು ಬಂದು.
Gunman is different. Who stays?
ಇವನೇ ಗನ್ಮನ್. ಸೆಕ್ಯೂರಿಟಿನೇ
He is the gunman.
ಸೆಕ್ಯೂರಿಟಿ ಅವನು ಹೋಗಿಲ್ಲ ಬೇರೆ ಕಡೆ.
ಅಲ್ಲ ಆತರ ಮನೆ ಒಳಗೆ ಇರಲ್ವಲ್ಲ.
ಮನೆ ಒಳಗಡೆ ಇರೋದು.
ಹೌದಾ?
ನಾವ್ ಎಲ್ಲಿದ್ರೆ ಅವನಲ್ಲಿ ಇರ್ಬೇಕು. ಜನ ಬರ್ತಾರಲ್ಲ ಹಾಲಲ್ಲಿ, ಹೋಗ್ತಾರೆ ಬರ್ತಾರೆ.
ನಮ್ಮ ಹತ್ರ ಯಾರು ಇರೋದೇ ಇಲ್ಲ ಈಗ ಅದಕ್ಕೆ.
ಅಲ್ಲ ಆಕ್ಚುಲಿ ಅಲ್ಲ, ತಮ್ಮಂತವ್ರು ಸೆಕ್ಯೂರಿಟಿ ರಿಸ್ಕ್ ಯಾವ್ದು ಇರೋದೇ, ಸೆಕ್ಯೂರಿಟಿ ಬೇಕಾಗೇ ಇಲ್ಲ ತಮಗೆ. ಈ ರಾಜಕೀಯದವ್ರಿಗೆ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಸೆಕ್ಯೂರಿಟಿ ಬೇಕಾಗುತ್ತೆ, ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ.
No, why was the gunman inside the house?
ಹೌದು, ಇರೋದೇ ಅಲ್ಲಿ ಮನೆಯಲ್ಲಿ.
Yes, all right.
ಎವಿಡೆನ್ಸ್
ಅವ್ನ ಕೆಲಸನೇ ಅದು. Why did you examine then? Arre, you can't have the cake and eat it too. You have examined him. You have cited him as a
ಯಾಕೆ examine
prosecution
ಮಾಡ್ಬೇಕಾಗಿ?
witness. Now you want to dub him as
Why-
a witness.
Why
because
did you examine the gunman?
ಅದ್ ಮಾಡ್ಲೇಬಾರ್ದಾಗಿತ್ತು ಅವರು. Why did you examine?
Yes.
Having examined, you have got to accept it. That is the statement or the evidence which the gunman would give before the
But
investigation.
whether these statements can form a part of a quashment proceedings under 482, that instead of reading the statements, ನೀವು ಅದು ತೋರಿಸ್ಬಿಟ್ರೆ ಸಾಕು.
ತೋರಿಸ್ತೀನಿ. ಅಲ್ಲ ಯಾರ್ಯಾರು ಏನೇನು ಹೇಳಿದಾರೆ ತೋರಿಸ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ ಎಲ್ಲ ನಿಮ್ ಫೇವರ್ ಇದಾನೆ ಅಂತ
ಎಲ್ಲರೂ ಇದ್ದಾರೆ
all,
except in this lady.
all witnesses state in your favor, victim states her version, or there is any witness again stating against you. They are witness versus witness, statement versus statements. Can that form a part of quashment proceedings under 482? At the initial stage itself, recording witness, these witnesses do not inspire confidence of this court, so I quash it. It's a little difficult.
No, pardon. You'll examine it.
That's the only thing.
ಮಾಡ್ತೀನಿ. I shall put my best efforts. Try to lay
Best
my
effort
hands.
ಬೇಡ ನನಗೆ, effort ಸಾಕು.
Try to lay my hands.
That's
Having
what-
understood
because
the-
there are 2-3 judgments of the apex court, Rajiv Kaurav and others, which say, relying on a 161 statement, the court should not quash proceedings under section 482 unless it finds that it is frivolous or the matter goes at the stage of charge sheet. You have the evidence while after the charge sheet and other things before the framing of charges. Those are the areas. That's what I feel. Yes.
I certainly try to satisfy your lordship's.
Because the whole problem here is victim statement under 160.
ಅಲ್ಲ ನನ್ನ ಪ್ರಕಾರ ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. ಅದು 161 ಇದು 161 164 my lord.
No, it's a different provision, that's all.
ಅಷ್ಟೇ.
And a forum.
That's
See,
it.
161 statements are disbelieved for the reason that it is taken by the police. By what method, you don't know.
ಅಷ್ಟೇ.
164 is on a higher pedestal because it is
Yeah.
before the magistrate.
But as far as the evidentiary value is concerned, they are at par with each other. That is what the Supreme Court has said.
That's way back in 1970.
That is what, but why the Supreme Court would say is, when once the victim or the witness is taken before the magistrate for the purpose of recording the statement under 164, is tomorrow if that witness does not propose or choose to support the case of the prosecution in the manner it has been projected in the statement.
In under 161.
161.
So 164 will come into.
164 will come into place.
Because cannot wriggle out of a statement. in
Yes,
164.
because that is a statement that is recorded
On
by the
oath.
magistrate on oath.
Oath.
Oath. Then my lord, prosecute the witness for perjury. ಈಗ ಅಪ್ಲೇಟ್ ಏನಾಗ್ತಾ ಇದೆ ಅಂದ್ರೆ ಅದನ್ನು ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ, ಪರ್ಜುರಿ ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡಕ್ಕೂ ಆಗೋದಿಲ್ಲ. ಲೂಪ್ ಹೋಲ್ಸ್ ಏನು ಅಂತಂದ್ರೆ ಇಟ್ ಇಸ್ ಫಾರ್ ದಿಸ್ ರೀಸನ್ ಮೇಲೆ we put it to your lordship. How your lordship would say it is a different thing. Well, my statement before the magistrate under 164 on oath is there. He has recorded it. But the witness, in the event of he making a statement during the evidence that is during the trial of the case, that I did not make such a statement at all, then my lord, it becomes perjury. On oath, you have said it there like this. Here on oath, you are saying that you are virtually denying the whole statement. But some intelligent defense would make the witness say, in the event of that witness not choosing to toe the line of the
So
prosecution.
we'll continue it tomorrow. There are so many waiting. Professor, sir.
Just in
Now-
answer to the question so many times repeatedly put to my learned friend, may I just show one statement,
Of victim.
victim,
Page
page 208
of the charge sheet.
of the charge. Kindly
ಕೊಡಿ.
take. Just one statement.
ಅರೆ ನಾನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅಲ್ಲ ನೋಡ್ಬಿಡ್ತೆ.
ನಾವು
ಅಲ್ಲ
ಹೇಳಿಲ್ಲ,
ನಾನೇನ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತಂದ್ರೆ
ನಾವು ಹೇಳಿಲ್ಲ, repeatedly it was.
ಹೇಳಿಲ್ಲ ಅಲ್ಲ
ಅಲ್ಲ ಇದೆ against ಇದೆ ಅಂತ ಹೇಳಿದ್ರು.
ಇದೆ ಅಂತಾನೆ ಹೇಳಿದೆ ನಾನು.
Yes, 208.
ನೋ
ಇದು 5 ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ.
Kindly take page 208 of the charge.
This is the statement of the victim.
Yes,
ಅಲ್ಲ running into so many pages.
yes. In detail she has given. I'll not trouble the court with the whole this thing. Kindly permit me to show one para. I'll not trouble the court at this stage. Kindly come to it. Para 2. Para 2 at page 209. Till then, she has narrated how she went there, how the mother talked to the accused, and what happened there afterwards. All these things are stated. Kindly come to para 2. Later on, Sri Yediyurappa called me inside. At that time, my mother asked whether she too is permitted to come inside or not. At that time, he instructed my mother to be outside. At that time, I thought, during inquiry of the previous POXO case, I have been inquired privately. So I thought like that only. At that time, my mother also instructed me to give case details properly. Accordingly, I followed Mr. Yediyurappa, went to one room which was situated inside the hall, in which few sofas and few tables were there. Immediate entering in that room, Yediyurappa locked the door with key. Sir, kindly mark it. He locks the door from inside. By observing this locking process, I thought why he is locking the door. He approached near to me, asked, am I able to identify the culprit's previous case? I say yes loudly. At that time, again he asked about my age at that time, committal of previous offense. I told 6.5 years old. That is the previous
So
POXO case. She had already suffered one.
Against the same person?
No, no,
Different person.
different. It is to get justice in that case, she goes to Yediyurappa.
All right, ಇಲ್ಲಿ ಮುಂದೆ ಓದ್ಬೇಡಿ. It is unreadable.
Unreadable.
ಅಲ್ಲ, it is unreadable, don't. read.
Unreadable. Now,
Allah.
now this will not rest there.
No, no.
He goes to
I will-
commission of
I will
police on
read
that day itself.
ಅಲ್ಲ ಮುಂದಕ್ಕೆ
ಅಲ್ಲ,
Goes to commission of police on that day itself.
ಸ್ವಲ್ಪ ನಾನು
ಅಲ್ಲ, all right.
I'm on my legs.
What happened to the
Sir,
complaint?
what happened there afterwards is
ಅಲ್ಲ,
she-
ಮುಂದೆ ಓದ್ಬೇಡಿ ನಾನು.
she comes out of the room and she is in tears. The mother, she does not say anything to the mother. Para 2, para 3, para 4.
We'll continue tomorrow. ನಾಳೆ ಆ ಕೇಸ್ ಆದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ನಾನು
ಬೇರೆ ಟೈಮೇ ಇಲ್ಲ.
ಹೇಳೋದಕ್ಕೆ ಮೊದಲು ಇನ್ನೊಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ನಾನು
ಹೇಳಿ.
ತೋರಿಸ್ಬಿಡ್ತೀನಿ.
ಹ್ಮ್.
This did not stop there. She goes out and after going out of the house, she narrates the whole thing, what happened
To
to
the
her
mother.
mother. Her mother, she immediately rushes back to the accused
Hmm.
and confronts him. I would just like to show what the accused said.
Where do you get that? Mother's
It is very
statement
much-
is there?
Sorry?
Mother's statement cannot be there.
ಅಲ್ಲ ಮದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ.
ಇದೆಯಾ?
ಅಲ್ಲ ಮದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ yes, because it is she who confronted him.
Oh, she was there.
He went back and confronted him. Why the hell did you do this to my daughter?
All right. Where is that page?
Kindly, shall I state the version of the victim herself?
No. Mother statement ಇದೆ.
ಅಲ್ಲ
Confrontation.
ಇದು ವಿಕ್ಟಿಮ್ದೇ ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಅಲ್ಲ, confrontation victim ಹೇಳ್ತಾರಾ?
Victim was present.
All right.
Not only she was present.
Page.
Same statement. Kindly come to page 212. Para 6. Within seconds, she rushes back after hearing about this ordeal of her daughter.
Hmm.
Page 212, para 6. When my mother was talking in phone at that time, I was thinking that in the previous cases, the police officials and public have asked me and my mother about the evidence to prove the incident. Hence, at this time, also I thought that the officials may ask about evidence of the present incident. Then I made up my mind to record the conversation to be held with the above said Sri Yediyurappa. Then, without knowledge of my mother, after taking a selfie with cash, the persons who were in the meeting came out. Then, while entering inside, I set my phone for recording. the persons who came outside, known by my mother, and my mother spoke with them and requested them to be there only till we come out. Accordingly, we entered the house. At that time, Mr. Yediyurappa was watching TV. My mother asked him what he has done to her daughter inside that room. Yediyurappa replied to my mother that I am just like his granddaughter. Immediately, my mother raised the question, if it is so, why did you put your hand in her shirt or blouse?
ಅಲ್ಲ ಅದಕ್ಕೆ ಅದನ್ನ ಓದ್ಬೇಡ.
No, what is the reply given by the accused?
ಅದೇ
ಅದನ್ನ ಅದಕ್ಕೋಸ್ಕರ ಓದ್ತಾ ಇದ್ದೀನಿ. Immediately he dragged my mother's hand, made her to sit in sofa. I too followed my mother. Sri Yediyurappa explained that he checked me and I am just like his granddaughter.
All right.
Sir, he has admitted the whole incident. What the hell are we doing reading CW 13?
What the hell?
Allala, CW 12.
That is not
Allala,
that is not.
accused has admitted, sir.
Kindly pardon me for a second.
Not the
She would make a statement saying that I have filed a false case. Some politician has asked me to file the complaint. I shall read her statement.
Accused has admitted and it is recorded. I'll give the
Politician,
entire
No,
evidence.
all that is fine.
Then
The
what is
language,
the
what the hell are we
I
doing
will
here?
give the entire
Need not-
evidence.
That need not be, sir.
No,
But,
even
yeah,
that,
her statement is some
respectfully
politician
submit-
has asked me to file a complaint
the
against the
whole thing
petitioner.
has been recorded.
I have filed a false
and the
complaint.
recorded
And
evidence
here-
is also available.
But she comes
I'll
on
place it.
5th, she comes
my
on
learned
17th, she comes on 20th to take pictures with me. And she would make a statement saying that some politician has asked me to file a complaint against Mr. Yediyurappa, therefore I have filed it. I'm sorry, I want to apologize to him. That is her statement. I shall read to your lordship her statement.
Accused has candidly admitted the entire incident.
ಇದೆ ನೀವು
He said
ನಿಮ್ಮ ಯಾವ
he
ತರ
has-
Tomorrow.
Yes.
We'll continue it tomorrow at
on
4
the
o'clock.
date of the incident, she goes to complain to the
ನಾಳೆನಾದ್ರೂ
police.
ಅಟ್ಲೀಸ್ಟ್ 2:30 ತಕೊಂಡ್ರೆ
2:30 ಅದನ್ನ ಇಟ್ಕೊಂಡಿದ್ದೀನಲ್ಲ. ಅದಕ್ಕೆ 2:30 ಅದಾದ್ಮೇಲೆ. Yes.
But on the date of the incident, she goes to commissioner of police.
Yes.
5 statement ಇದೆ. All the statements are
ಮುಗಿಲಿ
recorded.
sir,
outside.
ಆಮೇಲೆ ಹೇಳಿ ನೀವು.
Submission
And-
ಅಷ್ಟೇ.
and- and
There
a
are
question-
5 statement recorded
whom?
by of the victim.
5 statements.
There are 5
Why
statements.
5 statements?
ಒಂದೊಂದು ಚೇಂಜ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಇಲ್ಲಿ ಬೇರೆ ಎವಿಡೆನ್ಸ್ ಬಂದ್ಬಿಡ್ತಲ್ಲ, ಅದು ಕುತ್ರ ಹೇಳ್ಬೇಕಲ್ಲ.
ಒಂದಕ್ಕೆ ನಾವು ಹೇಳಕ್ ಬರುತ್ತೆ.
To overcome,
Just
to
refer to
overcome the evidence
CID.
which the IO would collect through the mouth
On a
of
question of
prosecution
law.
witnesses.
On a question of
statement.
law,
160
between contradictions between the witnesses and the victim, I'll produce any number of authorities. The sole testimony of the witness, the victim, is enough to convict.
ಇಲ್ಲ,
Not only to
ಆಮೇಲೆ
initiate
ನಾವೇನ್
the-
ಮಾಡ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ, ಅದು high court.
29
ಹೇಳಿದೆ, even to convict, sole testimony is enough. It is not necessary.
doctor
it
also,
should be
when
corroborated.
she was subjected to medical exam, even doctor recorded her statement. So like that.
God
there are-
recorded what statement?
A
Medical
state-
examination ಯಾಕೆ ಇದ್ರಲ್ಲಿ?
After
There-
2 months,
There is no forensic.
after 2 months,
No, no. Very same day, immediately after the incident,
doctor.
he makes a call to the advocate. There was a conversation. Who is arrayed as witness number 6? There are consistent material, not only 161,
We'll see.
164, but also digital
Well,
evidence.
the doctor,
Even CCTV footage.
my learned friend, Mr. Balan said immediately after the incident, she spoke to her advocate, Mr.
That
Hiremat.
can't come out on
Correct,
record.
sir, Satya. But Hiremat himself would say that I asked her what happened, she said nothing happened. What in the next door?
See,
All right.
all
Hiremat's
that-
statement is there. I asked her immediately, what happened? Nothing has happened.
It's not a final argument.
Because since
of
my
the
lord has
conclusion of
said
trial. This
That
is
the
under
doubt that needs to be
482.
clarified. That is why, my lord, I kept quiet.
Legal, see, we are on legal jugglery here, not on factual jugglery. It is all there.
ಅಲ್ಲ ಸೋಲ್ ಟೆಸ್ಟಿಮನಿ ಅನ್ನೋದಕ್ಕೆ ಒಂದೇ ಒಂದು ಅಥಾರಿಟಿ ತೋರಿಸ್ತಾರೆ.
ಅಲ್ಲ ಯಾವ್ದಾರ ನಾಳೆ ಕೊಡಿ.
ಆಯ್ತು.
Yes.
So many.
ಆಯ್ತು.
ನಾಳೆ ವಿಲ್ ಸ್ಟಾರ್ಟ್ at 5 PM.
5 PM.
ಎಲ್ಲಾರ್ನೂ ಕಳಿಸ್ಬಿಡ್ತೀವಿ. ಎಲ್ಲ
ಅಟ್ಲೀಸ್ಟ್ 4 ಗಂಟೆಗೆ ಶುರು.
ಅಲ್ಲ
4 ಗಂಟೆಗೆ
advocates,
ಶುರು ಮಾಡಿ.
because it's only 2 days left. All of them are waiting. They
Because
will
my
be
learned
waiting.
friend has not yet come to either the CW1 or CW.
ಅಲ್ಲ ಅದಕ್ಕೆ ಇನ್ನು ಎಷ್ಟೋ
CW 13, 14,
ಅದಕ್ಕೆ
15
ಎಷ್ಟು ದಿನ
ಅಲ್ಲೆಲ್ಲ
ಆಗುತ್ತೆ
ಓಡಾಡ್ತಿದೆ.
ಗೊತ್ತಿಲ್ಲ. ಸೊ ನಾಳೆ ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಏನ್ ಹೇಳ್ಬೇಕು ಅದೇ ಹೇಳಿ. ಬಿಕಾಸ್ 482 jurisdiction ಅಷ್ಟೇ ಬೇಕಾಗಿ. ಎಸ್ ನಾಳೆ we'll start at 5 p.m.
ಇದಕ್ಕೂ ಕೂಡ ಅಥಾರಿಟೀಸ್ ಕೊಡಿ.
5 p.m.
Please.
Yes. Yes.
Entry model.
That will correct.
Entry model.
Yes, heard ಎಲ್ಲ ಹಾಕಿ, heard in part, enter model subsystem. Reporting settlement.
Reporting settlement 144.
Serial number 130 also copper.
ಒಂದು ನಿಮಿಷ ಕರೆ ಎಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಎಲ್ಲ ಮುಗಿಸ್ತೆ. ಲಂಚ್ ಅವರ್ ಯಾರೋ ಹೇಳಿದ್ರಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಇದೆ ಅವ್ರದ್ದು ಎಂಡ್ ತಗೊಳ್ಳಿ. ಎಸ್, ಸೀರಿಯಲ್ ನಂಬರ್
144.
ರಕ್ಷಿತ್ ಏನಿದೆ ಒಫೆನ್ಸ್?
Offense 498A, 504, 506, 109.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್
Respond counsel is here.
ಇದಾರ?
She's here.
ಎಸ್. ವೆಕೇಶನ್ ಬೆಂಚ್
145 also. Same part.
144, 145 ಎರಡು ಸೇಮ್. ಎಸ್, ನೆಕ್ಸ್ಟ್
Order sheet signatures.
PB ರಾಜು
146.
146 ರಾಜು ಇಲ್ವಾ?
146. 147.
Offense is 420, 406, commercial transaction.
ಇಬ್ರು ಇದಾರ?
ಇಬ್ರು ಇದ್ದಾರೆ.
ಸೊ ಅಂಡ್ ಸೊ
Connected matter moved at 230 minutes.
ಹಾ ಸರಿ, ಅದು ನಂಬರ್ ಹೇಳ್ಬಿಡಿ.
Number
257.
ಸೆಟಲ್ಮೆಂಟ್ ಕೊಡಿ.
257. This is affidavit. Settlement is filed in this 2090. Is that the affidavit?
ಎಸ್ KG. Next.
The petitions.
Both.
48.
ಲಂಸಮ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ.
ಈಗ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲಾ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅವರೇ ಕ್ವಾಶಿಂಗ್ ಮಾಡಬಹುದು ಅಂತ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ ಬಂದು ಹೇಳಿದ್ದಾರೆ.
ಈಗ ಅವ್ರು ಇಲ್ವಾ?
ಅವ್ರು ಲಾಸ್ಟ್ ಟೈಮ್
My lords,
ಬರ್ಲಿಲ್ಲ, ಬಿಫೋರ್ ಲಾಸ್ಟ್.
For respondent number 2, my lords.
ಇಲ್ಲೇ ಇದಾರೆ ನೋಡಿ. ಎಸ್. ಸೆಟ್ಲ್ ಆಗಿದ್ಯಾ?
Yes, my lords.
ಹಾ ಕೊಡಿ.
Settle agide, my lords.
ಸೆಟಲ್ಮೆಂಟ್ ಎಲ್ಲಾಗಿದೆ ಅಲ್ಲಿ?
ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ?
ಇನ್ನು ಪೇಜ್ ನಂಬರ್
ಪೇಜ್ ನಂಬರ್
MC ನಂಬರ್ 93.
ಪೇಜ್ ನಂಬರ್ ಅಂದ್ರೆ MC ನಂಬರ್ ಅಂತ ಇದ್ದೀರಾ?
ಸಾರಿ ಸರ್.
ಹಾ,
ಪೇಜ್ ನಂಬರ್
ಇದೆಯಾ ಇಲ್ವಾ?
ಇದೆ
ಹಾ.
ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
ಇಲ್ಲಿ ಎಲ್ಲರೂ ಇರ್ಲಿ, ಅದಕ್ಕೆ ಪೇಜ್ ಅಂತ ಇರುತ್ತಲ್ಲ.
117 ಮಾಡಿ. ಸಾರಿ,
ಎಸ್
1780.
117 ಕವೆ ಬರ್ಕೊಂಡು
117.
ಯಾವ್ದೋ ಜಡ್ಮೆಂಟ್ ಇದೆ.
ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲೇ ಡಿಸ್ಪೋಸ್ ಆಗಿ ಲಂಸಮ್
ಎಲ್ಲಿದೆ? ಎಲ್ಲಿದೆ?
13 ಲಕ್ಷ ಆಗಿ ಲಂಸಮ್.
Page number 117,
ಹಾ.
118.
ಕವೆ ಪ್ಯಾರಾ 8
8.
ಕೋರ್ಟ್ ಪ್ಯಾರಾ 8 ಕ್ಲೋಸ್ ಇಟ್.
Both matter.
ಬೋತ್ ದ ಕೇಸ್.
Grateful, my lords.
ಹೆಂಗ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? ನೆಕ್ಸ್ಟ್
149.
498 ಫೈಲಿಂಗ್ ಜಾಯಿಂಟ್ ಮೆಮೋ.
In this case,
149
149.
respondent
I am for the respondent number 2, Your Honor.
undertakes to enter appearance for the
Call for
respondent.
respondent number 2, Your Honor.
Joint memo.
ಸೆಕೆಂಡ್ ಅಂಡ್ ಥರ್ಡ್ ಪೈ ಆಫ್ ಜಾಯಿಂಟ್ ಮೆಮೋ.
ಅವ್ರಿಗೂ ಡ್ರಿಲ್ ಗೊತ್ತೀಗ, ಅಷ್ಟು ಸಾಕು. ಪ್ಯಾರಾ 2 and 3. ಎಸ್, ನೆಕ್ಸ್ಟ್.
ಮಚ್ ಒಬ್ಲೈಜ್.
ಎಸ್
150.
150, only one pass over.
ಪಾಸ್ ಓವರ್.
Respondents just waiting for respondent.
ಪಾಸ್ ಓವರ್.
151.
ಸೆಟ್ಲ್ ಆಗಿದೆ. ಅಫೆನ್ಸ್ ಏನು ಮೇಡಮ್? ಅಫೆನ್ಸ್ ಏನು? ಆಯ್ತು, ನಾನೇ ನೋಡ್ತೀನಿ, ನೀವು ರೆಸ್ಟ್.
504, 147, 350.
ಸೆಟಲ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
My lord, ಇಲ್ಲಿ settle.
ಸೆಟ್ಲ್ ಆಗಿಲ್ವಾ?
ಸೆಟ್ಲ್ ಆಗಿಲ್ಲ ಮೆಲೋಡ್.
ಹ್ಮ್.
ಮೈ
ಕೂತ್ಕೊಳ್ಳಿ,
colleague-
ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ, 5 ನಿಮಿಷ ಬಿಟ್ಟು ಕರಿತೀನಿ, ಕೂತ್ಕೊಳ್ಳಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್ ಕರೀರಿ. ತೇಜಸ್.
My lord, offense 307, husband and wife, my lord, parties are present before. this
ಹಸ್ಬೆಂಡ್ ಅಂಡ್
court.
ವೈಫ್ 307.
Yes, my lord.
ಮದುವೆ ಆಗಿದಾರಾ?
ಮದುವೆ
ಈಗ
ಆಗಿದೆ.
ಆಗಿದಾರಾ?
Already having children, my lord, some sudden quarrel took place in the house itself. I have filed along with IA, my lord, for compounding.
ಎಲ್ಲಿದೆ ಅದು?
Annexed with the petition, my lord. Separate IA has been filed.
Respondent.
Wakalat ಇದೆ, IA ಇದೆ.
ಕೆಜಿ 307 ಸುಮಾರಿದೆ. ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್. ಎಸ್,
Grateful.
ನೆಕ್ಸ್ಟ್.
Order sheets, name but.
ಆಮೇಲೆ ಇಲ್ಲಿ ಸೈನ್ ಆಗದೆ ಆರ್ಡರ್ ಬರಲ್ಲ.
I'm for the respondent. 307 and 326, my lords.
307, 326. ಎರಡು
Case
10
and
year-
counter.
ಎರಡು 10 years.
Case and grievous. 155.
ಗ್ರೀವಿಯಸ್ ಇಂಜುರಿ
ಎರಡು grievous.
ಮತ್ತೆ
No, my
set ಏನು
ಎರಡು ಕೇಸ್ ಅಲ್ಲ.
ಎರಡರಲ್ಲೂ ಗ್ರೀವಿಯಸ್ ಇಂಜುರಿ.
ಎರಡು ಕೇಸಲ್ಲಿ
My lords, may I be permitted to submit? My lords, here in the spur of the moment, the case has came to be filed, my lord.
ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್.
Yes, please, my lords.
ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್.
Please, my lords.
Family member.
Huh?
Please, my lords.
Brother-in-law. and
Now
sister.
they are in one shelter, my lords. Arising,
ಬ್ರದರ್ಸ್.
yes, springing out of matrimonial dispute, my
ಆಲ್ ರೈಟ್,
lords.
ದೇ ಆರ್ ಬ್ರದರ್ಸ್.
No.
Brother-in-law and sister-in-law, my lords.
Brother-in-law, sister-in-law.
ಎಲ್ಲರ
ಬ್ರದರ್ ಇನ್ ಲಾ, ಸಿಸ್ಟರ್ ಇನ್ ಲಾ.
Please, my lords.
ದೇ ಲುಕ್ ಲೈಕ್ ಅದರ್ ಇನ್
ಹತ್ತಿಗೆ ಮೈದ.
ಲಾ.
ಹತ್ತಿಗೆ.
ಎಸ್,
ಹತ್ತಿಗೆ ಮೈದ. ಮೈದನ.
ನೋಡಿ
Affidavit, my lords.
ಕೊಡಿ. ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕಾದ್ರೆ ಅವ್ರದ್ದು ಹಾಕಿಲ್ಲ ಇವತ್ತು. ಇಲ್ಲ, ವಕಾಲತ್ ಅವಿನಾಶ್, ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
Yes, yes.
ನೇಮ್ ಇದೆಯಾ?
ಹೌದು.
ರಿಜಿಸ್ಟ್ರಿ ಟು ಪ್ರಿಂಟ್ ದ ನೇಮ್ ಆಫ್ ಅವಿನಾಶ್ ಅಂತ ಹಾಕಿಲ್ಲ. ಎಸ್ ಮೇಡಮ್.
154.
ಅಲ್ಲ, ಅವ್ರ ಮೇಡಮ್ ಕರೀರಿ. ಏನಾಗಿದೆ ಮೇಡಮ್?
151.
ಒಂದ್ ನಿಮಿಷ ಕರೀತಿ.
appealing for the petitioner here.
ಈಗ ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ ಮೇಡಮ್?
ಸೆಟ್ಲ್ ಆಗಿಲ್ಲ ಮೇಡಮ್. ಆಕ್ಚುಲಿ ಎರಡು ಮೆಮೊ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ನಮ್ ಕಲೀಗು ಬೈ ಮಿಸ್ಟೇಕ್.
ಯಾವತ್ತು ಬೇಕು?
It is been put like it is for the settlement ಅಂತ, but it is for the regular hearing ಮೇಡಮ್. IML stay ಆಗ್ಬೇಕಿತ್ತು, ಅದಕ್ಕೆ ಹಾಕಿದ್ದೀವಿ. The
ಆಯ್ತು.
main case is already been stayed.
ಕೊಡಿ,
Is it connected?
ನಂಬರ್ ಕೊಡಿ.
In this case, PW 1 to 5 already examined. PW 1
ಚಾರ್ಜ್
to
ಫ್ರೇಮ್ ಆಗಿದೆಯಲ್ಲ ಮೇಡಮ್, ಏನ್ ಮಾಡಕ? ಮೇಡಮ್,
ಇಲ್ಲಿ. ಅಲ್ಲಿ.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗೋಗಿದೆ.
Yes, my lord. ಇಲ್ಲಿ main case ಅಲ್ಲಿ ಅವರು petitioner is not been specifically mentioned in the charge sheet and
Merits ಮೇಲೆ
FIR. my lord.
ಬರಲೇಬೇಡಿ. ಆಫ್ಟರ್ ಚಾರ್ಜ್ ಇಸ್ ಫ್ರೇಮ್ಡ್,
PW 1
You-
to 5 examined.
ಕಮ್ ಆನ್ ಫ್ರೈಡೆ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಎಸ್, ನೆಕ್ಸ್ಟ್. ಈಗ 150
146.
ವೇಟ್ ಸರ್, ಅದಕ್ಕೆ ವಾಪಸ್ ಹೋಗೋಣ.
54.
ಎಸ್, 154. ವೈ ರವಿಶಂಕರ್ ಸರ್ ಹಿಯರ್? ರವಿಶಂಕರ್ ಸರ್, ಸೆಟಲ್ಮೆಂಟ್
Serial number 150, my lords. Lords,
ಒಂದ್ ನಿಮಿಷ, ಅದು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
ಆಯ್ತು.
154. 154
54.
ಪರಮೇಶ್ವರಪ್ಪ. 155 ಅವಿನಾಶ್.
Yes.
55.
Case and counter case.
Case
ಏನು ಅಫೆನ್ಸ್?
307, 326.
ಏನ್ ಎಲ್ಲ ಅದ್ರಲ್ಲೇ ನಿಮ್ದೆಲ್ಲ ಅದೇನಾ?
ಅಲ್ಲ, both
My lords,
same.
this,
ಇದು
my
ಕೇಸ್,
lords,
ಇದು ಕೌಂಟರ್ ಕೇಸ್.
this, my lords, spring in the moment of the.
ಆಯ್ತಾಯ್ತು, ಸೇಮ್ ಆ ಕಡೆ ಇದ್ದಿದ್ದು ಹೇಳಿದ್ದೀನಿ, ಈ
Yes,
ಕಡೆ
yes.
ಬಂದು ಹೇಳ್ಬೇಡಿ.
Please, my lords.
ಡೋಂಟ್ ರೀಪ್ಲೇ. ಎಸ್ ಮೇಡಮ್.
153 and
153 and 155
Five.
ಎರಡು ಸೇಮ್ ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್. ಎಸ್, ನೆಕ್ಸ್ಟ್ ಸತೀಶ್.
56.
But it is at the
ಸತೀಶ್ ಸೆಟಲ್ಮೆಂಟಾ?
verge of settlement.
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿಸ್ತೀರಾ?
This is the case where, my lord,
ಹ್ಮ್,
it is at the verge of settlement.
ಸರಿ, ಏನೀಗ ಹೇಳಿ?
La, your lordship.
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
respondent number 2 in this matter, my lordship.
Yes,
Accused
madam.
number 1 to 10, there is no discussion regarding settlement. 11 to 13 are
List
sorted
after
out.
vacation.
ಅಲ್ಲ,
Yes, next.
but
In the
le-
date may be
11
fixed,
to-
my
ಯಾವ್ದು
lordship.
ದಟ್ ಇದಾ?
sub-registrar.
ಏನಾಯ್ತು?
That's
ಏನಾಯ್ತು?
sub-registrar one's
ಏನಾಯ್ತು
matter.
ಈಗ?
11 to 13, it is at the verge of settlement, but civil dispute is already settled.
ಅದಾಯ್ತು. ಈಗ
No, civil dispute is still pending.
ಈಗ ಇವ್ರು
Your lordship.
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ ಇಲ್ವಾ?
ನಾಡಿದ್ದು ಹಾಕೊಳ್ಳಿ.
ಆಯ್ತು ಸರ್,
Right.
ನಾಳೆ ಲೆಟ್ಸ್ ಟುಮಾರೋ at 4 PM.
Much obliged, my lordship.
Yes, next. 157.
Day after tomorrow.
7.
Complaint from Chennai, it intern.
Day
Day
after
after tomorrow.
Day after tomorrow. ಯಾರಿಗೆ? ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ವೆಂಕಟೇಶ್ ಅರ್ಬಟ್ಟಿ. submits that enters appearance for the second respondent, registry to print the name of so and so as appearing for the second respondent. ಈಗ 150 ತಗೊಳ್ಳಿ. Yes, Ravishankar.
50, but I pay for the response. Some communication gap, there was a lawyer who was appearing for the complainant, given no objection, my learned friend is appearing now. That's account transfer is 1 crore 25 lakh rupees. I am giving 50 lakh rupees by means of demand draft today. Remaining 75 lakhs, I am filing an undertaking affidavit that I will clear it within a period of 6 months. But the proceedings may be quashed. They say that there is a cash component, let them prove and recover it.
Both of you agree settlement ಆಗಿದ್ರೆ we'll close it.
I'll take instruction as far as that is concerned.
ಆಯ್ತು,
Now,
ನಾಳೆ
today-
4 ಗಂಟೆ.
Please, my lords.
Yes.
Nobody else. Close.
146 ಕೊಡಿ. ಏನು offense ಏನು?
498
ಕೊಡಿ 146.
ನಾಳೆ ಒಟ್ಟಿಗೆ ಕೊಡ್ತೀನಿ.
ಪಾರ್ಟೀಸ್ ಇದಾರಾ?
Parties petitioners ಎಲ್ಲ ಬಂದಿದ್ದಾರೆ.
ರೆಸ್ಪಾಂಡೆಂಟ್
Respondent, they supposed to come, my lord, they don't come.
ಸಪೋಸ್ ಟು ಕಮ್.
Intimate ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ sir. Even the TD also ready, my lord, we have.
ಆಯ್ತು, ನಾನು ಕರ್ಕೊಂಬನ್ನಿ ನಾಳೆ. Let's tomorrow at 4 PM. Yes.
File number 130, my lord.
ಅದೇನು offense?
498 EM.
ಎಲ್ಲರೂ ಇದಾರಾ?
ಇದ್ದಾರೆ sir.
ಕೊಡಿ ಅದು.
Petitioner 102 and respondent number
ಕೊಡಿ
2.
ಕೊಡಿ ಅದು. ಎಸ್ ಮೇಡಮ್ ತಗೊಳ್ಳಿ, ಆಮೇಲೆ ಕೊಡಿ ಫೈಲ್ ಅವರು.
Serial number 130.
ಆಮೇಲೆ ಇಸ್ಕೊಳ್ಳಿ. ಇದು 2 ದಿವಸ ಮಾಮೂಲಿ.
Number.
Yes. Who is the respondent? Complainant. ಇದಾರಾ ಇಲ್ವಾ? All right, ಸರಿ. Yes. Next. ಅಷ್ಟೇ. Call the further hearing ಎಲ್ಲ ಇದೆ ಮೇಡಮ್ ಇದು.
Sorry.
139 ನಿಮ್ದು.
130.
ಹಾ.
ಮರಿಯ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಯಾರು?
CR ವೆಂಕಟೇಶ್. ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ವಕಾಲತ್ ಇದೆ.
Yes.
ತಪ್ಪಾಗಿದೆ.
Land council sounds. Yes, next. To the remote matters ಇದೆ ಮೇಡಮ್. ಬಂದಿದ್ಯಾ? There's some problem with the system for 230 mood matters. ಬರ್ಲಿ ಅಲ್ಲ?
Further hearing matters.
ಅಲ್ಲ, further hearing will go to 16 January. All ಅಲ್ಲ, only 7 ಇದು. ಬೇರೆ ಎಲ್ಲ ಇದೆ. 1 ನಿಮಿಷ. 1 minute. Further hearing.
167 my lord is
1 minute.
7A.
1 minute.
158.
ಅಲ್ಲಿಂದ.
Millet 158, the interim order itself, it is covers, millet, Prasad is there. ಒಂದ್ಸಲ ರಿಸರ್ವ್ ಆಗಿತ್ತು 29/8/2024 ಗೆ. No submissions.
Further hearing. 158. ಈಗ ರಿಸರ್ವ್ ಮಾಡಲ್ಲ.
ಅಲ್ಲ, ಅದು ರಿಸರ್ವ್ ಒಂದ್ಸಲ ರಿಸರ್ವ್ ಆಗಿತ್ತು
Further hearing
29/8.
ಹಾಕಿರ್ತೀನಿ, ಅವತ್ತು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ.
ನಾನು ಅವ್ರ ಪ್ರಸಾದ್ ಏನಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ನಾನು ಕಳ್ಸಲ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದೆ, ಅಷ್ಟಕ್ಕೆ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಬಂದಿದ್ದದು ಅಷ್ಟೇ.
ಆಯ್ತು, ನೋಡುವ. ಎಸ್.
Millet,
ಈಗ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಉಂಟಲ್ಲ.
entry ಮಾಡ್ರು ಉಂಟು.
ಹಾ.
Past 2018 millet, their promotions have been held up. Prosecution withdraw ಮಾಡ್ಲಿಕ್ಕೆ government order ಇದೆ. Everything is there.
All right.
ಅದಕ್ಕೆ ನಾನು
ಎಲ್ಲ ರಿಸರ್ವ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಇಲ್ಲ, ಪ್ರಸಾದ್ has himself consent millet re-reserve.
ಆಯ್ತು, ಜಡ್ಮೆಂಟ್ ನಾನ್ ಬರಿಬೇಕಲ್ಲ. ಮತ್ತೆ ಬರೀ ಅಲೌಡ್ ಅಂತ ಬರೆಯಕ್ಕಾಗತ್ತಾ?
ರಜಾದ ಮೇಲೆ
ರೀಸನ್ ಕೊಡ್ಬೇಕು ತಾನೆ. ರಜಾ ಇದೇ ಮಾಡಿ ಅಂತ
ಹಂಗ ಏನ್ ಹೇಳ್ತಾರೆ. 2018 ಇಂದ
ಗೊತ್ತಾಯ್ತು ಸರ್. ಐ ಹ್ಯಾವ್ ಹೋಲ್ ಲಾಟ್ ಟು ಡೂ ಇನ್ ದ ವೆಕೇಶನ್. ಎಸ್, ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್ ಆನ್ 13th. ಪರವಾಗಿಲ್ಲ. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಪ್ಪ 30 ಯಾವತ್ತು ಹಾಕಿದೆ ನಾವು? ಅವತ್ತೇ ಆಗತ್ತೆ.
But I am requesting
By
on
then,
that
by
day.
then I will pass some order and pronounce it on that day. Next.
159.
Exoneration, my lord, so I will file the comparative statements.
23rd, yes. Next. 160.
For petitioner you are.
I'm for the
7A
respondent number 2.
7A.
Interim order is there.
ಎಲ್ಲ ಇದೆ ಗೊತ್ತು. 7A ಯಾವತ್ತು ಮೇಡಮ್? ಆಲ್ 7A ಕರಿತಾ ಹೋಗ್ತೀರಾ ಬೇಕಾ? All 7A matters. All 7A matters will come on 16th.
Please.
Yes.
Please, your.
Much obliged. I'm for R2.
Entry model ಎಲ್ಲಿದೆ ಎಲ್ಲ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Don't have to worry about it.
Please, please.
No, come to ಅದು ಒಂದು ಫುಲ್ ತೆಗೆದ್ಬಿಡಿ. ಎಲ್ಲ 7A ಇದಾನೆ ಅಲ್ವಾ?
From 179 onwards, my lord, there are DA matters.
ಒಂದು ನಿಮಿಷ. 161.
61.
Petitioners in this.
ಹಾ.
Senior counsel is up.
Senior counsel.
No.
List on 23rd. Next.
Sir, 161.
23rd, yes. Enter ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ. Yes,
ಫೈನಲ್
next.
ಅಂತ ಹೇಳಿದ್ರಿ.
ಈಗ ತಗೊಳಕ್ಕಾಗತ್ತಾ ಸರ್? ರಿಲೀಸ್ ಮಾಡ್ಲಾ?
ಬೇಡ.
Yes, next.
163.
7A.
164. 65.
7A, my lord.
Yes,
66.
yes.
67.
My lord, it is on the petition, my lord, 167.
7A na 13 na?
7A.
7A,
7A.
yes, next. Yes.
My lords, 167.20. Lords,
Sir,
it-
VC ಇಲ್ಲಿ ಬೇಕಾರೆ wait sir,
I'm
please.
sorry, my lords.
167.46, my lord. Lord, this matter is connected with serial number 123.
ಇದೆಲ್ಲ 7A ತಾನೆ?
My lord, the interim order passed in this case is, my lord, not to file a charge sheet.
ಹೌದು.
My lord, already in this case, my lord, charge sheet is.
ಆಲ್ರೆಡಿ
filed.
ಆಗಿದ್ರೆ ಏನು
My
ಮಾಡಕ್ಕಾಗಲ್ಲ.
lord, since 123, my lord, serial number 123, this honorable court is pleased to pass interim order to defer the framing of charges.
We'll see,
My lord,
yes.
with respect to that, my lord.
We'll
same
see,
order-
yes, yes.
Same order is passed, my lord.
My lord, it is with respect to 167, my lord. It's a departmental inquiry, my lord. I have been examined in the departmental inquiry
Solid.
on the
That-
same
that
set
is
of
on-
charges.
That is on 16th, yes, next.
Yes, interim order is required, my lord. Interim order already identical charges ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇದಕ್ಕೆ interim order ಕೊಡಿ.
ಯಾವ್ದು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗೋ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಯಾವ್ದು ಇದು 4 ಇಲ್ಲ ಸ್ವಾಮಿ, ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ
ನನಗೆ ಗೊತ್ತು ಎಕ್ಸಾನರೇಷನ್ ಆಗಿದೆ, ಕ್ರಿಮಿನಲ್ ಕೇಸಲ್ಲಿ ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
ಕ್ರಿಮಿನಲ್ ಕೇಸಸ್ ಇನ್ನೊಂದು ಚಾರ್ಜಸ್ ಫ್ರೇಮ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಆಗಿದೆ.
ಥ್ಯಾಂಕ್ ಯು.
ಇದು
ಬರ್ಲಿ 16th ಬರ್ಲಿ, ನೆಕ್ಸ್ಟ್, ಎಸ್.
interim order is required ಸ್ವಾಮಿ.
ನೋ ಸರ್, ಎಸ್. 7A. ಮೇಡಮ್ ಅದ್ರಲ್ಲಿ 13(1) ಯಾವುದು ಅದನ್ನ ಬೈಫರ್ಕೇಟ್ ಮಾಡಿ ಇನ್ನೊಂದಕ್ಕೆ ಟ್ಯಾಗ್ ಮಾಡಿ. 7A that will be there. 7A ಏನಿದೆ ಅದನ್ನ ಇನ್ನೊಂದಕ್ಕೆ ಟ್ಯಾಗ್ ಮಾಡಿ.
167.69, my lord, 7A. I may be permitted to file citations, my lord.
ಎಲ್ಲ ಏನ್ ಬೇಕು ಮಾಡಿ, ರಿಜಿಸ್ಟ್ರಿಲ್ ಫೈಲ್ ಮಾಡಿ, ಇಲ್ಲಲ್ಲ
Register.
ಇಲ್ಲಿದ್ರೆ ಎಲ್ಲ ಹೋಗ್ಬಿಡುತ್ತೆ.
ಇಲ್ಲ.
ರಿಜಿಸ್ಟ್ರಿಲ್ ಏನ್ ಬೇಕು ಫೈಲ್ ಮಾಡಿ.
Yes.
ಎಸ್.
38, my lord, there is no interim order.
ನೋ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್, ಎಸ್.
Sanction is refused.
Sanction is refused.
Sanction is refused, page number 7. And Vedappa to don't, that is all.
ಪೇಜ್ ಅಲ್ಲ 167 ಪಾಯಿಂಟ್
38.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋ ಬದಲು ನಂಬರ್ ಹೇಳಿ. ಸ್ಯಾಂಕ್ಷನ್ ಇಸ್ ರೆಫ್ಯೂಸ್ಡ್.
Sanction is refused.
ಹಾ,
Trap is failure. ದುಡ್ಡು ಬೇಡಪ್ಪ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ದುಡ್ಡು ಬೇಡಪ್ಪ, ಹಾಗಾದ್ರೆ ನಿಮ್ ಇಂಟರ್ ಮಾಡಿ ಕೊಡೋದೇ ಇಲ್ಲ.
Page number 20.
ನೀವು ಡಿಮ್ಯಾಂಡೇ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ನೀವು ಅನ್ಬಿಕಮಿಂಗ್ ಆಫ್ ಅ ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್. ಎಸ್,
168.
ಅದು ಅದರಲ್ಲಿ ಕನ್ಸರ್ನ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ? ದಿ ಕನ್ಸರ್ನ್ ಕೋರ್ಟ್ ಶಲ್ ಡೆಫರ್ ಇಟ್ಸ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ಅದರಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ ವೇಟ್ ಚೇತನ್. ಎಸ್, ನಿಮ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗೋ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದ್ರೆ ಕೊಡಲ್ಲ. ಎಸ್, ನೆಕ್ಸ್ಟ್ ನೆಕ್ಸ್ಟ್
168.
My lords, 167 ನಲ್ಲಿ 20 ಅದು ಡೀಲ್.
ಆಮೇಲೆ ಹೇಳಿ ಸರ್ ಅದನ್ನ. ಟೆಲ್ ದಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಲೇಟರ್. ಎಸ್.
169.
For petitioner, my lords.
169 ಏನು?
My lords, 13B, my lords, 13B of PC Act, my lords.
ಅದನ್ನ 13 ಜೊತೆಗೆ ಹಾಕಿ ಮೇಡಮ್. ಎಸ್,
70.
ಸೋಮಣ್ಣ ಸ್ಟೇ ಇದೆಯಾ ಅದರಲ್ಲಿ?
My lords, not to file charge sheet.
ಅದೇ ಎಲ್ಲರಲ್ಲೂ ಅದೇ ಆರ್ಡರ್. ಎಸ್, ನೆಕ್ಸ್ಟ್
70.
DA, ಅದನ್ನ DA ಕನೆಕ್ಟ್ ಮಾಡಿ ಮೇಡಮ್. ಎಸ್, ನೆಕ್ಸ್ಟ್
171.
Appear for the respondent, your lordship.
DA. 7A.
7.
ಫಕೀರಪ್ಪ.
Yes, your lordship.
72.
Fakirappa. Have you taken up any?
ವಿಲ್ ರಿಸರ್ವ್ ಇಟ್.
I have to ask.
ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್?
Yes, your lordship. It's a typical clear case for false promise to marriage.
ಎಸ್, ನೀವಿದ್ದೀರಾ?
173.
ಎನಿವೆ 23rd.
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 Interim order.
ಯಾಕೆ ಕಂಟಿನ್ಯೂ. ಎಸ್, ನೆಕ್ಸ್ಟ್
173.
My lord, this is that 138A proceedings, 391 applications, ಎರಡು ಕಡೆ hearing ಆಗಿದೆ. ಸಂದೇಶ senior appear ಆಗಿತ್ತು.
ಸರಿ. ಎಸ್,
Petitioner, my lords.
6 January. ಎಸ್, ನೆಕ್ಸ್ಟ್
These are-
391.
Yes, my lord, 391.
ಸಂದೇಶ್ ಚೌಟ ಅಪಿಯರ್ ಆಗಿದೆ. ಇದು ಹಿಯರ್ ಮಾಡಿದ್ದೀನಿ, ರಿಸರ್ವ್. ಎಸ್, ನೆಕ್ಸ್ಟ್
Interim order, my lord.
ಇಂಟರ್ ಮಾಡ್ ವಿಲ್ ಕಂಟಿನ್ಯೂ. ನೆಕ್ಸ್ಟ್
174.
My lords, habitual complainant wherein earlier also this court was quashed the matter of first husband,
ಹೌ ಮೆನಿ ಹಸ್ಬೆಂಡ್ಸ್?
2 husbands.
2 husbands. ಆಲ್ ರೈಟ್, 16 ಇಂಟರ್ ಮಾಡ್ ಇದೆಯಲ್ಲ.
Interim order. Extent.
ಎಸ್, 175.
75.
Appear for the respondent, your lordship.
ಎಲ್ಲಿ ಇದು ರೀಕಾಲ್ ಮಾಡಿದ ಆರ್ಡರ್ ಅಲ್ವಾ?
Appear for the respondent, your respondent.
ಹಾ,
BV party.
ಗೊತ್ತು
ಏನ್
ಸರ್.
case ಹೇಳಪ್ಪ?
Yes.
KRDB matter ಇದೆ ಸರ್.
ಗೊತ್ತು ಸರ್, 16th, ಎಸ್. ನಾನೇ ರೀಕಾಲ್ ಮಾಡಿದ್ದ ಆರ್ಡರ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದೇನೆ. ನೆಕ್ಸ್ಟ್
176.
ನೆಕ್ಸ್ಟ್
Respondent, DA case your lordship.
DA ಜೊತೆ ಹಾಕಿ. ವೆಂಕಟೇಶ್,
177.
4 years of inquiry without 17.
ಇದು ಏನಾರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಿದೆಯಾ? 2 ನಿಮಿಷ. ಯಾವ 2 ನಿಮಿಷ? ಲಿಸ್ಟ್ ಆನ್ 9th ಫೈನಲಿ. ಎಸ್
178.
ಎಸ್, ಟ್ಯಾಗ್
179.
DM.
ಟ್ಯಾಗ್ ವಿತ್ ದಟ್. ಎಸ್
180.
ಸೇಮ್ ಟ್ಯಾಗ್ ವಿತ್ ದಟ್. ಟ್ಯಾಗ್ ವಿತ್ ದಟ್. ಎಸ್
181.
Not 81, 82, 83 all DM.
ಸರಿ. ಆಮೇಲೆ
84.
ಇದು ಅಷ್ಟೇ. ದಿಸ್ ಇಸ್ DA.
185.
ಎಸ್ ಬಿ ಪಾಟೀಲ್.
185.
185.
Dereliction of duty, your lordship.
13.
Neither DA nor 7A.
ಇದು ಸಪರೇಟ್ ಆಗಿ ಟ್ಯಾಗ್ ಮಾಡಬೇಡಿ ಮೇಡಮ್. ಲಿಸ್ಟ್ ಆನ್ ರಿಲೀಸ್ ದಿ ಮ್ಯಾಟರ್ ಫ್ರಮ್ ಸ್ಟೇಟಸ್ ಬಿಂಗ್ ಪಾರ್ಟ್ ಹರ್ಟ್ ಫಸ್ಟ್ ಬಿಫೋರ್ ದಿ ಬೆಂಚ್ ಹ್ಯಾವಿಂಗ್ ರೋಸ್ಟರ್. ನೆಕ್ಸ್ಟ್
186.
ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. 186 ಲತೀಫ್.
186.
ಎಸ್
70.
Next to DA case 7A.
186, 187, 189 ಇದೆಲ್ಲ 7A ಪ್ರಸನ್ನ ಕುಮಾರ್.
88, 89 not DM.
ಟ್ಯಾಗ್ ವಿತ್ ದ DA.
190. 191.
191 ಈಗ ಹಿಯರ್ ಮಾಡ್ಬೇಕು. ವೇಟ್ ಜಲ್ದಿ ವೇಟ್. ಎಸ್ ವಿಲ್ ಟ್ಯಾಗ್ ಇಟ್ ಲೇಟರ್ ಬಟ್ ಐ ಆಮ್ ಹಿಯರಿಂಗ್ ದಟ್ ವಿಲ್ ಕಂಪ್ಲೀಟ್ ಇಟ್. ಎಸ್
192.
92, 93 not DM.
ಸೇಮ್
190. Sorry, 194.
195.
55.
195 DA.
ನೋಡ್ರಪ್ಪ ಇಲ್ಲಿ
195.
195 ನಾವಿಲ್ಲ. DA case.
DA ನಾ?
195 DA.
All right. 6.
This is the CBI investigation.
ಇದು ದಿಸ್ ಮ್ಯಾಟರ್ ಸಪರೇಟ್. ಇದು ಹಿಯರ್ ಮಾಡಿದ್ದೀನ. ವಿಲ್ ಪಾಸ್
Sir.
ಆರ್ಡರ್ಸ್.
Yes, madam.
ದಿಸ್ ರಿಸರ್ವ್. ಎಸ್ ಸಂದೇಶ್ ಹೊರಟು ಮಾಡಿದ್ದ.
Please.
ಪ್ರಸನ್ನ ಕುಮಾರ್ ಅಲ್ಲ, ಸ್ಟೇಟ್ ಅಡಿಷನಲ್ SPP ಮಾಡಬೇಕು ಅಂತ ನೋಡೋಣ. ಅದು ಹೇಳಿರ್ತೀನಿ ನಾಳೆ ಬೇಕು ಅಂದ್ರೆ.
191.4. Our name may be deleted, your lordship. Latif means
ಆಯ್ತು
ಅವರಿಗೆ serve
ಆಯ್ತು.
ಮಾಡಿದ್ದಾರೆ.
ಅದು ಹೇಳಿ ಇಲ್ಲಿ ಬರ್ಕೊಡಿ. ನೆಕ್ಸ್ಟ್
91.
Tomorrow, my lords, 196.
ನೋ ಇಟ್ಸ್ ರಿಸರ್ವ್ಡ್. ಎಸ್ ಇಫ್ ಜಗದೀಶ್ ಸೇಸ್ ಸಮಥಿಂಗ್ ದೆನ್ ವಿ ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್. ಎಸ್
197.
DA, my lords.
ಆಲ್ ರೈಟ್, ಟ್ಯಾಗ್ ವಿತ್ ದಟ್. ಎಸ್ 198 ಆಯ್ತಲ್ಲ. ಆಮೇಲೆ ಇದ್ಯಾವ್ದು ಇದು 199.
ಇನ್ಸ್ಪೆಕ್ಟರ್ ಸೂಪರ್ ನ್ಯಾಚುರಲ್.
ಇನ್ಸ್ಪೆಕ್ಟರ್
PNDT.
PCPNDT.
ರೋಡಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ದಾಗ ಸಂಶಯ ಬಂದಿದೆ. ಕಾರನ್ನು ಸೀಸ್ ಮಾಡಿ ಆಮೇಲೆ
ಓ ದಟ್
ಹುಡುಗಿ ಹೆಸರು ಗೊತ್ತಿಲ್ಲ.
ಪ್ರೆಗ್ನೆಂಟ್ ವಾಸ್ ದೇರ್ ಅಂತ. ಅಟ್ ಲೀಸ್ಟ್ ಆಫ್ಟರ್ ಬೇಕು. ಇಂಟರ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲರೂ
ಮಾಡಿದೆ ಒಂದು
ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಇಂಟರ್ ಮಾಡಿದೆಯಲ್ಲ
ಇದೆ ಸ್ವಾಮಿ.
13. ಇಲ್ಲ ಬೇರೆ ಬೆಂಚ್ ಮುಂದೆ ಬರಲಾ
ಸ್ವಾಮಿ?
ರೆಗ್ಯುಲರ್ ಬೆಂಚ್ ಮುಂದೆ ಬರಲ್ಲ, ಆಮೇಲೆ ರಿಲೀಸ್ ಮಾಡ್ಲಾ?
ಬೇಡಿ ಸ್ವಾಮಿ, ತಾವೇ ಹಾಕಿ.
ಅಲ್ಲ 13th ಹಂಗ್ 13th
ಆಗ್ಬೋದು ಸ್ವಾಮಿ. ಎಲ್ಲಿಗ
13th. ಎಸ್ 200. ಇದರಲ್ಲಿ IO to be ಅವಾಗ್ಲೇ ಹೇಳ್ಬೇಕು ತಾನೆ ನಂಗೆ. IO ಪ್ರೆಸೆಂಟ್ ಇದ್ರೆ ವೈ ಟು ದಿ ಆಫೀಸರ್ಸ್ ವೇಟ್? ಯಾಕೆ ಇದು?
Offenses 406, 428. It shall not go going hand in hand.
ಅದಾಯ್ತು. ಈಗ IO ಪ್ರೆಸೆಂಟ್ ಇಡೋದು ಯಾಕೆ?
In flagrant violation of section 41A, he has been arrested. And
Investigating
without
officer.
following the procedure.
present, man.
Where is he?
41A notice issued, my lord.
Issued?
Issued, my lord.
Two
Two times issued, my lord. Third time intimation also delivered, my lord.
But really 41A notice were to be issued. But there should be a document indicating that. But after that, there must be a proceeding saying that and what.
ಈಗ 14 ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ.
Please, ma'am.
ಯಾರು ಕಂಪ್ಲೇಂಟ್ ನೀವು ಅಪೇರ್ ಹಾಕಿ.
It could,
ಮೇಡಮ್
order sheet indicate.
My lord, some
that
wait for
directly they
complaint.
produce.
wait.
ಕೊಡಿ. ಅವ್ರು ಕಮ್ಮಿ. ಕೊಡ್ದೆ. ಕೊಡಿ.
ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ, 41A ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದೆ, ಅರೆಸ್ಟ್ ರೀಸನ್ ಕೊಟ್ಟಾಗಿದೆ. ಹಾ, ಎಲ್ಲ ಇದೆಯಲ್ಲ ಸರ್,
ಕಂಪ್ಲೈ ಮಾಡಿ.
17 ಮೇಲೆ 19 ಅರೆಸ್ಟ್ ಮೆಮೋ
ಅದು
Alright.
ಇದೆ,
ಅದರಲ್ಲಿ
ಅದರಲ್ಲೂ ಎಲ್ಲ
41 ಮೇಲೆ ವಿತ್ ಡ್ಯೂ ರೆಸ್ಪೆಕ್ಟ್ ಟು ಕೋರ್ಟ್.
ಅದ್ರಲ್ಲಿ 41A ಮೆನ್ಷನ್
They have not issued at all. If really they are issued, my lord, I would not have rushed before this honorable court. My lord, after filing the application, my lord, this petition.
ಒಂದ್ ನಿಮಿಷ,
10:30 I filed
ಒಂದ್
this
ನಿಮಿಷ ಸರ್. When
Please.
were you arrested?
12th night, man. 12th night.
12th night, ಯಾವ ಶೇಕ್ಸ್ಪಿಯರ್ ಡ್ರಾಮಾ ಅಲ್ಲ, ಯಾವತ್ತು ಹೇಳಿ ಸರ್?
12/12/2024.
12/12.
2024.
9/11 is the first 41A notice. 11/11 is the second 41A notice.
After 1 month.
Personal intimation is issued in the end of November. You did not appear or cooperate. Crime is
My lord,
registered long ago.
Absolutely, my lord.
No,
I'm appearing before the court.
Sir, one ನಿಮಿಷ. Crime is registered long ago on 1/6/2024. You have not cooperated for the investigation despite issuance of notice. So you are taken into
My
custody.
lord, kindly order sheet, my lord.
I know.
11th.
ನೀವು
12th.
ಇದ್ರಲ್ಲಿ ಇರೋ ಬದಲು
13th
ಬರ್ದ್ಬಿಟ್ರೆ ನಿಮ್ಗೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ? ಅರೆಸ್ಟ್ ಮೆಮೋಲ್ ಬರೆಯಕ್ಕೆ ನಿಮ್ಗೆ
Well, that is, my lord, what they are saying that ಹಳೆ crime ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ ಅವರು,
ಹಳೆ ಕ್ರೈಮ್,
which your lordship has stayed.
ಕ್ರೈಮ್ ನಂಬರ್ ಏನಿದು? ಇಂಪ್ಯೂನ್ ಕ್ರೈಮ್.
192, crime number 192, which your lordship has stayed.
Sir,
But
this is
after-
not crime number, this is 371 of 24. I am reading the
371.
documents in 371 of
Yes, madam.
24.
Order sheet ಅಲ್ಲಿ kindly produce ಮಾಡಿದ್ದಾರೆ.
Order sheet ತಪ್ಪಿರ್ಬೋದು, all the records are here.
My lord, order that they have not signed. My lord, if really they have
Signed, my
side of me, my lord, certainly I would have.
And he is a
would have
habitual
appeared.
offender, my
Right.
lord. There are 2 other cases also.
But let me
registered.
submit.
One
certainly,
ನಿಮಿಷ,
sir.
what is the complaint?
My lord, complaint
My
would
lords are
say
appearing for
there
the
is no
complainant.
allegation.
Statement.
My lord, there is no relationship
Now,
between me and the
now
complaint.
there was no warrant to summon the investigating officer at all.
My lord,
Yes, what's your name?
one submission, my lord.
Who is the SHO of Jayanagar Police Station? You are Deepak?
My lord, one submission, my
ನಿಮಿಷ.
lord. And
These
crime
re-
number
one ನಿಮಿಷ, sir.
371. Please.
These records are
What were you after
371 of
comment?
24, crime number? Crime number 371 da ಇದು?
Yes.
Huh? No, 192 or 374? 371. Notice ಇವರಿಗೆ 41A ನೋಟಿಸ್ ತಲುಪಿತ್ತಾ?
My lord,
ಕೊಟ್ಟಿದೆ.
this very crime registered on 9/11 itself, 9/11. 6/11 they are showing.
Correct, 9/11 ಕೊಟ್ಟಿದ್ದಾರೆ.
9/11 ಅಲ್ಲಿ crime register ಆಗಿದೆ.
We have
My
taken
lord,
this.
11/11 they are claiming now, my lord, they are claiming they have served this notice upon me.
ಹೌದು.
My lord, there is no iota of evidence to
They have
indicate
taken
that
the
I have done.
signature, my lord.
If we gone disbelieving every 41A
And,
notice that is issued,
My lord,
Yes,
and
my lord.
ಆಯ್ತು 41A notice,
order sheet ಅಲ್ಲಿ if really they are assume for a moment they have issued
One ನಿಮಿಷ.
notice, my lord.
41A notice ಅಲ್ಲಿ
Please.
ಕ್ರೈಮ್ ನಂಬರ್ 371 of 24 ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ, 406, 420 ನಿಮ್ಮ ಮೇಲೆ ಏನಿದೆ ಎಲ್ಲ ಹೇಳಿ.
ನಮಗ್ ಬಂದೇ ಇಲ್ಲ. ನಮಗ್
That's
ಬಂದೇ ಇಲ್ಲ.
inspection.
What means they have sent? They have taken the signature on the notice. That is also not there. My lord, if really they have signed, my lord, really they have
ಆಯ್ತು,
signed.
ಈಗ 2 ದಿನ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಅರೆಸ್ಟ್ ಯಾಕೆ ಮಾಡಿದ್ರಿ? ಹಾ, ಪ್ರೀವಿಯಸ್ ಕೇಸ್ ಇಂದ ಅರೆಸ್ಟ್ 192 ಅಪಿಯರ್ ಆಗಿಲ್ವಾ?
That is staying.
192 ಸ್ಟೇ ಆಗಿದೆ, ಅಪಿಯರ್ ಯಾಕೆ ಆಗ್ಬೇಕು? ಸ್ಟೇ ಆದ್ಮೇಲೆ ಅಪಿಯರ್ ಯಾಕೆ ಆಗ್ಬೇಕು?
Being enraged with that, my lord, they are doing this.
192 ಸ್ಟೇ ಆಗಿದೆ. ಬಿಫೋರ್ ದಿ ಸ್ಟೇ ಯಾವತ್ತು ಸ್ಟೇ ಆಗಿದ್ದು? 192
Stay. My lord, 9 July 2024.
9th July 24.
Please, my lord.
ಅದಕ್ಕೆ ಮುಂಚೆ ಅಪಿಯರ್ ಆಗಿಲ್ವ ಇವರು?
Absolutely.
We can't, sir, we can't doubt. ಇದ್ಯಾರ
After
signature?
one-
What's
after
your
1
name?
month he is
That-
arrested.
Am
my lord.
Prasad.
Ashwin R. Prasad.
Ashwin.
Ashwin R. Prasad. My lord, order sheet
ಇದು
would indicate,
ಇದು ಯಾರ
371 order sheet would indicate.
signature?
Please.
Your signature is here.
My lord, these in
Sir,
custody.
signature ಅಲ್ಲ
ಅಲ್ಲ
ಸರ್.
custody ಅಲ್ಲಿ ಇದ್ದಾಗ
ಯಾವ
ಇವಾಗ
41A ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದಕ್ಕೆ
ಅಲ್ಲ, ಈ custody ಅಲ್ಲಿ ಇದ್ದಾರೆ.
9/11ಗೆ 9/11 ಯಾವತ್ತು ಕಸ್ಟಡಿಗೆ ತಗೊಂಡಿದ್ದು?
12th ಗೆ custody
12th
ತಗೊಂಡಿದ್ದಾರೆ. ಯಾವ
ಒಂದ್ ನಿಮಿಷ, 12th ತಾನೆ. 9/11 ನಿಮ್ ಸಿಗ್ನೇಚರ್ ಇದೆ, 11/11 ನಿಮ್ ಸಿಗ್ನೇಚರ್ ಇದೆ. You did not appear, 12th ಕಸ್ಟಡಿ
The conversation between me at the time when they waylaid me and arrested, and conversation is there. You come to the police station, I'll serve the notice. If your lordship permit me, my lord, I will show, I will.
Look at this.
Uh,
In police forgery ಮಾಡಿದಾರಾ?
That is the case, my lord.
Certainly, my lord, in this case, my lord, I don't, I'm sorry to say this, my lord, in this case, certainly, my lord, and my lord, if really they have signed, if they really they have
ನಾವು
summoned,
ಪೊಲೀಸ್ ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇವತ್ತು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಆಮೇಲೆ there is no there is no allegations,
Seek
406 and 406.
bail, seek bail.
420 and 406. My lord,
ಇವತ್ತು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ವಿ. ಇವತ್ತು today is
my
the
lord,
last date.
my lord, in the one more sub, kindly, my lord, bear it, my lord, 1 minute. And there between victim and me, there is no there is no transaction at all.
ಅದು
But
merits
she would
ಮೇಲೆ.
say, my
I-
father has,
sir,
he has been cheated.
I did not entertain the petition on the ground of merits. Only on the score that you said you are
My
49
lord,
notice.
my lord,
On that I have
on
recorded
this count,
whatever.
one submission. 371 order sheet kindly produce, my lord, ಕೊಟ್ಟಿದ್ದೀನಿ. If really they have served notice, my lord, they should want all these things. My lord.
That
They
is-
have not,
that is the mistake they have done. ನಿಮಗೆ
And
ಬರೆಯಕ್ಕೆ
they
ಅರೆಸ್ಟ್
have not
ಮೆಮೊಲಿ
taken permission from the
ಎಲ್ಲ
court.
ಬರೆಯಕ್ಕೆ
Permission ಕೊಟ್ಟು ತಗೊಂಡಿಲ್ಲ.
ಏನ್
magistrate
ಪ್ರಾಬ್ಲಮ್
ಅಂತ.
ಬರೆಯಕ್ಕೆಲ್ಲ 2 ಲೈನ್ ಜಾಸ್ತಿ ಬರೆಯಕ್ಕೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್?
My lord, the direction,
ಅಲಿಗೇಷನ್ ನೋಟಿಸ್
the
ಕೊಡ್ತಾರೆ.
guidelines and directions issued by this one of court time and again. Time and
That
again.
is followed, sir.
ಹೌದು.
That is followed in this case.
ಅಲ್ಲ ಇದರಲ್ಲಿ magistrate permission ತಗೊಂಡಿಲ್ಲ.
ಯಾವ್ದಕ್ಕೆ ಪರ್ಮಿಷನ್?
ಇದರಲ್ಲಿ to arrest the process. That's what, my lord, in the Apsana case, Supreme Court also said, my lord.
If you don't cooperate with the investigation, they have a right to take you into
Yes, my lord, for that, my lord, they have to make out a ground before
ಅದನ್ನೇ
the
ಹೇಳಿದ್ದು,
magistrate
ಅದನ್ನ
court,
ಗ್ರೌಂಡ್ಸ್ ಯಾಕೆ ಮಾಡಿ?
before the magistrate court, and obtain permission from the magistrate court. And magistrate has to examine whether really I have cooperated or not, and grounds have made or not.
You take out all the grounds on Friday. List on Friday. ಈಗ ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
ಯಾಕೆ?
ಇವತ್ತು ಕೊಡ್ತೀವಿ.
Then waiting, passed over matter, waiting for the,
Yes, list on Friday in the fresh matters list on merits. You apply for bail. We'll see if it is stayed, not necessary. If it is not stayed, you have to secure bail.
My lord,
Please.
one humble
Correct.
submission, we've not received any copy, none of the
ಅದೊಂದು
respondents.
ಕೊಟ್ಬಿಡಿ ಸರ್, ಕಾಪಿ ಕೊಡಿ.
None of the respondents have received any copy, all 5.
How many respondents are there?
5.
straight ಕೊಟ್ಟಿದ್ದೀವಿ.
You want 5 copies?
Straight
No, I am just one.
One
Straight
copy ಕೊಡಿ.
Bill.
Yes.
Please.
Henceforth, when you record something, you record every reasons ಕೊಡಿ ಅದರಲ್ಲಿ. ಬರುತ್ತೆ. Yes.
Magistrate, my lord, again,
ಅದು ನೋಡೋಣ, on Friday we'll take it.
because since ಇದು pending ಇರೋದ್ರಿಂದ ಅದಕ್ಕೆ
ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿ ಕೊಟ್ರೆ bail ತಗೊಳ್ಳಿ. Yes. 406, 420 bail ಸಿಗುತ್ತೆ, don't worry. Yes. Next.
at least some directions into that.
Why is madam waiting?
Ah, my name is here,
To that extent, my lord,
my name.
ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲ?
to direction to the magistrate, to that extent.
What bail ತಗೊಳಕ?
Yes, my lord, that's just.
Apply for bail.
ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಇದು objection
Without
ಅದು
bail
ಇದು-
ನಾನು ರಿಲೀಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಕ್ಕಾಗತ್ತಾ ಇಲ್ಲ?
ಅಲ್ಲ, ಮತ್ತೆ objection ಈಗ peculiar circumstance ಅದಕ್ಕೋಸ್ಕರ.
You apply for bail. Anyway, you are appearing there also. Then you will get bail. Yes. After 15 days. You are going to object. Alla? Yes.
Friday.
If it is stayed, no bail. Not necessary for a bail. If it is not stayed, then you will have to secure bail. On Friday, copy ಇವತ್ತೇ serve ಮಾಡಿ.
Tomorrow.
Copy ಇವತ್ತೇ serve ಮಾಡಿ.
Sir.
You are being sent to judicial custody. Yes. Next.
All right from Anish Kumar and Apsana, custody also is not required.
Whatever Afsana is there, we'll see later.
Even my lord. And your lordship to more than one occasion also directed to follow the.
What
proposed
Afsana
follow-
we'll see later.
But
Yes.
with scant respect, my lord, I have not followed in the.
Sir,
end of the day
every,
after
ಅದು
arresting-
ಇದ್ದಿದ್ರೆ ಇವಾಗ್ಲೇ, if that was there, ಇವಾಗ್ಲೇ ರಿಲೀಸ್ ಮಾಡಕ್
ಅಲ್ಲ,
ಹೇಳ್ತಾರೆ.
ಅದೇನಂದ್ರೆ after-
Everything is
Lord,
here.
it's all after that, my lord.
ನೋಡಿ, after thought.
All ಇದೆಲ್ಲ
ಗೊತ್ತಾಯ್ತಲ್ಲ?
arrest ಆದ್ಮೇಲೆ they have taken it.
Yes, SHO. ನಿಮ್ಮೇಲೆ ಈಗ ಆಫ್ಟರ್ ಥಾಟ್ ಆಮೇಲೆ ಬರ್ದಿದ್ದೀರಾ ಅಂತ. ಬರೆಯಕ್ಕೆ ನಿಮಗೆ 2 ಅಕ್ಷರ. ನೀವು ಅರೆಸ್ಟ್ ಮೆಮೋಲಿ ಬರೆಯಕ್ಕೇನು ಕೋಆಪರೇಟ್ ಮಾಡಿಲ್ಲ, ಅದಕ್ಕೆ ಟೇಕ್ ಇನ್ ಟು ಕಸ್ಟಡಿ ಅಂತ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಬಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕೇನದೆಲ್ಲ ಪ್ರೊಸೀಜರ್ ಗೊತ್ತಿಲ್ವಾ?
Conversation records. Conversation records ಮೇಲೆ if your lordship permit me not 1 minute, I'll demonstrate.
Friday, yes. Next, yes.
For the petitioner, my lord.
Yes, Arjun,
Data,
ನೀವು
my lord.
ಸಬ್ಮಿಟ್
My
ಮಾಡ್ಬೇಕು.
lord, my submissions are ready.
ಅಷ್ಟೇನಾ?
No, I'll submit
Yes.
also. I'm placing this for convenience. Not, at the
Serving my
outset, I
friend
must
a copy.
apologize
Ah.
to my friend and as well as to the court because I said I'd served online. There was some miscommunication. It's been sent to
Given.
a wrong individual. So
Okay.
but it was served and
There
then.
are many
it was-
Arjuns.
No, no.
thing had happened. I have to apologize for my friend because I said in open court that I'd served on him. I'd in fact said because he was on VC, so I've made sure that he should have a copy.
All right, all right.
May I, my lord?
Ma.
Lords, I've prepared my response in seriatim to what my
Whatever
learned
he
friend-
had.
Whatever he
So
had said. my lord.
seriatim versus seriatim.
Seriatim versus seriatim.
All right, yes.
I'll keep it brief, my lord.
All
Lord,
right.
the first submission, my lord, is there is a violation of Priyanka Srivastava. My lord, he says that I should have filed an affidavit saying that I have followed that procedure.
Hmm.
My lord, here is a case where I filed a complaint before the learned magistrate under section 200. My prayer was for cognizance, securing presence and punishment. And my lord, my oral submissions on the date of presentation are recorded to the effect that I am seeking cognizance. I never sought investigation, my lord. It so happens that the learned magistrate referred it for investigation. That happens later. That's post facto. Now, my lord, clock can't be turned back and it be said that my complaint is, that's one aspect. Second aspect, my lord, my learned friend says that the complaint can't be looked into now. My lord, I have prepared a complaint with what I thought was further facts. Voluminous material is there. Now, my lord, the
And you
police
said
wait-
you did not draft it anyway.
My lord,
You did not draft.
I did not draft it, sir.
All right, yes.
Neither do I know which city that lawyer is from.
In the address, you can find it in the complaint in para 1 is addressed.
But my lord, I make an effort, I place all of that. Thereafter, my lord, the police takes 5 long years, as my learned friend correctly pointed out. And they file a charge sheet where, my lord, column number 17 is 6 lines. And they choose some documents from my complaint and put it there. Now, my lord, I can't be left wholly to the mercy of what the investigating officer deigns fit to place before the learned magistrate. After all, my lord, even in these proceedings, I am heard. It's not only the charge sheet. That's on that. The other aspect, my lord, my learned friend said that there is non-application of mind because the very same offenses mentioned in the complaint are referred for investigation and the same offenses are also found in the charge sheet. That can't be the standard, my lord. That by itself does not. Then, my lord, my learned friend sought to take advantage of the fact that the order taking cognizance says peruse the complaint. Typographical error. Just after that, the learned magistrate says complaint, mazar, statements and other materials. All of those are only with the charge sheet. Errors happen, my lord. Can't take advantage. Then, my lord, non-application of mind because 447 of the Companies Act, the cognizance has them. I must concede, my lord, that can't. As far as 447, that has to go. Then, my lord, my learned friend says higher standard of review because it is a lawyer drafted plaint. Lord, it's a PCR. Lawyer will have to make some effort to present it
No, he did
for
not
a
say-
magistrate.
He did not say urgent drafted, so don't worry. Yes.
That's one thing. In fact, my lord, that judgment would only say that even if all the ingredients are made out, court can look into other circumstances also. That judgment never says that simply because a lawyer's pen has touched the paper, it must be viewed with suspicion. Does not say that. Then, my lord,
No, Supreme Court said circumspection, not suspicion. Yes.
not suspicion. Then, my lord, again, my learned friend says 161 statement is not there with the, my lord, I have been called, I have been summoned, I have gone there. I have recorded my statements. Again, I'm at the mercy of the police. My lord, victim cannot be left at the mercy of what the police decides after 5 years. Then, my lord, on mutually destructive offenses. My lord, the burden is on my learned friend to show which are the offenses, how they are mutually destructive, which are the facts in respect of those offenses. That burden is not discharged except for presenting a general proposition. Also, my lord, my lord, I'd like to rely on section 221 of the CRPC, where, my lord, there is a doubt that certain facts or series of facts may constitute more than one. Magistrate can decide later. That can also be taken up in discharge. That by itself, my lord, respectfully would not be a ground for quash. Then, my lord, the issue of, and my lord, in fact, in this case, with regard to the theft and the misappropriation, it's a series of acts, my lord. He has my laptop. He misappropriates it for use of another rival business which he starts. Thereafter, my lord, he leaves. I demand its return. He knows it's mine, he doesn't return it. Respectfully, my lord, that's theft. That would come under the illustration. Series of acts can be different things. Then, my lord, my learned friend says data cannot be the subject matter of theft under 378.
No, 378, it's under 66D.
In my respectful submission, my lord, certainly it can be under 378. I'll also come to how these can coexist. But firstly, my lord, whether it would qualify for 378. My lord, the Evidence Act has been amended. Document includes electronic records. The Honorable Supreme Court has held, my lord, I placed that judgment. Document and information contained therein is also corporeal for the purposes of 378, 379.
Correct.
By that, my lord, data can also be stolen. Can be the subject matter of this. The judgment on electricity, my lord, in 1956, before data was, I don't think, Then, my lord, on these general, the question of whether the general offenses under IPC eclipse the specific offenses under the ITN. My lord, in my respectful submission, my friend has misread the judgment in Digumati. Digumati does not lay out such a general proposition. It says what it says with regard to that offense of obscenity. The Honorable Bombay High Court has read Digumati, my lord, and passed a judgment interpreting how Digumati should be followed. I placed that also. The ratio there is when, my lord, the offenses are not only identical, but the ingredients are also identical, then, my lord, one would have to only seek relief under the special law, which is the IT Act. Yeah, my lord, my learned friend respectfully has not discharged that burden, except for placing a general proposition, which in my respectful submission is wrong, not discharge that burden at all. Then, my lord, my learned friend said that the court must distinguish the emotional experience of, lord, with respect, my lord, there is a charge sheet. My friend should show what the material is, how no offense is made out, various are they. I don't think this endeavor, my lord, is. Allegations are civil in nature. That was the other limb. Yes, my lord, there was a civil suit, and I placed references for your lordship's convenience. Civil suit is filed subsequently. I first rushed to the Honorable Magistrate. And, my lord, I don't need to make these submissions, but both can coexist, my lord, so long as each is individually made out. My friend's written submissions appear to advise us, say, certain advice that some remedy is better. Maybe so, my lord, but this can also coexist. There's no. Then, my lord, on some submissions which were consciously not made on behalf of the petitioner, they have only raised these legal points, which in my respectful submission, I made an attempt to address. Their burden is to show your lordships what is the material, how no offense is done. Thereafter, seek. And the standard there is higher, my lord, because after all, there is a remedy of discharge available for my learned friend. They can't now ask your lordships to split hairs and decide whether a certain set of facts constitutes one offense or the other. And certainly, my lord, even if my friend says it can't be both, the result cannot be that it is neither. That can't be, and 221 is an answer to that also. Then, my lord, I won't detain your lordships by taking your lordships through it, but all material, whatever is there, I placed references. On final submission, my lord, here is a case where the director and senior employees have left with data, started arrival. My case is that they have sabotaged my business while in my employ and then gone there and taken benefit. They always have the remedy of discharge. Complaint averments are there. There is material. Justice would be served, my lord, in my most respectful submission if they are relegated to that remedy. Not here.
3 minutes in response. I have one list of citations in response. Oh, sorry, I've already served. Lord, the first point that Priyanka Srivastava need not have been complied with, because what was filed was a 200 complaint with no accompanying affidavit, and the request for the prayer was for taking of cognizance on that complaint. Please take, my lord, page 54 of his petition. Para 24 and 25, he says what has been the subject matter of theft is copyrighted material. I, as an individual, do not have the power to go and seize laptops, seize electronic records. So the police have the power to seize this. Police have state power, they can go seize it. So he says the police can do it. So essentially his prayer was that the police must exercise their state power and confiscate it. That could only have been done if there was a 156.3 reference.
Your suggestion is, once 156.3 is sought for, affidavit is mandatory. Because he says police have to investigate it.
No, let me clarify. In his prayer, he's not asked for a 156.3 reference.
No,
he asked for cognizance. The effect in his complaint, he asked for police to investigate because he wants seizure of laptops. He cannot come into my property, seize my laptops. So please see para 24-25. He says copyrighted material has been stolen. So if copyrighted material, he says only the police can seize it. So he wants the help of police. So he cannot say he went to 200 and wants court to take cognizance on 204 on the documents he has. If he has to prove that data was in fact stolen, he'll need the laptop and the data to be sourced from my laptop. That was not done. So on Priyanka Srivastava, that's my response. His second point, my lord, is that the complaint would in fact have to be looked into. Lord, as I told your lordships, whether your lordship will look at the complaint or whether your lordship will look at the charge sheet will entirely depend on what cognizance was taken. He approached the magistrate. He wanted the magistrate to take cognizance on the complaint. Magistrate did not take cognizance on the complaint. Magistrate has the liberty to refer it for police investigation. In fact, that's a better resort than cognizance because he never had that data in his laptop and he could not have got it on a magistrate taken cognizance, 204, if even have summoned, he could not have shown that. He needed the police. So, my lord, cognizance was taken after a 5-year investigation without an FSL report, without any recovery, on a charge sheet and a cybercrime police charge sheet. It was not the regular police. So, cognizance having been taken on a charge sheet, the case becomes a case instituted on a police report. If it's a case instituted on a police report, the prosecutor will have to conduct prosecution, not the complainant. Under 301, he can only assist the prosecutor subject to application. So he cannot say that the complaint also should be looked at. Not, it's completely inconsistent. Even if he files a separate complaint under 210, the complaint will be stayed and it will become the prosecutor-led prosecution. So the complaint cannot even be looked into. If the complaint cannot be looked into, my friend says it's my burden to show what is there in the charge sheet. My burden I have discharged by saying there is nothing in the charge sheet. My friend has not reversed that burden and shown what is there in the charge sheet. So that's point number 3, my lord. Point number 4, my friend very fairly concedes a typographical error that in fact goes to my advantage. Because if my friend says it was not perused the complaint and cognizance taken on a complaint, it's cognizance taken on a charge sheet. If it's a cognizance taken on a charge sheet, it must be the case that it's a case instituted on a police report. That's point number 3, my lord. Point number 4, my lord, on lawyer drafted complaint, my friend is right. He's read. My learned friend, sorry, my lord. My learned friend is right in saying that Mohammad Wajid, Justice Padiwala does not say in the context of a lawyer drafted complaint. Why I emphasized on a lawyer drafted complaint is because what Justice Padiwala cautions the court is, if through the device of clever drafting,
Both in Muhammad Ali and Wajid.
both in Muhammad Ali and Wajid, the idea is through the device of clever drafting, if you bring in allegations which fit the ingredients of the offense, the 482 court must be more suspect. There must be a more searching inquiry. It's not the case.
Not suspicion, sir.
Not suspicion, more
Circumspect.
circumscribed, a deeper inquiry. That's all I ask. And that's assuming, my lord, your lordships can see the complaint. Your lordships have already shown in a case instituted on a police report, your lordship will refrain and completely do away with the complaint. Because the magistrate itself did not find any reason to take cognizance on that. Point number 5, my lord. No 161 statement my friend himself has admitted. So you have a 5-year police investigation, no recoveries, no 161 statements, and you have 6 witnesses, 3 police witnesses who testify that one has recorded the Mazar, one has recorded the FIR, and one investigating. When the complaint himself suggested 4 witnesses who were his IT staff who had apparently recorded and recovered material, they are not investigated. That's point number 5. Point number 6, on mutually inconsistent allegation, my friend says it is my burden to show to your lordships how I've understood the complaint. My friend must show from the complaint, because he says your lordship should see the complaint. He's not shown your lordships the complaint.
Right.
My learned friend, sorry. So my learned friend has shown that your lordship should see the complaint. If your lordship see the complaint, your lordship will really, not even in a lawyer drafted complaint, I'm really confused as to what is the case against me. It cannot be the case. I've shown your lordships, it can't be data theft as well as data misappropriation. And that also, my lord, if my learned friend had first satisfied the larger burden on his part to show data constitutes property, which my learned friend has not. Lord, point number 7, whether data can form subject matter of an offense of theft. Lord, I have given your lordships another judgment which I had not produced on the earlier day. I went back and did some more research. As I told your lordships, my friend has also not shown any Indian judgment. I have not found any Indian judgment. There is one judgment of the Supreme Court of Canada. Because it's a Commonwealth country, my lord, it can have some persuasive burden on your lordship. Your lordships will see that. Your lordship will find whether confidential information can form the subject matter of an offense of property was in detail considered. One of the reasons why they said it cannot be property for the purpose of theft is, at the end of the day, how does a court decide which information is confidential? Will the 482 court sit and decide what information? Today he says price list. If I sit in front of a computer laptop, if I were to through my naked eyes read what is said and incorporate that in a separate laptop, will that amount to theft? What has he been deprived of? It's already in his laptop. Same, lord, but your lordships will have to decide, my lord, and accept or reject my argument whether data, whether confidential information which my learned friend has been stolen from him can form the subject matter of an offense of theft, because that's his best case. Your lordships have already said that there is no entrustment of data which can happen, because entrustment will require that possession is lawfully acquired by me. In his case, he alleges that property was removed from him without his consent. So I've given that judgment of justice of the
Delhi High Court.
Supreme Court of Canada, my lord.
Canada.
And there are 2 more judgments of the Delhi High Court is on a different point. On 8, my lord, my learned friend says I have misread
Don't worry about it.
Digubarti, my lord. Digubarti, your lordships will see. There the context was IT Act and 292 of obscenity. Special will displace the general. charge sheet material 10 allegation is civil. My lord.
That's fine.
And my
Heard
lord, I have
this.
also given your lordships original notes of Lord Macaulay, in which he discusses on chapter on offences against property. Your lordship will also consider that. My lord. Grateful. My lord.
You have anything again on Macaulay?
Nothing
Yes.
at all.
Yes, heard reserved. Yes,
Grateful.
Sangat, yes. Heard the learned counsel Angat Kamath appearing for the petitioner and Arjun Rao representing the respondent. Reserved. Intermodal ಇದೆಯಲ್ಲ?
ಇದೆ.
Intermodal.
Intermodals there, my lord. Intermodals. Grateful. My lord.
Both matters. Both matters. Both matters. What's the other one? Same. Other one same ಅಲ್ಲ?
Same thing, the accused number.
ಇದ್ರಲ್ಲೂ ಅರ್ಜುನೇನಾ?
Yes.
Same thing?
If they take the same grounds, my reply is.
They're all employees of the company, your lordship, same.
Same thing. 230 matters ಬಂತ ಮೇಡಮ್. ಇದು ಇನ್ನೊಂದು ಮುಗಿಸ್ಬಿಡಿ ಅದನ್ನ. Next 202.
Petitioner in this case, my lord.
Please direct us
ಯಾರು
to not
ಹೋಗ್ಬಿಟ್ರು
file
ಅಂತ
this
ಹೇಳಿದ್ರಲ್ಲ
synopsis.
ಅದಿಲ್ವಾ?
Synopsis ಸಾಕು ಕೇಳಿದ್ದು.
ಕೊಡಿ. ಸಿನಾಪ್ಸಿಸ್ ನೀವು ಕೊಡಿ.
As regards to 202.1, my lord, I had filed an impleading application to be impleted.
ಬರ್ಲಿ ಬಿಡಿ. ಏನಾಗುತ್ತೆ?
I am filing some few documents to be perused.
ಯಾವ್ದ್ರಲ್ಲಿ? ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್.
ಅಲ್ಲ ನನಗೇನಾರ
ಅದವ್ರ ಕಾಪಿ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ sir.
ಹೆಂಗು ಇದ್ರಲ್ಲೂ ಜೊತೆಗಿದ್ದೀರಾ? ಅದ್ರಲ್ಲೂ ಜೊತೆಗಿರಿ. ಏನು?
My lord, there is another one more submission in this
The
matter.
one ನಿಮಿಷ. The learned counsel for the petitioner has filed an application seeking impleadment as a party respondent in 202.1. In the light of the learned counsel will say an objection.
ಏನಾದ್ರು ಇದ್ರೆ I'll file synopsis.
Learned counsel P. Prasanna Kumar submits that he has no objections at this juncture, but if necessary would file written submissions qua the impleading applicant as well. Therefore, the impleading application is allowed, the petitioner is permitted to come on record.
Please.
The impleading applicant is permitted to come on record as a party respondent.
The other submission is, my lord, all this litigation emanates from certain writ petitions between the parties, my lord. The subject matter of investigation is also the same, my lord. I am requesting this honorable court through a memo.
That cannot be because we are litigating as far as KLR is concerned. But that will not take away the jurisdiction of this honorable court.
Oh, my lord.
To decide whether or not there is an offence or not.
The memo depicts this, my lord. The documents which they allege that we have forged is all produced before the honorable court, which before the coordinate bench. Just making a mention, my lord, to consider the memo file.
ಅದು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನೋಡೋಣ ಬೇಕಾದ್ರೆ. ಇದು ಹಿಯರ್ ಆಗ್ಬೇಕಾದ್ರೆ ಬೇಕಾದ್ರೆ
ಆಯ್ತು.
ಫಸ್ಟ್ ವಿಲ್ ಹಿಯರ್ ದಿಸ್. ಇನ್ನೇನಿದೆ ಈಗ? ಬಟ್ ಇವತ್ತಾಗಲ್ಲ. ನೀವು ಇದ್ದೀರಾ ಮೇಡಮ್ ಇದರಲ್ಲಿ?
Your lordship, just one mention, your lordship.
In this matter?
In 167.31, your lordship, the batch of 7A matters. In ours, we've been mentioning last two occasions, your lordship. Despite your lordship's interim order, they have proceeded and they have forcibly recorded evidence and gone ahead with the matter. And I just
Interim order is not to file charge sheet.
Interim order, yes.
If not to file charge sheet ಅಂದ್ರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಲೇಬೇಕಲ್ಲ?
ಇಲ್ಲ, no coercive steps ಅಂತ. But your lordship, they're aware that if these matters are heard and therefore they've gone about it.
Let BB Patil come, or ಯಾರಿದಾರ ನೋಡಿ. I'll take it.
Please.
Yes. You want to submit now?
I think I already made submissions. Could be resolved.
ಸಾಕಾ?
In response, I need some time.
ನೀವೇ ಟೈಮ್ ಬೇಕು ಅಂದ್ರೆ.
ಅವರೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದು ನಾನು ರಿಪ್ಲೈ ಮಾಡಿ.
ಅವರು ಮಾಡಿದ್ರು. I wasn't present and I.
ಅಲ್ಲ ಇದ್ರಲ್ಲ.
In your absence, I have not heard anything.
He was there. He was very much there. ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು ನಾನು ರಿಪ್ಲೈ ಮಾಡಿದೆ ಅಷ್ಟೇ. You should direct us to file synopsis. That's all.
That is the case.
One time ಅಂದ್ರೆ I'll grant, but it can't be
on this
year, next year. Next year, probably.
I need to argue on those writs also, drawing relevance.
It's whatever. List on 9th.
Please.
There's one request. No, the documents which I say that he has fabricated are produced by him, not in OS 42 of 2022.
Other than the records.
Adರಲ್ಲಿ, my only request is, now he has made an application seeking return of those documents which are all fabricated and forged. My only request is that there be direction to the principal district judge Bangalore
Let us not
to
see.
retain it.
Allah, let us not.
Let him not take it all.
No, some matters are before the other courts.
Please.
And some matters are here.
Please.
Some matters you say are in the OS.
Please.
If you want, we'll tag everything together and hear it whole hog. ನನಗೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಮಾಡ್ಬೋದು.
But if the direction is to be given, then in 482 ಏನ್ ಕೊಡಕ್ಕಾಗಲ್ಲ. If you want everything to be.
ಏನಿಲ್ಲ, my only request is documents ಇರೋ safe custody ಇದ್ರೆ ಸಾಕಂತ.
ಅಲ್ಲ,
Let
but
him not take it and will not destroy it.
ಇದು ಯಾವ್ದ್ರಲ್ಲಿ ಕೇಳಿದಾರೆ ಅದನ್ನ ಅವರು?
Not the, no, no.
IO is sought. that
IO
is-
has sought.
IO is sought honorable court.
Hmm.
The
Which
honorable
court?
Not in Bangalore city, city civil court, Bangalore.
Which are those documents?
But those are the documents which according to us, not the forged documents, forged outside the court and then produced inside the court. So 195 CRPC also may not be applicable.
195
ಬರೋದಿಲ್ಲ, ಬರೋದಿಲ್ಲ.
who attracts. No money.
that is subject matter which proceeding?
OS
That is
24
when OS.
ಅದೆಲ್ಲ
44
OS.
OS
ಇದ್ರಲ್ಲಿ ಅಲ್ಲ ಅಲ್ವಾ?
ಅಲ್ಲ, ಅದರದೇ those documents are not the forged documents according to us. On the basis of my complaint, the present FIR is registered.
That is
But
why I
check up.
made a submission, my lord.
If all of you say, we'll hear everything together, we'll hear everything
think-
together.
And the memo, I'm
Please, no,
permitted to
I shall give hand over not the list of the other cases.
ಎಲ್ಲ ಕೊಡಿ, we'll
Please.
tag everything together and hear it on 9th or 10th.
Please.
My lord permits, I will file now only.
ಏನ್ ಕೇಸಸ್ ಅದು?
ಎಷ್ಟು ರೇಟ್ ಪೆಟಿಷನ್ಸ್ ಇದೆ ಅಂತ all these.
ತುಂಬಾ ಇದೆ.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಇಲ್ಲ ತೊಂದ್ರೆ ಇಲ್ಲ. ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಒಂದೇ ಇದೆ.
ಆಯ್ತು ಸರಿ.
ಮಲ್ಟಿಪ್ಲೈಡ್ ನಾಟ್ ದಿ
No
ಡಿಫರೆಂಟ್
problem.
petitions.
ಅದೇನ್ ಈ ಪ್ರಾಪರ್ಟಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಏನೇನ್ ಕೇಸ್ ಇದೆ ಎಲ್ಲ ತಗೊಳ್ಳಿ.
Please.
Yes, and ಅದಾದ್ರೆ in that I can give a direction that IO shall not.
Please.
Or ಕೆಲಸ ಮಾಡಿ, learned counsel files a memo. The learned counsel, both the parties submit that all the litigations concerning the same property, if heard by this court, would be appropriate. Therefore, tag this petition along with so and so. The learned counsel for the respondent P. Prasanna Kumar submits that the IO has sought
The doc.
return of all the documents.
ಐವೋ ಅಲ್ಲ, ಅವ್ರು ಕೇಳಿದ್ರೆ ಕೊಡಬಾರ್ದು ಅವ್ರಿಗೆ ಅಂತ.
I have sought to take it back.
Don't take it.
ಅವ್ರು ಕೊಡಕ್ ಬರಲ್ಲ.
Take it back, my lord. We will leave it. in
The
court.
learned counsel P. Prasanna Kumar submits that the petitioners have sought return of all the documents that are alleged to be forged on an allegation by the petitioner before the concerned court. Therefore, the concerned court, the application of the IO shall not be considered by the concerned court till the disposal of the petition.
Application of petitioner.
Application of the petitioner shall not be considered by the concerned court till the disposal of the petition.
Please.
ಅದು ಇರೋದು ಅಲ್ಲೇ ಇರಲಿ.
ಅಲ್ಲೇ ಇರ್ಲಿ ಅಷ್ಟೇ.
ಇರೋದೇ ಅದು
ಅಲ್ಲ,
ಒಂದೇ
ಅಲಿಗೇಷನ್ ಫೋರ್ಸ್ಡ್ ಮತ್ತೆ ನೀವು ಅಲ್ಲೇ ವಾಪಸ್ ತಗೋಬೇಕು.
even before filing of all these things.
Let it be not in safe custody. Please.
ಅಲ್ಲ, we will not
And
take it back.
The
Give an
concerned court,
undertaking before.
concerned court is directed to place the same in safe custody.
Please.
Next, ಅದು we'll post it on 13th.
Please.
Serial number 26. ಯಾಕೆ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ? 230 ಬಂದಿದೆ ಮೇಡಮ್ ಎಲ್ಲ. All matters.
It is covered by judgment.
ಒಂದ್ ನಿಮಿಷ ಇರ್ಬೋದಾ? 230 matters ತಗೊಂಡ್ಬಿಡ್ಲಾ? I'll dispose your matter and go, don't worry.
Board passed over matter.
ಎಲ್ಲ ತಗೋ. ಇನ್ನು 6 o'clock, wait sir. Yes.
Lordship, Mr. Patil's colleague is.
Baby Patil ಎಲ್ಲಿ?
His colleague is.
No, he would know it better. ಹೊರಟ್ಬಿಟ್ರಾ?
Yes, please.
Ask Baby Patil to come. ಬರಕ್ ಹೇಳಿ.
Yes, please.
ಮೇಡಮ್ ಇನ್ನು 6 o'clock ಇರಿ. ಎಸ್. ಎಸ್ 230 matters ಕರೆ. ಒಂದು ನಿಮಿಷ. ಅಬ್ರಾಮ್ ನಿಮ್ದು ಯಾವುದು? ಎಲ್ಲ ಆಗುತ್ತೆ ಅಬ್ರಾಮ್ ಇವತ್ತು. ವಾಟೆಡ್ ಮ್ಯಾಟ್ರಾ? ಡೇಟ್ ಕೊಡ್ತೀನಿ. ನಾನು 14% ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಯಾವತ್ತು ಕೊಡ್ಲಿ? 7 but he is the complainant in that matter. ಯಾವ 13th ಕೊಟ್ಟಿದ್ದೀನಿ ಆಲ್ರೆಡಿ ಡೇಟ್. 13th 16th ಕೊಟ್ಟಿದ್ದೀನಿ ಡೇಟ್. 16th. You can appear online also in case I am not here. Yes.
30 more matters, fresh matters, still number 1. Prasanna DP.
I'm for the petition, my lord. 488 my lord. After lapse of 12 years.
ಇಲ್ಲ ಇಲ್ಲ ಸರಿ ಹೋಗಿದ್ದೀನಿ ಬಂತ ಈಗ. ಇದೇ ಮಾಡ್ತಾರೆ. Yes sir.
After lapse of 12 years, the wife has lodged the.
After 12 years?
She has lodged the complaint, my lord.
Why?
She deserted the petitioner in the year 2012. my
You are
lord.
the husband, sir.
Husband, my lord.
Deserted in 2012.
12, my lord.
How do you show that?
Kindly see the page number 31, my lord. Charge sheet, my lord.
The petitioner is the husband, is now knocking at the doors of this court, calling in question proceedings in CC so and so. for offense CC so and so. For offense punishable under section so and so. Madam, 490. The complaint itself narrates that the incident of 2012 is sought to be projected to become an ingredient of 498A in the year 2024. The learned counsel for the petitioner prima facie demonstrates that the wife has deserted the husband 12 years ago. The complaint is in vindication of the said submission. Therefore, there shall be an interim order of stay qua the petitioner till the disposal of the petition. 1 HCGP to emergent notice. Copy ನಾಳೆ ಕೇಳಬೇಡಿ.
No, no.
Yes. ಈಗ 6 ಗಂಟೆ ಆಗಿದೆ. Next.
Bill number 2, Karnataka P.
Appear for the petitioner. Fake Facebook ID was created in the name of the complainant. There is a complaint against the petitioner. But only allegation was that the OTP was sent to that mobile number of the petitioner. And on that basis, the complaint was, the Facebook ID was created. But the complaint is at page number 1. Apart from that, my lord, there is nothing.
No,
Page number 19.
come to page 19, sir. 19. Yes. Come to page 19. ಮಧ್ಯದಲ್ಲಿ 4 ಲೈನ್ ಓದಿ. Yes, 1 HCGP to emergent notice. Let the complainant come. Yes. Next.
Number 3, Jagdish Chandra Kamath.
Lord, in 2007, the Karnataka Housing Board allots me a site. Sale consideration was paid, sale deed was executed.
13(1)(c), 13(2). Charge sheet ಆಗಿಲ್ವಾ?
No, Lord. 2007 sale deed is executed. 2008, I've already sold it. In 2019, an FIR comes to be registered by the anti-corruption branch for
No, are you a
13(1).
private-
I'm
not a
private
public
person.
servant?
I'm not a public 13(1), 13(2). And I am a
But the
purchaser.
learned counsel Angat Kamath appearing for the pit. But there are other offenses. 420, 465, 468, 470.
Which I was addressing, that in 2007, I have been allotted a site. 2008, I have subsequently sold it.
To whom?
To a third person, not to a third person, I have sold it. Karnataka Housing Board, who's my allottee, has not pursued me for any allegation that I have given some fraudulent address. I have given where I was staying. I was living in a rental accommodation. I was allotted a site. The site has been then subsequently sold. In 2019, some RTI activist approaches the Honorable High Court, and then the proceedings are transferred to ACB, not. And ACB then registers for 5 years, nothing happens. I am a cancer patient, age 75. Now they're approaching my door, asking me to come and participate.
Bail ಕೊಟ್ಟಿಲ್ವಾ?
Bailu ಕೊಟ್ಟಿದ್ದಾರೆ.
3 years. Bail ಯಾಕೆ ತಗೊಂಡಿಲ್ಲ?
I am on anticipatory bail.
Yes.
I have to apply.
Heard the learned counsel Angat Kamath appearing for the petitioner. The petitioner is accused number 5 in a crime registered so and so for offense so and so. The counsel for the petitioner submits that in 2008, 2007, he was allotted a site by the Housing Board, Karnataka Housing Board, and the same is sold in the year 2008. Thereafter, it transpires that public servants were alleged of the offenses.
The FIR, all are private persons, still 13(2) is there.
All are
All
private.
allottees are being pursued.
The petitioner is accused number, sorry, madam, lastly. The learned counsel submits that all the persons, despite the offense under section 13(1)(c) and 13(2) are private persons. No public servant is arraigned in the crime. The crime itself, prima facie, could not have been registered in that for the offenses under the Prevention of Corruption Act. Therefore, there shall be an interim order of stay of further investigation, is it? Further investigation, where the petitioner till the next date of hearing. Next, yes. Next. One CJP, sorry. BB Patil is directed to accept notice for the respondent, petitioner to serve set of papers upon the aforesaid counsel. So, complainant yaru? Complainant idara?
Informant.
Emergent notice to the respondent, second respondent. Next.
Bill number 4, TN Raj.
My lord, matter referred to 125 mediation center, my lord. Before the mediator, my lord, for talks going on.
354, sir.
Assault on force. Yes, my lord. Before the mediator, in court center, my lord, she made false allegations against advocate also, my lord.
Yes, sir. Amale.
Included advocate also, my lord.
Advocate yaru, sir?
Accused number 5, my lord.
Will stay only against that.
My lord,
One HCG.
all are aged persons, my lord, all are aged persons, my lord.
That
Even
is
they appeared
later.
before the court of police station also, they gave statement, my lord. They
Yes, who has assaulted husband?
husband, my lord.
Who is the husband here?
Accused number 1, my lord.
Assault,
125%.
ಯಾರ ಮೇಲೆ ಇದೆ assault?
My lord, before verbal abuse ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿ, my lord.
Well,
They
yes.
created story and filed
No
complaint.
problems, yes.
My lord, they appeared before the.
ಒಂದು ಲೈಂಗಿಕ ಜೀವನ so and so 2, 3, 4, 5. Yes, one HCGP, two emergent notice, there shall be an interim order of stay of further proceedings, qua 2, 3, 4, 5. Yes, it is made clear, further proceedings shall continue against the accused number 1. Next.
5, Kendra,
Adu cause-
But the second respondent files a complaint before the police. Or I think page 26, my lord, alleging that I have trespassed into their house. And I created, he has suspicion that.
Why did you trespass?
Trespass ಮಾಡಿಲ್ಲ ಅದನ್ನ ಹೇಳ್ತೀನಿ. Police
ಯಾಕ್ ಮಾಡಿ?
police subsequently
ಹಾ.
inquired with, he inquired me and gave a endorsement stating that it is purely a civil dispute. Page 30, man. Page 30 is the
ಏನ್
endorsement.
father and son?
ಅಲ್ಲ, sister and brother.
Copy not, sir.
Copy not served. Day after tomorrow.
I have given, my lord.
ಕೊಡಿ, ಇಲ್ಲಿ ಕೊಡ್ಬೇಕು 2:15. Yes, they are 82 years. In the meantime, next.
Please.
ಕಾಪಿ ಕೊಡದೆ ಎಷ್ಟು
ಅದೇ
ಸರ್ತಿ
right
ಹೇಳ್ಬೇಕು ನಿಮ್ಗೆ? ಈಗಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಬೇಡ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಬರ್ಲಿ.
86 years old, my lord.
ಪರವಾಗಿಲ್ಲ, ಅದಕ್ಕೆ ಕಾಪಿ ಕೊಡ್ಬೇಕಾಗಿರುತ್ತೆ.
ಈಗಲೇ
ಲಿಸ್ಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಎಷ್ಟು ಸರ್ತಿ ಹೇಳಿದ್ರು ಕೇಳಲ್ಲ ನೀವು. 2:30 ಮೂವ್ ಮಾಡೋದು ಮಾತ್ರ ಮಾಡ್ತೀರಾ. 40 ಮ್ಯಾಟ್ರ್ ಒಂದು ಕಾಪಿ ಇಲ್ಲಿ ಕೊಟ್ಟಿರಲ್ಲ. ಎಲ್ಲ ನೆನ್ನೆ ಮೊನ್ನೆ ಕೊಟ್ಟಿರ್ತೀರ ಅಲ್ಲಿ, ಇಲ್ಲಿ ಬಂದಿರಲ್ಲ. They are not obliged to get the copy, sir. The moment you move at 2:30, it's your duty to keep a copy here to the councils are present. How many times I've been telling for the last 6 months? ಅದಕ್ಕೆ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡಕ್ಕೆ ಸ್ಟಾಪ್ ಮಾಡಿದ್ರೆ ಸರಿ ಹೋಗುತ್ತೆ. Yes, day after tomorrow. Next.
number 6, Amar Kori,
Breach of promise to marry, 376.
ಇದ್ಯಾಕೆ ಬಂತು ಮತ್ತೆ?
In fact, it will come day before.
Modification,
Charge sheet file ಆಗಿದೆ. We have modified the prayer, my lords.
Amend the petition.
We're filing the memo of citations as well as the brief submissions, my lords. On the
Stay ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ವಾ?
stay, but on the facts of the case, my lords, there is a,
ಈಗ 2:30 ಮೂವ್ ಮಾಡಿದ್ ಯಾಕೆ ಸರ್?
but we had moved in the morning. Monday, this matter was listed. My lords had given a date for today. It had not come in the list. So we moved in the morning. my lords.
So 2:30ಗೆ.
ಹೌದು.
ಹಾ,
Because
ಈಗ
it was a date given.
ಈಗ
by-
ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳ್ಬೇಕಾ?
Tomorrow, my lords, kindly.
Tomorrow, sorry.
This remain on the facts, this remains covered by so many of my lord's judgments, my lords.
The offense is committed first and then the consent is taken. You don't need the.
Consent is taken ಅಂದ್ರೆ ಹೆಂಗ್ ಕೊಟ್ರಿ ನೀವು consent?
No, consent, sir. Said, okay, I will marry, okay, I will not raise a complaint. That is what the 164
Fact,
statement.
my lords, during the discussion of
If I read
finalizing the
164
proposal,
statement-
my lords,
All right, let's come. List on 8th.
as part of.
8th for further hearing. It's already parted, right? 8th for further hearing.
Please,
Yes.
please.
Next.
7, Satish K,
Ikesh Babu.
13 P, my lord.
Ah.
No preliminary inquiry.
Not to file charge sheet.
Lord, suspension, Lord,
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
FIR stage. My lord has granted the identical entry mode not to precipitate.
ಈ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಹಾಕದೆ ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರಾ, ಎಲ್ಲ ಇಲ್ಲೇ ತಗೊಂತಾ ಇದ್ದೀರಾ.
ಇಲ್ಲ,
ನೋ ಸರ್.
ಇಲ್ಲ, ತಾವು ಬನ್ನಿ. ಖಂಡಿತ Lord, on the face, I will show you, Lord.
ಆನ್ ದ ಫೇಸ್
On the face.
ಆಫ್ ಇಟ್.
ಅಲ್ಲ, on the face of the FIR, I will show.
ಅದೇ ಹೇಳಿ, ಆನ್ ದ ಫೇಸ್ ಅಂದ್ರೆ
No, not on the face of source report.
ಆನ್ ದ ಫೇಸ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಅಂದಂಗ ಆಗತ್ತೆ.
Source report.
ಎಸ್.
Page 44, my lord.
Ah.
Item assets, like, my lord, ಖಂಡಿತ P, all assets.
No, serve on baby Patil. We'll take it day after tomorrow, Friday. Serve on baby Patil. List, serve on baby Patil list day after tomorrow. Next, that order will pass on Friday. Yes, next.
Is a
Fresh matters. Sir, Friday irade fresh matter. Yes, next.
order
ಕೆಲವರು
syllabary,
136 ಅಲ್ಲಿ ಅದು 13B ತಾವು ಹಿಯರ್ ಮಾಡಿದ್ದೀರಿ. 13B.
ಅವತ್ತೇ ಮಾಡೋಣ. Yes.
ಅಲ್ಲ, ಇವತ್ತಿತ್ತು ತಾವು.
ಅದೇ ಇದನ್ನ ಮಾಡಿದ್ದಕ್ಕೆ ಹಾಕಿದ್ದೀನಿ. Yes, ಅವ್ರು ಸರ್ವ್ ಮಾಡಿ. Next.
order syllabary, Raghu,
My lord,
sir.
though there is interim order staying the investigation, the police have filed a charge sheet, my lord.
ಅದು ಗೊತ್ತಿರಲ್ಲ ಸರ್, ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿರಲ್ಲ.
The case and I filed a challenging the
ಇದು
charge sheet, my
ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
lord. ಮಾಡಿದ್ದೀನಿ, my lord, ಅದನ್ನ list number 4, list seal number 8, it
ಆಯ್ತು,
listed.
ಇದು ವಿಡ್ರಾ ಮಾಡಿ ಹಂಗಾರೆ.
I'm filing memo.
Yes, in terms of the memo. Next, Rohan.
Fresh matter.
All right, tell me.
Application seeking discharge is refused.
Huh.
Does not take into account the fact that I have produced material of sterling quality.
Offense,
376,420, your lordship, promise to marry
how
rate.
many years?
2 years after the relationship begins, she files a complaint and she does not produce the charge sheet, the WhatsApp messages which are exculpatory in my favor. I secure that production in a parallel proceeding.
Sometimes that exculpatory material can become inculcate.
Your Lordship may have
dangerous.
for 1 minute, Your Lordship may have page 761
WhatsApp
of
chat
audio.
beda. Where is the complaint?
Your Lordship complaint, Your Lordship will find at page 48.
Page?
48. Annexure B. They meet on Bumble, the dating / social media application.
Social media, it's a dating app.
It's a dating app.
Ah.
They meet on that application.
Why do you give it a status of social media?
She calls it an application through which she wants to find a matrimonial partner.
All right.
They meet in July 2020. Till April 2022, nothing is spoken about. April 2022, she files a complaint against me saying I have beguiled her, seduced her into having sexual intercourse at the pretext of marriage, taken certain amounts of money from her and haven't returned it. The WhatsApp chat she produces as a part of the charge sheet is one single document. I file an application before the trial court, which Your Lordship had in fact heard, seeking production of the entire WhatsApp chat record. That application came to be rejected. I came before Your Lordship.
Idralla.
In this same matter, Your Lordship.
Okay.
Last year, Your Lordship remanded the matter for fresh consideration. That again got dismissed. Then she had filed a parallel complaint under 138 of the NI Act. In that deposition,
How much money have you taken?
23
her.
lakhs. 23 lakhs I have taken. Your
From
Lordship.
her?
Yes, and returned significant amount. There is, in fact, the WhatsApp chat record shows that she is continuously using my credit card. So
You gave the credit card?
yes, Your Lordship. That is the situation. In fact, if I could request Your Lordship to have volume 2, page
Heard the
711.
Learned Counsel Rohan Kothari appearing for the petitioner. The case is yet another illustration of the dangers of dating app. The petitioner and the complainant meet on Bumble in 2020. The meeting leads them to coffee in Starbucks. Coffee in Starbucks leads them to a relationship. Relationship blossomed into physical relationship and sustained for 2 years. The sustenance, according to the complainant, is on the pretext of promise of marriage. The promise of marriage having been broken, the complainant walks to the jurisdictional police to register a crime for offense punishable under section 376 and 420 of the IPC. The Learned Counsel for the petitioner, taking this court through the documents appended to the petition, would seek to demonstrate that there are plethora of conversation between the petitioner and the complainant, which would demolish the theory of consent being taken out of deceit for it to become rape. The Learned Counsel submits that all consensual acts for 2 years is now projected to become a crime. Therefore, there shall be an interim order of stay of further proceedings qua the petitioner, failing which it would run foul of the judgment of the apex court in the case of
Your Lordship, this is
Mandar so and so. 2024 SSC online SC page 3. Search, sir.
Yes, Your Lordship.
2024 SSC online SC page 3471. I'm faster than that, don't worry.
I'm obliged.
Yes.
Deeply obliged.
There shall be an interim order of stay. Next.
Milords, 1980 FIR for an alleged incident.
ಇದು ಮತ್ತೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ದೇನಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಹಾ ಸರ್. ನೀವು ಸ್ಪ್ಲಿಟ್ ಚಾರ್ಜ್ ಶೀಟಾ?
ಸ್ಪ್ಲಿಟ್ ಚಾರ್ಜ್ ಶೀಟ್
ಎಲ್ಲರೂ ಅಕ್ವಿಟ್ ಆಗಿ ಹೋಗಿದಾರಾ?
ಹೌದು. ಇಬ್ರು ಅಕ್ಯೂಸ್ಡ್ ಅಬ್ಸ್ಕಾಂಡಿಂಗ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ಅವ್ರ ಮೇಲೆ ಈಗ ಹೊರಟಿದ್ದಾರೆ. ಒನ್ ಆಫ್ ದ ಅಕ್ಯೂಸ್ಡ್ ಇಸ್ ಬಿಫೋರ್ ಲಾರ್ಡ್ಶಿಪ್.
ಎಲ್ಲಿ ಹೊರಟಿದ್ದಾರೆ?
ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಹೊರಟಿದ್ದಾರೆ. In 2022, my lords, it was open. In 1993 itself, all are acquitted.
A case of 44 years is alive, is still alive, shocks the conscience of the court. The reason for it to be alive is the split charges drawn against a few of the accused, against 2 of them, one of which is the petitioner. The crime comes to be registered in the year 1980.
1980. 32 of 1980.
What?
1980.
32 of 1980 for several offenses, number 7 in the synopsis. The accused who are available for trial are tried and are acquitted. The acquittal happens in the year 1994. The acquittal against those cases are 1993, acquittal against
388.
against those accused has become final. And the case against the petitioner is also closed on the score that it is a long pending case.
Yes.
But 44 years after the registration of the crime, the criminal case that was registered now haunts the petitioner. The petitioner is sought to be arrested on the score that he was an accused who was not available for trial at the time when others were tried in the year 1980. The petitioner, who was 28 years then, is 80 years today. The crime still hangs on his head. Therefore, there shall be an interim order of stay of all further proceedings square the petitioner till the next date of hearing. Dispose Marana will quash this. List the matter on 9th for further hearing.
Fine.
Yes. Why is Ravi Shankar sir waiting? Oh, ಇದೆ 2:30 matter ಅಲ್ವಾ? Yes, yes. ಇನ್ನು 6 o'clock ಅದಕ್ಕೆ ಇರಿ. Yes. Serial number 11 withdrawal ಮೂವ್ ಮಾಡಿದ್ರ ಯಾಕೆ ಸರ್?
Charge sheet is
ಹಾ
filed.
ಕೊಡಿ. ಮತ್ತೆ ಆ ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ ಅಂತ ಕೇಳಿದ್ರಿ?
That is a different case.
ಹಾ ಸರಿ. ಅದು ಅಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡಿದ್ರೆ ಅಲ್ಲೇ ಬರುತ್ತೆ, ಇಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡಿದ್ರೆ ಇಲ್ಲೇ ಬರುತ್ತೆ. ಎಸ್.
ಇನ್ನೊಂದು ಇದೆ.
Reporting settlements. Bill number 12.
ವೆಂಕಟೇಶ್ 12 ಇದು ಕನೆಕ್ಟೆಡ್ 150ಗೆ ದಲ್ವಾಯ್ ವೆಂಕಟೇಶ್ ದಲ್ವಾಯ್ ಮನೆಗೆ ಹೋದ್ರ?
ಇದು ಕಾಲ್ ಹೋಗಿಲ್ಲ.
ಎಸ್, ನೆಕ್ಸ್ಟ್ ಲಿಸ್ಟ್ ಕೊಡಿ ಮೇಡಮ್. ಇನ್ನು ಇಲ್ಲೇ ಇದೆ. ದಿಸ್ ಇಸ್
Number 1. Vanity case.
Lord, I appear for the petitioner, Lord. Lord, a sexual harassment complaint was lodged against
sir,
the
where are you?
petitioner.
You are not to be seen.
Yes, little bit, yes, yes, now it's better. A sexual harassment complaint was filed, Lord, against the petitioner, and a B report was filed after a thorough investigation of the police. B report is at page 59. Then, my lord, a second complaint is set up by the earlier complainant. The earlier complainant was an ex-employee of the institution.
What happened to the B report?
It was, they said there are no findings of sexual assault at all.
ಅದು ಫೈನಲ್ ಆಗಿದೆಯಾ ಅಂತ?
Final agide. And it is not questioned before the court.
Yes,
No.
heard the learned senior counsel. ಏನಿದು ಯಾವ ಸ್ಕೂಲ್ ಇದು?
This was
You are a
VGS.
teacher.
No, my lord, I am the head of the institution.
Whom are you harassing, sir?
First round, an employee who was dismissed from service filed this complaint, my lord. Then he has set up
Yes.
the second complaint on
The
parameter same.
Complainant, according to the learned senior counsel Vivek Reddy, is the second in line. The first complainant had, after her removal from service from the institution, had
His
sought-
removal, my lord.
Huh?
His removal. It was a dismissed
his-
male employee.
His removal from service had his removal from service had sought the criminal law, sought to set the criminal law into motion. The said complaint results in investigation into investigation into a B report. The said B report becomes final. Who is this? How do you say she is set up?
Lord, the para one of both the complaints
Are similar?
at page
is it?
number are exactly the
Yes.
same. Lord.
The learned senior counsel submits that the present complainant is set up by the person who could not secure a charge sheet at the hands of the investigating officers. It is evident from the complaints made by the complainant and the present complainant and the earlier complaint. They begin with verbatim similar statements.
Yes.
Therefore, there shall be an interim order of stay of further proceedings. 1
Please.
HCGP 2 emergent notice. Next.
Please, oblige.
Bill number 2. Arvind.
Arvind,
Yes, your lordship.
Ah.
I'm the petitioner and accused number 3 in the crime.
ಆಮೇಲೆ offense.
3, 4, 5 and 6 of the ITP.
Accused number?
3, your lordship.
Customer.
Cashier.
Cashier.
Accused number 1 and 2 are absconding.
Absconding.
Yes, sir.
Kashta.
And they did not find them, so I was booked. I am neither the customer nor the owner, your lordship.
Alla, you are not the owner, not the customer, but the cashier. Very difficult. ಎಲ್ಲಿ ಇದು? ಸ್ಪಾನ?
No.
Hotel.
So one hotel, one King Shoot Hotel in the Ashok Nagar police jurisdiction.
King Suit Hotel. ನೀವೇನು ಫಸ್ಟ್ ಟೈಮ್ ಅಪೇರ್ ಆಗ್ತಿದ್ದೀರಾ?
I already filed one petition and withdrawn it.
ವಿಡ್ರಾನ್. ಅದೇ ಫಸ್ಟ್ ಪಿಟಿಷನ್ ನಿಮ್ದು?
Yes, your lordship.
ಯಾರ್ಯಾರು ಇದ್ದಾರೆ? ಅಕ್ಯೂಸ್ ನಂಬರ್ 3 ಮಾತ್ರನಾ?
Yes, number
4 ಯಾರು?
only 3.
Only 3 remains now. 1 and 2 are absconding.
Yes, your lordship.
9 2 are absconding.
ಮತ್ತೆ ಇವ್ರನ್ನ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಿ? He was collecting their cash. He is caught in this circumstance. Yes. The accused number 1 and 2 are said to be running a racket which becomes ingredients of sections 2, 3, 4 and 5 of the ITP. The petitioner is accused number 3, a cashier. Accused 1 and 2 are absconding. In the light of the accused 1 and 2 absconding, the axe has fallen on the petitioner. Therefore, there shall be an interim order of stay of further proceedings against the petitioner till the state would make their submissions with regard to the role of the petitioner, or for a period of 4 weeks, whichever is earlier.
Grateful.
Next.
Number 3, Ramani HV.
Civil suit is pending between the husband of the complainant and the petitioner number 3. During 2020, since 2020, my lord, just a dog bite case is converted into SC/ST offences. After 10 days, my lord, complaint is came to be lodged.
Dog bite.
ನಾಯಿ ಕಚ್ಚಿರೋ ಸ್ವಾಮಿ ಅದನ್ನ after 10 days, my lord, converted into SC/ST case. No publics were present at the time of incident.
ನಾಯಿಗೆ SC/ST ಗೆ ಏನ್ ಸಂಬಂಧ?
ಸ್ವಾಮಿ ಅದು ಹಾಗೆ
ಹಾಗೇನೆ
ಬೈದ್ರು ಅಂತ
ನಾಯಿ ಬೈದ್ಬಿಡ್ತಾರೆ.
ಕಂಪ್ಲೇಂಟ್ ಹೇಳೋದು ಇವ್ರು ಬಂದು ಬೈದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ.
ನಾಯಿನ ಬಿಟ್ಟು ಕಚ್ಚಿಸಿದ್ದಾರೆ.
ನಾಯಿನ ಕಚ್ಚಿಸಿದ್ರು ಪ್ರಾಪರ್ಟಿ ವಿಚಾರವಾಗಿ ಕೇಳಿದ್ದಕ್ಕೆ ಬೈದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ.
Now,
publics were present, my lord.
who let the dogs out?
ಇಲ್ಲ, dog belongs to the petitioners. That is a Pomeranian ನಾಯಿ song.
Then
Pomeranian dog. It's a small dog.
Pomeranians.
Pomeranians.
Pomeranian.
Sorry, madam. Pomeranian dog. ಅದೇನೋ ಅವ್ರ ಬೀದಿಯಲ್ಲಿ ಹೋಗುವಾಗ ಪರ್ಚಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು after 10 days, my lord, they lodged a complaint. No publics were present. It is clearly attracts the.
Tetvac ಬೇಕಾಗ್ಲಿಲ್ವಾ?
ಏನ್ ಸಮಯ?
ಅಲ್ಲ, Tetvac ಇಂಜೆಕ್ಷನ್ ಬೇಕಾಗ್ಲಿಲ್ವಾ? Yes. Yes, sir. Who let the dogs out?
Yes.
Yes. ಆಯ್ತು, ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಸ್ಟೇ ಮಾಡೋಣ.
ಎಸ್, ಈ ಬೇರೆ ಅಫೆನ್ಸಸ್
ಬೇಡ, ಗೊತ್ತಿಲ್ಲ ನಾಯಿ ಯಾವಾಗ ಬಿಟ್ರಿ, ಯಾವಾಗ
ಅಲ್ಲ, ನಾಯಿ ಕಚ್ಚಿದ ಬಗ್ಗೆ ನೋ ಅಫೆನ್ಸ್ ಇಸ್ ಮೇಡ್ ಮೇಡಮ್. ಇಲ್ಲ,
ನಾಯಿ ಕಚ್ಚೋದಕ್ಕೆ ಒಂದು ಸಪರೇಟ್ ಅಫೆನ್ಸ್ ಇಲ್ಲ
ಅಲ್ಲಲ್ಲ,
ಸರ್.
ಅದು 291 ಇಟ್ ಇಸ್ ಅಗೇನ್ಸ್ಟ್ ದೆಮ್, ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಮೈ ಲಾರ್ಡ್. ನಮ್ಮ ನಾಯಿಗೆ ಹೊಡಿತಾರ ಅವರು.
ನಾಯಿ ಕಚ್ಚೋದಕ್ಕೆ ಬೇರೆ ಅಫೆನ್ಸ್ ಇದೆ ಅಂತ IPC ಅಂದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ.
ಅಲ್ಲ, ನೋ ಇಂಗ್ರೀಡಿಯಂಟ್ಸ್ ಆರ್ ದೇರ್ ಮೈ ಲಾರ್ಡ್. ಆಫ್ಟರ್ 10 days, ಮೈ ಲಾರ್ಡ್, ಸಿವಿಲ್ ಸೂಟ್ ಇಸ್ ಪೆಂಡಿಂಗ್.
ನಾಯಿನ ಚೂ ಬಿಟ್ಟಿದ್ದು ಅಂತಲೇ ಹೇಳಿ ಕಂಪ್ಲೇಂಟ್. ಯಾವ ನಾಯಿ ಅಂತೇನು ಹೇಳಿಲ್ಲ ಅವ್ರಿಗೆ.
CCTV ಫುಟೇಜ್ ಎಲ್ಲ ಇದೆ ಸರ್.
ಎಸ್, CCTV ಇದೆಯಾ?
CCTV ಫುಟೇಜ್
ಸದ್ಯಕ್ಕೆ ಅಟ್ರಾಸಿಟಿ ಸ್ಟೇ ಮಾಡೋಣ, ನಿಮ್ಗೆ ತೊಂದರೆ ತಪ್ಪದು ಅದರಲ್ಲಿ.
ಸ್ಟೇ ಮೇ ಬಿ.
Yes, 1 HCGP 2 emergent notice, there shall be an interim order of stay of the offences under the Atrocities Act only, and the stay regarding the other offences will be considered after the appearance of the complainant, as it is required to know who let the dogs out.
10 days ಆದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್.
ಪರವಾಗಿಲ್ಲ. Yes, next.
Number 4, Yashwant Swami.
360 subclass 2 and 318 subclass 3 my lord. 316 316
ತುಂಬಾ ಸುಸ್ತಾಗೋಗಿದೆ ಸರ್, ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಹೇಳಿ.
316 subclass 2 and 318 subclass 3.
ಅದು PNS 406 420 ಅದೇ ಹೇಳಿ. ಎಸ್, ಪರವಾಗಿಲ್ಲ ಹೇಳಿ.
ಲಿಂಕ್ ಪೇಜ್ ನಂಬರ್ 18.
ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ಲಿಲ್ಲ, ಏನ್ ಗೊತ್ತಾಗುತ್ತೆ ನಿಮ್ಗೆ?
ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
ಆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದ್ರೆ ನಿಮ್ಗೆ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ಬಾರ್ದು ಅಂತಿದ್ಯಾ?
ಡಾಕ್ಯುಮೆಂಟ್
406 420 ಗೆ ಏನ್ ಬೇಕು? ಬರೀ FIR ಹಾಕ್ಬಿಟ್ರೆ ಸಾಕ?
ಅಲ್ಲ,
ಆಧಾರ್ ಕಾರ್ಡ್ FIR.
ಅಲ್ಲ, ನಿನ್ನೆ
ನಾನು ಮೊನ್ನೆನೂ ಹೇಳಿದ್ದೀನಿ ನಿಮ್ಗೆ.
ಅಲ್ಲ, ನಿನ್ನೆ FIR ಆಗಿದೆ.
ನಿನ್ನೆ FIR ಆಗಿದೆ, ಇವತ್ತಾಗಲೇ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದೀರಾ?
ಯಾಕೆಂದ್ರೆ harassment ಅಲ್ಲ, ಯಾಕೆಂದ್ರೆ ಅಕ್ಯೂಸ್ ನಂಬರ್ 6
ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಸರ್.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಷ್ಟು ಬಿಟ್ಟರೆ ನಂತರ ಡಾಕ್ಯುಮೆಂಟ್ ಏನೂ ಇಲ್ಲ. ಯಾಕೆಂದ್ರೆ
ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಅಲ್ಲ, ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ ನಾನು ಅಂಗಡಿ ಓನರ್ ಸ್ವಾಮಿ. ನಾನು
ಅಕ್ಯೂಸ್ ನಂಬರ್ 6 ಏನು ಅಂದ್ರಲ್ಲ, ಅಕ್ಯೂಸ್ ನಂಬರ್ 6 ಏನು?
ಅಕ್ಯೂಸ್ ನಂಬರ್ 6 ಓನರ್ ಸ್ವಾಮಿ.
ಹಾ,
ನನ್ನ ಹತ್ರ ಯಾವುದೇ ರೀತಿಯಾದ
ಪ್ರೊಡ್ಯೂಸ್ ಆಲ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ನನ್ನ ಹತ್ರ ಗೋಲ್ಡ್ ಏನು ಪರ್ಚೇಸ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು.
ಲಿಸ್ಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಬರೀ FIR ಆಧಾರ್ ಕಾರ್ಡ್ ಹಾಕಿದ್ರೆ ಸ್ಟೇ ಕೊಡಲ್ಲ.
ಅಲ್ಲ, ನನ್ನ ಹತ್ರ ಬೇರೆ ಇನ್ನೇನು
ಕಲೆಕ್ಟ್ ಮಾಡಿ ಸರ್, ಮಾಡ್ಬಿಟ್ಟು ಅಫೆನ್ಸ್ ನೋಡಿ, ನಿಮ್ ಡಿಫೆನ್ಸ್ ಅಲ್ಲಿ ಏನ್ ಬೇಕು ಅದನ್ನೆಲ್ಲ ಕೊಲೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಹಾಕಿ. ಸುಮ್ನೆ ಇದು ಇಲ್ಲೋ ಅಂತಂದು ಹಾಕ್ಬಿಡೋದಲ್ಲ. ಎಸ್, ಆಧಾರ್ ಕಾರ್ಡ್ FIR ಅಲ್ಲಿ ನಾನು ಯಾವ ಸ್ಟೇನು ಕೊಡಲ್ಲ. ನೆಕ್ಸ್ಟ್.
Number 5, Pin Hegde.
Lordship, I pay for petitioners, my lordship. My lordship, petitioner college is.
406, 420.
Please, my lordship.
Ah.
Seat blocking, my lordship.
ಅದು
Well,
ಸೇಮ್ ಟ್ಯಾಗ್ ದಿ ಪೆಟಿಷನ್ ಅಲಾಂಗ್ ವಿತ್ ಸೋ ಅಂಡ್ ಸೋ ಅದ್ರಲ್ಲಿ ಏನ್ ಕೋರ್ಸಿವ್ ಸ್ಟೆಪ್ಸ್ ಆರ್ಡರ್ ಹೇಳಿದೀನಿ ಅದೇ
Page number 86, my lordship.
ಟ್ಯಾಗ್ ದಿ ಪೆಟಿಷನ್ ಅದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಹಾಕಿದ್ದೀನಿ, ಇದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಹಾಕಿ.
Grateful.
ಎಸ್ ನೆಕ್ಸ್ಟ್
Bill number 6, Sharath J.
ಶರತ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್. ನೆಕ್ಸ್ಟ್ ಇಲ್ಲ ಕೊಡಿ, ಮೂವ್ ಮಾಡಿದ್ದಾರೆ ಇವ್ರು, ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ಹಾಂ ಸರ್, ಫಾರ್ ವಿಡ್ರಾಯಲ್. ಎಸ್ ನೆಕ್ಸ್ಟ್ ಜಗದೀಶ್.
7.
My lord, I'm for the,
Which page?
my lord, complainant is a advocate, my lord.
Hmm.
This complainant is advocate. Petitioners.
Complainant is an advocate.
Complainant is advocate, my lord. It's a 138 case, 138 NI Act, my lord.
Ah.
Wherein petitioners engage the complainant as a advocate for their property dispute, my lord.
ಸರಿ, ಚೆಕ್ ಕೊಟ್ಟಿದ್ರಾ?
ಚೆಕ್ ಅದು irrevocable retainership ಅಂತ agreement ಇವ್ರು ಗೊತ್ತಿಲ್ಲದೇನೆ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ, my lord.
ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ಇಂಟರ್ನ್ಶಿಪ್ ಹೆಂಗೆ ಆಗುತ್ತೆ ರಿಟರ್ನ್ಶಿಪ್?
There is two retainership agreement, my lord, wherein they have replaced 3 pages of the agreement from the earlier agreement, my lord, where it was stated that 10%
All
of the
that is a
property
matter
value
of evidence, madam. ಈಗ ಏನಕ್ಕೆ, why are you before the court?
My lord, he has filed he has produced a check for 40,20,000, my lord,
Huh.
stating that he has taken a loan, petitioners have taken a loan from him,
Loan from the advocate.
a loan from the advocate 32 lakhs. Wherein we have produced bank statements, my lord, in the annexure,
Yes, petitioner to serve on the council who represents the respondent in the trial proceedings and file an acknowledgement to that effect. The learned counsel for the petitioner submits that the instrument that is projected to become an offence under section 138 is said to be a loan secured by an advocate from the hands of these petitioners. A loan secured by the petitioners from the hands of the advocate. The learned counsel submits that the advocate was engaged for the purpose of conducting their cases, and there is no other privity of contract between
my
the
lord,
two.
we have produced the bank statements.
Therefore, there shall be an interim order of stay of further proceedings, square the petitioner to the next date of hearing. Next. Kumar, maintain relative second criminal petition.
Just now withdraw.
Withdraw, adena?
Just now withdraw.
Ah, yes.
Kindly see paragraph 186, my lord, page number.
Offense.
420 and 406, my lord. Where, my lord, the interim order is granted, staying the investigation and holding that it's of civil nature, my lord. Kindly 186, my lord, page number.
Page 186.
186.
Yav case alli?
In
Tag
first
the
case, my lord,
petition.
in first case.
Madam, tag the petition with 186. Yes, same order. Farmers.
He has stayed the investigation, my lord. In this petition, challenge.
1 minute, even company na?
My lord.
Huh?
I am not a company, individual, my lord.
Which is this farmers ಗೆ ಯಾವ್ದು ಹೋಗ್ಬೇಕಾಗಿತ್ತು?
Alla farmers came, my lord. They entered agreement of sale
With whom?
with the farmers. Farmers,
Who-
alla, my lord. No,
who-
not farmer.
who
With the
you're-
farmers, I am a.
Who
broker.
entered into?
My lord, I am a broker, my lord. I am a broker.
Ah,
I facilitated agreement of sale with the farmers with the company.
all right.
Thereafter,
What was the agreement for?
agreement of sale, my lord. It was executed, my lord. It was executed.
Sale deed ಆಯ್ತಾ?
Well, sale it, kindly see, my lord.
ಆಮೇಲೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
Well, kindly see
Anyway,
statement, my
tag
lord.
this petition along with page 186, same order. Next.
Number 9.
My lord, submission, my lord.
Huh?
It is actually, my lord, the
Actually,
NBW is issued in the, by the magistrate. my lord.
ಅದೇನು ಆ ಕೇಸಲ್ಲಿ ಸ್ಟೇ ಇಲ್ವಾ?
ಅಲ್ಲಿ ಸ್ಟೇ ಇದೆ, my lord. ಅಲ್ಲ ಸ್ಟೇ ಇತ್ತು, ಜಸ್ಟ್ ವಿಡ್ರಾ ಮಾಡಿದೆ.
ಇಲ್ಲ ಸರ್, ಈಗ ಜಸ್ಟಿಸ್ ಹೇಮಂತ್ ಚಂದನ್ ಗೌಡ್ರ ಆರ್ಡರ್ ಸ್ಟೇ ಇಲ್ವಾ?
ಅಲ್ಲ ಅದು ಸ್ಟೇ ಇತ್ತು, my lord. ಸ್ಟೇ ಇದ್ರು ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
ಅದನ್ನೇ ವಿಡ್ರಾ ಮಾಡಿದ್ದ?
ಅದಕ್ಕೆ withdraw ಮಾಡಿದೆ.
There shall be, in the light of the interim order subsisting at the stage of crime, there shall be an interim order of stay in the case at hand as well on the same reasons. Yes, next. Dispose ಆಯ್ತು, ವಿಡ್ರಾ ಮಾಡಿದ. Yes.
Offense of 376, promise to marry, my lord.
ಯಾರು?
Silema 9,
Aditya
please.
went away home, huh?
It's a medical emergency.
Yes.
My lord, promise to marry
376,
76.
ಇದು promise to marry ಇಲ್ಲ ಇದು. 376 2N and 376 1, where is the complaint?
That's page number 31, my lords.
Hmm.
Annexure A. My lord, since 2021, they are in a relationship. The alleged incident is dated 13/10/2023. It starts from there. Then, my lord's complaint is filed. on
How are they in a relationship in 2021?
My lords, in the second paragraph, at page number 31, my lords. It starts from ನಾನು ಮೇಲಿನ ವಿಳಾಸದಲ್ಲಿ. Then, my lords, in the middle portion, ನಾನು 2021ನೇ ಸಾಲಿನಲ್ಲಿ ಅಂಬಾಳ್ ಗ್ರಾಮದ ನಮ್ಮ ಅತ್ತೆಯ ಮಗ ಆಸಿಫ್ ರಾಜಾ ಸಾಹೇಬ್ ಮಿರಜ್ ಇವರ ಗೆಳೆಯನಾದ ಅದೇ ಊರಿನ ಮುಮ್ತಾಜ್ ಮೊಹಮ್ಮದ್ ಅಲಿ ನಾಯ್ಕರ್ ಇವನ ಪರಿಚಯವಾಗಿದ್ದು, ಅಲ್ಲಿಂದ ನಮ್ಮಿಬ್ಬರ ಸಲುಗೆ ಬೆಳೆದು ಆಗಾಗ ಫೋನಿನಲ್ಲಿ ಮಾತನಾಡುತ್ತಾ ಬಂದಿರುತ್ತೇವೆ. Mohammad Ali Naikar, ಇವನು
In the
ಬೆಂಗಳೂರಿನಲ್ಲಿ.
meantime, next.
Number 10.
My lord, this is connected with serial number 7, my lord.
Same order, next. Serial number 10, ಯಾರು ಬೇರೆ advocates ಎಲ್ಲ?
Avachanam.
Huh?
Same. That was my senior. It's my lord. My lord, in this, they have filed a
What
forgery
is the
section.
connection?
Say, parties are the same, my lord. And matter is also with respect to the irrevocable retention
ಹಂಗಾರೆ
agreement.
ಸುಮಾರು ಜನ ಚೆಕ್ ಇಸ್ಕೊಂಡಿದ್ದೀರಾ ನೀವು?
ಇಲ್ಲ, my lord.
ಇಟ್ಟಿದ್ದೀರಾ?
Same, ಇಲ್ಲ, ಅದೇ party, my lord.
Same complainant?
Same complainant, my lord. Wherein he has filed this
420 case.
420, ಮತ್ತೆ forgery sections ಹಾಕಿದ್ದಾರೆ, my lord. 465 he has filed this.
ಮಾಡಿ.
Wherein he made a party of the.
1 HCGP 2 emergent notice tag along with 7. In the light of the reasons rendered to
My lord.
grant an interim order in serial number 7, a number haki. There shall be an interim order in the case at hand as well. Next.
11.
Petitioner's counsel. But 504 is the offense.
504 ಗೆ ಈ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗ್ತಾ ಇದೆ?
Orally, my lord, they have been threatening me because, my lord, I'm an office bearer in the Waqf board. Kindly see page 17, my lord. The allegation is that page number 17, the complaint is that I spoke in a manner which hurt his feeling. ಅಷ್ಟೇ.
ಯಾರಿಗೆ ಬೈದ್ರಿ?
ಇನ್ನೊಬ್ಬನ್ ಬೈದೆ ಅಲ್ಲೇ board ಅಲ್ಲಿ. The only allegation is that I hurt his feelings. I spoke to him in a manner which is bit rude.
Feelings?
Sticker 504 is.
Yes.
Page 17 is the complaint.
So and so. 1 HCGP 2 emergent notice in the meantime. Next.
Great.
12.
Lords, petitions are the family members and owners of certain properties. 155 sites are formed for which khata is issued and computer generated tax paid receipts are there. Page number 43, if your lords is for
Who
just
is the
one.
complainant?
Lords, complainant is the corporator.
Corporator?
He's the TMC councillor, my lords, of that area. Now we want to sell the sites. Comes and asks me that now you want to sell the sites, you will have to
Part with something.
respect my existence as a corporator in this area. So the disrespect results in a commission of the offences.
1, 2, heard senior counsel in the meantime.
Please.
Detail order break exhaust.
Yes. Great.
13.
The petitioner, my lords, minor objections, my lords, with respect to typed copy. my lords.
ಮೆರಿಟ್ ಮೇಲೆ ಹೇಳಿ ಸರ್ ಆಮೇಲೆ.
Lord, there is an injunction order, my lord, in favor of the petitioner in a suit filed by him, my lords, for permanent injunction.
ಈಗ offense ಏನು?
Lord, offense, my lords, 447 and my lord, section 3(1)(f), my lords, with the.
Next.
14.
States. Stay ಮಾಡಿ.
Please. Oblige.
Office objections to be complied with.
Please.
ಎಲ್ಲದರಲ್ಲೂ office objections to be complied with the next date. Yes, next.
Number 14.
Rakshit.
Case.
Rakshit connected with Shatabdish. ಏನಿದೆ?
The petition in 14.3, man.
What is this one?
I filed this petition is seeking defreezement of bank accounts. On 19/11/2024, this 14.3 was listed, man. And your lordship was pleased to tag the matter along with all these.
ಮಾಡಿದ್ಯಾ? 230 ಗೆ ಯಾಕೆ move ಮಾಡಿದ್ರಿ?
No, my lord, the matter was tagged with all these petitions.
All right.
And your lordship was pleased to grant an interim order of stay for the defreezing. Then subsequently, I came later and clarified, my lords, that there's no interim application as such. Therefore,
Oh,
I
ಅದಕ್ಕೆ
requested for detagging. Then, my lords, your lordship had accommodated a particular date in order for me to file the application. The application now stands filed.
In which all the petitions?
In 14.3, my lords.
ಅದ್ರಲ್ಲಿ ಮಾತ್ರ ಡಿ-ಫ್ರೀಸಿಂಗ್ ಕೇಳಿದ್ದೀರಾ?
Please, yes.
Freeze ಆಗಿದೆ. So
ಅಲ್ಲ ಈಗ ಸ್ಟೇ ಆಗಿದೆಯಲ್ಲ?
Stay, everything is stayed, my lords, on the, in fact, on perusal of.
Why de-freezing?
My lords, I haven't paid my income tax returns. I'm at the risk of facing
Still investigation is going on, my lord.
ಸ್ಟೇ ಮಾಡಿದೀವಲ್ಲ ಸರ್?
It's all stayed. If I may take a lordship to page 38 of this petition.
ಎಲ್ಲ all accounts ಬೇಡ. Whichever account you want, correct ಆಗಿ ಹೇಳಿ.
My lords,
You do one thing. What are the payments that you are required to make? And which account ಇಂದ ಹೋಗ್ಬೇಕು? ಅದನ್ನ Friday fresh matters ಅಲ್ಲಿ ಹಾಕ್ತೀನಿ. You bring a list, we'll pass orders.
This may be D-tagged.
14, D-tag 14.3 listed on Friday in the fresh matters list. You get that chart.
Yes, please. And
14.3 matra. All other matters after vacation, interim order subsisting will continue to the next date.
Great.
All other ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಬೇರೆ ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ. Yes. ಇನ್ನು 6:30, wait. Yes. ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಇದೆ 2:30. ಮೇಡಮ್ ಅರ್ಜೆಂಟಾ? 6:30 ಇನ್ನು. ಅವ್ರು ಇರ್ತಾರೆ ಬಿಡಿ, ಅವ್ರು 8 o'clock ವರ್ಗೆ ಇರ್ತಾರೆ.
Definitely.
ಎಸ್ ನಮ್ದು ಒಂದೇ ಕೋರ್ಟ್ ಅಲ್ಲ, ಪಕ್ಕದ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ ಇನ್ನು. ಎದ್ದಿಲ್ಲರಲ್ಲ ಅವ್ರು. ಎಸ್.
Narayan Swamy PM.
ಅಭಿಷ್
341, 504, 325, madam. Complaint.
325 ಯಾಕೆ? ಯಾರಿಗೆ ಹೊಡೆದಿದ್ದೀರಾ?
Complaint 2 days delay, my lord.
2017 ಕಂಪ್ಲೇಂಟ್. ಯಾವ ಕಾಲದ ಚಾರ್ಜ್ ಶೀಟ್ ಇದು? CC of 2018. Why have you moved it now? What is the stage?
For the trial court, my lord, warrant issued by the trial court, my lord.
Why warrant is issued? Appear ಆಗಿಲ್ಲ.
Please,
Next ಯಾವಾಗ? Next date ಯಾವಾಗ?
31/25.
Huh?
31/25.
31/25. The learned counsel for the petitioner submits that the next date of hearing is 30th January 2025 and the warrant is hanging on his head. The petitioner shall appear before the concerned court on 31/2025. In the event, subject to the said condition, the warrant shall remain stayed. In the event the petitioner would not appear, the warrant shall be executed without any order from the court. Yes. Next. ಅದು ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರೆ ಅಷ್ಟೇ, ಆರ್ಡರ್ಡ್ ಅಕಾರ್ಡಿಂಗ್ಲಿ ಅಷ್ಟೇ ತಾನೇ ಕೇಳಿರೋದು. ಡಿಸ್ಪೋಸ್ಡ್. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Number 2, case Narayan.
For the petition in this case, my lord.
ಎಸ್ ಮೇಡಮ್.
My lord, section 406, 420, 465,
420. Why?
My lord, the husband and wife, my lord, petition.
Husband and wife are 420 na?
Please, my lord, it is, she filed an PCR in the year 2019, alleging that the petitioner has sold and site number 16 in favor of their daughter, my lord. Subsequently, in the year 2021, she has executed an MOU and taken 12 crore rupees, and the very same day executed one more gift deed upon the very same property, my lord,
Gifting it to whom?
in favor of the petitioner only. Kata is,
Petitioner alla.
please, my lord, petitioner only.
Who has executed the gift deed?
The complaint number 2, respond number 2.
Wife.
Please, my lord. Kindly see, my lord.
Everything was good at that time.
My lord, she has filed many litigations, my lord. For the compromise, she had received the amount and executed the gift deeds, my lord.
And
Now she kept
One
quiet.
HCGP in the meantime. Copy ilva?
3,
No entry ಮಾಡಿ. ಎಸ್. ಅವ್ರಿಗೂ ನಾಡಿದ್ದೊಂದು ಹಾಕ್ದೆ ಮೇಡಮ್, ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವಾಗಲೇ. ಅವ್ರಿಗೂ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಟ್ಬಿಡಿ. ಎಸ್. ನಿಮಗೂ ಕೊಟ್ಟಿದ್ದೀವಿ. ನೆಕ್ಸ್ಟ್.
My lords, the offences are 498A, 504, 506, and section 3, 4, and 6 of the
Dowry prohibition.
dowry prohibition.
All right. ನೀವು ಯಾರು? ಹಸ್ಬೆಂಡ್ ಅಲ್ಲ, ಮದರ್ ಇನ್ ಲಾ?
I'm the petition number 1 is father-in-law and sister-in-law.
Yes.
They both.
Payal Sharma. Next. Stayed. Yes.
4,
For petitioner, my lord. My lord, the offence is under section 323, 504, 506, my lord.
3 non-cognizable ಎಲ್ಲ.
Please, my lord.
ಹಾ.
The allegation is with respect to year 2021, in respect of which I have already laid.
Meantime. Yes, next.
5, Mahendra Gowda.
My lord, offense under section 505 clause 2 of IPC, my lord.
Why ಏನ್ ಬರ್ದ್ರಪ್ಪ? ಸೋಷಿಯಲ್ ಮೀಡಿಯಲ್ಲಿ ಏನ್ ಬರ್ದ್ರಿ?
ನಿಮ್ದಲ್ಲ.
ಅವ್ರು ಯಾರು?
ಬೇರೆ ಯಾವ್ದೋ ಕೇಸ್.
ಫೇಸ್ಬುಕ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದೀರಾ?
Facebook, my lord, he had a Facebook page by name Sam Audios.
Sam Audio.
SAM Audios,
Ah.
which petitioners trolled as scam audios.
Oh.
Therefore, my lord, in this Facebook page, my lord, he used to.
Meantime. Yes, next. Tahir.
Voting settlement.
Settlement, parties are there?
Yeah, husband and wives are there.
630 ಆದ್ರೂ ಇದಾರಾ? Okay, yes.
In the DV case, year 2017, they have settled the matter.
All right, yes.
Page number 72 is
Sign
the
ಮಾಡಿ
joint
ಕಳಿಸ್ಬಿಡಿ.
application.
ಹೇಳಿದಿರಲ್ಲ ಅದ್ರೆಲ್ಲ. ಬಟ್ ಕಾಪಿ ಅರ್ಜೆಂಟ್ ಆಗಿ ಕೇಳಬೇಡಿ. ನಿಮ್ದು ನಾಡಿದ್ದು. ನಾಡಿದ್ದು. Yes.
After vacation, let it be. Lord.
ಇದು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಕಾಪಿ.
Review.
ಅದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. Yes.
Flag.
Yes.
Obliged.
ಇಷ್ಟೊಂದ ಹೇಳಿದಿರಾ ಯಾಕೆ?
Wife did not come forward. We informed the police. Police also.
Where is the wife?
The wife is here.
Then?
There. Before the police trial court, she didn't come forward to settle the matter. Then both
ಇದು
parties.
ಮೇಡಮ್ ಎಲ್ಲಿ ಕೇಸ್ ಬಗ್ಗೆ ಇರುತ್ತೆ ಅದು ಮಾತ್ರ. ವಿಚ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ತಾಹಿರ್?
The flag lordship in that.
ಫ್ಲಾಗ್ ಹಾಕಿದ್ದೀರಾ?
That is in DV proceeding, they have closed the matter. Then in the affidavit also we had given it.
Yes. Next. ಮುಗಿತಾ? ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಇದೆಯಾ ಮೇಡಮ್? ಮುಗಿತಾ?
190.
ಒಂದ್ ನಿಮಿಷ ಮೇಡಮ್ ಇದ್ರ ಮೇಡಮ್ ಬನ್ನಿ. ಬೇಬಿ ಪಾಟೀಲ್ ನಿಮ್ದು ಬಂದಿಲ್ಲ ಲಿಸ್ಟ್ ಇನ್ನು.
ಅಲ್ಲ ಅದಿನ 198 ಅಲ್ಲಿ.
ಒಂದ್ ನಿಮಿಷ ತಾಳಿ.
Order sheet signature.
ಅಲ್ಲಿ ತಾಹಿರ್ ಡೋಂಟ್ ಸೆಂಡ್ ದೆಮ್ ಅದರ್ವೈಸ್. ಎಸ್.
ಹೊಸ ಮೂವ್ ಮಾಡಿದ್ವಿ, ಬರ್ತಾ ಇದೆಯಂತ.
ಬರ್ತಾ ಇದೆಯಾ ಈಗ? ಹೊಸದಾಗಿ ಮೂವ್ ಮಾಡಿರೋದು?
ಹೌದು.
ನಾವು ಎಷ್ಟೊತ್ತವರೆಗೆ ಇರ್ಬೇಕು ಅಂತ?
serial
ಒಂದ್
number
ನಿಮಿಷ ಲಕ್ಷ್ಮಿ ಮೇಡಮ್. ಎಸ್. ಬಿ ಪಾಟೀಲ್. Why are you pestering them despite?
No, my lords, we're not pestering it.
ಮತ್ತೆ?
Ali Lokaयुಕ್ತದಲ್ಲಿ it's not even it doesn't emanate from the FIR. My lords, let them file a
Let pass
proceeding
this
and
on.
all these are under question.
Thank you.
ಇದು departmental inquiry by Lokayukta under KCSR rules.
Your Lordship, I understand.
ಅದಕ್ಕೆ
It
ನಾವು
is a-
ನಾವು ಅವರಿಗೆ ಇದ್ರದ್ದು ಏನು ಸ್ಟೇ ಮಾಡಿಲ್ಲ ನಾವು ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
is not-
ಏನೇನು ಮಾಡಿಲ್ಲ ನಾವು.
It isn't the parent body who is, it is the Lokayukta. I understand it is the KCSR rules. I understand, Your Lordship.
My lords, I even recommended to my learned friend here, learned senior friend here, with utmost respect, file a fresh petition day after tomorrow, secure a stay. We are not against it. But you can't stay, my lords.
ಈಗ ಏನ್ ಬೇಕು ಮೇಡಮ್?
Your Lordship, the difficulty.
What are you
is-
asking?
Your Lordship, they are trying to beat us to the race before Your Lordship even hears this matter. Ever since this interim order was
Interim order
granted,
ಇದೆ ಅಲ್ವಾ?
interim order was granted,
What is the interim order? Wait.
please. Your Lordship, the interim order is not to take any coercive steps as against the petitioner.
All right.
Now, this is not the parent body that is
No,
conducting.
that's all right. Coercive steps against the petitioner, what? Which crime?
Yes, Your Lordship,
Which crime?
the FIR.
All right. If they have called you for investigation in the crime, you tell me.
Your Lordship, it is emanating from the state. The difficulty is this, Your Lordship. If any departmental inquiry would go on in a span of maybe a month or
Madam,
two,
what you
here,
should
Your
do-
Lordship.
No, what you should do is file a petition in the service court, take a stay on the ground of stay that is granted in the criminal.
Your Lordship, all we are stating is, since it emanates from the very same issue,
That it
Your
will be-
Lordship,
it
if
will
they,
be
if they
outside my-
conclude this,
Outside my jurisdiction.
Your Lordship, Your Lordship, if the parent body was conducting the departmental inquiry, I understand.
Parent body may
He's-
conduct 10 inquiries.
Your
Can
Lordship,
this court
this
go
is-
beyond
this
the,
is the
beyond the
respondent.
prayer?
This is the very same respondent, Your Lordship.
I thought they're, after granting an order not to take coercive steps, they're calling you for investigation in the crime.
Your Lordship.
In a
they-
departmental inquiry, if they're
they
doing,
e-
that is not visible.
Your Lordship, they go ahead with a written statement, they go ahead with
That is in the departmental inquiry, madam.
even, I understand, even evidence is concluded so as to ensure that even before orders are passed before the Honorable Court, next hearing is on 30th. Your Lordship, all we are saying is the very
I
same
will be
respondent.
committing a harakiri if I pass any order. on this.
Lords, even otherwise, if there is a kind of a finding given there in the departmental inquiry,
That is not.
that would
binding
not
here.
bind this criminal proceedings. It's a settled position of law now.
Yes, Your Lordship, even this morning, Your Lordship had mentioned even to another, in another matter.
Yes.
I understand, Your Lordship. In this, the difficulty is that they are conducting it in a span of a week or so and then to conclude it before
I
Your
just now
Lordship.
told you what should be done.
Even
Yes,
I,
Your
Should be
Lordship,
done, that should be done without any loss of time.
I would have done that if it was the parent body, Your Lordship, in view of the
No,
fact
there's
it's the
nothing
very
like
same
parent body
respondent.
or subsidiary here,
Your
madam.
Lordship is the
What-
same respondent, Your Lordship.
Madam, how can I grant stay of departmental inquiry here? What is,
it's
The
not even impugned here, my lords, it would be.
I have stayed the crime.
Please, Your
If
Lordship.
they're continuing departmental inquiry, how can I say don't do anything?
It is the very same Lokayukta, Your
Maybe,
Lordship.
madam,
I
very
understand.
very same,
Speak from the same
madam,
FIR.
very same department, government department will be doing so many things.
Lords,
We are concerned about crime.
I beg to differ, but it doesn't emanate from the FIR. It is independent of the FIR.
Then, because it's the same petitioner and Lokayukta, it can't be.
Same set of facts, my lords. No,
No,
even I seconded what my lord said, that file a petition and get a stay day after tomorrow on the very ground that there's a stay here.
ಅವರು ವೆಕೇಶನ್ ಬೆಂಚ್ ಇದೆ.
We'll have to time it also then accordingly.
ಅದು ಗೊತ್ತಿದ್ರೆ ಅವಾಗ್ಲೇ ನಿಮ್ಮನ್ನ ಕಳಿಸ್ಬಿಡ್ತಾ ಇತ್ತು. ಇದು ಲೇಟ್ ಆಗೋಯ್ತು.
No, that's okay. Obliged.
Made you wait till 6:35.
Hello.
That's because
Deeply
BP party
obliged.
was not there.
My sincere apologies.
No, he's been busy. He was grateful to come all
No,
the
no,
way
lords,
just
not
for
in the
this,
least.
yeah.
My duty, please, oblige me.
Obliged.
All right.
My lords, 191, my lords.
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಇಲ್ಲ ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಇದೆ ತಾಳಪ್ಪ. ಎಸ್.
I'm for the petitioner, my lord.
ಹಾ.
This case, my lord, I have purchased a property in auction, my lord.
ಹಾ.
I purchased it, Kata has been transferred, my lord. After 1 year, my lord, a third party files a complaint saying that this property was mortgaged to me several years back.
ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕೊಳ್ಳಿ ಬಿಡಿ.
ಅಲ್ಲ, ನನ್ grievance ಇಲ್ಲ, ಅವ್ರ grievance.
ಅದೇ ಅವರೇ ಹಾಕೊಳ್ಳಿ ಬಿಡಿ.
Now, criminal case has been registered against
In
me
the
saying,
main.
why have you purchased the property?
In the main.
My lord, interim order.
They granted. Yes. Mahesh,
Where from Supreme Court, the PML matter is remitted back in.
PMLA ಮ್ಯಾಟ್ರಾ?
ಹೌದು.
ಇದು ವಾಪಸ್ ಬಂತ?
ಅಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ 198 ಅಲ್ಲಿ ವಾಪಸ್ ಬಂದಿದೆ. ಇದು ಫಸ್ಟ್ ಪಿಟಿಷನರ್ಗೆ ಫೈಲ್
ಮೈ ಆರ್ಡರ್ ವಾಟ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ನ?
ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರಿ.
ಡಿಸ್ಮಿಸಲ್ ರಿವರ್ಸ್ ಆಗಿದೆಯಾ?
Then to consider one particular aspect,
ಹಾ,
the matter is remitted back to your lordships. It was in the section, serial number 198, petition number 2. 151 Supreme Court order, page number 151.
ಅಲ್ಲ, I'm Supreme Court, I saw the order.
Yes, my lords. But today at 3:30, your lordship was pleased to list it at serial number 198.
ಹಾ,
That is petition number 2. ಇಲ್ಲಿ petition number 1 ಗೆ there is a
ಆಯ್ತು, ಏನ್
direct,
ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದೆ?
ಅದೇ ಪೆಂಡಿಂಗ್ ಆಗಿಲ್ಲ,
ಪಾಸ್ ಓವರ್.
ಪಾಸ್ ಆಗಿ. ಸೊ ಎರಡು ಜೊತೆಲಿ
ಎರಡು ಜೊತೆಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್
After
ಹಿಯರ್
vacation.
ಮಾಡಿ.
ಇದು ಅದಿರೋದು.
Yes, anyway, because it is my order, I only have to hear it. Yes. 13th, ನೀವಿದ್ದೀರಾ ರೆಸ್ಪಾಂಡ್ ಅದರಲ್ಲಿ?
ಇಲ್ಲ, ಇವರು
ಎನ್ಫೋರ್ಸ್ಮೆಂಟ್ ಡೈರೆಕ್ಟರೇಟ್.
ಮಧುಕರ್ ದೇಶಪಾಂಡೆ ಸರ್ವಾಗಿದೆ.
ಅದಕ್ಕೆ ಆಯ್ತು, ಸರಿ. ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ.
ನಾ ಹೇಳ್ತೀನಿ.
ವಿಲ್ ಕೀಪ್ ಇಟ್ ಆನ್
14th
ಹಬ್ಬ. ಹಾ.
15th or 16th.
Huh?
15th or 16th.
16th.
Very well.
Yes.
Great.
Tag along with that.
Maybe permit.
ಮೆಮೋ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಹಾ?
But serial number 143, my lords, 13-2 matter, my lords.
13?
13-2, my
ಹಾ,
lords.
ಏನಾಗಿದೆ?
But the matter
ಒಂದ್ ನಿಮಿಷ,
is set-
ಈಗೆಲ್ಲ ಒಂದೊಂದಾಗಿ ಪಾಸ್ ಓವರ್ ಕರ್ದ್ಬಿಡಿ ಮೇಡಮ್.
Number 26.
ಏನು ಸರ್ ಅದು?
Lords, it is up to the section 171E, 188 and
ಅದು ಕ್ವಾಶ್ ಮಾಡಕ್ಕೆ ಅಂತ
covered by judgment.
Yes, ಅದಕ್ಕೆ ಇಷ್ಟೊತ್ತು ಕಾದಿದ್ದಾರೆ, ಅದು ಕ್ಲೋಸ್ ಮಾಡ್ಲೇಬೇಕು. ನಮ್ ಜಡ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಪೇಜ್
Compilation.
ಕಂಪೈಲೇಷನ್ ಒಂದ್ ಹೇಳಿ ಸರ್. ಉಮೇಶ್ ಶೆಟ್ಟಿ ಕವರ್ಡ್ ಮೇಡಮ್.
132.
ದೀಕ್ಷಿತ್ ಸಾಹೇಬ್ರದ್ದು ಇದ್ದಾರೆ. ಉಮೇಶ್ ಶೆಟ್ಟಿ ಅಂತ ಇದರಲ್ಲಿದೆ, ಹುಡುಕ್ತೀರಾ ಕೊಡ್ಲಾ?
Dheeraj Muniraju, State of Karnataka.
ಅಂದು ಇದೆ ಸೇಮ್
Criminal petition number
ಕಂಪೈಲೇಷನ್ ಇದೆ. ಎಸ್, ಅಲೌಡ್ ಕ್ವಾಸ್ಟ್. ವಿ ಕ್ಯಾನ್
Against
ಗೋ
both
ವಿತ್
the
ಪ್ಲೀಸ್.
petition.
ಹಾ,
Against both the petition.
ಬೋತ್ ದಿ ಪೆಟಿಷನ್. ಎಸ್, ಎರಡು 171 ಸೇಮ್ ಅಫೆನ್ಸ್ ತಾನೆ? ಎಸ್, ಹರೀಶ್
171E, 188.
ಸೇಮ್ ಅಲ್ವಾ?
49.
Serial number 49, I'm appearing for the respond number 2.
Ah.
This is that landlord tenant dispute, my lords. Last date of hearing a
ಅದೇ
direct them to
ದುಡ್ಡು
secure
ಕೊಟ್ಟಿರ್ಬೇಕು.
instructions.
Lord, I appear
Morning
for
when the
Arun.
matter is reached.
I'm here, my lord. I appear
Yes,
for the
sir.
petitioner.
You have
My lord,
not paid any rent. This can't be
my
the-
apologies, my lord. My apologies. My lord, your lordships had directed me last time. I said I would come up with a plan. My lord,
Yes.
unfortunately, my client's father, my lord, is in the hospital. His father is undergoing some brain.
All right.
Therefore, my lord, I will submit a plan. My lord, your lordship has my word. I will submit a plan, my lord, on how I will repay all the rent. My lord,
I'll
I will-
post it on 8th.
Lord, made.
Very well. Very
8th
well.
for further hearing. ಈಗ ಇರೋದೇ
Very
ಅಲ್ಲ.
well. Very well. Very well.
ಅದು ವರಿ ಮಾಡಿ. 8th for further hearing. Yes.
Very well.
Yes, next.
Obliged. But the interim order expires.
That will continue. Yes.
Let's say interim order. Yesterday also I had moved.
ಯಾವ್ದ್ರಲ್ಲಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಎಂಟ್ರಿ ಮಾಡ್ರ?
Extension of.
ಬಂದಿಲ್ವಾ ಅದು?
ಬಂದಿಲ್ಲ.
ಮೇಡಮ್ ಯಾವ್ದು?
Serial criminal petition number 11202 of 24.
ಧಾರವಾಡದ?
Okay. Some.
ಧಾರವಾಡದ?
ಅಲ್ಲ, ಇಲ್ಲಿಂದ.
11202. ಅದು ನಾನು ಜನರಲಿ ಲಿಮಿಟೆಡ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಡೋದೇ ಇಲ್ವಲ್ಲ? ಬೇರೆ ಬೆಂಚ್ ಕೊಟ್ರದ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ತಾವೇ ಕೊಟ್ಟಿರೋದು ಆನ್ 4/12/2024.
Yes.
ಆ ಲಿಮಿಟೆಡ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವತ್ತು ಆನ್ 14
ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಾ?
ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತ 4/12 ಕೊಟ್ಟಿದ್ರಿ.
ಹ್ಮ್.
ಅದಾದ್ಮೇಲಿಂದ 14/12 ಬಂತು ಸ್ವಾಮಿ.
ಅವತ್ತೇನಾಗಿದೆ?
ಅವತ್ತು ಅದೇ ಟೈಮ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇದಾಯ್ತು ಸ್ವಾಮಿ, ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ರಿ.
ಹಾ.
ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಐ ಸೆಡ್ ರಿಕ್ವೆಸ್ಟ್ ಇಟ್ ವಿಲ್ ಕಂಟಿನ್ಯೂ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ತಾವು
Correct.
ಹೇಳಿದ್ರಿ ಸ್ವಾಮಿ.
ಹಾ.
ಬಟ್ ಬೈ ಇನ್ಆಡಿಟ್ಲಿ ಇಟ್ ಈಸ್ ನಾಟ್ ಬಿನ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್.
ಅದು ನೋಡಿ ಮೇಡಮ್, ಯಾವ್ದು ಚೆಕ್ ಮಾಡಿ ನಾನು ಮಾಡಿಸ್ತೀನಿ.
ಅದು ಒನ್
ನಂಬರ್ ಕೊಡ್ಬಿಡಿ ಅಷ್ಟೇ.
112.
ಡೋಂಟ್ ವರಿ. ಎಸ್.
ಮಚ್ ಆಫ್ ದಿಸ್.
Serial number 117, my lord.
Ah.
It's a 498 case, man.
117.
Admission giತ್ತು, my lord.
ಯಾಕೆ
Admission ತಗೊಳ್ಳಿಲ್ಲ.
ಅಲ್ಲ, ಅದು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು.
First time, my lord. So, my lord,
ಒಂದು
ಇದರಲ್ಲಿ
ನಿಮಿಷ, ನೋಟಿಸ್ ಆಗಿದ್ರೆ ಮತ್ತೆ
ನೋಟಿಸ್ ಆಗಿದೆ, my lord. ನೋಟಿಸ್ ಆಗಿದೆ.
ಅಡ್ಮಿಷನ್ ನೋಟಿಸ್ ಆಗಿರೋವೆಲ್ಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
No, my lord, date may fix, my lord. Any date, my lord. After
ಆಯ್ತು,
vacation,
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ. ಅಡ್ಮಿಷನ್ ಮೇಡಮ್, ಡಿವೈಡ್ ದಿ ಅಡ್ಮಿಷನ್ ಕೇಸಸ್ ಇಂಟು 3 dates.
please, my lord.
ಟ್ಯೂಸ್ಡೇ, ವೆನ್ಸ್ಡೇ, ಥರ್ಸ್ಡೇ. ಫಸ್ಟ್ ವೀಕ್ ಬೇಡ, ಸೆಕೆಂಡ್ ವೀಕಲ್ಲಿ ಮಾಡಿ.
Please, my lord.
ಟ್ಯೂಸ್ಡೇ, ವೆನ್ಸ್ಡೇ, ಥರ್ಸ್ಡೇ ಹೇಳ್ದವ್ರು ಮಾಡಿ. ಯಾರ್ಯಾರ್ದು ಡೇಟ್ಸ್ ಬೇಕು ಅದನ್ನ ಹೇಳ್ಬೋದು.
134. Number 127.
On the 12th for it to be coming up on in fresh matters today.
Huh.
Not been admissions. It's a fresh matter where no notice has been issued. Could I
ನಾಟ್
request-
ಇವನ್ ಒನ್ಸ್?
Not even once.
ದೆನ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
Yeah, I'm okay.
ಒಂದ್ಸರಿ ನೋಟಿಸ್ ಇಶ್ಯೂ
Not at
ಆಗಿಲ್ಲದೆ
all, not
ಇರೋದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
Completely fresh, in the fresh matters list.
ಇರೋದೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Very, I'm with you.
ಎಸ್ ಮೇಡಮ್.
191, my lords.
191.
The 7A matters.
Ah.
We've completed the argument you had asked. Wait, we've completed our argument.
Patil
We've
Rai.
But
submitted the
everyone is
document.
of a notion that they have more or less said what they want to say in terms of senior counsels on the petitioner side, as well as my lords, with the deepest respect, I and some of the counsels on behalf of Loka Vitta also we have had an opportunity to make a few submissions and have filed our compilations. Now, my lords, I only request, my lords, if that is the submission of the petitioner's counsel, I would request my lords to fix a date by which whatever written submissions we want to file on the principles of law, we'll file it. From then on, we can go ahead with the 10 matters as my lords have rightly.
Yes, Sanya, tell Sandesh.
Please, my lords, one more thing is R2 had to be served, my lords. We had to take out hand summons.
ಅದಕ್ಕೆ ಬರ್ಲಿ.
Some of
Now
them have
you
been
take,
served.
some of them are served in those cases. By the next date, I think everybody would be served. I'll take those matters on, I'll fix it.
16th, my lords has given a date on 16th.
16th we'll do it.
16th. So from 16th onwards, my lords, we could have a 10 matters
We'll
every
see.
day.
I don't know the planetary position after vacation.
Please,
Whether I
Subject-
will be,
subject
I
to
will be
convenience
here
of my
or
lord.
outside or whatever. We'll see.
please, please,
We'll fix it. If it's outside, then on VC.
please,
Yes.
deeply.
My lords, 190.
Serial number 191.5. Lord, second respondent is served by hand. He is present before the court.
ಅವ್ರ ಹೆಸರು ಯಾರನ್ನ ಎಂಗೇಜ್ ಮಾಡ್ತೀರಾ? ಅದು 191.5. The respondent is present in person, seeks 10 days time to engage the service of a counsel. List the matter on 16ನೇ ತಾರೀಕು ಹಾಕಿರ್ತೇನೆ.
In 191.5, my lords, the interim order was not extended last time, my lords.
ಅದು ನೋಡ್ಕೊಂಡು.
My lords,
There won't be any problem from Lokayukta, don't worry,
Please.
unless I hear these matters.
my lords, serial number 137.
ಏನ್ ಬೇಕು?
Deeply obliged.
23rd ಬೇಕಾ? ಹಾ ಸರಿ, so what? ಎಲ್ಲ 23rd ಡಿ ಅದೆಲ್ಲ. ಎಸ್
Serial number one,
Serial number
serial number
127.
127, my lords. Serial number 127.
Ah.
I filed an objections to for vacating IA as well, my lords. ಅದು NA Act ಅಲ್ಲಿ
ಏನ್
there is-
ಬೇಕು ಸರ್?
ಅಲ್ಲ, there is a presumption of, ಇದು statutory presumption of section.
ಈಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕಾಗತ್ತಾ?
At least
After
vacating.
vacation.
Date may be given, my lords.
Who is the petitioner there?
He is absent.
ಯಾರು? ಅವಿನಾಶ?
Absent.
Where is ಅವಿನಾಶ್? ಅವಿನಾಶ್ ಹೇಳಿ ವೆಕೆಟ್ ಮಾಡಿದ್ದಾರೆ ಮನೆಗೆ ಹೋಗಿದ್ದಕ್ಕೆ ಅಂತ interview.
Please.
Yes,
My lords,
My
serial
lords,
Date may be
number
given.
139, my lords.
one minute. Niಮ್ದೇನ್ ಒಂದು serial number 138?
127.
Offense is 138.
Section 130.
All right, ಸರಿ. ಅದೊಂದು ಫಿಕ್ಸ್ ಡೇಟ್ ಮೇಡಮ್. 17th, yes.
Serial number 139, my lords, has been issued.
Stay vacate, my
If I may be allowed to argue.
Now,
Yes, my lords.
seriously. Yes, sir.
It's actually on parity.
Notice issue ಆದ್ಮೇಲೆ ಇಲ್ಲ.
ಅಲ್ಲ, on
ಆಮೇಲೆ
parity, ಇದ್ರ
after-
same, similar grounds ನಲ್ಲಿ ತಾವು
after
stay
vacation.
ಕೊಟ್ಟಿದ್ದೀರಿ. On
ಈಗ
parity.
ನಾನೇ ನೋಟಿಸ್ ಮಾಡಿರೋದಾ?
ಹೌದು.
After vacation.
my lords, serial number 137. If interim order may be extended till the next date of hearing,
That'll
I'm
wait.
appealing for the petitioner.
Don't worry.
Much obliged.
My lord, serial number 138, my lord. Serial number 138, my lord.
ಏನದು?
Kindly have it a day after tomorrow, my lord.
Day after tomorrow, why sir?
My lord, it is a POCSO matter.
Settlement?
No, my lord.
Then?
There is a stay without treating a witness
After
hostile.
vacation, yes, next.
My lords, serial number 143, my lords. Because I'm told the charge sheet is filed and it's set out for trial. Therefore, my lords, request for deferment of trial, my lords. 13-2, my lords, PC Act. 140.
ಫೈಲ್ ಬೇರೆಯವರು ಕೇಳಿದ್ರಲ್ಲ ಮೇಡಮ್, ಅದು ಆರ್ಡರ್ ಬೇರೆ ಕೇಸಲ್ಲಿ ಮಾಡಿದ್ರೆ ಮಾಡಿ.
My lords, some matters are not listed.
ಎಲ್ಲ ಟ್ಯಾಗ್
Connect.
ಮಾಡಿಬಿಡಿ. Yes.
The pending. Great. Same order as 130.
43.
Same order as serial number.
23rd. Same order as which number?
Madam, that